the Constitution. The Law and Constitution Dialogue has emerged as India's biggest televised legal event that fosters public engagement by bringing together lawmakers, jurists, legal experts, law students, authors, entrepreneurs, and thinkers in live discussions on critical legal and constitutional matters. Ladies and gentlemen, Legally Speaking is India's first televised weekly platform dedicated to the legal community, airing on NewsX. It features prominent jurists from India and internationally, including the US, Australia, and the UK. It is hosted by the ITV network, which operates multiple news channels and newspapers. And the sessions reach a massive audience with 300 million monthly viewers and 40 million social media followers. With that, I request our team to please present the Legally Speaking show reel. Let's tell our audiences and our viewers what Legally Speaking is all about.
We are the mainstream media's dedicated platform to serve India's legal community.
एक देश, एक संविधान, एक झंडा. One country, one constitution, one flag. That is the core of our democracy. The legal community is the core of the core. We are here to build a community in the mainstream media for you, a platform for jurists, with jurists and by jurists. We are doing what it takes. Come join us and make this the go-to platform for serious news, views and conversations.
100 episodes of Legally Speaking have aired on NewsX, India's first and only primetime national television news show dedicated to the legal community. More than 100 dedicated columns published in the Sunday Guardian in print and online. More than 1,000 dedicated columns published in the Daily Guardian in print and online, with a dedicated website.
Today, law is a very popular profession. Today, a lot of people want to join the law.
We need to meet the parameters of the offences.
With deep dives.
In a constitutional court, there are lots of cross tensions.
We have to have very good trained mediators of established reputation.
With legal luminaries from across the world.
How much can a person be surveilled in the future? This is a role of court.
Unlike other countries, our two nations have a commitment.
In-depth biographical interviews.
I did huge number of cases.
For the first 3 months in Cambridge, I was a very active debater.
Full live prime-time telecasts of the Ram Jethmalani Memorial Lectures organized by Mahesh Jethmalani.
Overwhelming thank you to NewsX and the Sunday Guardian Foundation for not only telecasting live this event, but for the relentless publicity campaign that preceded it.
It has been a great honor reminiscing the legacy of Ram Jethmalani, one of the greatest of our times.
Hosting the Will of Steel Awards in the memory of Ram Jethmalani on his birth centenary year in 2023. The largest legal and public service journalism awards in the world, with the award winner receiving 12 lakh rupees. Full live telecast of the L.M. Singhvi Memorial Lecture organized by Dr. Abhishek Manu Singhvi.
The practice of democracy through universal adult franchise is not just limited to Delhi, but is happening in the remotest parts of India.
And the first Law and Constitution Dialogue hosted by Legally Speaking with Justice Suryakant in 2022.
Media has a heightened responsibility due to the greater power that it enjoys. The power to shape the views and attitudes of hundreds of millions.
Live primetime telecasts of the Justice J.S. Verma Memorial Lecture organized by Vivek Tankha.
Justice J.S. Verma, the iconic man of this place.
Our aim is to curate quality conversations with eminent jurists which take forward jurisprudence, also inform, educate, stir debate. This is what has been our aim at Legally Speaking. We also take up relevant issues from time to time that involve the future of the judiciary, also the court systems with eminent retired judges, also former ASGs, sitting ASGs, also eminent jurists. This is what we do on a weekly basis.
Because in the end, we need to restore and renew the logic of the mainstream media, which is to raise the bar, not just sink beneath it. It is our duty to put on the national agenda the very important issues raised by jurists who play such an important role in so many path-breaking matters in the country. Legally speaking, the future of community service journalism in India's mainstream.
With that, viewers, we also take a moment to look at the ITV network showreel. What is the ITV network all about? Could we have the ITV network showreel, please?
India's most credible journalists presenting you news, views and impact stories from India and across the world. Home of India's biggest news campaigns. Host to India's biggest platforms. This is India's fastest growing media house. This is the ITV network with 2 national news channels, India News and NewsX. ITV network has 6 regional news channels with landmark news events. Our viewers love to connect on their platform of choice and making news and information available at fingertips. ITV network has 5 newspapers, winning hundreds of awards as a testament to the value we bring to India's people.
Viewers, I now take a moment to welcome Mr. Rishabh Gulati, Editor-in-Chief of NewsX, to open the 3rd Law and Constitution Dialogue. Rishabh, over to you.
Devika, thanks a lot, and to our audience here, as well as to people watching this across the entire network, which is NewsX, India News, and all our regional channels. A very warm welcome to what is going to be a marathon all day with 21 sessions scheduled, and it is a fitting moment that this is happening on the eve of the 75th anniversary of India concluding its Constituent Assembly. A lot of conversation is going to be taking place here. A lot of conversation is parallelly taking place in Parliament. It is my proud privilege to welcome the members of Parliament, 22 of which are going to be with us on this podium today, including, of course, jurists. We are going to have judges of the Supreme Court, the law minister, judges who have already served in the Supreme Court, various high courts, and of course we'll be discussing a lot of controversial topics, from delimitation to secularism to Waqf to the Temple Act. It's all going to be here. We're going to get perspectives from all across the board. Due credit and my many thanks as a professional journalist to Karthikeya Sharma, who's the founder of this network, Member of Parliament in the Rajya Sabha. He has not only nurtured this network for the past 15 years, built it with 1,200 journalists across 17 major bureaus. And as we embark on new ventures, it is a pleasure to see Aishwarya Pandit Sharma, who has now taken over, of course, as chairperson of the Sunday Guardian Foundation and plays an active role in our ventures as well. My thanks as well to Rana Yashwant, the editor-in-chief of India News, Rakesh Singh, our managing editor, Tarun Nangya, the editor of Legally Speaking, Priya Sehgal, our editorial director, and all the senior team staff members that have put this together. It is going to be a jam-packed day. Let's just get started.
Thank you so much, Rishabh. And with that, of course, without further ado, it gives me immense pleasure to announce our first session with Shri Kalanidhi Veeraswamy, Member of Lok Sabha, DMK. Sir, I request you to please join us on the stage. Shri Sasmit Patra, Member of Parliament from the BJD, and Shri P.P. Chaudhary, Member of Lok Sabha, BJP, as well as a senior advocate, to please join us on stage. The session will be moderated by Mr. Rishabh Gulati, Editor-in-Chief of NewsX, and of course they will be discussing the big topic, census and delimitation, the North-South test. Over to you, Rishabh.
Thank you very much, Devika. And yes, what a discussion topic to have to start this off with. Ladies and gentlemen, when the first census was conducted in independent India in 1951, we counted 361 million people. By the time we conducted the 15th census in 2011, we were counting 1.21 billion people. You all know that India now is the world's most populous country. As we speak, we are north of 1.5 billion people. In just a few weeks from now, the next census exercise will begin. And we will get a footprint and a fingerprint of where we stand as Indians. How many of us are there? And there are so many things that you know are going to become interesting as well as controversial. What are we going to learn? Is it true that in the percentage terms, the population in South India will go down? Is it true that it is in the north that the population is expanding? Is it true that in this country we need a caste census to reimagine ourselves? Will we figure it out and have controversies about what is the percentage of Muslim population in this country? What is the percentage of Sikh population in this country? And will this result in a delimitation exercise that fundamentally changes the structure of India's Lok Sabha? Let's have this conversation. Shri Kalanidhi Veeraswamy, Member of Parliament of the Lok Sabha from the DMK is with us. Shri Sasmit Patra, Member of Parliament is with us. He represents the BJD. And Shri PP Chaudhary, Member of Lok Sabha. He's a senior advocate and he's of course from the BJP. Mr. Veeraswamy, let me begin with you, sir. Just literally a few weeks ago, your party Chief Minister of Tamil Nadu, M.K. Stalin, is going out and telling Tamils, have 16 children. Why?
Good morning to every one of you. I think it was more of a figurative way of saying that. I mean, I'm sure he's not meaning that. But if you look at how Tamil Nadu has progressed over the past 75 years, you will find that Tamil Nadu was one of the poorest states, the bottom three. It was in the bottom three. And over the past several decades, we have reached where economically we are the second largest in the country. And also, when the government of India came out with this issue of population rise, so we have taken measures where the implementation of family planning was done effectively, and earlier where our total fertility ratio was above 3, today it is 1.7. So when you talk about total fertility ratio, it is the number of children a woman can have in the childbearing age. And if you have a number of 2.1, the population sustains. Yes. So if the number is above 2.1, the population is bound to keep increasing. So what we find is most of the southern states have achieved this, where their total fertility ratio has come down to 1.6 or 1.7, like Kerala, Tamil Nadu, and even Andhra, Karnataka. But sadly, the total fertility ratio of most of the north states, especially Bihar and UP, still stays about 2.7 or more than 3. So what is happening now is the population of Tamil Nadu, Tamil population, is falling. And you will find that there has been an influx of a lot of people from northern states who come there as migrant laborers or for better opportunities.
So Mr. Veeraswamy, you are saying that we are a success story. Tamil Nadu, you know, there is a space center being built there in Tuticorin. We are seeing the latest technology, the Apple iPhones. It's a state with a huge maritime potential. You are a success story in family planning. But because you've been a success story in family planning,
we are being penalized.
Are you
we are being penalized. See, the whole point about the delimitation, since emergency, it has been kept being postponed for like 25 years and 25 years, mainly because if you're going to go by the census of 2011, and the present government, where the census should have been conducted in 2021, I think it is not by chance that the census is being postponed. Because the 2002 Delimitation Commission has said that after 2026, the census should be done, and only after that, the delimitation process should be exercised. So, taking that into view, I think probably it is by design that this government has not conducted the census in 2021, claiming that COVID as a cause. Because if COVID was a cause, they could have conducted it any time after 2021, where the whole exercise could have been finished within 3 months.
Okay, I'm going to ask you about the seats because it's a larger argument. Do we need more MPs in Parliament? Probably. But where is it go? Where are they going to come from? Where will the extra seats carved out? Dr. Sasmit Patra, the East is a similar story. Do you also feel that when the census comes up with the facts and figures, we'll have them maybe in a year's time, that we will see in percentage terms that the population in the north and west has gone up more than the south and the east?
Firstly, thank you so much to Legally Speaking, NewsX Network, my dear friend Karthike, and the entire team for inviting me today. It's indeed an interesting day, primarily because we are deliberating on law and constitution, especially when the Lok Sabha is going to start deliberations on a 2-day constitution debate, which is quite historic. And both Mr. Veeraswamy as well as Mr. Chaudhary would be participating on it, and on Monday and Tuesday we'll be doing it in Rajya Sabha. Coming back to Mr. Gulati's question relating to whether in the East we see it differently or the same. Firstly, everyone knows the fertility ratio or the fertility rate per se in every state. My 2 cents in this matter is, I would like to wait for the census to come in. There are many speculations that are doing the rounds, as Mr. Gulati has said, relating to would the southern states lose out? Would the eastern states lose out? Would the northern states gain more? I believe anything that does not go with the idea of equality as per Article 14 or somewhere violates Article 15 or Article 16 would surely be struck down. Now, whether that be the Delimitation Commission or whether that be the outcomes that comes from census and its further challenges to it. So I would rather wait, but one thing I must join issue on is the caste census. And the Biju Janata Dal and our leader, former Honorable CM Shri Naveen Patnaik ji, has always been batting for caste census. And the reason is, why? Is it a populistic measure? Is it sensational? That is why we are talking about the caste census? No. If you remember that all our welfare programs of the country stems from which? SECC data. Socio-economic caste census survey that was done in 2011. Today, between 2011 to 2024, you have about 13 years that have passed. Is the SECC data still relevant? May not be. But today, all our measures, whether it's the Pradhan Mantri Awas Yojana, whether there are the various schemes, still draws their details from SECC. So, more than caste census for political reasons, I believe caste census is essential to identify reservation and the proportion of reservation. Second, the welfare measures that needs to be provided, and social justice.
Okay, so you will be watching out not only for the overall population figures, because yes, you are probably concerned, but you will also be watching out for the caste census. Let me get Mr. Chaudhary into this conversation. Mr. Chaudhary, because we've heard M.K. Stalin, and it might be a rhetorical suggestion as Mr. Veeraswamy is saying, but we've also heard Mohan Bhagwat ji saying that look at what's happened in Japan, look at what is happening in Northern Europe, that yahan par all the populations are falling. While India is 1.5 billion, we still need to have a reasonable growth rate of population. Do you agree?
Yes, I agree with it, because initially we saw a few years back the population was there, but on account of the demographic advantage. So in India, the population is planning, and we have to make the pass for it. And I think, into my mind, the statement made by Mohan Bhagwat is perfectly correct, so far the Indian perspective is concerned.
Is that driven by the fact that the good of the country will be served with a sustainable population? Mr. Veeraswamy said that is 2.1, the fertility rate is 2.1. Or many people will say that, look, there is a concern that the percentage of Muslim population is rising, and that's what's driving it. This is not meant to all Indians, this is meant to Hindus.
This is nothing to do with that, because overall, this is nothing to do with the particular religion or this anything other. But this, so far as this earlier, the population is falling so far as India is concerned if you compare the other years. So that's why it is a relevant statement made in this perspective.
Okay.
One second.
Yeah, Mr. Veeraswamy, go ahead.
No, I just wanted to clarify about our Chief Minister's statement. See, in Tamil Nadu, whenever we go and attend a wedding, we always say, Padinarum Petru Peruvar Varga, which translates to have 16 wells and prosper in life. So when he says have 16, he probably is meaning about...
He's being rhetorical, obviously, but...
No, it's about 16 wells, which is not children. So it's basically about health,
children.
long life,
much lost in translation, but the premise remains that there is a concern in Tamil Nadu that the population in the north will go up, and which brings us to the subject that we've touched upon, but let me jump into it. Ladies and gentlemen, in this country, every Lok Sabha member of parliament represents 16 lakh voters and 27 lakh people. In the United Kingdom, with a population of 68 million, they have 650 members of parliament in the House of Commons. They represent 1 MP per 1 lakh. Mr. Chaudhary, do we need more MPs in the Lok Sabha?
First of all, I would like to correct on that. In some of the states, it is 16 lakhs voters. But in a state like me, and so far as my constituency is concerned, we are having around 22 lakhs voters.
Yes, yes.
So, because if you want to have the effective representation of the member of parliament to deal with the constituencies, then I think the more Lok Sabha MPs must be there.
So yes, so that's a yes. Sasmit Patra ji, we have gone through the last 3 decades where we are saying that we need to create the state of Jharkhand, we need to create the state of Chhattisgarh, we need to have Uttarakhand. Therefore, the number of chief ministers has gone up, the number of MLAs has gone up, the number of state ministers has gone up. Why not the members of parliament?
No, I'm not contesting that there shouldn't be an increase in the members of parliament with respect to the ratio. But it's interesting, as a country, we call ourselves the largest democracy in the world, but there hasn't been a single data point, a single study that has studied the performance of one member of parliament versus the total constituency. One member of legislative assembly versus the total constituency. What is the right mix? What is the right ratio of a population versus one member of parliament? Is it 10 lakhs, 15 lakhs, 20 lakhs, 5 lakhs? So I believe instead of looking at numbers from the perspective of volume, we should be rather looking at efficacy and effectiveness.
Okay, so if anybody out there is running a think tank watching this broadcast, this is an open call that we have to have science behind it. It cannot be an arbitrary figure. The science has to tell us what is the most efficient representation per MP, per the number of constituents. But we have general consensus, sir, Mr. Veeraswamy, that the number of MPs should indeed go up.
My view on this is that the representation of people adequately should be done where, like, the numbers should come down, the number of population. So I agree with the number of MPs going up. But I also would like to say that when I used to look at the US system of elections, they have something called as the electoral college.
Yes. So on proportional representation, I'm just going to come to you. So in premise, everybody agrees that number of MPs should go up. The big question then is, by how much? PP Chaudhary ji, we have to implement 33% reservation for women as it is in 2027. So we are just a couple of years out from that. So should the number of seats go up by 33%? By a thumb rule, ladies and gentlemen, the new Lok Sabha that has been built can host 800 people. Okay, so that's the cap right now, physical cap right now. Mr. Chaudhary, by how much? 30%, 50%, how much?
Because first of all, this formula is required to be devised, and it is for the Delimitation Commission and the lawmaking authority. Because we can't say just now what is the proportional representation. Suppose you have to strike the fine balance between the state and the population of that state. So in northeastern area, just in Arunachal Pradesh, you have 2 members of parliament. The area is very large. Now if you say that because the population is less, member of parliament should be more. And in those areas where the population is more, we can't have the more member of parliament. So between the states and the population, the fine balance is required to be struck, and the fixed formula can't be there, that on the basis of a particular population, you must have one member of parliament. It may differ state to state, but at the same time, we have to strike the fine balance between the states and the population of that state.
Okay, so Mr. PP Chaudhary is actually giving the reasonable consideration that the states that have actually managed their populations very well should not be punished in representation in parliament. But how do we do? So sir mentioned how the United States works. They have electoral colleges, which means the states like Utah, Nebraska, with small populations still matter when it comes to electing a president, which is why you can lose the popular vote and still be president. But Mr. Veeraswamy, how do we then do it? Do we say that, okay, if there are 42 MPs in Tamil Nadu and there are 80 MPs in UP, so if you are increasing by 33%, then everybody gets 33%. You get 15 more MPs, UP gets 25 more MPs. Should it be proportional or should it be population? Or should it be a mix?
See, as it is, if you look at the southern states, the 5 states all put together, we have a total of 130 members of parliament.
Yes.
So the balance of, say, about 423 MPs come from the northern states. And for any government which is interested, I mean, any party, political party, which is interested in forming a government, they need not even bother about this 130 MPs. And they can focus on the 423 constituencies where they probably will be able to form a majority. So this is what we believe is happening, because Bharatiya Janata Party today, the ruling government, they do not have any consideration for the southern states, be it either as flood relief or for any kind of disbursements of the funds. I mean, like if you're looking at the taxes which are being devolved to us, for every rupee that Tamil Nadu pays, we get back only about 29 paisa. Whereas Karnataka gets, for every 1 rupee given, they get only 16 paisa. So most of these states, we are bearing the brunt of development. And now you're saying that the proportionate representation is going to make it where we are going to lose further in the number of MPs in comparison to most of the northern states. I feel that there should be some kind of an adjustment where, like the electoral college, individual state should have certain numbers to match, so that if you're going to say that we are going to increase the number of MPs in Tamil Nadu by only, say, about 5, yes. Whereas in Uttar Pradesh, from 80, if they're going to make it 100, I say the strength of Tamil Nadu should be increased by 20 points, okay, which will be added.
So yes, proportional, that if we are increasing 20%, then 20% for everybody. This is what you're saying. If 30%, 30% for everybody.
No, I am saying based on your development and your contribution to the country, both economically and in achieving your sustainable development goals. Based on that, give points to individual states.
So calculate, and as Karthi Chidambaran ji is walking in, he'll probably agree with that. But Mr. P.P. Chaudhary is being reasonable. Mr. P.P. Chaudhary, do you discriminate at the center, regardless Congress, BJP? Do you ignore the southern states, the northeast states, because electorally in parliament, they don't matter?
Because electoral college, at the same time, is very, very important. You can't ignore. Basically, we go by that, and our system is based on that. Simply because the geographical area or the state is demarcated, all the states are not demarcated on the basis of the population. So either you go for the demarcation of the states, the revision of the states, all this. So initially I have said you have to strike the fine balance. It can't be the exactly same. But at the same time, you can't ignore the population. After all, they are the electoral college. They are the voters. And you can say the smaller number of voters can have the more say. So that's why you can't have to strike a fine balance. So justice should be done with the both.
Okay, that is the complexity of the argument.
You can't a straight jacket formula.
That's why it's complex. There's no straightforward solution. Sasmit ji, do you agree with the premise that if the state is not the fulcrum, in make or break of a government at the center, therefore it is subconsciously those in the center will ignore that state in terms of development priorities?
No, I don't think any government, whether in the center from whichever party, can really afford to neglect the state. I don't think in a federal form of governance we have. And I would also not like to dwell on the north-south debate, because we do not know in terms of delimitation how it's going to play up. My understanding is, instead of, as I said, we do not have scientific data, or we do not have a scientific study to identify what should be the ratio of public representatives versus a population. Let's say in a state X, maybe one member of parliament may be good for 10 lakh voters. Another state, one member of parliament may be relevant for 7.5 lakh constituents. So therefore, to have one size fits all, you come to my state of Odisha, there are primarily 3 regions: the coastal Odisha, the western Odisha, the southern Odisha, and there is a part of the northern part of Odisha. Now, all the 3 or 4 regions have distinct socio-economic presence, also have cultural identities, which also have subtext. Now, if you were to mix all of them up and say all of them are one, it's not true. Similarly, every state has their own understanding in terms of one MP constituency means what. So I believe instead of probably defining it only by number terms and saying 10 lakhs, 15 lakhs, 20 lakhs, it will do, let's cut it by 30%, 40%, add 20% all around. It's like a, it's like a piece of cake.
Okay,
You cut
all right.
more and
We've got rare consensus that the number of MPs should go up. But we have no clear formula on how to do so. This is why it's going to be very complex. So, Mr. P.P. Chaudhary, let me ask you the one question you raised. We only got 2-3 minutes left. Caste census, it has been the primary pitch of the opposition parties since before the Lok Sabha elections. The logic that Sasmit Patra is telling us that if you want to do reservation, if you want to do government schemes, if you want to do welfare, you need to know it. This is a basic thing that you just need to know as a data point, forget the politics. Do you agree?
Yes, I fully agree with it, because otherwise no purpose will be served with it. And once you have to determine, just because once you belong to a particular SC or ST class, the reservation is already there. But knowing the number of those persons will not give any helpful this thing. But only thing is that if you want to increase the reservation system or that. But since it has been fixed in the Constitution itself and everybody is satisfied with the basis of reservation, so in my opinion, no purpose will be served for the caste census.
Okay, we got a couple of minutes, so I want to address these hot potatoes. Mr. Veeraswamy, it's a genuine issue because caste is an issue of controversy and conversation in this country. Religion remains an issue of controversy and conversation. You and I know, sir, that once the census figures come out, they are probably going to tell us that not only in real terms, but in percentage terms, minority populations have gone up, Muslim population has gone up. Will that create concern in this country? Will it become a political hot potato?
Definitely. That is the reason why the present government dispensation is not keen on having a caste census. So, and they have been kind of postponing it. And I feel that the whole purpose of this exercise of census is to ensure that we identify the target people who have to be reached out. Like Mr. Patra had said, regarding the benefits which are going to be given to them, opportunities and reservations which are going to be given to them. And in that note, I would also like to say when we are going to have this constitution debate happening in Parliament, you have to understand that the 17th Lok Sabha was passed without a deputy speaker being elected, which is a constitutional post. So the present dispensation is so insecure that they do not even want to give the post of a deputy speaker even to their alliance parties. And they have been like the census also, with great design, they have planned it in such a way that it can be conducted in 2026. Otherwise, if it had gone by schedule, the census should have been conducted in 2021.
Okay, so you say it's conspiratorial because the government doesn't want you to know the data
because the next census would have been 2031.
Or may change things. But P.P. Chaudhary, let me ask you this question, sir, because you know this will be an issue. Should Hindus in this country be worried if they see that in percentage terms the Muslim population is going up?
Yes, definitely, because that is not a reasonable and it will create inequality among the society.
Let me ask the opposite question to Sasmit Patra. Should Muslims then be worried that Hindus are worried about their growing population?
You know, Mr. Gulati, I'll not get drawn into your question.
I'm trying.
You're trying, but I'll not get drawn in. All I'll say, let me give you a generic answer to this. The generic answer is that in the census, or even let's say caste census happens, whatever findings we have will be dwelt and looked through the prism of politics. Many narratives will be drawn, each suiting to oneself. And that's how it's going to play up into the delimitation and then on to the reservation and then on to 2029. If one nation, one election happens before, as we hear, then probably we might have one even before this starts.
Okay, we're going to come back and discuss one nation, one election in a different panel. But I want to touch upon this for a second because it's very real. Our entire lifetimes have been spent worrying about too fast population growth. Will the next generation be worried about population collapse, Sasmit Patra?
Well, population collapse is not going to happen anytime soon, but we should surely plan to see that we don't become an aging population.
Okay.
With the fertility
We should
ratio
not grow old before we grow rich. Are you worried about a population collapse, Mr. Veeraswamy, in Tamil Nadu?
No, it is bound to happen. I feel that Mr. Patra's hopes are not going to be met because there is a study which says that the population of India will start falling from 2060. And I mean, I'm sure that even the northern states, the total fertility ratios are bound to come down.
Yes.
And just like how Japan is facing a senior citizen crisis, I mean, like the number of population above 60 is become huge. I'm sure sure that in the next 3 decades, we will be facing a crisis.
Mr. P.P. Chaudhary has already said that he agrees with Mohan Bhagwat that, that we have to concern ourselves not with the increasing population, but the potential of a declining population. This has been a fascinating conversation. Thank you for navigating it with me, and it's been a treat. Thank you to all of you, and thank you to our viewers for watching this.
Thank you very much. Thank you.
This morning to open the third Law and Constitution dialogue, I will request Mr. Kalanidhi Veeraswamy, Mr. Sasmit Patra. I would request Mr. Kalanidhi Veeraswamy and Mr. Sasmit Patra and Mr. P.P. Chaudhary to please accept a token of our appreciation. We highly respect that you've taken out moments from your precious time to be with us here today. A very special memento being presented to our panelists. It's a copy of the Indian Constitution. And this is, of course, a photograph of the first meeting of the Constituent Assembly, which was attended by 205 members, viewers, including 9 women under the chairmanship of Dr. Sachinananda Sinha on the 9th of December 1946. We thank once again Shri Kalanidhi Veeraswamy, Shri Sasmit Patra and Shri P.P. Chaudhary for joining us at the third Law and Constitution Dialogue 2024. Let's have a huge round of applause for all our panelists. I request all our audiences to please. Let's keep that round of applause going. And after this, we have, of course, another very interesting session. We will be discussing if it's time to increase our members of parliament. And for that, we have with us Shri Karthi Chidambaram, member of the Lok Sabha for the Congress Party. Shri Karthi Chidambaram, I request you, sir, to please join us on stage to take that very pertinent conversation forward. The session will be moderated by Mr. Rishabh Gulati, Editor-in-Chief of NewsX, and myself.
Okay, right as we finish the last session, because the themology of this is going to be similar, our guest here requires no introduction. His father, and of course, has a long lineage in Indian politics. Karthi Chidambaram is with us. Mr. Chidambaram, as we were entering, you were saying you disagree with a few of the points made, even the questions that were asked. What is your point of disagreement, sir, please?
Why did you have to ask whether the Hindu population will be worried if the Muslims go up? You should have asked whether what would have happened to all the people who are fanatics if the atheist population goes up. Why should even religion even matter? We should be worried about economic inequality, lack of opportunities, rather than one's practice of the faith.
So do you think it's a non-issue? It's a total non-issue what happens in religion? Because it becomes a point of conversation.
It's a conversation for perhaps for instigating electoral partisan sloganeering. That's all. It's not for any practical purpose. What's one's faith is a private matter. Whether you believe in God and how you choose to worship, or you don't believe in God, how should it even be relevant to the economic progress or the unity of India?
Okay. But Mr. Chidambaram, would you agree that then, as per you, does caste matter more than religion?
See, I have no problem in taking a caste census. First of all, I don't belong to a caste.
Right.
I negate the idea of caste. I've never identified myself with any caste. In fact, when I put my daughter in school, even though most application forms have a caste column, I said it's not applicable. That's where my personal position is. But it's a sociological fact of India. My point is there's no harm in doing a census because we are only collecting data. How we choose to act on the data is a completely different debate. Just because we are collecting data, you can't presuppose how the data is going to be used. Suppose we do a survey of how many people are left-handed in India, because most doors are made for right-handers, locks are made for right-handers. The world is unfair to left-handers. Why can't we do a survey and find out how many left-handers are there? That doesn't mean we're going to change all the doors. Doesn't mean we're going to change all the locks. I mean, I think in India too, it's a little inconvenient being over 6 feet tall. You know, I don't get enough leg space, even in Parliament. Airline seats are small. So if we do a survey of people over 6 feet tall, doesn't mean we are going to have broader seating in the airlines. So just collecting data is not a bad idea. Let's collect data.
Okay.
Let's have another debate on how we're going to use the data after we collect the data.
Okay, but on the larger premise, is there a concern that do you have as a representative of the Tamil people that because of
non-Tamils also.
Yes,
you know,
yes, or people from Tamil Nadu, from your constituency,
yes,
that because the state of Tamil Nadu has done a good job in population control, it's an economic success story, it's an education success story, that in any delimitation exercise that happens post a caste census, there is a concern that the representation may fall.
No, these are two completely different things. The caste census is not tied to the delimitation. They're not tied to each other at all. First of all, I do not believe that we need more members of parliament. I know the previous panel seemed to suggest they need more members. As it is with 543 people, we don't get a chance to speak. And the larger the house, it will only become a stamping house. It won't be a house for debate. As it is, only Nishikant Dubey gets chance to speak in 0 hour. We all don't get a chance to speak in 0 hour. So if you have more members in parliament, 846 or 888, I know the seats have been designed for 888, but I think the number is going to be 846. It will be less of a debating house. First of all, you won't get space to speak. And it will just be a stamping house where you will follow party whip and raise your hands. In fact, we do not need more parliamentarians for an effective legislative body for India.
Okay, so on the issue of population, when Mohan Bhagwat says that, listen, we should have 3 children, there is an issue about population collapse. How do you respond to that?
I don't really think that's a concern at all, because India, you know, when Subramania Bharati, you know, sang his famous song, Muppadu Kodi Mugamudeyal, which was about, in the 1930s, India's population, which included Pakistan, Bangladesh, and India, all in the greater, I mean, Akhand Bharat, if you want to choose to call it, had only 30 crore people. Now we have grown 5 times that. We don't have opportunities for the 5-time growth. In fact, I would welcome a decreasing population, because with the newer economy and newer technologies, we do not need those so many more people. And if through natural progression our population comes down, I don't think it's a cause of concern. What's the cause of concern today is that we don't have employment opportunities for our educated youth. So we really shouldn't be concerned about a declining population. I have a completely contrarian view to that. I know we'll have an aging population, and whether the young population can support the aging population or not, but people's working lives will get longer, technology will step in, and we would not need so many people at all to keep this going.
But Mr. Chidambaram, if that were true, why are countries like China, Japan, South Korea panicking at this point in time? Because
Japan has reasons to panic. I don't think China is panicking. Japan has reason to panic. I think smaller European countries might have reasons to panic because they think that their population is falling at a dramatic level. But I don't think China is panicking. I don't think we should panic as yet at all.
Okay, but there is a disparity because the population in the north is going up faster than the population in the south. Does that concern you?
That concerns me. More than the population, the economic inequality, the social inequality concerns me. The fact that Tamil Nadu has 6% of the population of India, but we have 12% of the doctors. North India does not have enough doctors. You know, our educational levels are higher. Our per capita contribution is higher. I mean, so in all social parameters, the South is better off than the North. That worries me.
But Mr. Chidambaram, would you not then suggest that you mentioned social parameters, education, healthcare, that the South is better, but Southern MPs also have lower number of constituents? Tamil Nadu, Kerala have lower number of constituents, members of parliament.
You're mistaking the role of an MP. And an MP is not there to look after roads, sewerage, even though that's the common refrain from people, you know. The MP is here to legislate in parliament. You don't need more people to have an effective debating house. You need better, what you need is better local government. Maybe more representative at the local government, not at the parliamentary level. Having more MPs is not going to give you better roads. Having more MPs is not going to make your street lights work. That's not the job. That's where the grouse is. The grouse is at the local government level. An MP's job is not that. Mistakenly, everybody believes that's the MP's job. So having more MPs is not going to improve those amenities. In fact, it will lessen the quality of the debate we have. As it is, we don't get time to speak in parliament. As it is, we are voting according to party lines. We are not convincing anybody else. There is no debate and discussion about issues. So if you want to have an effective debate and discussion, you need to have a smaller chamber and not a larger chamber.
Okay, you just heard your alliance partner of the DMK, Mr. Veeraswamy, say that if you take the southern Indian states, put all the MPs together, because they don't make the difference for some parties sometimes in government formation, therefore in governance also, the center gets distracted. Is that true?
True. If you actually go through your delimitation exercise, our weightage will even get lower. We'll even become more irrelevant. All you need to do is win the bigger northern states, and then you'd be close to forming majority. Yes, we don't get our say. We don't get our weightage. So we need to, maybe have some sort of a super majority things. States have to also accept some sort of legislation, not just mere numbers of how parties vote. Okay. We must have an idea of a super majority, perhaps.
But sir, won't you say that it's actually more efficient to just have more people? Because we have in the past, as you've mentioned, and we've also said that we've decided to carve out smaller states. We've decided to increase the number of MLAs, we've decided to increase the number of chief ministers. When you just spoke about representation of North versus South, wouldn't it be better for people as a whole to have more members of parliament to put across their points?
I don't think so at all. I think it'll just become a stamping house. It'll become like the Chinese Politburo, where 1,000 people will come and raise their hands. That's what will happen. You will have no debate in parliament with a larger number. In fact, what you need is more effective local government. That's what you need to deliver services to the people, not a legislative body in Delhi which is bigger and mammoth. Not at all.
Okay, let me bring you back to the census. Now we know the census has been delayed. The government says, look, 2021 was obviously COVID. Now they're planning 2025 start. Results will come out in 2026. What are the things from the census that you're going to be watching out for? You already mentioned caste census is important. You don't feel religion really matters. So what will you be watching out for?
I don't know whether caste census is going to be part of that census at all. I mean, I don't know. But if they are going to enumerate that, that's fine. But how we act on it could be a separate debate completely. We can gather the data, but how do we choose to act on it is a completely separate debate. But whether that's going to be part of the census, I don't know. What I really want is women's reservation. That can happen right now. Political parties can do it right now. There's no legal bar to nominate more women as candidates. Only two parties do it. The TMC and the BJD do it effectively. No other party does it, including mine. Do not give enough women opportunities. And I don't think a woman is a lesser candidate than a man in a general election. It's not. A woman is as effective as a candidate as long as she's contesting on a party and alliance ticket. That's what we need right now. We need more women in parliament, not more people. We just need more women in parliament.
But Mr. Chitambram, what is keeping political parties from giving tickets to female candidates? You've just accepted that Congress is also...
I'm not the leader of a political party, so that's one of the reasons.
Okay, so how do we do 33% reservation? Should it be carved out from the existing seat? Should it be rotational? Yeah. Should it be, in fact, that the number of seats should be increased?
No, increasing the seats is going to make parliament even less effective. As it is, we are not debating enough. As it is, members don't get enough chance to speak in parliament. Having more members is not the answer. Having a much more effective debating house is the answer, and I think this number itself is large, and you should have 33% reservation within this 543.
But I'd also like to understand from you, what if a census or a delimitation exercise makes your constituency reserved for women?
I have no problem. I'm sure the party or my alliance will come up with an effective, educated woman to represent the constituency. I have absolutely no problem with that.
Okay, so let me take a question forward. Is this going to organically create a lot more women politicians in this country? Because we've had, at the senior most level, we've had women presidents, women prime ministers. At the Panchayati Raj level, we have women in order to find 150, 170 MPs from the current 30, 40, 50, 70, which is what the total right now is, do you see this giving a lot more women opportunities? Yes. Or does it happen, as we've also seen, that the wives and the daughters then get put forward?
See, in local bodies in Tamil Nadu, you have 50% reservation.
Yes.
For the first round, it will be wives, sisters, daughters kind of thing, first instance. But then they'll come on their own. Then it'll also start throwing up political leaders on their own right. But you need to fast track it. If you do not have this compulsory reservation, parties will not come forward to nominate, which is the case now. Except for two parties, no other party nominates enough number of people to be candidates for parliament.
Okay, Karthi Chidambaram, I have to ask you this before I let you go, sir. Because we are in the middle or really starting a big debate on the constitution in parliament. Why does the parliament need to debate the constitution?
It's 75 years. It's a nice way to spend 2 days.
Do you think that there's something substantive being achieved here, or is it just about, making an ode to the parliament or to the constitution?
I really think we're not going to. I mean, it'll bring out different perspectives from various parts of the country and from various political leaders. It'll bring up perspectives. We're not moving any amendments to the constitution. We're not going to do it, but it'll just bring it to the fore that we have had a document, living document, which has been the framework of keeping this union together and keeping this union united. And it'll bring out different perspectives for 2 days if people care to watch it.
When all of you were swearing in this time around, you had a copy of the constitution in your hands. Was that symbolic of something?
No, it's also making a point that the constitution is eternal. It's a superb document. And it took about 2 years and 11 months for very wise people to draft it. And we are respecting it, and it should be preserved.
Okay, Priyanka Gandhi might just make her first speech in parliament. She's become an MP for the first time. Are you happy that she's in parliament with you?
Yes, I am very happy she's there. She's a natural leader. I mean, whether you like it or not. And the party cadre, right from Kanyakumari to Kashmir, have a bond with her. And I think she's going to have a long innings in parliament, and I'm looking forward to her first speech.
For those people who say it was the Congress who put emergency, did this, did that, and now the Congress says...
we apologize for it.
And now the Congress says the constitution is under threat.
Listen to me. We've made mistakes. We are open to accepting the fact that we've made mistakes. Mrs. Indira Gandhi expressed regret for the emergency. She lost elections in 77. She won in 80. Tell me one instance where the BJP has expressed regret for anything. Anything at all. Including the traffic jam or the pollution or anything. Just tell me one instance where the BJP has expressed regret. We are expressing regret. I express regret for the emergency. I express regret for 1994. Delhi, Prime Minister Manmohan Singh has expressed regret. Tell me one instance where the BJP has expressed regret for anything at all. Have they made no mistakes? Intentionally, unintentionally? They have nothing to look back and express regret about? We express regret for the emergency. No problem at all in accepting that.
What do you make of all the election results that have come our way after the Lok Sabha? You almost made it to 100 seats, which was
it's a setback for us. It's a setback for us. We need to really look at it hard and see why those happen. But state elections, as I've always said, are like a tennis match. One set is completely independent of another set. It doesn't influence one state election, doesn't influence another state election, but we have to look at the factors why we went wrong in those.
Do you think the 2029 election is going to be fundamentally different from the one that has just concluded?
I don't know. 4.5 years, I can't predict. I really can't predict.
Okay, fair enough. It was a pleasure, sir, to have this conversation, and I know a heated conversation are going to happen in Parliament, and a lot of the issues that will come out of delimitation. But Karti Chidambaram has said he wants old-fashioned debates and conversations in Parliament that are meaningful, not just more people talking for shorter. Thank you very much, Mrs. Chidambaram, as always, for this interaction.
Thank you so much, Mr. Chidambaram, for taking out your time. We, of course, present you a small token of our appreciation, a copy of the Indian Constitution, along with a very special photograph of the first Constituent Assembly. Thank you so much. Let's have a huge round of applause for Mr. Karti Chidambaram. I take this moment now to welcome on stage with us Justice Rajesh Tandon, former judge of the Uttarakhand High Court. Justice Tandon, thank you so much, sir, for joining us on the third Law and Constitution Dialogue. I, of course, since you belong to Uttarakhand, sir, I have to, of course, ask you about the Uniform Civil Code. Your thoughts, is India ready for a UCC?
Thank you very much. Uniform Civil Code, it has to be implemented. The judges of the Supreme Court have already pronounced the laws that the Article 44 has to be implemented, Mudgal case and all that. This judgment of the Supreme Court is there, and Article 44 is very good for the citizens, that there should be one law for the divorce, there should be one law for the marriage ceremony and all that, and that is why Article 44 has been there, and the Supreme Court from time to time has already announced in so many judgments, Mudgal judgment and all that, it has to be, much time has passed, but the Article 44 has not been yet implemented, and therefore it is now high time that the Supreme Court judgment has to be implemented for the uniform civil court. Yes, sir.
Okay, but then Justice Rajesh Tandon, if you're saying that the courts are in agreement that UCC must be implemented, what, as per you, is the biggest impediment to its implementation today?
That is for the parliamentarian, for the MLAs and all that. This topic is for them to say what is the obstruction and what is the hindrance for that. But our society consists of various castes and various castes of persons are residing. I will not say they are obstructing, but it is the society. If something is not good for the society, or if the society wants something else, they will demonstrate that what should be the idea of Article 44 and what should be the other method. That is a question, a political question, and I say excuse to you, and I may not be able to answer that.
All right, Justice Tandon, we'd also like to understand, when we talk about uniform civil code, it's there are some sections of society which believe that it is anti-Muslim, or they start saying that this is against Muslims who are a minority in India. What is your thought on that? Why is it that some sections of society understand UCC?
The same thing you are asking, and therefore come to the next point. That will be good.
Okay. I'm unable to get some clear answers there, but I completely understand, because the Supreme Court has just yesterday asked all the judges to really refrain from social media and all of those things. So I completely understand, your hesitations there as well, sir. But coming back to Uttarakhand, and this is not a political question at all, what really have been the learnings of Uttarakhand as a state as far as UCC implementation is concerned?
Same thing you have asked.
My apologies, sir. Let me move on then from UCC. Let's come, of course, to 75 years of the Indian Constitution. Of course, it's a historic landmark, milestone moment for India that we're celebrating this year.
इस पर आ जाइए, डिजिटल अरेस्ट जो आजकल चल रही है उस पर
बिल्कुल आएंगे सर. अगर आप 2 सेकंड मुझे देंगे तो मैं उस पर भी आ जाऊंगी. पर अगर 75 years of the Constitution पे अगर हम 2 सेकंड बात कर सकते हैं, how, or rather, what is your understanding of the Constitution of India, and do you feel that we have today allowed it to be a living document that it was envisioned to be?
For Constitution of India, it is really a living document. If we come to the preamble of the Constitution, one thing has been which is not being followed by our society. That is, the preamble of the Constitution relates to the dignity of a man, and that dignity has been followed under the Human Rights Act also. That is Section 2D of the Protection of Human Rights Act 1993. The dignity of everyone is common, and every citizen has dignity, and that has also been followed from Article 21 of the Constitution of India. That Article 21 says that the living patterns of the society should be supreme. Now, how it can be when we don't have the food, we don't have the shelter, we don't have the clothing? How can we improve our dignity? How a citizen can be supposed to live properly? In large numbers of flyovers, you see, just behind the flyovers, large numbers of citizens are sitting, and they don't have any house, nothing of the kind. They don't have any shelter home.
Okay.
How he can be happy? And therefore, Constitution of India provides, Article 21 of the Constitution of India, to live properly. Human rights that is to live properly. Our Universal Declaration of Human Rights provides to live properly. These things are very important. Take the example of the Kapila Hingo Rani's case of 2003. Supreme Court has announced that the three things are very important for the society, that is food, shelter and clothing. How we are able to provide the food, shelter and our society, for the low cost people, and for the people who are just have no house and nothing to eat. And therefore these things under the Constitution, dignity is paramount. Dignity of everybody is paramount, and that the Constitution of India protects our dignity, our life is getting, and everything that is nowadays in winter vacations. Now the winters are there in Uttarakhand. When I was judge of the Human Rights Commission and Law Commission, and there was large number of applications are coming that we don't have any home, we don't have any shelter home, nothing of the kind, and the people are lying like this. Then I was directing to the district magistrate to take care of these people who have no house at all.
Justice Tandon, I'd also like to understand from you. Now you're talking about a certain part, a very relevant and true part of India, right, where we continue to struggle to provide the basic needs to some people. But at the same time, the judiciary, which is supposed to be the segment of society, or rather the part of democracy that delivers justice, what is your take on the pendency of cases before our judges today? How do we deliver, or how do we focus on giving out those basic needs when people are struggling with the large number of cases before our justice system?
Thank you very much. This question relates to the judiciary. Of course, large number of cases are pending, and every judge from 10 to 5 o'clock and even more than that, they are laboring hard to dispose of the cases. And for that purpose, my opinion is that the retired district judges, retired munsifs, retired high court judges and retired Supreme Court judges must be utilized for disposing of the cases. Only that is the only criteria. Otherwise, the huge arrears are there for the Supreme Court, High Court and all that. The Uttarakhand High Court has invited me for disposing the matters under the Lok Adalat, which I am doing as a Lok Adalat, as a member of the Lok Adalat, and I am disposing of 30 to 40 cases daily in Uttarakhand, and that will be the procedure that the retired judges may be taken for disposing of the judges. Only that is the criteria. Otherwise, the huge arrears are there. Everybody knows that.
Absolutely. Thank you so much, Justice Rajesh Tandon, former judge of Uttarakhand High Court, for joining us at the third Law and Constitution Dialogue. So we take this moment to present you with a token of our appreciation for being with us today, sir. That is a copy of the Indian Constitution. Can we please have a huge round of applause for Justice Tandon? And that, of course, is a photograph of the first Constituent Assembly meeting. A very, very special photograph as we mark 75 years of the Indian Constitution. Thank you so much, Justice Rajesh Tandon, for joining us at the third Law and Constitution Dialogue.
Right, thanks very much to Justice Tandon as well as to my colleague Devika. Let's get cracking with the next Power Pack panel, because I already have sitting in front of us people who've been deep into constitutional matters and of course political matters sitting with us up front. The former Chief Election Commissioner of India, Shri S.Y. Qureshi, is with us. Let's give him a round of applause, ladies and gentlemen. We all recognize him, we all know him. We are going to be discussing One India, One Election. Is it doable? Can it work out? None other than the former Chief Election Commissioner of India to have that debate with Supriya Shrinate, who's the national spokesperson of the INC. Shri Aman Sinha is joining us, senior advocate of the Supreme Court of India, and Shri GVL Narasimha Rao, now a former member of the Rajya Sabha of the BJP, somebody I've sat and debated with for many, many years. GVL ji, so good to see you. Could I request all of you to kindly come on stage and request my colleague and executive editor of NewsX, Megha Sharma, to kindly conduct this session.
Now, when we talk about one nation, one election, it's a hot topic. It has been discussed, debated for certain years now. And of course, questions being raised by the opposition over why is there a need for ensuring that one nation, one election is implemented in the largest democracy of the country. We all speak about the pertinence of one nation, one election in our history. This was between October 1951 and February 1952 that there were simultaneous elections that had taken place at the parliamentary level as well as the 22 legislative assemblies that went to poll. Now the cycle of one nation, one election continued smoothly up until 1970 when the then Prime Minister of the country, Indira Gandhi, decided to dissolve the parliament, dissolve the government and call for fresh elections. So I'm going to start my conversation, and I'm going to get Mr. S.Y. Qureshi to respond to me on this. Do you think it's pertinent, it's important, and the time has come for the need to have one nation, one election, primarily because it saves time, it saves energy, it allows perhaps for more voters to come out in large numbers to cast their vote?
Well, this subject has been on the table for the last 10 years or more. Current controversy started when Mr. Narendra Modi, before he became Prime Minister in 2013, he said that all three tiers of these election bodies, elections should be held simultaneously. And he gave the reasons: cost, paralysis of administration, no policy decision can be taken, and these were the reasons, good reasons. What he did not mention, even to make his case stronger, which I would like to, that because of frequent elections, casteism, communalism, crony capitalism, corruption is always there. So at least if we have elections once in 5 years, for the 4.5 years at least we'll live in peace. But repeated elections mean repeated hate speech, repeated unpleasant narratives and discourse. So this is the case for.
Okay.
But let me complete my thing. From the point of view of Election Commission, this is the nicest thing to do because voter is the same, polling station is the same, the machinery, the district administration conduct all the three elections, they are the same, security apparatus is the same. So once the polling station has been set up and secured, you as a voter, I as a voter go and press 3 machines instead of 1. Election Commission will be the happiest because for 5 years we'll go and play golf. But our convenience cannot be the consideration. Now, India is a big country. We sometimes I have read many articles, there are so many countries, look at Sweden, Belgium, these are small countries like the size of Karolbagh. So if we compare with them, we are 90 countries rolled into one. So we are a unique country with strong federalism. Even America may be a big country, but from coast to coast, they speak the same language, the same culture. We are a commonwealth. And therefore, what has been going on so far, why disturb something which is working? It should not be disturbed, and the reasons are not good enough. And I would, during the course of the discussion, I'll give you an alternative route, which has not been discussed. If I break down the cost for you, if I cut down the period for you, so you should at least look at it.
Okay, that's an interesting analysis and fair points made. GVL Narasimha Rao, let's hear it from you as well. Do you think if we keep having elections every 2 months, every 3 months, whether we take a look at Jharkhand, that happened, Maharashtra, that happened, in Delhi there is going to be an election that is going to take place in 2025, January, this keeps politicians, political parties on their toes, and the push and the motivation that comes to give maximum performance to the voters, because at the end of the day, they are seeking the votes of the voters.
No, see, elections are the integral and the most important part of a democracy. And we are holding elections to elect governments to govern us. So let's not forget the main purpose of elections. It's the integral and the most vital part of democracy. And if you have elections every 3 months, you are continuously in the election mode. And no government can work very peacefully. I think let's be very practical. If there are elections 6 months down the line, it will certainly be difficult for any party or any government to take decisions which are in larger national interest, but which might take some time for people to really understand and appreciate. So there will always be a hesitation to take some measures which are in larger public interest. So therefore, until 70, it worked very fine. So were we not a federal country until 1970? Were our constitutional framers, did they not consider this to be a violation of federalism? Post 1970, this cycle broke because of repeated fall of governments, dismissal of governments, and as a result, we have really a very hodgepodge cycle today. Certainly, it is in national interest, it is in interest of governance, it is in public interest, and in a democracy, that must be the paramount importance, nothing else.
Okay, Supriya Shenate, what do you have to view, particularly when he says, where does the question lie of this not being federal, this being draconian, as has been the opposition raised against it?
So let's just step back and say, why are we debating this? Why are you doing this? What is the trigger? The trigger is that the Union Cabinet has adopted the report presented by the committee headed by former President Kovind. It is likely to table this bill. All of us here who are fairly learned and understand parliamentary proceedings know this cannot go through because the government doesn't have the numbers. 50% of India's states are not going to ratify this. It will not be able to pass the muster of the House. This is a hot air balloon being floated so that summits like these debate this. This is a hot air balloon being floated so that we do not discuss the more pertinent issues that should be discussed. To my mind, and I just step back and say, what are we discussing? We are discussing a solution where we are trying to find a problem. We are trying to discuss a remedy where actually the disease does not exist. Let's just step back and say that. You know, this is a voodoo economic argument that this is going to save cost. This is hoodlum being talked about that, you know, because till 70s. Yes, till 70s they may have been because India became independent in 1947. We had elections thereafter. Obviously there was a harmonious cycle and then there were governments that fell. And the reality today is that whether we like it or we don't, there has been a rise of vernacular parties. There has been a rise of regional political parties. And you cannot ignore the fact that the BJP or the Congress are not the only custodians of democracy. And are you telling me that if you have simultaneous elections, you will be curtailing the term of not one but multiple state legislatures? Why should that happen? Is that not anti-democratic? Have you taken the states into confidence? Every single chief minister of the opposition, some chief ministers of the BJP, you speak to them off the record, they are vehemently opposed to this because this is a direct assault on federalism. Okay. I just want to add one point. This is not going to become a reality, definitely not before 2034. Even if it becomes a reality, are you going to curtail terms of 17 assembly legislatures? Is that what you're likely to do? And why should that be done? Are people in UP or in Delhi or in Karnataka or Telangana not, they've elected a government. They want that government to act at their behest. Why should those legislatures be dissolved? And then, of course, I'm sure through the course of the discussion, we'll be talking about scenarios. What happens if the central government falls? Do our state legislatures go into elections? Multiple points. But to my mind, it is a solution where we are still trying to find the problem.
Okay, all right. But there have been important points made by GVL Narasimha Rao.
I'm sure there are important points made by me as
yes,
well.
Yes, absolutely. I'm seeking an answer from you with regards to that. When you're talking about money, when you're talking about funds, when you're also talking about how there are perpetually elections taking place, so there are resources, important resources that are invested into it, that are expended. And do you think there can be a way? And as S.Y. Qureshi said, it may not be that there are
it's a very elegant mathematical
place, but could there be an alternative? Would political parties be willing to look at an alternative to reduce the costs for maximum public welfare?
I am presuming that this room did not miss on the sarcasm that was coming from Mr. Qureshi, with all due respect to him, and I think we missed the point that he was being sarcastic to a level. But this is a very elegant arithmetic argument, but the assumptions are very dubious. And I would want to say that once again. What do you mean by extra resources? Even with this report, even with the bill that has been passed by the cabinet, you are not going to have one nation, one election. There are local body elections that are not going to happen with this. And the reality is that there are about 30 lakh elected representatives in our local bodies. Those elections are not happening with this. That will entail an entire bandobast, poll parties, polling to happen all over again. So this is not one nation, one election. It's a very fancy acronym, ONOE, but that's what it is. It is not going to, I don't think there's a problem. So what is it seeking to resolve?
Okay.
And I agree with you.
There has been blind opposition to a lot of ideas.
Can I finish my point, GVL? You can come after that. And I think, the country has to step back and assess this argument being made. Extra expenditure. Why should political parties not be responsive? I am with the class that believes political parties need to be more accountable for the funds that they spend. I am with you on that. I am with the people of this country on that. But this is a very dubious argument that just because elections are going to be held simultaneously, it is going to curtail expenditure. What about the assault on democracy? What about the legislatures that will be curtailed? And whose benefit?
You're not answering that. Nobody is answering. How is it an assault on federalism? Or an assault.
Because GVL, there will be elected.
Just one second. We had elections in Andhra Pradesh.
Allow me to answer that.
In Andhra, let's have a very meaningful debate, not just give a lecture. In Andhra Pradesh, in Odisha, we had simultaneous elections in 2019. 2024 and even 2014. So, was federalism in Andhra Pradesh, Odisha, in states like this, was it under danger?
So by your logic, GVL, in 2024, if there was one nation, one elections, should governments in UP, should governments in Bihar, should governments in Telangana, in Karnataka, and Himachal be dissolved because you wanted to push through this grandiose idea? And this is
no, these are specifics.
Why is
these
it
are
specific? There are 17 legislatures which you will need to dissolve.
What is being mentioned in the bill, you don't know the bill yet. What the report said is it will be a one-time transitory measure. It will be a one-time transitory measure. How will fall of government's midterm be ensured? How will this cycle not be disturbed? All these are being a part of the bill.
Can I ask you a question?
And there will be a debate.
I have a very specific question.
Why do you need to oppose it?
Tomorrow, if the elections happen simultaneously and for some strange reason the central government were to fall, should all of India's state legislatures also go into election? That's a dubious argument.
Let's try to have an answer on that question from Aman Sinha, Senior Advocate, Supreme Court. Now, all these questions, technicalities, the legalities that will have to be figured out, drafted, because it's a complex issue. And Ms. Srinath, who has raised these important questions, what happens if the government falls at the central level or at the assembly level? Do we have any recourse to fall back on if we want to ensure that there's one nation, one election?
Actually, only 2 articles of the Constitution are required to be amended, primarily Article 83 and 172, which prescribes that the maximum tenure of a union legislature or a state legislature is 5 years. So, for the unexpired term, supposing that if a house is dissolved or there is loss of confidence in the particular leader of the house, then in that scenario, the election would happen for the unexpired term. So therefore, it does not require any large-scale amendments. The amendment which is required under Article 368, there is a procedure to amend the Constitution And as far as these two particular articles are concerned, it would not require ratification from all the states because under Article 327, the union legislature, which is the parliament, is empowered to enact laws with respect to elections to union and state legislature both. Now that apart, the foremost question which confronts us is that whether one nation, one election is prudent, desirable for our country or not. If it is desirable and prudent, then we must find ways and solutions to imbibe it in our system as it was happening from, as you rightly mentioned, from 50 to 67. This year itself, Megha, we had general elections from March to June. Thereafter, we had elections in Jammu Kashmir. We had thereafter immediately elections in Haryana. Then Maharashtra and Jharkhand results have just come out and we are on verge of announcement of elections in Delhi. Election year starts 1 year before any election is announced, and the first casualty is governance and administration and the massive public welfare schemes which are there. And therefore, we must all find ways to somehow or other ensure, because, and there was a technical report also on this in the committee that Supriya was also just mentioning, and all the panelists were in fact mentioning. And Qureshi ji also alluded to that fact. The committee had opined that it would lead to about 1.5% of addition to our GDP because the expenses which are entailed are somewhere in range of 6 lakh crores. The public expenditure is also, wasteful public expenditure is saved. Inflation also, there is solid data to suggest that after these regular frequent elections, inflation also rises. And if you have simultaneous elections, as happened from 50 to 67 also, there is saving of public, valuable public money, and which leads to lower deficit, which leads to lower inflation, in fact. So there is not only this. Qureshi ji was also alluding to the fact that the level of public discourse, that is also going to improve. That is also one point that we must all keep in mind. That apart, if I may just complete, I did not interrupt anybody. That apart, the uninterrupted development, the uninterrupted administration that can go on. We see that children's education is disrupted, schools are taken over for elections, teachers come in, security apparatus is put into mobilized all over the country. And model code of conduct, obviously, nothing, it's a state of policy paralysis, and it's not only just 1 or 2 months. It is that entire period of election year during which this policy paralysis continues. Therefore, in my assessment, in my opinion, clearly one nation, one election is an integral part of the foundation for developed India, and it will be for the welfare of the country.
How the democracy should
Can I make
function.
a very small point, please? General elections ended, and the election commission had the liberty to announce Maharashtra, Haryana, Jharkhand, and Jammu Kashmir together. They could not do 4 state assemblies together. We are talking about a general election in the center and all state legislatures. But this is exactly, I think the point that Aman was trying to make is a direct quote from the report. This is what I call dubious assumptions on the report. On what basis has this been assumed that inflation will be curtailed? On what basis is it going to add 1.5% to our GDP? This is exactly the argument, and I was an economic journalist back then, and GVL used to be on my shows. When demonetization happened, demonetization was imposed on this country, and then we kept looking for problems that it would solve. It has not solved a single problem. Today, cash in the economy is twice as it was in 2016.
The entire economy
today,
is
please let me finish.
digitized
Let me finish.
No,
Let me finish. Otherwise, I'll start interrupting
today
you.
we are a formal
I'll
economy.
start interrupting
We are the 6th largest economy.
GVL, 36 lakh crore is the amount of cash in the economy.
No,
it was 13 lakh crore in
can't give your
2016. I am not giving my figures. I'm giving figures from the budget of India. I hope you respect those numbers.
Have we not become
That's
the 5th
problem.
largest economy
The
from the
problem with
11th
the
largest
BJP
when you were in power?
You find a
If the
solution
decisions
to
that were
which you are
made
now
were
looking for a
erroneous,
problem.
we would
That's
not
the
be a
reality.
such economy
The
today.
reality also is that this report says hate speech will be curtailed. Why should there be hate speech at all during elections? Why are we not talking about this? The hate speech is coming from the Prime Minister when he's saying Mujra and
Sonia Gandhi, Rahul Gandhi,
pot shots at each other
because
political
Supriya
parties. I'm
mentioned
going
my name,
I'm going to quickly
Khun ki
request
kheti.
Mr. S.Y. Qureshi
People come up
to
with better
intervene in
arguments.
this on the subject and
If you're going to
speak
interrupt
about,
me, come up with
speak
better
about all
arguments.
these matters and speak about all these matters that have been raised by both political party spokespersons over here and discussing about what's the way forward. Do you think these are relevant, important, pertinent issues to be picked up, whether we talk about saving money, whether we talk about if there is a possibility and potential of more voters coming out and casting a vote because we have one nation, one election, and also, the contention that has been raised by regional parties particularly, that, their relevance is going to be reduced.
First of all, I would like to mention that when the Prime Minister started this debate in 2013, he insisted that there should be a national debate which should lead to a consensus. For 10 years we have been debating, but there has been no consensus. So logically, if there was no consensus, the idea should have been dropped. Now the decision has been taken unilaterally and the idea is to bulldoze, which has become the norm anyway. Now, the reasons which were given, let me come back to that. It will cut down costs. Center for Media Studies, I think it belongs to your family. Since last 2019 election, 60,000 crores. This time they say 1 lakh crores. What is spent? Very easy. 30-second solution for the Prime Minister. Put a cap on the expenditure of political parties, as you have on the candidate. From 60,000, it will come down to 6,000. Money problem solved. Secondly, it disrupts normal life. It is an exaggeration and it's a lie, I would like to say. I have implemented Model Code of Conduct. Just download Model Code of Conduct, all of you ladies and gentlemen. It's a 15, 16 page. And there is only one thing which is an irritant. It says no new policies will be announced. Why is it that all the bright ideas for development come to the mind of politicians after 4 years and 11 months in power? Just 2 weeks before the election, they have all the bright ideas, and they say the election commission is stopping us, or the hell on them. Now, this is wrong. Take your decision. Nothing is stopped by the Model Code of Conduct, except new on the policies, which you should have taken.
Okay, all right. Aman, I want to understand from you, and let's hear it. Can there be alternatives, and then can be variations to one nation, one election? Can we follow an American model where you have a midterm poll that happens, and every 2.5 years later, there are elections that take place across the states? Could that be a viable solution?
See, as far as one nation, one election bill draft is concerned, we are yet to see that. But in my opinion, it makes very, the proposals which are in offing should make very minimal changes. Article 82 itself provides that 82.1, when it starts, it says that Rajya Sabha will have a fixed tenure of 6 years. Now, the same thing has to be incorporated and imbibed in 82.2, whereby Lok Sabha will have a fixed tenure, and the unexpired term, supposing if, unfortunately some Lok Sabha MP expires or is, his election is set aside for whatever reasons, then the elections take place for the residual tenure only. The same thing would be incorporated in 82.2. So therefore, it is not any large-scale changes, nowhere near, affecting any or altering basic structure or, altering anything in the constitution, if at all. Actually, it is in consonance with 82 and in spirit of, having a full throttle democracy in our country. Now, that apart, one thing which Qureshi ji was mentioning, and Supriya took my name, although she forgot that I have also been on her debate many times, and she had called me. But one thing which is there is that I am sure she has seen the debate, the high-level committee report. There is a 100-page, technical report which is there, and they have opined on the reasons as to why and how they have arrived at this figure of at least 1.5% of addition to the GDP, and also of, lowering of public expenses. And if they have any objection, they could have put it to high-level committee, or, all the nice suggestions which are coming through, this could have been put to high-level committee. See, this is all work in progress, but we must realize and assess whether we are moving in the right direction. In my assessment, we are certainly moving in the right direction.
I have a huge problem with the composition of the high-level committee itself. So let's not get started there.
Can I?
Yeah,
see,
Qureshi wants to make a point, and then I'll move to you.
Just on this, the recommendation of the committee, Coven committee, itself has flaws. First it says that Lok Sabha and Vidhan Sabha elections will be separate, and Panchayat elections will be separate. That is not simultaneous elections, which they were supposed to do. Secondly, they say that Panchayat election will be done after 100 days. An election after 100 days is a separate event requiring totally new bandobast, and at a time when 15 million people who are our staff, they are all fatigued after the general election. And 100 days later, you call them again. So that is also not a simultaneous election.
Okay.
So what is being proposed? And thirdly, that the committee also said that there will be a midterm poll. So that means another violation. But let me just one last sentence. Now, but this midterm poll will be only for the remainder of the term, which means that candidates will be spending crores of rupees just for a 1 year or 2 year term. So it is not reducing elections, it is actually increasing expenditure.
Okay.
No, in the case, as Aman just mentioned, see, in the case of Lok Sabha by-elections, in the case of Lok Sabha vacancy arising, you're holding by-election to an entire Lok Sabha constituency. Only Priyanka got elected only a couple of weeks ago to Wayanad. There was a Lok Sabha by-election held in Nanded. One second, so by-election to Lok Sabha seats are held. By-election to Rajya Sabha seats are held for the remainder of the term. Therefore, why not? In fact, this will be a disincentive for any party to pull down a government because they have to face the election. So this will reduce the tendency.
The last 10 years.
This will reduce the frequency of fall of governments. It will lead to greater stability
I have something
by
to
default.
say here.
And in any case, you are saying one line, Srinath. Supriya, let me finish. See, you were saying at the beginning that people are not asking for this. This is not a priority for the country. No, why do you say so? Sometimes we don't even know what deformities that we have, what deficiencies we have. Once in a while, it's good to get a body diagnostic test.
Go ahead. Then I'll ask you another question.
I am absolutely stunned that you are comparing two bipoles of Lok Sabha to the
several
state
bipoles.
legislatures. One second. Your voodoo economics has now turned into voodoo politics. You are saying this is a very pressing issue. No, the pressing issue of our times is joblessness, price rise, income inequality, a caste census, and getting Mr. Adani to answer some questions before now.
And Mr. Rahul Gandhi to answer about George Soros link.
All run
Obviously,
away from.
let's discuss and debate
faces
everything.
a warrant. Make him accountable.
Let's debate on one nation, one election, and we will discuss about other things on the subsequent debates that we are going to be holding. But Supriya, one interesting question that I want to ask you is when the regional parties are saying, they're scared that they're very...
question for CIA funding in 1967.
You answer the current question.
I would like to bring back the discussion to one nation, one election, and particularly when regional parties says they're upset, they are scared that their relevance.
Scared is a wrong term.
Their relevance is going to become minuscule. Now, I want to understand, do political parties don't have confidence in the voter to then make a decision that even if there were simultaneous elections taking place, they would have the common sense and the judiciousness to decide who they want at the center and who they want at the state level?
No, but that's a very flawed argument that is being made by certain quarters, the one that you just repeated. I don't think political parties are scared. I don't think anybody in Indian politics is scared of what is going to happen. I think people in Indian policy making and polity believe this is against the very grain of our constitution. This is against the federal nature of our governance. And I think they have every business to voice concerns. This whole thing about regional parties being scared. I mean, I'm a national party and so is the BJP, but we cannot negate the importance, the relevance, and the emergence of regional parties in Indian politics. The reason why they were not there in 1970s is why they may have not voiced concerns. Today they do. I want to make one point very clear. Governments will not fall. It will dissuade people from making governments fall. In the last 10 years, the 6 times governments were made to exchange hands was at the behest of the BJP, their ugly money, their ugly agencies.
It was the Congress which did this 100 times before. Please mention that.
From Madhya Pradesh to Arunachal Pradesh to Goa to everywhere to Rajasthan.
It's so rich for the Congress party to talk about this.
The 6 times governments are being made
what
to
about
topple
100 times the Congress?
Don't get me talking.
What about the 100 times that Congress party has done?
Because you were just caught with your hand in the cookie jar.
What about Indira Gandhi dissolving democratically elected
governments
post-emergency?
please respond to a question I'm raising.
No,
In
I'm
the last 10
asking a
years,
question.
You are the
Was
one who
it
raised that
not the
point. I did
Congress
not.
party
You are the one who raised that point.
which murdered democracy?
Let him make the point. Supriya, you did. Let him make the point.
Governments.
Please
answer that.
in between. You did
When
not
did
stop
we?
him. Don't stop
We
me.
have not
Have a-
dismissed one
yes,
government.
I'm having a very unbiased, impartial discussion. Yes,
We
GVL.
have not dismissed one government.
You have
You
bought
have.
and
You
sold
have
MLAs.
done.
You
Indira
have
Gandhi has
auctioned
done
MLAs
dozens
across
of
states in this country.
dismissals.
Please
You
don't
are
get
I'm
me
going
wrong.
to once again get Mr. S.Y. Qureshi into the conversation, and particularly about this regional parties and this fear that they may have.
No, I was keen to answer the question that the voters are very intelligent. There was a study of IDFC for 16 years, and over a period of 16 years, voting behavior was studied. And they found that if there is a simultaneous election, 77% people vote for the same party. If it is separated by 1 month, it drops down to 61%. And if it is separated by several months, the figures are totally different. And one example is Delhi itself. Aam Aadmi Party getting 67 seats in one election. 6 months later, BJP getting all 7 Lok Sabha seats. Therefore, simultaneous elections actually influence voting behavior adversely. And finally, I would like to say, the election is going on all the time. Well, election was happening in Jharkhand. Which one of you whose life was affected, tell me?
Okay.
Only election commission busy, media is busy, and the top politicians are busy.
The top politicians run the government, Qureshi ji.
Yes.
Top politicians are important part
Ask
of
them
the
not to
governance at the
electioneer, ask them
center.
to sit here and
Do we disqualify ministers and
What
prime
policies
ministers
have you
or
made to
leaders of
create
the opposition
employment or to
from
rein in
campaigning
prices
elections?
or to bridge income inequality in the 4-year, 11 months
Aman
that you
also
had?
wants to make a point. Yes.
No, as far as regional parties are concerned, there was, I think, about 50, 60 parties were invited by this high-level committee. The majority of the regional parties have also supported this idea. And please envisage a scenario where, in fact, there was
Every
a
single
party
regional
from
party
Goa.
has opposed it.
There was a regional party from Goa, I'm forgetting the exact name, which in fact stated that because a national party, their energies, their resources will be scattered all over the country, even so their leaders, etc. Therefore, regional parties will get to focus on regional issues, regional leaders can thrive. So this is coming from regional parties.
It's a
Therefore,
dishonest argument being made. Not a single regional party has supported the HLC.
The
just for
presumption
your
that
fine information.
regional parties, this is going to be biased against regional parties is just a presumption. There is no solid data with respect to
Every
this.
regional party
And
government
in
has
fact,
opposed it. Every regional party
there
in
is solid
written
data to
recommendations
support
has opposed
that
it.
on
Please
large
don't
number of
misquote the
occasions there
regional
were
parties
simultaneous
here,
elections.
just because they're not being
and
represented.
people voted one way in assembly and other way in national elections.
Okay, all right. I've had a very fruitful discussion, insights being put on the various aspects of it. I thank all of you for joining me and talking about this very important integral subject today that is in discussion.
It's been a passionate discussion, no doubt. How fruitful it was, whether we come to a consensus, I don't know. I didn't see a consensus, but of course it's a contentious topic. And all our favorite speakers have come, all of whom, of course, you are very well known for TV. Let me request all of you to stay on stage. We have a special gift for all of you. Let me distribute it and get some photographs taken. All right, ladies and gentlemen, that was fun and very energetic. And speaking of energy, we have very passionate speakers who are about to join us. You all know who they are. The next topic we are discussing has been in the news for months. It's been heard by the Supreme Court. Bulldozer justice. Are we doing jugaad or real justice? The Supreme Court has had the last word, but will the politicians have the last word beyond that? Having this conversation is Tehseen Poonawala. You all know who he is, along with Sudhanshu Mittal of the BJP. And we have a special treat because Mr. S.N. Srivastava, the former Delhi Police Commissioner, is with us to have a conversation from a police person's perspective on how to serve justice in this country. The moderator will be our senior news editor, Devika Chopra. Devika, over to you.
We have to maintain the momentum of the last session.
Not in the acrimony.
Yes, absolutely.
I think a fish market is not what we're looking at.
No, absolutely. But very, very pertinent topic once again, bulldozer justice. You know, it's the topic of the day. The Supreme Court has recently given its own views and clarifications on bulldozer justice. But, Mr. Srivastava, I'd like to begin with you, sir. 4.5 crore pending cases before our courts today, right? 80,000 of those, over 80,000 in fact, cases pending before the Supreme Court as of January 2024 reports. In a country where we have these many cases pending today, what do we even tell the victims or their families who are clearly frustrated somewhere with the judicial system, with the justice system? Because even in a case like Nirbhaya, and I've worked very personally and closely on that case from a journalist's point of view, even in that case, it took 10 years for the criminals to actually finally face justice. So what does one then say to the victims or their families who are clearly frustrated today?
From both sides, from the victim perspective and also from the governance also, from the criminal justice system also. I mean, the amount of delay in finalizing the cases, that is troubling both sides. The victims have to wait for a very long time. I mean, 10 years in Nirbhaya case, that was a special case, and it could end up in 10 years. But there are many other cases where it takes much more time, 15, 20 years, for the cases to be finalized. And at the same time, from the, I would say, from the governance perspective, they also would like, from, let's say, as a police person, I would also like that the cases which are charge-sheeted be finalized, the trial begins quickly, and the judgment and appeal, etc., they all are done quickly so that the person is punished. And that will have effect on the society, the lawlessness in the society, that will have a good effect.
But at the same time, Mr. Srivastava, bulldozer justice as a concept has become a little popular amongst people as well, simply because they feel that at least criminals today are then afraid of losing something, of having a very immediate consequence to their actions, which otherwise one can say one can go to court, then there'll be a lower court, high court, Supreme Court, judicial petitions, review petitions, and the saga just goes on. So for years, you could just be roaming free as well, and there will be no consequence. What is your take on that? The fact that somewhere society finds this whole concept to be a little appealing.
Yes, I was speaking to, once I was told that I'll be dealing with this topic. So somebody suggested to me that why Amitabh Bachchan, in those days, Angry Young Man, why was his film liked apart from other reasons? One reason was that he could deliver justice immediately. But in the case of bulldozer justice, while you are able to deliver justice quickly, at the same time, the justice you should be able to, do it correctly. Because many a times, if you don't follow the process of law, then what happens is that you may have a tendency of making a mistake. And if the person whose house has been demolished, if he goes to the court and the court gives a ruling in his favor, then there's a loss of face for the government.
So what I feel is that you must do it quickly, but at the same time follow the process of law.
Okay, Sudhanshu Mittal, bring you into the conversation. I want to understand from you, Mr. Srivastava, we were just discussing pendency of cases as well. Isn't it then ironical that in fact the government is today the biggest litigant? 50% of the pending cases are government cases before the courts.
See, let's look at justice in the context of criminal justice. I think that's where this entire debate comes from. Civil jurisprudence can be debated later. Now, if you look at any civilized society, any developed country, what is paramount there? What is paramount is rule of law. The fear of rule of law. Nobody dares to violate the rule of law because they know that there are very serious consequences. You can't escape that. And the consequences are because the majesty of law enables that whosoever has violated the law gets punished. So punishment is fundamental to rule of law. If the punishment doesn't take place, then the majesty of law will get demolished, and the rule of law shall not prevail. That is the problem in this country. Can anybody sitting here vouch for the fact that there is really rule of law? We all look for alternate remedies. We all look at, yaar iske paas chalo, wo karwa dega. Nobody believes that the due process will get you justice. That's the irony of this country. And I think while Supreme Court has made its observation, it should seriously dwell on the fact as to how to ensure rule of law. When we grew up, what did we hear? Justice delayed is justice denied. If 24 years is not delay, if 10 years of Nirbhaya is not delay, if people get exonerated after 30 years, then what else is delay? I think while the wisdom of the judiciary manifests itself on every issue and any issue, the core fundamental issue of delivery of justice must get addressed.
But but on bulldozer justice, I'd like to understand from you. Of course, justice delayed is justice denied, but is it then fair for the other people living in that particular property to suffer the consequences of one person's actions? For example, there's a man or a woman in the house who's committed the crime, but for the rest of the people who may be living in that house, for them to also lose it.
See, I think there are two tendencies. One is we are all status quoists. We love status quo. Anything which breaks the status quo is looked at lot of skepticism. Second, we love to wallow on victimhood. You know, the criminal is also a victim. I mean, this dichotomy is something which I don't understand. Let me come down to this very issue of bulldozer. The laws, everybody's here, they'll bear me out. The laws in every state, in every municipality relating to demolitions are different. It's unfortunate that a dictate has been issued by the Supreme Court. You know, public property. If there is encroachment of public property, it has to be dealt differently. If there is an attempt to encroach public property, it has to be dealt differently. If there is illegal construction, it has to be dealt differently.
Yes.
Now, if a fundamental law has been violated by any officer, I am a firm believer of the rule of law. If a fundamental law has been violated by an officer, there are judicial remedies. But sweeping actions like this is illegal, how can it be illegal? It is case to case.
Okay.
It has to be dealt with case to case rather than in a sweeping context of a phenomenon.
Okay, Tehseen wants to make a point.
So thank you for having me here. Mr. Srivastava, thank you for your services to our nation and to the city. It's very tough to be a police officer in our nation because you always get rogered from all sides. But let me come to the simple thing Sudhanshu Bhai said. He said, Sudhanshuji, it wasn't an observation, it was a judgment of the Honorable Supreme Court. A very well-written judgment, a very thought-about judgment. A 95-page judgment, which is a short judgment in today's context of the Supreme Court. each paragraph going into each detail that Sudhanshu ji raised, and very well articulated. So for those of you who haven't read the bulldozer judgment, please read it. It is each para-wise, and it's very, very well articulated. There are a couple of points Sudhanshu ji raised. He says, how can the Supreme Court come up with one diktat? No, it is the job of the Supreme Court to save constitutional rights. Sudhanshu ji, may I please? To save constitutional rights. The rule of law, like Sudhanshu ji rightly said, is fundamental. What does the rule of law say? The rule of law says you are innocent until proven guilty. Can a police officer, with respect to you, sir, under pressure from a politician like me or Sudhanshu ji, come and say, she is guilty, he is guilty, he is guilty, and demolish somebody's entire lifetime earnings? A house is an asset. From the richest man in the country to the poorest man, there's two dreams every Indian has. One is to have a house, one is to get their kids married. Can police officers, along with municipal authorities, just come and bulldoze it because the government wants to fix somebody? Now, should somebody be punished? Yes. Where should they be punished? In a court of law. Are we going to give that power to police officers, to municipal authorities, to Zilla Parishad Adhikaris, to fix people without the due process of the law? At no point does that 95-page judgment, say that you cannot demolish public encroachment. It doesn't say that. What it sets in motion is a process across the great nation of ours of how a demolition will be done. So, for example, what it says is, listen, you should get a notice. So suppose, sir, you get a notice about your house, or Dr. Bagai gets a notice about his house.
Yes.
Dr. Bagai then has the right to go to the relevant authorities, A, to say, I will take care of that particular structure, or give a paper why it's not. Now, the right to be heard is a fundamental right. Second, you can't come suddenly and bulldoze and put a backdated notice. That notice has to have an electronic trail with the district magistrate. The district magistrate then, with a timestamp, sends the relevant authority that within a month such and such demolition will happen. How is that against the rule of law? Third,
okay,
if somebody decides that they want to move out of this construction, they should be given another 15 days to move out. Say, okay, they want to leave it, it is public encroachment, let us move out. Ultimately, do you want to see people on the streets, women, children, old people, to quote what the Supreme Court judgment? It breaks our heart. That is not what the framers of our constitution wanted. If there is lawlessness in our country, if the judicial reforms have not taken place, those who are running the country for the past 60 years or for the past 10 years, let's ask them questions. You can't give this arbitrary power to police officers, municipal authorities, or Zilla Parishad Adhikaris, or politicians like Sudhanshu ji, or political analysts like me. I'm sorry.
Okay. Sudhanshu Mitra wants to respond, then I'll get Mr. S. Srivastava as well.
Again, Tehseen, with due respect, I have great fondness for you, and I like your articulations always. But you're mixing a lot of things. You know, when we talk about due process of law, who's the lawmaker? Is the Supreme Court a lawmaker, or the lawmakers are the lawmaker? Every municipality is governed by a law.
Yes.
Now, Supreme Court, if thinks that this law is wrong, let it come down on the law and say it is ultra vires, the constitution.
Yeah.
You cannot give one dictate and say this will be the law of the day today, because there exists a law. What is happening is there is a growing tendency of pontification and creation of laws. You can't. I'm a purist when it comes to governance. I'm not. I believe that there is separation of power. So what is the power of the lawmakers is the power of the lawmakers. What is the power of the interpreters of law is the powers of the interpreter of law. And what has to be executed as per the law is the power of the executive to do so. Now, let's respect those boundaries. I'll just finish. What you are saying is Supreme Court has now laid the law that this is how demolition can take place. I'm sorry, I disagree with it completely. Because what has been given in the Constitution as areas of lawmaking have to be respected. Sure. And we are in Delhi. There is a law, Municipal of Delhi Act.
Yes.
The Act provides a certain process.
Yes.
Now that process cannot be overruled unless it is stuck down.
But
what is happening?
One
last this thing is, you are again assuming that there is a violation of law. The fundamental assumption is that when a demolition has taken place, it is against the law. I mean, I am saying,
May I
if
just
it is,
respond to it,
I'm
please?
just
Both those
finishing.
points, yeah.
If this is against the law, let somebody go with the facts of the case and let it be decided on the facts of the case.
But Mr. Mittal, by then they've lost their house, no?
Uske baad there are compensations to it also, na?
But
let me tell you one thing. The executive has ensured a certain execution as they believe it is the due process of law.
Yes.
Right? Now, if they have erred in that, I'm not a votary of that. If they have erred, let them be punished. But the assumption that every action which has been taken is a flawed action, this is fallacious.
No, but we are also assuming here that all of these cases where bulldozer justice, so-called bulldozer justice taken place, are cases of public encroachment. That is not true.
No.
May I just respond to it,
yes,
please?
Tessin, I'll bring, yes.
Can I just take one?
Yes, 30 seconds.
Classic case in this. You know, what normally happens, he's the one who's had the policing experience. But my limited understanding is, the moment there is criminality notice, then the records are checked.
Yes.
And when it is discovered that these were illegal constructions and they have always been booked earlier, but no action has been taken because the executive was bribed or whatever, that is when you pick it up and execute.
Okay. Okay.
So you will understand that it is not a fresh action which gets initiated once a criminality has taken place. The action was pending, but it never took place. But it got accentuated because a criminality was discovered.
Okay. Okay. All right. Tessin, before, yes. 30 seconds, Mr. Srivastava has been waiting.
No, I just want to rebut two very quick points. I'll just take a minute, less than a minute. One, Sudhanshuji asked, is it the job of the Supreme Court to lay down the law? No, it's not. However, in this particular case, like the framers of our Constitution, and you will give us the Constitution later on, please read Article 142. Article 142, but my leader carries it also, and so do I. But coming to the larger point, Article 142, especially the framers of our Constitution mandated. Now, if you read the constitutional debates, and it is amazing, and I'm so grateful that in this particular case, the Supreme Court used Article 142. It uses it rarely. It uses it rarely.
It is not applicable in this
to,
case.
To lay down the law. So it is excellent.
It is only when a law does not exist.
I know. So the Article 142. Now when you say that, but the assumption that you went into the Supreme Court that all action was illegal, that was not the assumption that went in. The assumption, there were two separate issues. Individual cases, like Sudhanshuji said, went to the respective district courts. So the demolitions in Rajasthan, the demolition in Madhya Pradesh, the demolitions in Uttar Pradesh, etc., went to the respective district courts. What the Supreme Court did is set down a set of guidelines that made the process transparent across the length and breadth of the country. That is it. If the house is demolished, let's take Sudhanshuji's argument, if the house is illegal, of a criminal who has bribed it, 15 days doesn't matter because he's already bribed and bought time. But 15 days to an innocent man, as you rightly put it, is their lifetime. Also, you cannot punish an entire family because somebody's house is illegal. And as I end my case, before we hand it over to Srivastava, in one of the cases in Rajasthan, where the BJP government demolished a house, the person staying there was a tenant. The landlord was somebody else. Right. And third person, and the house was on the landlord's mother's sister's name. Got demolished.
Okay. All right. Mr. Srivastava, make your points, but I'd also like to understand, we obviously cannot also be doing this justice by Jugaad system for too long, as the Supreme Court has also now opined. But do you think that it needs to come to an absolute halt, this concept of bulldozer justice, or should the politicians really look at then finding some other way? Because ultimately the conclusion of everyone on this panel is the same, that there is no fear of the law that is left in our society today.
See, I'm suggesting a bulldozer justice in a modified manner. The whole concept of bulldozer justice started with Vikas Dubey, if I am right, Vikas Dubey thing. Now, for a moment, I also, when this happened, I also was very happy that a criminal like Vikas Dubey, his house has been demolished, he has encroached upon the government land, and his house has been demolished. Before I answer your question, I'd like to also say, see, what the Supreme Court has not laid down any law.
Yes.
It has reiterated the law. The law is, for example, in Delhi, it's Delhi Municipal Corporation, the section is 343. It says that the power is given to the municipal corporation. Likewise, in UP, it is UP Urban Planning and Development Act. Under that act, the power is with the vice chairman. That's also a municipal act. So basically, the demolition, etc., is the municipal act. There is no involvement of judiciary in this. What the Supreme Court has said that we follow this process. So, and I would recommend that the due process of law is followed. The next thing which I am saying is, we don't have to do it in a reactionary manner, like reacting to a particular something, Vikas Dubey comes or somebody else, and then you demolish the house. What happens on a daily basis? You see unauthorized encroachment.
Yes.
Lots of things are happening. So the job of the municipal authority is to identify those areas which have been encroached, the government land has been encroached, or where the urban laws are not being followed, and then you identify those things and start demolishing. So that is also, you are using bulldozer there also.
Yes.
So you are administering a bulldozer justice with a different way.
Okay.
So I certainly, if somebody has encroached on somebody else's land or not followed the law, why should he have an exception? A normal citizen who is law-abiding. So likewise, the other people who have exceeded the law, they need to be dealt with in a different way through bulldozer justice.
But Mr. Srivastava, at the same time, now isn't it ironical that once again the Supreme Court, as you've said, they've reiterated the law, right, that you have to give a 15-day notice period. Tehseen also elaborated on it. 15-day notice period, then you have time to respond, and there's another 15-day notice period as far as...
And a timestamp.
Yes, a timestamp. But isn't it somewhere a little ironical, because the largest number of pending cases before our courts today are land and property disputes? Will this not then come under the same category? Are we in a position today?
While we are saying that the process of law should be followed, I think everybody has to follow the process of law and at least administering the justice.
Yes.
So if any judiciary, judiciary of highest level or district courts, they also have to administer the justice as quickly as possible, and not, there's a timeline for, let's say, for the police to investigate. I mean, if a person is arrested within 60 days and 90 days, and if the charge sheet is not filed within 60 and 90 days, depending upon the severity of the case, the accused gets a bail.
Yes.
So there is a stipulation for the police. Likewise, there should be a stipulation for the judiciary. I am not the person to suggest what should be done. It's the lawmakers who has to, do something like that. But definitely, I am in favor of that there should be a certain time frame within which you might expand the judiciary.
Okay.
You might have more courts, and give a time. There shouldn't be any adjournments.
Absolutely.
All those
100%.
things.
But, sir, I'll bring you in just a moment. Tehseen, how does that work? Because we've tried fast-track courts as far as rape cases are also concerned. What is the status of that? We've not managed to crack the code there.
So now you're asking me a futuristic vision. So when I'm in government, there are two things I will do. Point number one, bring courts on blockchain. As a result of which justice is delivered swiftly, hearings are done quickly. Take the courts to the people. So what you will require is a constitutional amendment to increase the age of judges' retirement ages, as a result of which judges in mobile courts, on which you said majority of the cases are property disputes, can actually go to the area, say, because wo ek ilake mein hote, so you have courts set up in that area, you have the justice. Secondly, the second thing I would do is, the Supreme Court in India remains an apex court for constitutional matters only.
Yes.
And you have 5 Supreme Courts set up in the rest of the country: North India, South India, East India, West India, and Central India, which will be the final arbitrator on ways of constitution, where the apex court in Delhi only hears matters of constitution. Please imagine, and I agree with what Sir says, today your lower courts, and I'm just going slightly away, and on the issue of criminality, your lower courts are not giving bail. Your Supreme Court is sitting on bail matters. So court cases pending hi rahegi na. Your courts are not giving bail. So you will have to make these reforms. These require, and technology will have to be taken to the people with AI, with judges, with quantum coming in, with blockchains, this will be swiftened up magnificently. Increase the age of judges, take the judges and the courts to the people. Take mobile courts to the people, especially in property. I'm not talking criminal, civil disputes. Take the courts, then solve the thing. Do your divorces, which are divorces together, which both parties are consenting to. Do it online. Why do you need to come all the way to the court?
Okay, Mr. Mittal's been wanting to read out the...
I would not like to digress from the topic we are discussing. I had earlier said the Supreme Court should be debating quick dispensation of justice. 142 does not talk what Tehseen you talking. Here's 142 for you. I don't want to embarrass you on this.
No, you're not. Article 142 is
142,
through which this judgment is done, sir.
Please read it.
Sir, through which this judgment
Please read it now.
142 is
140 does not, no.
So you challenge the judgment before
I'm not
higher
challenging.
bench.
I'm just telling
No,
you that you are
it
wrong.
is done.
That's another case added to the 4.5 crore pending already.
I did not interrupt you. So,
yes.
So 142 does not give powers for laying down law. And as Mr. Srivastava himself said, every municipality has a different set of law. And in which case notice will be given, how it will be given, what is the process, what is the adjudicating authority, it's all laid down. By one stroke, all that has been nullified to say this will now be the process. No, this is wrong. Unless you are striking down the provisions of those acts which are there in force. You can't have two acts in force. You can't have a municipal act which has all these provisions enforced while it has got superseded.
Okay, Tehseen wants to
but I'll
respond.
just
Yes.
last say, look, what is the fundamental debate? Debate is people want justice.
Yes. Yes.
And when criminals go unpunished for years and years and years, then this is the justice people appreciate and applaud. But which is not the right way. Due process should never be violated. But the assumption that the due process has been violated, so let us give another this thing and let us create victimhood out of it, that's wrong. That's populist. Let's not become populist. A case has to be decided on each individual facts of the case and not in its generality and say, this is bulldozer justice.
Okay, Tehseen wants to come in there.
Sudhanshuji, you never embarrass me, only get me good coffees, but Article 142 is under which the Honorable Supreme Court took this particular judgment. Article 142 has been debated. You have a lot of lawyers here. For sometimes the Supreme Court stretching its use, as it did in the cricket board case, which I thought was completely misuse of Article 142. A bunch of retired bureaucrats and some ex-cricketers profited. But this was what the framers of our Constitution had hoped for. But may I. There are not, the Supreme Court has again not come up with a new set of laws. What the Supreme Court has said is fundamental rights to life, housing, the fundamental right to appeal, the fundamental right that you're innocent until proven guilty, the fundamental right that others are not punished for a criminal action if of somebody else, and the fundamental right for the accused to defend himself or herself in a court of law, not before authorities, is what is upheld. That is the basic structure of our Constitution, and Sudhanshuji, that is very basic.
That does not get violated by what has been done.
It does.
If a house is demolished because it was illegal and it was encroached on public land, there's no fundamental, and allow me.
Sure, sir.
And the process that there is an appeal. There is an appeal, do it.
In UP, the notice was predated,
Now individual cases,
therefore I'm saying the law has to be applied.
But Mr. Mittal, there's a reason why the Supreme Court then also came in, right?
Supreme Court has given a generality, has gone into generality. I'm saying Supreme Court has to say each case has to be looked at differently.
It does.
In terms
It is
of
still.
That's it.
It still
Supreme
is.
Court cannot say this is what the process would be.
The process is what the Supreme
process
Court
has been laid down.
It's
The
laid down
process
by the
is laid down already in the acts.
Those acts have been upheld. Those processes have been upheld. Reiterated.
If it says 7 days and Supreme Court says 15 days, अरे ये क्या है भाई? अगर एक एक्ट के अंदर 7 दिन का प्रोविजन है कि 7 दिन के अंदर नोटिस आपको देगा, उसके बाद आपके पास 3 दिन का, that's an act.
In criminality, you're not changing the act.
This is not criminality. We are talking about demolition.
Demolishing somebody's house and livelihood and putting women and kids on the street is criminality.
It's
Done
not
by a criminal
criminality.
government.
No, it does not matter. What is
government is criminal when you take away people's lives.
Somebody has made an illegal construction.
And when the government is illegally breaking people's houses because it failed to uphold
if an officer does, if the courts don't punish, it's their problem, yaar. If a government
So
is
the
acting
courts-
illegally, no, please, don't confuse two things.
I'm not
If a
confusing.
government
The
is acting illegally,
acting on the officers acting on the orders of the
it
executive.
may be, but if it is illegal, then let the court punish
Constitution
them.
has to be upheld under all circumstances,
Court
sir.
may
Okay,
punish, nah.
all
Let
right.
the court punish them.
Okay,
But you don't
okay,
let
I want to,
civil
okay, I want
It
to,
can
okay,
punish them
I
on the
want to,
basis
okay.
of the certain laws being broken.
Okay.
There is no law which has been broken because there is law already there in existence.
Predating
Okay,
notices,
I'm assuming this
breaking
will be a
somebody else's
matter
house,
before
is
the
law
courts.
being broken?
This will be a matter before the courts very soon once again. But Mr. Srivastava, I want to understand from you, sir. One last question. Is the concept of a bulldozer justice then somewhere a reflection on the pace of India's judicial system? And should it be taken as a wake-up call to the judiciary itself? Because it's come in at a point where, as Mr. Mittal is pointing out, they've given out clarification on what the law states and what the procedure should be. But is it a reflection on their own pace?
Yes and no. No, because the power is with the municipal authorities. So let the municipal authorities, decide the matter. But if any matter goes to the judiciary, they should decide it quickly and not delay or not sit on it. You see, the best course of action, according to me, you didn't ask me this question, but then I'm just answering. The best course of action is that instead of acting in as a reaction,
okay,
what the government must do is identify the problems and try to deal with those problems at that time itself. Vikas Dubey, suddenly overnight he didn't become a criminal. He was criminal there for a long time. So some action should have been taken against him before. And if that action had been taken, I think he wouldn't have become such a criminal. So, and this is the thing that we have always been following, that if you have a control over the illegal activities, unauthorized activities, and deal with that at the first point of time, then I don't think issues will become so big.
Okay, just last 30 seconds, sir. We have to wrap up. Yes.
So we all heard the cry, Tariq pe Tariq pe Tariq pe Tariq. We thought at some point this will change. I'm sure it's the experience of all of you here that it has become worst. The tariqs have become frequent and longer. That's now how a civilized society can last.
Okay. Tehseen, last word to you.
Therefore, the solution to this is those who have been governing for 11 years and said that this will change have to be removed and new people have to come in who can bring in better reforms so that Tariq pe Tariq stops.
Okay. All right.
Without an iota of idea as to how it will change.
I just gave an idea.
You have given an idea which is silly.
I gave lots of ideas.
Increasing the ages, increasing the age of judges. How ridiculous. How ridiculous. Let me tell you, increasing the number of judges, I can agree. I can agree that and let me explain to you what is happening, which you probably don't know. Increasing the number of judges, yes. Increasing the age of judges, ridiculous. Second, I'll tell you. Use technology. Because now what has happened is, now you are allowed to take evidence on using electronic media.
But to be fair, he did raise that point.
I'm giving you all what happened.
Blockchain, AI,
absolutely.
is exact use of technology. The BJP will paraphrase what I say and will say, but this is you.
Let me allow.
Okay,
using exactly what
Let me allow. Sir, lastly, you should understand that the judicial process is governed by the Supreme Court itself, and no executive authority has any say on that matter. What will be acceptable as evidence and the methodology of evidence is what is laid down by the Supreme Court and not by the Government of India. So please,
and with technology coming in, Supreme Court needs to adapt to it.
I didn't want to make a political case here because it's a case of the
citizens.
With
AI coming in,
I did not want to get into. I didn't want to get into UPA versus.
Okay.
Unfortunately, we have to land up with that.
Yes, I have run out of time, but I promise you we will come back on this debate once again.
Bulldoze this issue.
Yes.
Much like the topic, yes, but hopefully some fruitful conversation has come out of this. Thank you so much once again to all of our panelists. May I invite...
At this point of time, request Tehseen Poonawala, Sudhanshu Mittal and Mr. S. N. Srinivastava to stay back on the stage. I would like to invite Dr. Aishwarya Sharma to come onto the stage and present this token of appreciation for all our guests. A round of applause, ladies and gentlemen. We are presenting all our guests with a memento, the picture of the first Constituent Assembly members, as well as the copy of the Constitution of our country, as we celebrate the 75th year of the adoption of the Constitution. Thank you very much. And we both are on the same side. Yes. Absolutely. I thank all of you for joining us for this discussion. Moving on, let's shift our focus to another enthralling conversation that we are going to be having with Mr. Kapil Sibal. He is a legal luminary. He is a member of Rajya Sabha, president of the SCBA, and my editor-in-chief, Rishabh Gulati, is going to be holding this scintillating conversation with him on the hot seat.
All right. Okay. Thanks a lot, Megha. Thank you. What a conversation. Yes, and that one's never going to end. It's going to go on. We have been stuck in these conversations for a very, very long time. But on that note, let me introduce a person who, of course, requires no introduction in this country. He's been a union minister sorting out 2G. He's been a senior advocate, now member of parliament, Rajya Sabha. Kapil Sibal, thank you very much for joining us on this special Law and Constitution dialogue. I have to ask you, sir, many congratulations for your election as president of the Supreme Court Bar Association. But you know that cases have been filed saying that lawyers should not have ideologies. I have to ask you, Mr. Sibal, you're on the hot seat. What is the ideology of Kapil Sibal? Are you a leftist? Are you a liberal?
Are you a lawyer has no ideology except his being wedded to the Constitution and the values that are enshrined in the Constitution. When we go to court, when we argue the case, the only Bible we have before us is the Constitution of India. We have no ideology then. We have an ideology outside the court, not within the court.
Okay, there's been a very high-profile case, the RG Khar case. You've been involved in this case, Mr. Sibal. What needs to get done for the safety of women doctors in hospitals? What can we do?
I'm not involved in the RG Khar case, hopefully. I am representing the state which was asked by the court to give facts which the court wanted to ascertain. And so we placed those facts before the court. And I was not representing the accused. I was not representing any private party. The court made the state a party and wanted some facts which we placed before the court. And now that the investigation is over and the charge sheet has been filed, it's quite clear that there was only one person who had perpetrated this horrendous crime. And he was caught by the West Bengal police, by the Calcutta police, and he's being prosecuted. That's all that there is to it.
Mr. Sibal,
as far as the safety of women is concerned, I think that whatever the court had suggested, and I'm glad to say that those suggestions have been implemented in the state of West Bengal, but I think much more needs to be done in other states of this country. I think that we are concentrating only on the state of West Bengal, but we need to make sure that women are safe in every situation when it comes to serving in the hospital facility in any state in this country. And I think other states which should be parties to all this will place before the court what they have done.
Okay, all right. I have to ask you, sir, we've been having, yes. Yeah, I have to ask you, we've been having a riveting conversation, Mr. Sibal. Yes. Can you still hear us, sir?
Supreme Court.
Yeah, if you can still hear us, sir, I have to ask you, we've been having a riveting conversation through the course of the day today. And the conversation has been on the census that is coming up.
Which is going to look at all this. And I think that's a very important issue. And congratulations to the Supreme Court for having done this.
Okay, I wanted to ask you about the riveting conversation we've been having about the census that is coming up in 2025. The results will come out in 2026. Is Kapil Sibal watching out for some data
Why
points?
should I watch out for anything? When the detail comes, we will then reflect on what it is, what the details are, and then make our comments on it. I'm not going to, in anticipation of what might happen, make comments at this stage.
But regardless, the population is going to go up, sir. Does an India with 1.5 billion people need more parliamentarians? Do we need more MPs in the Lok Sabha, sir?
First of all, India's population, I just heard Mohan Bhagwatji say that people should produce, you should have 3 children instead of 2. So I hope that this is not a signal to the country to increase our population, but be that as it may. I think as far as our population is concerned, we need to set systems in place because the larger the population, the more the complexities that will arise in order to serve 140 crore people in this country.
Mr. Sibal, regardless, there's an issue in the south, in the northeast, that, proportionally the seats will go down if delimitation takes place after the census. Is this a genuine concern, especially for those in the south?
This is a very contentious issue because there are states in the south who have controlled the population. And if you increase the number of seats based on population, then those who have not implemented, those who have not been able to increase levels of literacy, because of which population is on the decline, they will be rewarded on grounds of increase in population. So whether it's the Northeast or it's, parts of South India or North India, I think the country needs to reflect on this before any decision is taken, and I'm sure the government will do so. But certainly, we require an increase in the number of seats in Parliament.
Okay, the seats in Parliament, well, we now have 33% reservation that is coming up for women. We are going to discuss that in our next panel. How do we go about it? Should there be rotational basis of parliamentary seats? Should the number of seats go up?
Well, this is something that the government will place before us, and then we'll respond to that. I mean, there are several possibilities that we can adopt for the purposes of representation of women. But I think that the fact that 33% representation for women has been accepted is something that we've been sort of asking for a long time.
Okay, Priyanka Gandhi, first-time member of Parliament, Lok Sabha, expected to give her first speech. What tips do you have for any first-time?
I don't give tips to anybody, and why should I give it to an individual? It's for them to decide what is central to their vision as a member of Parliament. I am nobody to give advice.
But will she be a better future PM than Rahul Gandhi? Stick your neck out, sir.
Well, why are you asking me this question? I mean, can I ask an anchor, will somebody else be better than him? I guess he will say, why are you asking me this question?
Okay, but I want to ask you a question because there's a big case that has come out of a New York prosecutor's office. How does New York have locus standi?
Locus standi?
Yeah.
Well, that's for courts in the United States to decide, not for me to decide. I mean, if the government has a problem with that, or if anybody has a problem with that, you'll have to approach that court, no? You can make political statements in India, but ultimately, if proceedings are going on in that court, it's that judge presiding over that court who will decide whether or not a person who has complained has local standi or not.
Okay, but with that logic, Hunter Biden, if he has any dealings with any company in India, can we prosecute him from here? Can we file charges against him and then issue him summons? Can that also then potentially take place?
Depends whether your laws permit that to be done or not. If an offense is committed by anybody anywhere in the world in India, on the soil of India, which impacts us, why should we not prosecute him? If supposing somebody comes here and murders somebody, and he belongs to another country, we should not prosecute him. I guess we are entitled to prosecute him. It's an offense under the Indian laws, right?
Okay, big conversation going on in political dom where the ruling party says that George Soros, the opposition, the Congress are all in cahoots. They're working together.
Well, I don't know. I think the government knows more about this than I do. I think I can say that lots of people are in cahoots with lots of people in India, and I can make allegations which have some element of truth. But I think this government is well aware of the fact as to who is in cahoots with whom.
Okay.
But as far as I'm concerned, I have no such idea. At least I don't have any evidence to that effect.
Okay.
I mean, they know more about the deep state than I do. And maybe they are right, maybe they are wrong. Maybe it's political, maybe it's not.
Okay, you know, the CAA cases, sir, you were very actively involved in them. Now, given what's happening in Bangladesh, because the CAA was about the Hindus fleeing from Bangladesh, given what's happening, what do you make of the situation in Bangladesh, sir?
First of all, minorities anywhere in the world must be protected. Right? A Hindu minority in Bangladesh must be protected by all means. And we must, our government must be vocal about it. The people in India must be vocal about it. Hindus are a minority in Bangladesh, and any attempt to persecute them must be resisted, and we must articulate our vision and our opinion on these issues. And that's true of minorities anywhere in the world, including our own country.
But there are calls now for Muhammad Yunus as an undemocratic leader to be stripped of his Nobel Prize. A lot of people are discussing this globally, sir. Should that happen?
Well, why should I give an opinion on that? Those who awarded him the Peace Prize should decide whether or not he should be stripped of it.
Okay, before I let you go, sir, what is a fair, reasonable wage for a lawyer to be earning these
What
days?
is a fair wage for a lawyer? Whatever the client is prepared to give him. That's all. That's a fair wage. If he thinks that he is good enough for X amount of, money to be paid for legal services, that's a fair wage. And it's for the lawyer to decide whether he'll accept the brief or not based on that wage.
Okay.
But how can I decide for a lawyer what's a fair wage?
Okay, Kapil Sibalji, rapid fire. What is your favorite movie?
All the movies of Dilip Kumar are my favorite movies, and of course Amitabh Bachchan.
Favorite song? Favorite song? Favorite song?
My favorite song? Many of Kishore Kumar, many of Rafi, mostly.
Favorite restaurant, sir? What is your favorite place to eat in Delhi?
Many. I don't have one favorite.
What about things like holiday destinations and food? Yes,
Delhi,
yes,
I
food.
don't go
Yeah.
to too many restaurants, but I don't know. It depends on what cuisine you want to eat. So for different cuisines, you have different restaurants which are very good.
Okay.
Favoritism is not a concept that I really believe in, because beauty is so diverse, right? And the palates, the palate is so diverse in itself that for different things, the dishes are favorite. Your dishes may be different, and each of them may be a favorite.
Okay, you got a diplomatic answer on a very simple question, sir. Let me ask you about favorite holiday destination then. Where do you like to travel?
Anywhere that's beautiful. But, holiday, depends what kind of holiday again. Do you want to go and watch animals? Then your favorite place would be, maybe Corbett, maybe some other place. If you want to be by the seaside, then it's another place. How can I tell you? It's very tough to answer these questions.
Okay, Kapil.
I've never thought in terms of what, I can't now tell you who my favorite anchor is either. It depends on, different channels of different faces.
Okay, for a lot of law students sitting here, sir, 3 tips for young lawyers. Three tips
for
yes.
young. Be honest, be hardworking. Be honest, be hardworking, and be clear in what you want to say.
Okay, Kapil Sibal, thank you very much, sir. I know there are certain medical reasons you can't be with us here today, but you've taken out the time to have this conversation remotely. Really, really appreciate it. Round of applause, ladies and gentlemen. Everybody knows who he is, and many say that he's playing a very positive role now in the Supreme Court Bar Association and on many other fronts. Devika, back to you.
Thank you so much, Rishabh, for that session, and thank you so much, Mr. Sibal, for joining us virtually at the third Law and Constitution Dialogue. Without further ado, I now announce our next panel, another very pertinent, pressing issue for many decades now, but more so for this time around, particularly for this government, women's reservation. What is the plan? Joining us to take this conversation forward, we have with us Ms. Swati Maliwal, member of Rajya Sabha. Ma'am, please join us on the stage. We also have Ms. Jebi Mathur, member of Rajya Sabha from the Congress Party. Ma'am, request you to please join us on the stage. We have also with us Ms. Subrashra, who's an author and political strategist. Joining us and moderating this session is Ms. Priya Sehgal, editorial director of NewsX. Like I said, a very pertinent question being put forward here. Women's reservation, what is the plan? I request all our panelists to please be seated so that we can begin the conversation. Priyaji, over to you, ma'am.
Hello and welcome, and thank you all for joining us for what is really a very important part of our session and part of politics also, the Women's Reservation Bill. As we know, the bill has been passed in Parliament, but there is a delay in its implementation. We are going to be waiting for the caste census, we are going to be waiting for delimitation, and uske baad will be the implementation of it. So Shubrasta, I'll begin with you first. Why the delay? Everybody is saying karna hai to abhi bhi kar sakte hain. Parties like TMC and BJD have already given 33% reservations. So what are we waiting for?
I hope I could answer your question, Priya. We have been waiting for it since 1971, if I'm not wrong. So I mean, we all know the course of the bill. I don't want to get into the details of that. But I think Parliament, as everything else, is a reflection of our society. Do we really wish to see women at the forefront? Is the central issue that we would, we should ask. I don't want to get into party politics here and say that this party is doing better and that is not. But the point is that opinionated women even today are not a easy cookie to swallow. So to answer, I think I'm going to paint all the political parties with the same brush and say they are a part of the larger patriarchal setup, and nobody wants vocal women who have something, who can make a difference, come in the parliament and snatch the limelight away from the men around. Perhaps that's the reason for delay.
Why do you think, are you happy with the fact that, what the Congress could not do for so many years, the BJP has at least got the bill passed, even though, there is a delay, but at least we are on the right track?
When you say Congress couldn't do, you should say about what Congress has done as well.
Which is?
What we have seen, the 50% reservation in local bodies. Now I'm sitting in front of you all as a member of parliament. But my roots are from local body elections where we have 50% reservation, which is a realization of dream by Rajiv Gandhi ji. Something so magnanimous and so reformative. And given that point of time where women never used to come to any public life, and that opportunity opened the doors for women from the kitchen to the public life. So Congress, when in power, has done what, not just in words, but has made sure that it happens, and it happened, and it's a result what we are seeing now in local bodies and taking it to the next level. In our, when we were in government, we have tried our part of doing it. We got it passed in Rajya Sabha, but due to the numbers, we couldn't pass in Lok Sabha. Saying that, I want to also emphasize in the women reservation bill of UPA, we did not have these clauses where depending on two things, only then this is going to happen. So basically, this still remains a non-starter for the fact that, yes, it was a headline making, and also special session was called in the new parliament where nobody knew what's going to happen. So all that we welcome the fact that steps are being taken, but From that moment, in the parliament, outside the parliament, Congress party has taken the stand that we shouldn't be waiting for all these delimitation clause and census clause and all that, and we should make sure that with the available statistics and data and the census available, we should go for reservation, delay it. So the intention of Congress is very clear. We have done it in the past. We have been saying it, and we'll continue to stand for
But you
women.
still haven't given, what are you waiting for also? As an individual level, TMC gave 33%, BJD did. So why doesn't the Congress give 33%? What are you waiting for?
No, Congress, certainly we have done that Ladki Hu Lad Sakti, who was an initiative of Priyanka Gandhiji in Uttar Pradesh, and significant number of seats were given to women. So it's not the case that we have not started it. And also everywhere we are making sure, and at the organizational level, if you look, well, taking from the Youth Congress is a frontal organization of Congress party. At every level we have reservation for women. Again, I'm a product of that. Whereas Youth Congress State Gen Secretary I became because there's a reserved for women for every level, which is Rahul Gandhiji's dream. So organizationally also, we are making sure that women come to the forefront.
Swati, I know you have to leave, and we also welcome Ikra Hassanji. Role of women, how do you see the women? You've been in the headlines also a lot. Women do get in, but then what happens after that? The fight has just begun. Getting your foot in the door is the first step. After that, what happens?
I think, unfortunately, I'm the classic example of that. And I became an MP. I've struggled on the ground for 20 years. In 2006, I finished my engineering, and after that, I've been working on the ground in slums. I've done so much of work in Delhi Commission for Women. 9 years, we've handled 170,000 cases. And I think it was historic, the kind of work that we were able to do, and that's why I was given a ticket and I went as an MP in Delhi. But what happened after that, I think the entire country knows, and it's very unfortunate. So I think that women reservation is something which is very crucial. It's not just a political issue, it's a social issue. I think women have to be given their equal representation in the parliament. It's so unfortunate that right now only 14% of the parliament is women. I think that's something that is very shameful. That number has to be raised, but at the same time, implementation is the key, because just by bringing a law which is strong, which gives representation to women, and even if we have 33% women in the parliament, what happens after that? Are the parties, political parties, bold enough to accept strong voices from women? That's a question. Also, if something happens to a woman in the party, if something happens to a woman, if she's assaulted, if there's sexual harassment, what kind of systems do we have to protect women in politics? Do we have strong internal complaints committees in each and every political party? Do we have mechanisms that suppose some problem occurs, and if the party leadership decides to completely finish off one woman, will other women in the party stand up for her? Will other women across party lines stand up for her? I think these are important questions which reflect the patriarchy that exists in our society as well as in our systems, and something has to be done about it.
We do hope so. I think you raised some good points. But Ikra, you come from a party jahan pe you have the famous saying, Netaji ka Mulayam Singh Yadav said, boys will be boys, ek samay. Now, and pehle they opposed the women reservation bill. Now you have Akhilesh Yadav supporting the women reservation bill. So you think there is a change in the mindset also in terms of, it's a positive change, which you've been seeing firsthand?
I would first like to apologize for being late. And thank you for having me. There is a change, and I think it's for the benefit of women. And I'd like to also address why Netaji first opposed the bill. It was because he wanted sub-categorization within the women's reservation, not just, he wanted reservation for OBCs, women OBCs within the women's reservation. So I think that was the point why he was opposing it. And I think that's also necessary. We need to have women from all stratas of the society to be able to come forward and take the lead. And like my colleague just mentioned, it's not just about I think reservation is the first step, but what will we achieve by reservation? we will only enable a certain number of women to come forward. But are we as a country, as a society, ready for women leadership is the question. Or will we just tick mark 33% of women who will come forward? And like we've seen before, how at the very lower level, at the panchayat level, you have pradhans. And you have pradhan patis as well for the seats that are reserved. So it's not just for the sake of it that we demand women's reservation. I think the country needs to be ready for women to take lead, for women to be able to be leaders and lead the way for other women. And I think these dialogues, I would like to thank you for initiating these dialogues. And I think these are very important. This is a very important topic that needs to be discussed. And I've had the fortune to, right before the session, to visit Norway with the UN Women. And I would like to share some insight from there. They have a parliament which has 45% women representation. And they did so not with affirmative actions, but by enabling changes in the society. So it was very interesting to see how they've brought about that change. And I think something in that regard we also need to do as a society. For example, childcare there is not just a responsibility of the women, but the state has taken it upon itself to have creches, to have kindergartens where women can leave children. So they have paternal leave, maternal leave, and all of those things. And I think these things are very important if we need to take women forward. We need to first remove these foundations that women have on themselves. Only then can we expect for women to take lead in all spheres and fields. And I think the reservation bill is the first step in that regard, and we need to do much more.
Actually, it's because we have feisty women like all of you, the panel, that people are actually, taking notice, and this topic gets more credibility. Swati, I know you have to leave, so I'll ask you one more quick question. In terms of, implementation, what you've said, once you get in, what is the feedback you've seen, and what else can we expect, from the fellow MPs? For instance, your case, what has happened? What has been have you got support from party lines? Or is it just people are taking political positions or gender positions?
It's very unfortunate that in most cases people take political positions. As long as the accused is from another party, then everybody will come up and everyone will be talking about it and, trying to shame the other party. But when it comes to your own party, when it comes to taking a stand, I think people don't walk the talk. That has been my personal experience. At the same time, because Delhi elections are coming up, I think it is very important that while there is a law that exists, it is yet to be implemented. I would really, really request all the political parties fighting in Delhi to implement it on their own. You see, even in my party, out of the 70 tickets that were distributed last year, only 6 went to women. And all 6 of them won. So I think it is very important that political parties understand that women, if you give them tickets, they can win, they can deliver, and they can bring about policies which are way more inclusive and way more effective. You see, world over research talks about that when women participate in decision making, when women participate in governance, there's much more focus on healthcare, there's much more focus on education, there's much more focus on gender-based issues. Then why is it that parties, especially now in Delhi in the upcoming elections, why is it that only 6 or 7 tickets are going to be given to women? I think it is very important that at least 50% of women should be there in all the state assemblies, in all the in the parliament, and I really believe that that will bring about a change. At the same time, like you asked, it's not easy to be a woman politician, and it is not easy to be a woman politician who dares to question the might of political parties, as well as some leaders who think that they are God. So it's extremely important to be able to protect our women politicians. Otherwise, how is it that people will be able to come forward? You see what happened with me, the kind of spectacle that I was made of.
What message did that give to youngsters? That if you come to politics, if you come to the parliament, anything can happen to you. So I think it is important across party lines to support each other, and especially for women to support each
on
other.
gender issues, which is why, Shivrasta, can you all come together irrespective of politics on some issues, in terms of women issues, whether it is, as she said, having creches in parliament or some implementation, bring a more humane thing to become a lobbying group cross party lines.
Absolutely. And I, among the four of us here, I'm the only person not in politics as such. Of course, I'm a part of political strategy making, and it doesn't matter to me which political party wins at the end of the day if they are delivering for the public. Right. Now, the point is, very important points have been raised by both, the three of them, in fact. I don't want to get into 50% reservation, Bihar ne pehle kiya, Congress sarkar nahi thi, and all of that jazz. I don't want to fact check, because I understand where she is coming from as well, where the Congress MP is coming from as well. My point is very limited. What kind of leadership are you giving to this country, even if we talk about women reservation?
Explain.
Still, when will we talk about the quality of women leadership? Right now, we're talking about numbers, and I know it's easy for me to say this because I'm not in the fray. I'm not somebody who is fighting for tickets. I'm not somebody who is lobbying for a Rajya Sabha ticket or whatever for that matter. So for me, it's very easy to take these moral grandstanding positions, but these positions are important. And it's really interesting that it came from a Samajwadi Party politician. The structures in anywhere, in corporate India or in parliament, are not women friendly. Come on, even in media, these chairs are not comfortable for postpartum women. let me tell you.
We will.
When she is raising these issues, these are very fundamental issues. If you really want to talk about women leadership, the question that she asked was, is India ready for a woman leader?
We've already had a woman leader.
I was just coming to that. I was just coming to that. This whole conversation about our leader gave.
Is BJP ready for a woman president?
I don't think so. I don't think so. I wouldn't say just about BJP. Any political party in this country today, if they do not come from, Congress, it's easy to say because Congress is a family-based, corporation. However much they would want to deny it, however much they would want to deny it. I don't have any agenda to grind here. All these conversations about Indira Gandhi, well, how many women leaders did Indira Gandhi promote during her leadership? I come from Nalanda. We had an extremely meritorious candidate.
I think Indira Gandhi was women or men same. She had the same rule for all. She did not promote, beyond a certain level.
Yes, so then we can talk about the quality of that leadership. Indira Gandhi, as a prime minister, has delivered a lot for the country. But I'm talking specifically about women leadership. Okay. The question that if women leaders are at the forefront, do they support other women leaders? And yes. We can take, I think, TMC, the panel, it does not have a TMC representative. I think TMC is the only political party in the country, and I know this, I'm sticking my neck out and saying so, who has actually respected women leadership at the cadre level. At the cadre level. Okay. Even BJD to, when you compare BJD to TMC, TMC is way, way ahead. Okay. They have them. You might have issues with their ideological, understanding of women leadership and how they, completely dish their political opponents. But when it comes to giving a neck-to-neck fight with women, in terms of women leadership, I think TMC is way.
Let me bring JB in now too.
Yeah, so you don't even need to even ask. Before that, let me respond.
Yes.
So I want to actually draw the point that you look at United States of America with such a long democratic history. You cannot name one US president who is a woman, okay? And then not just that, in our recent memory, we have Hillary Clinton and also Kamala Harris fighting, but absolutely we have not seen any kind of anybody, taking any, giving them any step to be the president of United States of America. Now, come back to India. Who is India's first woman prime minister? Please. Indira Gandhi. And which party does she belong to? Okay. Who was India's first woman president? Who made? Congress party.
But how many tickets has the Congress since? It's good to make leaders from one family.
No, that's not right. Who was the first woman speaker in India? Who was the first woman chief minister?
Because you were in power at that time, so you would have the first woman speaker.
Kripalani, first woman chief minister. So it's not the case. See, let us be very, very honest that we have done whatever it takes. You should think of that period also. In that period, with such limited years as well, we can showcase before the world that India had a prime minister, a woman prime minister. Okay. So nobody can deny that fact. So that is the truth. And this bringing in family, and just because one family, I disagree with that. Indira Gandhi is a woman icon. I think every woman in India feels proud of her. Although years have passed, and just attributing it to that Indira Gandhi is because she belongs to one family, I think that is totally very, very...
We give you Indira Gandhi, we give you the first speaker, but what is the road ahead is what we are looking at. You can't just keep saying, हमने ये किया था.
That is what I'm saying. So road ahead is, have we not taken the steps to bring in? See, if you have to talk about words, first you have to have the letters. Okay. You need to learn ABC and then go talk about supercalifragilisticexpialidocious. Okay. So the first step of local body, we have done it. We have done it. There was so much of opposition. Even against that, there were parties who were not supporting local reservation in local bodies. Now we are taking this next step ahead. Okay. So that is what we are saying. So Congress party in its thinking. Secondly, now if you are looking at the mindset of people, I want to just say that issue starts from the mindset of even women. There's an inherent inferiority complex somewhere that we should be behind. No, we should not be standing here. We should not come ahead. I think that should be broken in the largest perspective. Any party, any state, anybody, that perspective should be changed from within the woman, and we should be mentally prepared also to come and achieve and take on responsibilities and these posts as well. That is also one factor.
Yeah. Okay. But Ikra, I'd like to bring you in. Let's not talk BJP Congress. Let's talk about women from big towns to women in smaller towns, and from Uttar Pradesh also. How have you seen in the past few years, how easy or difficult is it? And from a party like the Samajwadi Party, which is a patriarchal party, at the end of the day, I know. But how has your journey been? Tell us your story.
I come from a lot of privilege. First, I'd like to specify that. But even then, I think... as ma'am was saying, we need to first break the notions that we have in the society, and that will take a long time. So there is space, but we need to effectively occupy that space, not just, as ma'am said, not just in numerical sense, but in a very effective manner. For me, because my family was in politics, I got a headway, I got a start, but I would still say it's still a man's world, and everything needs to be, as a woman, you need to be aware of everything. You need to keep looking over your shoulder all the time, and these are societal things. These cannot be changed only through political intervention. I think as a society also, we need to, all of us, not just the politicians, but I think the media has a role to play, and NGOs and other social activists, I think, are doing a lot more than we are doing. So as a society, we need to see women there. We need to see them take the lead, and only then can we expect for things to change in a better way. And I would also like to mention that if Congress hadn't put Miss Gandhi where she was, I think that would be embarrassing, because Congress was the oldest party, so it's only just to expect it from the Congress. So I have deep admiration for her.
So another question to you, taking off from what you said about societal changes, can there be a cross-party consensus on, say, issues like rape? Let's not have politics. And the women should get together and say, whether it is a Nirbhaya or what happened in West Bengal, domestic violence, some issues where women's rights are concerned, you should, can you all at least get together and tell your leadership that on these issues, let's all of us, whether it's BJP, Congress, SP, everybody get together?
No, I think there is a consensus on these issues. I can only speak for myself and the time that I have had in the politics. I think people tend to get together on these issues, and that's a great start. But there are also technical limitations. For example, if I'm a woman and I want to speak on something in the parliament, there is a lot of balloting limitations, time limitations for the parties, and all of those things. So that kind of somewhere limit you, and you need to give in to the top leadership. And top leadership, as we all know, is mostly occupied by men. So
We have to fix that.
we have to fix that.
Okay, just stay away from partisan, from bipartisan politics. In terms of being a woman in politics, a women thing, are there something extra that we have to look for which men don't? You know, whether it is the clothes you wear, the words you use, how you address an issue. There are all these extras that we have to also bring to the table before we actually express ourselves.
And I think I'm thankful, frankly, for the fact that we have to be extra cautious, because I don't think men have set a great example on the kind of language they use, the kind of conduct they have with other women politicians, the kind of issues over which they have fought, even within the party. So I think it's okay for us to be cautious, and I'm not saying this out of this Mother India mentality. I think it's okay to present to be more presentable, to be more accessible, and to be more moralistic. I don't have an issue with that. My problem arises when, I have an issue when we start talking about reservation and rape. When we take only these two incidents, or when we take only these two conversations that have to be around women, why can we not talk about, say, for example, women farming issues? Why do we not talk about women reservation when it comes to farming in India? Yeah. Not exactly like how many women farmers should we have, but the fact that there are specific issues of women farmers which never gets addressed. The whole country was in hullabaloo, but we never talked about women farmers. They were only propped up as a frontline attack. There are a lot of, I can see a lot of military people here as a frontline warriors. Yeah. Similarly, it happened with CAA. Women were propped up and we were used as props. And the sad part is we were comfortable being used as props. So my problem with, at the risk of again repeating myself, my problem with propping up Indira Gandhi as leadership, as an example of effective leadership, is not her comparison with Tarkeshwari Sinha. Tarkeshwari Sinha came from a middle class family in Bihar, same age as Indira Gandhi, more meritorious than Indira Gandhi. She went to London School of Economics on her own merit. But do we as a country recognize Tarkeshwari Sinha also today?
I think there's a perspective to that. Let GV answer that. But also, I got it. We are out of time, so I want to give everybody some time.
One question. Was the Congress party open to having a debate between Tarkeshwari Sinha and Indira Gandhi when they handed over the reign of Prime Minister to her? Simple question. I want a simple answer to this.
See, in a democracy, people are elected by the situation, and then the MPs involved. If it's the chief ministers, MLAs involved, it's the parliamentary party's decision. So Indira Gandhi is considered to be the Iron Lady of India. We all agree. So we should be proud that we have a prime minister who is a woman, and not just woman, that she's respected worldwide.
Why are we still debating Indira Gandhi today's? No, Subrata, let her finish. Yeah, let her.
She's still asking, madam is still asking whether she should have been
made or should not have been made. Can we critique women leaders is the question. Okay. Can women leaders critique women leaders? Appreciate and critique at the same time? Because if we don't have this quality conversation, then what's the point of women reservation in parliament? Or anywhere for that matter? If we cannot improve the quality of the leadership that we have, then what's the point of reservation? Please, we have had, Pradhan.
Okay, let me ask a good point. I've understood your point. Let her answer.
About?
No, she's saying that in terms of why are we promoting only one kind of woman? In terms of the quality of women leadership?
No, quality of women leadership, it's there at every level. Now, when it comes to BJP as a political party, they are not interested to showcase or project Indira Gandhi's qualities. Is their political strategy or an agenda? So, we don't have to agree to that. The fact that India as a country, in the history and in the books and in the records, when a country like United States of America, still with such a long history, cannot even show a head as a woman, we can show, we can portray, we can project, we can still say. Now we don't know now next Prime Minister when we are going to have a woman, but until then we can say that Indira Gandhi was...
But will it be Priyanka Gandhi if the Congress has a choice, or will you go beyond? I think that is a question.
No. See, Priyanka Gandhiji has won with over 4 lakhs majority.
We're debating that. We just say
This is again, see, when it comes to politics, when you're contesting election and when you're winning, I think after winning that, you cannot be questioning whether what is the surname and then go behind the surname, and because of the surname is not the issue. People accept them, people love them. And that is why Priyanka Gandhi ji has won with over 4 lakhs majority.
Okay.
So if she has won, she has won. She's a leader. Now she's going to speak in parliament. I would say, you know, all of everybody, madam can also listen to what Priyanka Gandhi ji is going to
Madam
speak
will listen,
in Constitution.
sure. But Swati, you know, just going beyond Priyanka Gandhi, Indira Gandhi, in terms of being a woman, are we judged for something extra than just our politics?
Absolutely. I mean, every woman faces that in society. What you wear, what you talk, how you get up, how you sit down, what time are you coming back home, what time do you leave your home, everything you're judged at. I mean, I have felt it personally even in the parliament that what I wear is something that gets very noticed. Like I remember that one male politician walked up to me in the last session, and I was wearing Western formals, and I was told that अब तो हम आपको नेता बनाना चाहते हैं और आप साड़ी पहन के आया कीजिए. So I love wearing saris, I love wearing Western formals, I love wearing formal clothes to the parliament. Being a part of the parliament, being a member of parliament is a matter of great pride for me. Every time I walk inside the parliament, I feel that sense of responsibility. I feel so energized, and I feel that, you know, there's so much that we can achieve. But that's the way that everybody thinks. Yeah. Why is she wearing this? Why is she not wearing this? So I think it's important that, and it's something that is that's so entrenched in our society that, you know, you don't even sometimes feel that, oh, what did he say? Yeah. Because it was said in a very, it was said out of concern for me. It was said out of, you know, it was said out of that, like, you know, we really like you, do this. But it is said in those manners.
Not without its patronizing touch.
Yes, but it is extremely patronizing because people don't realize, men actually don't realize.
Okay. Ikra, last word to you, taking into account what Swati has said, is it a plus or a minus being a woman politician?
I think there are lots of plus, but like what she said just now, comments about how you look, they kind of diminish your credibility, I feel, because we're not here to be appreciated for the way that we are presenting ourselves outwardly. But comments like those kind of leave a bad taste in your mouth. And I think we've all been through those comments. And I cover my head. So a lot of attribute is given to, because I cover my head, so I get a lot of credit for it. And I don't think that's why I do it. But to attribute things to your appearance, I think is unnecessary. And like ma'am said, male politicians or males in general unknowingly do it because it is so deeply entrenched in the society. So they're unknowingly doing these things, which kind of restrict us in a way.
I don't know what is worse, that they're doing it unknowingly thinking or they're doing it, knowingly.
There is no stop to it also. Like she was wearing Western formals. There was a comment on that. I cover my head. There's a comment on that. So you can never, you don't know how to play this game because for everything you do, there will be a comment. So we need to stop that. We need to stop giving them that leeway that they can comment on how we appear because we don't do that with male politicians or anybody in any other field.
Very good point. And we're totally out of time. I'm sorry because we're being asked by the men to wrap up. On that note, thank you.
Thank you so much once again, Swati Maliwal, Ikra Hassan, Subrashra, and JB Mathur for joining us at the third Law and Constitution Dialogue. We're going to take a moment. I'm going to invite Dr. Aishwarya Pandit Sharma onto the stage to present a small token, rather actually not small today, but a token of our appreciation, a rather heavy token of our appreciation to all of our women panelists who've joined us to take this very pertinent conversation forward. That is Subrashra, author and political strategist. Thank you so much for giving us your precious time. You're also being presented with a photograph of the first meeting of the Constituent Assembly, viewers, which was attended by 205 members, and interestingly, this included 9 women on the 9th of December, 1946. Let's have a huge round of applause for our women parliamentarians as well as political authors, strategists and thinkers who've joined us today to take our pertinent conversation on women's reservation forward. And with that, it's time for us to move on to our next enlightening session. We have with us Shri D. Raja, former member of Rajya Sabha, with us, and we also have Mr. Rakesh Sinha, former member of Rajya Sabha as well. We have two former members of parliament with us to have a very pertinent conversation on the Indian Constitution at 75. Is it stronger than ever or is it under threat? I'm going to request our next panelists to please join us on stage. Mr. D. Raja, former member of Rajya Sabha, and Mr. Rakesh Sinha, former member of Rajya Sabha as well. The moderator for this session is Mr. Rishabh Gulati, Editor-in-Chief of NewsX. They will be discussing whether the Constitution at 75 is stronger than ever or is it under threat.
Microphone.
Rishabh, over to you.
Thanks a lot, Devika. Thank you. And yes, this is why we have gathered here, because it's the 75th anniversary of when the Constituent Assembly finished drafting the Constitution. Of course, it was adopted officially on the 26th of January 1950. But a big debate is happening in Parliament. 2 days for the Lok Sabha, then Monday, Tuesday, we pick it up in the Rajya Sabha. We are discussing the Constitution of this country. Is it an ode to the Constitution? Are we paying tribute to it? Or is there something substantive to actually debate and discuss? Let's pick up this conversation. Mr. D. Raja, we are constantly being told when opposition members now swear in they carry a copy of the Constitution that the Constitution is under threat. How is it under threat, sir?
Definitely, there are threats to the Constitution. You must have noticed during the Lok Sabha elections, one of the central themes in campaign was how to safeguard the Constitution. Because the very slogan, Char So Par, some leaders gave an impression if they get massive majority, they can replace the present Constitution, they can throw out the present Constitution. Definitely, there are threats to the Constitution. There are threats to the very foundational principles of Constitution. How to save the Constitution? Because it is not me, the prime architect of the Constitution, Dr. Ambedkar. When he was speaking while presenting the Constitution, he gave the caution, on 26th January 1950, India will become a democracy. That means government for the people, by the people, of the people. But the question is whether India will remain as a democracy with the Constitution or we will lose the Constitution.
Okay, but
this is what Ambedkar said. Ambedkar also had such doubts. What is going to happen to Indian democracy, Indian Constitution? Today
but
we
Indian
are
democracy
facing
is doing well, sir, because you're General Secretary of the CPI. When we look at countries that have gone communist, those are the countries that have become dictatorial, that have become autocratic. It's the Congress that imposed emergency in this country. Why do we feel suspicious? Is it the BJP that will demolish the Constitution? If anybody is to fear, it's the communists.
I do not agree. You have your right to articulate your views, but it doesn't mean I should agree, because Ambedkar was under pressure, I am telling you. When we won independence, partition took place. After 1 year, Mahatma Gandhi was assassinated. The work on the Constitution was going. Ambedkar was under tremendous pressure to declare India as a theocratic nation. Ambedkar emphatically rejected that idea of theocratic nation. In fact, you are taking the name of Communist Congress. I am taking the name of some Hindu communal forces. They forced Ambedkar to declare Hindu Rashtra. Ambedkar said, if at all Hindu Rashtra becomes a fact, that will be the greatest calamity for India. I am not saying. Dr. Ambedkar gave this warning. And that's what one should understand, how to safeguard our constitution.
Okay, but again, safeguard from what? So let me be devil's advocate with Rakesh Sinha as well. Rakesh Sinha ji, now 15 years, all right. There's another election that will happen in 2029. Does the BJP intend to rule forever? And if you get a 300, 400 majority again, will you convert India into Hindu Rashtra? Doesn't make a difference what the constitution says.
D. Rajaji is my good friend, but I like to correct him. In the entire discourse of the Constituent Assembly, there is not a single demand for Hindu Rashtra. Not a single member raised the issue. I don't know from where it may be in the Communist dictionary. And the Constitution is not a dead book. It is a lively. And when Constitution is progressing or Constitution is being attacked, it's just by the behavior and the action of the ruling party. Tell me one instance since 2014, Narendra Modi ji came into power, that BJP or the Prime Minister did anything which is going against the Constitution. Rather, he's quoting Ambedkar. Dr. Ambedkar talked about the social democracy. A social democracy is not by slogan, it's by substance. By empowering women, by empowering the farmers, by empowering the Dalits and tribals, OBC, the Prime Minister created a situation for the social democracy. But I'm coming to the core question. Who attacked the Constitution? D. Rajaji is a communist, and he remembered that time the Communist Party was not undivided Communist Party. First elected communist government in Kerala, led by EMS Namudripad. And Nehru had thrown out the elected government of Communist Party in Kerala. That time debate in the Lok Sabha and Rajya Sabha, you go through the debate. And it was the prediction of the communist parties that if Congress party would continue, the constitution would be thrown out in the dustbin. I'm talking about the first amendment. After the enforcement of the constitution, you see the two constitutions, American constitution, our constitution. America, the first amendment was the enlargement of the freedom of right, protection of the press, protection of the right to speak. But India, the first bill after 15 months of the constitution was the curbing the press. And the Home Minister, the then Home Minister Rajaji told, just like a headmaster keeps a stick but does not like to use it, we are keeping a stick against the press. We will not like to use. So it is a progressive deterioration of the opposition politics led by Congress, which led the erosion of the constitutional value. I don't want to again and again remember emergency, but just one instance I will tell you. How cruel an emergency was and coercive emergency was, we cannot imagine. B.M. Sinha was a journalist. He was a very known journalist. He was arrested and his mother died. The reason of arrest was he was expected to spy his own colleagues and comrades, journalists. He refused. His mother died. He wanted to join the funeral of his mother. He was not allowed. So I think if you see the history of the Congress, and that time D. Rajaji's party, Communist Party of India, was completely in collusion with the Congress Party. They were, when Jayaprakash Narayan was fighting for the liberty of the people, democracy, then Communist Party and Congress Party was organizing international anti-fascist conferences in Patna and other places. So I think that for the if any degeneration in the constitutional morality, I not say the degeneration of the constitution, constitutional morality, the communists and the Congress both are responsible.
Okay,
I say that communists are equally responsible. They don't have commitment for the constitution.
Okay, I'll give him a chance to respond, but before that, Rakesh ji, it is a conundrum because we are trapped in a loop. If during emergency the preamble is changed and words are added, if 40 years later you try to remove those words, you are being accused of tampering with the basic structure of the Constitution. Why should the words secular and socialist be removed from the preamble?
You know, those people who again remember Dr. Ambedkar and says the Ambedkar's constitution should not be changed. I am reminding the people that in Constituent Assembly there was a member K.T. Shah. He brought the proposal that in the preamble of the Constitution, socialist and secular words should be added. It was Dr. Ambedkar who opposed. He said no requirement, kindly don't imprison your future generation. Constitution, he said, Constitution is a mechanism for managing the governance. Constitution is not the mechanism to imprison the people. So I think that what if we are going to do, we are going to show our commitment for Dr. Ambedkar's values, words.
So Mr. Raja, why is it okay for an emergency government 40 years ago to change Dr. Ambedkar's constitution? Why was that okay?
Now, firstly, with all respect to my friend Rakesh, he is one of the learned persons in that camp. I must say, I'm not bringing things from communist dictionary. I can very well quote RSS dictionary, from Golwalkar to anybody. I can quote. I'm not doing that. The point is, we have a constitution. That constitution gives 3 definitions. 1, India should continue to be a democratic republic, number 1. Democratic republic. It means secular democratic republic. 2, Indian state should be a welfare state. State should ensure all means of livelihood to all its citizens, men and women. People should have the right to live with dignity. This is what Constitution says. 3rd, India, that is Bharat, union of states, union of states. In fact, originally Ambedkar talked about United States of India, but when he drafted the Constitution, he opted for union of states. Now, union is undermined, one nation, one elections. We can debate on those issues. But coming back to democracy and emergency, of course, emergency was opposed, we condemned, but the point now we are discussing, now what are we discussing? Why we discuss constitution? Why parliament should discuss constitution? We observed the 75th anniversary of the constitution.
Yes.
Everyone who went outside, who saw Ambedkar statue, touched his feet. But what is happening actually?
No, what is happening? What is the issue? What is happening that you're saying this is a red flag?
Listen to me. Constitution preamble says liberty, equality, fraternity.
But everybody agrees with that. Who disputes this?
Who is agreeing? What is happening in practice? Where is the fraternity? Why communal conflicts are taking? Why atrocities against Dalits, tribals are on increase? Why atrocities on women are on increase? Are we not responsible? If we have that commitment to Constitution, we should stand up for the welfare
Mr.
of...
Raja, you critique your own country, but you don't critique China. You won't. Which communist country is a democratic country? You critique our own country, but why not critique the others who are communist countries? They're not democratic.
If you want to discuss communist countries, you have a separate discussion. I will have a discussion with you. And some people...
Is China a democratic country?
Some people ask me, oh, America is not welfare state. I asked, if America is welfare state, why Black Lives Matter? Why that agitation emerged? Still it is continuing. So let us not discuss those. Let us discuss our own country. Our own country, India. We the people. We have the Constitution. Okay. And the Constitution says justice. Justice, social, political, and economic.
Okay.
And where is the... No, let me finish. Where is the justice? In India, what is the problem? Caste, patriarchy are major challenges.
Okay, let me take a question first. Let me take a question first, because this became controversial. Rakesh Sinha, you know this, sir. that just a few months ago a G20 was held, and for the first time we saw the placards that read Bharat. It didn't say India. Now, there is a technicality because the constitution says India, that is Bharat. But people say first you do Bharat, then you add Hindu Rashtra, then you do Ram Rajya. That's what they fear.
You know, India is a unique country. Unique in the sense that other countries' history, you go through the history of any country of the world, it is a high 500, 600 years. India's history is time immemorial. At least 8,000 to 10,000 years you can easily characterize India's history. So it is their reconnecting with these civilizational roots. That is very important for the country. We cannot compare ourselves with USA, China, or Britain. We are reconnecting to the roots. This means reconnection with the ancient period. And I am remembering one of the person in the Constituent Assembly. He was from Odisha. He said that by secular is a slippery word. This is being used by certain people just to bypass the ancient Indian culture. We just see the history of Congress party for last 7 decades, governance of the Congress and communists. What happened? The ancient Indian history has been completely shrugged off from the history book. Now we know the sacrifice of Guru Tegh Bahadur. Can there be any parallel? A person is sacrificing his life for the freedom of religion, not for the Hindus. He was fighting for the freedom of religion. Can there be any parallel of Guru Gobind Singh, the father, any father in the civilizational history of the world, not in India, not in Europe, entire civilizational history of the world, that he is sacrificing 2 sons, minor sons. What for? The freedom of religion. Dignity of the people. You cannot convert the people.
But that's the point.
So I'm just concluding. So India's history has been the history of suppression of the Hindus. And you just imagine that Hindus population is going to be less than 50%. India can be automatically theocratic state, whether Islamic state or Christian. I'm completing. And one question for the D. Raja, that you can you tell that the part of India, Bangladesh and Pakistan, once Afghanistan was part of India, and they are the theocratic state.
Okay,
we are secular because Hindus are in majority. The moment Hindus would be in minority, India would be a theocratic state.
Let him respond.
Like
D. Raja, respond to that.
Firstly, my friend referred to Mr. Shah in the Constituent Assembly. When Mr. Shah asked Ambedkar, why can't you put that word socialist? Dr. Ambedkar replied, what all I have said in the directive principles of state policy, they are nothing but socialism. Let him read what Ambedkar has said during Constituent Assembly debates. So I'm not getting into it. Then he says Hinduism is the oppressed religion. How can you say that oppressed religion? If you ask me, who oppressed Dalits? Who oppressed Dalits? Who oppressed tribal people? Even today, why our women are passing through such miseries? Dalits I am talking. That is why Ambedkar said annihilation of caste. He just doesn't say.
But the point Rakesh Sinha made, that undivided India under the British went up to Afghanistan. Look at Afghanistan, look at Pakistan, look what's happening right now as we speak in Bangladesh. These are unhappy things.
No, division took place. Now let us focus on our country, India, our nation, Mother India. Let us focus on India.
Okay.
And India, we have...
I want to flip the...
Listen.
Yes, please.
India, we have several religions. And we must have religious harmony, communal harmony. That is what has been said in the Constitution, Article 25. Then you go another subsequent articles.
Okay, we're all believers in religious harmony, so let me turn the question around.
No, people have the right to follow any faith.
I have limited time, so I want to...
We should uphold that right.
Okay, let me turn the question around. Rakesh Sinha, we are seeing a constitutional crisis in Sri Lanka, constitutional crisis in Bangladesh. Nepal has just come out of constitutional crisis perpetually in Pakistan, you in South Korea. Is it not reasonable for the opposition to say that even the constitution as it exists 75 years later should not be taken for granted? It needs to be protected constantly.
No, the question is that when a opposition party is talking, just BJP demanded or aspires for a debate in the Rajya Sabha and Lok Sabha. What is the debate? George Soros, A 94-year-old billionaire is declaring from Europe that he would destroy Narendra Modi government. Who is he? Democracy and sovereignty are not threatened by the men in uniforms. It is also threatened by the men without uniform, and George Soros is example. There is a relationship between George Soros and the Congress. And one question to D. Rajaji, he is talking about Dalit. Communist Party and Congress Party have alternatively ruled in Kerala. And there is tremendous untouchability. Who is responsible? Why not you are bringing social legislation?
Okay.
So I think that it is a communist and Congress hypocrisy
Okay.
when they
All
talk
right.
about the
I'm out of time. I'm out of time. 30-second response, Mr. Lada. Last word.
No, my friend should know. He refers to Kerala. I am telling you, Kerala is the #1 state as far as literacy is concerned. Why it happened? Here many learned people are there. They must know. There was one revolutionary, Ayyan Kali. He represented Dalits. He started the agitation. He did not ask, open the gates of temple, this temple, that temple. He said, open the gates of school. My children should go. My untouchable children should go and read. That is how Kerala moved to this extent and emerged as #1 state as far as literacy is concerned. The other thing, he brings so many issues. I can ask the electoral bonds. I was in Parliament. When it was brought, I opposed it. Mr. Arun Jaitley was the finance minister. Then it was brought as a finance bill. Okay. Now who gained through the electoral bonds? Even the Supreme Court has said it is unconstitutional. It is BJP which looted and amassed money through the electoral
I know
bonds.
this is a never-ending conversation. We've run out of time, and I know this conversation will happen in Parliament. I know it'll continue with you two gentlemen as well. There are so many hot topics, but for engaging with us on it, we'll leave the open questions to pick up on the next session as well. Rakesh ji, Mr. D. Raja, thank you so much for taking out time for the third Law and Constitution Dialogue, sir. Thank you very much.
Thank you. We will have discussion on specific issues.
For sure, sir. We'll sit down. Look forward, sir.
Okay. Thank you.
Thank you so much once again, Mr. D. Raja and Mr. Rakesh Sinha, for joining us. Please do accept a token of our appreciation for joining us at the third Law and Constitution Dialogue. That's a copy of the Indian Constitution being presented to Mr. D. Raja, and we also have a photograph of the first session of the Constituent Assembly. Could we please have a round of applause for Mr. D. Raja and Mr. Rakesh Sinha? Thank you so much once again to both the gentlemen for joining us. And with that, ladies and gentlemen, we move to our next impactful session. We have with us Shri Sudhanshu Trivedi, Member of Rajya Sabha. He'll be addressing several questions, but the most pertinent one: does India need a debate on the Constitution? This conversation will be moderated by Mr. Rishabh Gulati, Editor-in-Chief of NewsX. I request Sudhanshu ji to please join us on stage. Sudhanshu ji, thank you so much, sir, for taking out your time and joining us at the third Law and Constitution Dialogue. Rishabh, over to you.
Okay, Devika, this is going to be a tough one because the best way to interview Sudhanshu Trivedi is to just let him talk, because he can take it on by himself. We've all seen his very, very fiery speeches. Perhaps not just a politician, but one of the best orators of our times. Sudhanshu ji, what a treat it is to sit with you. there is a debate going on for 2 days in the Lok Sabha, then following 2 days in the Rajya Sabha on the Constitution. Is there a debate, sir? Are we doing a tribute to the Constitution, or are there serious matters that require a very serious consideration?
I just want to point out that you are saying this in this session since last few days going on. Can you remember any of the sessions in the last 3-4 years when there was not a problem during the process of session? Always there was a ruckus whenever the parliament is in session. And sometime or the other, just before the session, some scrupulous news emerges in the Western media, and then everything starts going on here. So it is a typical characteristic of the last few years. And I would like to give an example. This month, 25th of November, the session was starting, and 20th of November, as US Attorney report has come. Now you just go back. In the month of August, when monsoon session was there, then the report against SEBI came. If you remember that the parliament session was starting on 30th of January 2023, on 24th January, the report on Hindenburg came. If you remember, on 18th of July, Manipur video came. On 19th of July, monsoon session was starting in 23. If you remember, in 22, on 19th of July or 18th of July, Pegasus report came. On 20th of July, the session was there. You go way back. On 3rd of February 2021, the reports against farmer came, and the parliament was in session during the budget session. And every time there was a ruckus. तो अब इसमें क्या कहा जाए? उधर से चुटकी बजती है, इधर से ताल लगती है, उधर से कहते हैं मिले सुर मेरा तुम्हारा, और फिर पार्लियामेंट में बवाल हो।
चुटकी कौन बजा रहा है?
अब ये तो समझने वाली बात है, सबको समझ में आ रहा कौन बजा रहा है। वही लोग बजा रहे हैं जिन्होंने प्लेज कर रखा है कि आई हैव प्लेज $1 billion टू रिमूव द मोदी गवर्नमेंट, which has never happened in the documented history of the country, when a billionaire sitting outside has openly said that I have put so much amount of money to remove the Modi government.
So are you saying that that they are taking cue from a George Soros, or are you saying they are following instructions from a George Soros?
What I am saying, I have given you one sequence, complete. Then you yourself can draw a conclusion कि जो कुछ वहां बोला जा रहा है वो यहां हो रहा है. दूसरे examples हैं कि there are so many things like Salil Shetty, who is a vice president in their foundation. He was with Rahul Gandhi ji in Bharat Jodo Yatra. Sonia ji was there in that institution which is financed by Soros Foundation. So it is very evident in the public. I don't think there is any scope of debate. And further I would like to extend. ये आज के थोड़ी सोरस की बात है. अरे भैया ये तो 40 साल से चल रहा है. Whenever a scrupulous and suspicious person in West arises, he is having some relation with the top leadership of the Congress party. In 1984, during the Bhopal tragedy, Warren Anderson, किसने भगाया था? कनेक्शन किससे निकला? ऊपर से. Then the Bofors frame, Ottavio Quattrochi, किससे कनेक्शन? टॉप लीडरशिप से. Then Guido Heschke, Augusta Westland fame, कनेक्शन ऊपर से. Christian Michel, connection top leadership के साथ. Even if you remember Volcker report, Paul Volcker's report in 2006 on the oil coupons, Saddam Hussein has directly given money to Congress party, and now Soros. So from 84 to 2024, ये हमेशा.
But Sudhanshu Trivedi, the Congress says that, listen, because the agencies under your government do not investigate your own government, that's why all the leaks have to come, all the cases have to come, corruption scandals have to come, then they have to come from abroad.
So in 84, our government was there. During the time of Quattrochi, our government was there. The time of Guido Heschke, another 2010 issue, it is there. It was not our government. और ये मैं पहले भी बोल चुका हूँ, ये frivolous charge है, जो वो कहते हैं, जैसे बहुत से लोगों ने कहा ना कि वो केजरीवाल जी जेल चले गए तो he was the first chief minister. Again, I would like to remind, सोनिया जी और राहुल जी जिस मैटर के ऊपर बेल पे हैं, वो 2013 अक्टूबर में स्टार्ट हुआ by the Delhi High Court. It was not by our government. अब ये बताइए, कणिमोजी जी जेल गए 2013 में और ए राजा हमारी गवर्नमेंट थी. ये सुरेश कालमानी went to jail in 2010, हमारी गवर्नमेंट थी. शिबू सोरेन went to jail in 2006, हमारी गवर्नमेंट थी.
Karunanidhi went to jail in 2000, Jayalalitha went to jail in 1996, Lalu Prasad Yadav went to jail in 1997, Jharkhand Mukti Morcha bribery case 1994, Rajiv Gandhi पे allegation 87, FIR 1990. सर क्या बात कर रहा है कोई अगर ये कहे कि साहब हमारी गवर्नमेंट कर रही है?
You've had 12 years of government. How many convictions have we seen in political corruption? Because you saw 12 years ago, the corruption was the biggest issue. There was 2G, there was coal scam, CWG scam. It's all gone. We don't talk about it anymore.
Definitely. The conviction and final conviction is a process which is related to the judicial process. And in our country, the judicial process takes time. And that's why the Bharatiya Nyaya Sanhita लाई गई है, ताकि वो delay ना हो. And in this context, I would like to remind, इस देश में सबसे बड़ा एक ऐसा crime हुआ, which doesn't need any evidence. Prime Minister was killed by her security personnel in Prime Minister house. 31st October 84. कितना समय लगा convict करने में? 5 years. 1989. जब आपकी पार्टी नहीं आपके बेटे की सरकार थी. Why? Every proof was there. But still the process took 5 years. So that's why there is a procedure of judiciary which takes long time.
All right, let's take an example because I am going to make a supposition. I can't say as a fact that a particular prime minister of a neighboring country goes to visit China. She spends 10 or 11 days. She comes back. There are nothing happening in the country. Suddenly protest takes place. Two weeks later, she is now taking political asylum in India. And a person who was working for the Clinton Foundation now takes over in an undemocratic fashion. So if we assume that this is not a coincidence, that this is what you suggest, somebody is doing chutki, what are we doing to fight back?
सिर्फ इतना ही नहीं है. What happened in Bangladesh, you can see what happened in Sri Lanka, what happened in Pakistan, what happened in Afghanistan, even the turbulence in Nepal. हमारे इर्द गिर्द में सब जगह तो वो है. सिर्फ यहां पर इसलिए स्टेबिलिटी है कि मोदी है तो मुमकिन है. We are having such a strong, capable, far-sighted leadership, and our systems are robust. That's why they are unable to play any game. They are playing, but they are unable to get the desired result.
No, but why do we hesitate from playing the game back? If we are saying that a New York prosecutor can file a charge sheet talking about allegedly corruption taking place in India, mostly in opposition-ruled states at that point of time, why cannot we prosecute a Hunter Biden and issue him summons? He's also accused of corruption. He's been pardoned by his father, the president.
हाँ, अब देखिए आपने देखिए कितनी अच्छी बात बता दी कि उनके फादर ने उनको पार्डन कर दिया है. Or they used to give us the sermons of transparency, justice, equality of all. That itself is an example कि वो अपने बारे में क्या आचरण करते हैं, जिसे हिंदी में कहावत होती है ना, पर उपदेश कुशल बहुतेरे. And on this issue, for the first time you have seen that our government has taken such a firm stand that you cannot comment on our internal issues. आपने कभी इससे पहले ध्यान दिया था? कभी ऐसा हुआ? अभी देखिए फॉरेन सेक्रेटरी गए ढाका. After that, they have arrested 88 people. Just, you can say it is because of that, but there's a 24 hours gap. 75 cases were registered and 88 people were arrested. So that's why we are saying that a very dexterous diplomatic policies has been executed by Prime Minister Shri Modi. I just want to give 2 examples. Russia has given us S-400 anti-missile system, which it has given to nobody. We are the only country. And America is done an agreement to give us Predator drones, which they have not given to any non-NATO country. We are the first non-NATO country to get the Predator drone, and we are the only country to which Russia has given S-400 anti-missile system. It's only possible under the leadership of Modi ji. You never would have found कि बाइडेन ने भी अपने घर में उनको स्पेशल डिनर दिया और पुतिन ने भी दिया. In a span of just 3 weeks, you have seen he was hugging Putin also, and he was hugging Zelensky also. So our diplomatic policy, which has started with the non-aligned movement, has come to the position of all-aligned movement. अब सब हमारे साथ हैं. एक ज़माने में हम किसी के साथ नहीं.
But it's also sometimes convenient that every time you critique the government, you are saying you are anti-India. Okay, you are sold out to the billionaires. You are working with Soros. How does an opposition critique your government, ask you questions, demand answers, whether it's on billionaires, whether it's on port deals, on solar plants, without being accused of being anti-India?
हाँ, वो जो आपने बात कही वो बिल्कुल सही है. ये बताइए सोलर की एनर्जी की कंपनी को लेके हुआ है? I am not taking side of anybody. Forget about
largest solar plant in the country.
Yes. Forget about X company or Y company. I just want to ask, open your mobiles. Which country is controlling the solar cells industry in the world? China controlling 95%. Which country is having maximum control over solar energy sector in the world? China is controlling 80%. And wherever you say, you blame the government for Hambantota. Who was the second bidder? China. Chinese company. You are talking about the power project in Bangladesh. Who was the second bidder? Chinese company. Who was the second bidder in Hambantota, Sri Lanka? Chinese company. तो साफ बताइए ना किसकी मदद करना चाह रहे हैं? जो आप एलिगेशन लगा रहे हैं उसमें तो कुछ साबित नहीं हो रहा है, मदद किसकी करना चाह रहे हैं ये साफ हो जाता है. एंड वन मोर थिंग आई वुड लाइक टू से, एक दौर में हम लोग जब बच्चे थे तो कांग्रेस कहती थी सरकार चलाना उन्हें आता है. अब तो जनता ने बता दिया कि सरकार चलाना किसको आता है, पर मैं ये कहना चाहूंगा अपोजिशन में कैसे रहना चाहिए ये उन्हें नहीं आता है. व्हेन वी वर इन अपोजिशन एंड एवरी मोमेंट ऑफ क्राइसिस वी सपोर्टेड द गवर्नमेंट. I give you one example. In 2010 or 9, when Nawaz Sharif has used a very demeaning words for Manmohan Singh ji. वो याद है आपको फेमस उन्होंने कहा था वो देहाती औरत की तरह रो रहे हैं वगैरह वगैरह. At that time, our chief minister, our present prime minister who was chief minister there, Modi ji has said, कौन होता है किसी दूसरे देश का प्रधानमंत्री हमारे प्रधानमंत्री के बारे में बोलने वाला, ये 120 करोड़ देशवासियों का अपमान है अगर वो बोलते हैं. Now, Atal Bihari Vajpayee ji, in 1995, when Pakistan brought a resolution on the issue of Kashmir against India in Geneva, Atal Bihari Vajpayee, as leader of the opposition, led the delegation and supported Narasimha Rao government, given full credit to Narasimha Rao government in Geneva. And when we came back, then we started opposing the government. आप सोचिए और 1971 की वॉर के समय तो तमाम हमारे कांग्रेस के मित्र कोट करते हैं कि इंदिरा जी की बहुत तारीफ की थी अटल जी ने. वैसे वो नहीं बोला था जो कहा जाता है, वो अभी तक कहीं रिकॉर्ड में नहीं है, मगर तारीफ की थी. और 1965 की वॉर के समय जो काम किया उसमें फॉरगेट अबाउट जनसंघ, राष्ट्रीय स्वयंसेवक संघ के गुरु गोलवलकर जी को ऑल पार्टी मीटिंग में लाल बहादुर शास्त्री जी ने बुलाया ड्यूरिंग 62 चाइना वॉर. जिस ढंग का सपोर्ट किया जनसंघ ने और आरएसएस ने, जवाहरलाल नेहरू इनवाइटेड आरएसएस for 26 January 63 in the parade. ये है हमारा track record. So they should learn how to be a mature opposition.
Okay, so let me ask you, when you hear Rahul Gandhi speaking in Cambridge, okay, and he's talking about democracy, when you see the US democracy index, the press freedom index, religious freedom index, and press freedom, we are supposed to be worse than Afghanistan. Why is it a supposition that if the foreigners are lecturing us, at least Rahul Gandhi is our own person, he's a member of parliament here, he has questions, why not answer him?
देखिए वो अगर अब I will give you answer of this because your group might be having some linkage or connection that also. On 16th of May 2014, when we got the clear majority under the leadership of Sri Modi, on 18th of May 2014, the Sunday Guardian of London in its editorial has written an article by the heading India's Second Tryst with Destiny. And in that, the sentence was written that on 16th of May 2014 should be go in Indian history on the day on which Britishers finally left India. Because it has said कि उससे पहले जो भी गवर्नमेंट थी वो ब्रिटिश कॉलोनियल लीगेसी की माइंडसेट और आइडियोलॉजी से प्रभावित थी. फॉर द फर्स्ट टाइम एन एब्सोल्यूट पावर हैज कम टू दैट आइडियोलॉजी व्हिच इज हैविंग नो कनेक्शन विद द ब्रिटिश कॉलोनियल लीगेसी. अब वो लीगेसी अभी तक, और इसमें मैं एग्जांपल के साथ बोलना चाहता हूं, कोई हवा में नहीं. यू नो इंडिया का जो बजट सेशन है, बजट 1997 तक कितने बजे प्रस्तुत होता था? 5 बजे. क्यों? क्योंकि ब्रिटेन में 11:30 बज रहे होते थे. 50 years were carried over the legacy. It was changed in Vajpayee government. और when Modi government came, हमारा बजट 28 फरवरी को आता था. क्यों? क्योंकि ब्रिटेन में फरवरी के एंड में बर्फ पिघलती है, मार्च से काम करने लायक मौसम होता है. हमारे यहां तो जून के फर्स्ट वीक में मानसून आ जाता है. मोदी जी चेंजेस टू 1st of February. तो अब कुछ लोग अभी भी उस दौर में हैं जिनको लगता है कि जो फॉरेन में बोल दिया गया वो ब्रह्म वाक्य है. तो एक पंक्ति उनके लिए कहना चाहूंगा कि अपने वतन पर सदियों तक है रही हुकूमत गैरों की, लेकिन कुछ चेहरों पर अब तक धूल है उनके पैरों की.
Okay, I'm limited time. I know you have appointments, so my last question. We are seeing a world in crisis, sir. We've talked about Bangladesh, Sri Lanka, Pakistan, perpetual crisis, South Korea crisis. There is a crisis in Ukraine. There's a crisis in Gaza. What is more dangerous, internal enemies or external enemies?
Definitely एक्सटर्नल एनिमीज तो दिखाई पड़ते हैं और इंटरनल एनिमीज डिस्गाइज में रहते हैं। तो इसको आप पंचतंत्र की जो कहानियां आपने सुनी होंगी, मतलब किसी को पर्सनली, मतलब उसको कोई पर्सनल रंगे हुए सियार की कहानी सुनी है ना, तो वो ज्यादा खतरनाक होता है जब आके कोई बैठ जाता है। मैं इसलिए फिर मैं कहना चाहूंगा एक पंक्ति में कि कहनी है एक बात हमें इस देश के पहरेदारों से, संभल कर रहना अपने घर में छिपे हुए गद्दारों से।
Okay, well, you might agree or disagree with the politics, but there's no doubt Sudhanshu Trivedi is one of the best orators of our time. As always, Sudhanshu ji, so good to have you. Thank you for taking our time for this.
Thank you so much, Sudhanshu ji, for joining us at the third Law and Constitution Dialogue. I will request, Sudhanshu ji, we'll just request you to stay back on stage. We also request Sri Kartikeya Sharma, who joins us, Member of Parliament, Rajya Sabha, to please present a token of our appreciation to Mr. Sudhanshu Trivedi. Could we please have a loud round of applause? Sudhanshu ji, we're presenting you with an original copy of the Constitution. Along with that is a very special photograph. Along with that, sir, there's a very special photograph of the first session of the Constituent Assembly. Thank you so much once again, Sudhanshu ji, for sparing your precious time to join us at the third Law and Constitution Dialogue. With that, ladies and gentlemen, we slip into a very quick 15 to 20 minutes of a lunch break. After that, we have more sessions lined up, riveting sessions. I will request all our guests to please join us for lunch. Lunch is served to your right, please.
We are the mainstream media's dedicated platform to serve India's legal community.
एक देश, एक संविधान, एक झंडा. One country, one constitution, one flag. That is the core of our democracy. The legal community is the core of the core. We are here to build a community in the mainstream media for you. A platform for jurists, with jurists and by jurists. We are doing what it takes. Come join us and make this the go-to platform for serious news, views and conversations.
100 episodes of Legally Speaking have aired on NewsX, India's first and only primetime national television news show dedicated to the legal community. More than 100 dedicated columns published in the Sunday Guardian in print and online. More than 1,000 dedicated columns published in the Daily Guardian in print and online, with a dedicated website.
Today, law is a very popular profession. Today, a lot of people want to join the law.
We need to meet the parameters of the offences.
With deep dives.
In a constitutional court, there are lots of cross tensions.
We have to have very good trained mediators of established reputation.
With legal luminaries from across the world.
How much can a person be surveilled in the future? This is a role of court.
Unlike other countries, our two nations have a commitment.
In-depth biographical interviews.
I did huge number of cases.
For the first 3 months in Cambridge, I was a very active debater.
Full live prime-time telecasts of the Ram Jethmalani Memorial Lectures organized by Mahesh Jethmalani.
Overwhelming thank you to NewsX and the Sunday Guardian Foundation for not only telecasting live this event, but for the relentless publicity campaign that preceded it.
It has been a great honor reminiscing the legacy of Ram Jethmalani, one of the greatest of our times.
Hosting the Will of Steel Awards in the memory of Ram Jethmalani on his birth centenary year in 2023. The largest legal and public service journalism awards in the world, with the award winner receiving 12 lakh rupees. Full live telecast of the L.M. Singhvi Memorial Lecture organized by Dr. Abhishek Manu Singhvi.
The practice of democracy through universal adult franchise, it not just limited to Delhi, but is happening in the remotest parts of India.
And the first Law and Constitution dialogue hosted by Legally Speaking with Justice Suryakant in 2022.
Media has a heightened responsibility due to the greater power that it enjoys. The power to shape the views and attitudes of hundreds of millions.
Live prime-time telecasts of the Justice J.S. Verma Memorial Lecture organized by Vivek Tankha.
Justice J.S. Verma, the iconic man of this place.
Our aim is to curate quality conversations with eminent jurists which take forward jurisprudence, also inform, educate, stir debate. This is what has been our aim at Legally Speaking. We also take up relevant issues from time to time that involve the future of the judiciary, also the court systems with eminent retired judges, also former ASGs, sitting ASGs, also eminent jurists. This is what we do on a weekly basis.
Because in the end, we need to restore and renew the logic of the mainstream media, which is to raise the bar, not just sink beneath it. It is our duty to put on the national agenda the very important issues raised by jurists who play such an important role in so many path-breaking matters in the country. Legally Speaking, the future of community service journalism in India's mainstream.
India's most credible journalists presenting you news, views and impact stories from India and across the world. Home of India's biggest news campaigns, host to India's biggest platforms. This is India's fastest growing media house. This is the ITV network with 2 national news channels, India News and NewsX. ITV network has 6 regional news channels with landmark news events. Our viewers love to connect on their platform of choice and making news and information available at fingertips. ITV network has 5 newspapers, winning hundreds of awards as a testament to the value we bring to India's people.
We are the mainstream media's dedicated platform to serve India's legal community.
एक देश, एक संविधान, एक झंडा. One country, one constitution, one flag. That is the core of our democracy. The legal community is the core of the core. We are here to build a community in the mainstream media for you, a platform for jurists, with jurists and by jurists. We are doing what it takes. Come join us and make this the go-to platform for serious news, views and conversations.
100 episodes of Legally Speaking have aired on NewsX, India's first and only prime-time national television news show dedicated to the legal community. More than 100 dedicated columns published in the Sunday Guardian in print and online. More than 1,000 dedicated columns published in the Daily Guardian in print and online, with a dedicated website.
Today, law is a very popular profession. Today, a lot of people want to join the law.
We need to meet the parameters of the offences.
With deep dives.
In a constitutional court, there are lots of cross tensions.
We have to have very good trained mediators of established reputation.
With legal luminaries from across the world.
How much can a person be surveilled in the future? This is a role of court.
Unlike other countries, our 2 nations have a commitment.
In-depth biographical interviews.
I did huge number of cases.
For the first 3 months in Cambridge, I was a very active debater.
Full live prime-time telecasts of the Ram Jethmalani Memorial Lectures organized by Mahesh Jethmalani.
Overwhelming thank you to NewsX and the Sunday Guardian Foundation for not only telecasting live this event, but for the relentless publicity campaign that preceded it.
It has been a great honor reminiscing the legacy of Ram Jethmalani, one of the greatest of our times.
Hosting the Will of Steel Awards in the memory of Ram Jethmalani on his birth centenary year in 2023. The largest legal and public service journalism awards in the world, with the award winner receiving 12 lakh rupees. Full live telecast of the L.M. Singhvi Memorial Lecture, organized by Dr. Abhishek Manu Singhvi.
The practice of democracy through universal adult franchise is not just limited to Delhi, but is happening in the remotest parts of India.
And the first Law and Constitution Dialogue, hosted by Legally Speaking with Justice Suryakant in 2022.
Media has a heightened responsibility due to the greater power that it enjoys. The power to shape the views and attitudes of hundreds of millions.
Live prime-time telecasts of the Justice J.S. Verma Memorial Lecture, organized by Vivek Tankha.
Justice J.S. Verma, the iconic man of this place.
Our aim is to curate quality conversations with eminent jurists which take forward jurisprudence, also inform, educate, stir debate. This is what has been our aim at Legally Speaking. We also take up relevant issues from time to time that involve the future of the judiciary, also the court systems with eminent retired judges, also former ASGs, sitting ASGs, also eminent jurists. This is what we do on a weekly basis.
Because in the end, we need to restore and renew the logic of the mainstream media, which is to raise the bar, not just sink beneath it. It is our duty to put on the national agenda the very important issues raised by jurists who play such an important role in so many path-breaking matters in the country. Legally Speaking, the future of community service journalism in India's mainstream.
India's most credible journalists presenting you news, views and impact stories from India and across the world. Home of India's biggest news campaigns. Host to India's biggest platforms. This is India's fastest growing media house. This is the ITV network with 2 national news channels, India News and NewsX. ITV network has 6 regional news channels with landmark news events. Our viewers love to connect on their platform of choice and making news and information available at fingertips. ITV network has 5 newspapers, winning hundreds of awards as a testament to the value we bring to India's people.
We are the mainstream media's dedicated platform to serve India's legal community.
एक देश, एक संविधान, एक झंडा. One country, one constitution, one flag. That is the core of our democracy. The legal community is the core of the core. We are here to build a community in the mainstream media for you. A platform for jurists, with jurists and by jurists. We are doing what it takes. Come join us and make this the go-to platform for serious news, views and conversations.
100 episodes of Legally Speaking have aired on NewsX, India's first and only prime-time national television news show dedicated to the legal community. More than 100 dedicated columns published in the Sunday Guardian in print and online. More than 1,000 dedicated columns published in the Daily Guardian in print and online, with a dedicated website.
Today, law is a very popular profession. Today, a lot of people want to join the law.
We need to meet the parameters of the offences.
With deep dives.
In a constitutional court, there are lots of cross tensions.
We have to have very good trained mediators of established reputation.
With legal luminaries from across the world.
How much can a person be surveilled in the future? This is a role of court.
Unlike other countries, our 2 nations have a commitment.
In-depth biographical interviews.
I did huge number of cases.
For the first 3 months in Cambridge, I was a very active debater.
Full live prime-time telecasts of the Ram Jethmalani Memorial Lectures organized by Mahesh Jethmalani.
Overwhelming thank you to NewsX and the Sunday Guardian Foundation for not only telecasting live this event, but for the relentless publicity campaign that preceded it.
It has been a great honor reminiscing the legacy of Ram Jethmalani, one of the greatest of our times.
Hosting the Will of Steel Awards in the memory of Ram Jethmalani on his birth centenary year in 2023. The largest legal and public service journalism awards in the world, with the award winner receiving 12 lakh rupees. Full live telecast of the L.M. Singhvi Memorial Lecture organized by Dr. Abhishek Manu Singhvi.
The practice of democracy through universal adult franchise is not just limited to Delhi, but is happening in the remotest parts of India.
And the first Law and Constitution Dialogue hosted by Legally Speaking with Justice Suryakant in 2022.
Media has a heightened responsibility due to the greater power that it enjoys. The power to shape the views and attitudes of hundreds of millions.
Live prime-time telecasts of the Justice J.S. Verma Memorial Lecture organized by Vivek Tankha.
Justice J.S. Verma, the iconic man of this place.
Our aim is to curate quality conversations with eminent jurists which take forward jurisprudence, also inform, educate, stir debate. This is what has been our aim at Legally Speaking. We also take up relevant issues from time to time that involve the future of the judiciary, also the court systems with eminent retired judges, also former ASGs, sitting ASGs, also eminent jurists. This is what we do on a weekly basis.
Because in the end, we need to restore and renew the logic of the mainstream media, which is to raise the bar, not just sink beneath it. It is our duty to put on the national agenda the very important issues raised by jurists who play such an important role in so many path-breaking matters in the country. Legally Speaking, the future of community service journalism in India's mainstream.
India's most credible journalists presenting you news, views and impact stories from India and across the world. Home of India's biggest news campaigns. Host to India's biggest platforms. This is India's fastest growing media house. This is the ITV network with 2 national news channels, India News and NewsX. ITV network has 6 regional news channels with landmark news events. Our viewers love to connect on their platform of choice and making news and information available at fingertips. ITV network has 5 newspapers, winning hundreds of awards as a testament to the value we bring to India's people.
We are the mainstream media's dedicated platform to serve India's legal community.
एक देश, एक संविधान, एक झंडा. One country, one constitution, one flag. That is the core of our democracy. The legal community is the core of the core. We are here to build a community in the mainstream media for you. A platform for jurists, with jurists and by jurists. We are doing what it takes. Come join us and make this the go-to platform for serious news, views and conversations.
100 episodes of Legally Speaking have aired on NewsX, India's first and only prime-time national television news show dedicated to the legal community. More than 100 dedicated columns published in the Sunday Guardian in print and online. More than 1,000 dedicated columns published in the Daily Guardian in print and online. With a dedicated website,
Today, law is a very popular profession. Today, a lot of people want to join the law.
We need to meet the parameters of the offences.
With deep dives.
In a constitutional court, there are lots of cross tensions.
We have to have very good trained mediators of established reputation.
With legal luminaries from across the world.
How much can a person be surveilled in the future? This is a role of court.
Unlike other countries, our two nations have a commitment.
In-depth biographical interviews.
I did huge number of cases.
For the first 3 months in Cambridge, I was a very active debater.
Full live prime-time telecasts of the Ram Jethmalani Memorial Lectures organized by Mahesh Jethmalani.
Overwhelming thank you to NewsX and the Sunday Guardian Foundation for not only telecasting live this event, but for the relentless publicity campaign that preceded it.
It has been a great honor reminiscing the legacy of Ram Jethmalani, one of the greatest of our times.
Hosting the Will of Steel Awards in the memory of Ram Jethmalani on his birth centenary year in 2023. The largest legal and public service journalism awards in the world, with the award winner receiving 12 lakh rupees. Full live telecast of the L.M. Singhvi Memorial Lecture organized by Dr. Abhishek Manu Singhvi.
The practice of democracy, universal adult franchise, is not just limited to Delhi, but is happening in the remotest parts of India.
And the first Law and Constitution Dialogue hosted by Legally Speaking with Justice Suryakant in 2022.
Media has a heightened responsibility due to the greater power that it enjoys. The power to shape the views and attitudes of hundreds of millions.
Live prime-time telecasts of the Justice J.S. Verma Memorial Lecture organized by Vivek Tankha.
Justice J.S. Verma, the iconic man of this place.
Our aim is to curate quality conversations with eminent jurists which take forward jurisprudence, also inform, educate, stir debate. This is what has been our aim at Legally Speaking. We also take up relevant issues from time to time that involve the future of the judiciary, also the court systems with eminent retired judges, also former ASGs, sitting ASGs, also eminent jurists. This is what we do on a weekly basis.
Because in the end, we need to restore and renew the logic of the mainstream media, which is to raise the bar, not just sink beneath it. It is our duty to put on the national agenda the very important issues raised by jurists who play such an important role in so many path-breaking matters in the country. Legally Speaking, the future of community service journalism in India's mainstream.
India's most credible journalists presenting you news, views and impact stories from India and across the world. Home of India's biggest news campaigns, host to India's biggest platforms. This is India's fastest growing media house. This is the ITV network with 2 national news channels.
Ladies and gentlemen, could I request you to kindly take your seats? Your plates are welcome inside and you can grab a seat, please. Could I request some of my colleagues at the back to also tell those who have finished lunch outside to kindly return inside the boardroom so that we can start? I don't mean to rush your lunch, but we have a schedule to stick to over here. I'm going to once again request my colleagues to guide all my colleagues who are looking here and there and waiting. I'll request my colleagues to guide the people outside to return back into the ballroom to kindly take their seats. Several people would have finished their lunch and they can join us as we begin the next session. Could I once again request my colleagues that those who have actually finished their lunch can be guided back into the ballroom so that we can begin our session in the next minute or two. All right, ladies and gentlemen, our TV telecast is set to begin, so I'm going to kick this off and request Devika to introduce the next panel.
We've had an excellent morning, and we promise that our evening sessions will be even better than what we witnessed in the morning. Some more pertinent conversations are lined up on the law, on the Constitution. Without further ado, I'm going to introduce our next set of panelists as well as our next session. We have with us Ms. Malvika Rajkotia, founder, Rajkotia Associates Advocates. We have with us Ms. Manali Bhandari, an advocate, and also Ms. Alkanshi Dahar, founding and managing partner of Law Offices of India. They will be moderated by Ms. Priya Sehgal, editorial director of NewsX, on very pertinent questions that continue in the field of law. We're taking a break a little bit from the politicians and the politics, and we are moving now to another important conversation on aspects of divorce, inheritance, women and men, and everything in between. I request everyone in the hall to please find a seat for yourself so that we can proceed with the next session. Thank you so much, Malvika Rajkotia, Manali Bhandari, and Alkanshi Dahar, for joining us. Priya Sehgal, over to you.
Thank you, Devika. And, you know, we are the unfortunate between the food and the conclave. So we hope to get people here after the food for thought. But because the topic what we are discussing is a very important one. We're talking about women and the law, women's rights, and also the fact that, you know, there are women's rights, but there is also huge misuse of that, the abuse of that. And we've seen recently what happened, you know, to that techie Atul Kashyap, who actually committed suicide, alleging harassment, and he left a, you know, 40-page suicide note. So taking that into account, what are the takeaways? Alka, I know you and I have been talking about this case, so I'll begin with you first. We've been talking about misuse of laws. So is the, you know, so then first tell me about Atul's case, then I'll take the story further.
See, the Atul's case was, is it on? Hello, yeah. So the Atul's case was, I think, just, you know, the boil had to come to a peak, and it did that. Notwithstanding that, we've all been talking about it for so many more years. Bottom line is that we do have all the acts. See, Atul's case was very unfortunate. It's so emotionally charged that whatever we say, I mean, you can't take away the fact that it was a tragic case which resulted in very, very bad, adverse, and unfortunate consequences. See, but like personally, the practical side of it is also entirely different. I mean, we do have cases where we do have this multiple millions of women who are actually suffering at the hands of the judiciary system. The system has to be revamped. The very fact that he committed suicide was unfortunate. But you really can't, I know this sounds politically very incorrect, but you really can't point it all on, I mean, I don't know the facts of the case, but you really can't say that the wife and the in-laws and all need to be put behind the bars. There are instances when the in-laws and the wives, you know, they really don't do much, and in spite of that, the husband has committed suicide. I've had one of those very unfortunate cases. So it really depends on the individual. It depends upon the facts and the circumstances of the case, and we really can't say that the laws are being misused. But yes, in the last 1 week, 2, 3, 4 weeks, and in a month, the Supreme Court has also repeatedly said 498A has been misused, and yes, it has been misused. On the other side, you have to look on both sides of the coin. On the other side, too.
1 second, Alka. I request everybody, please keep silent at the back. We are also recording this for television and it's going live, so please keep silent. Sorry.
Okay, now going back to what I was saying.
Misuse of 498A.
Misuse of 498A. So the laws have to be there because the Indian women are vulnerable, so they need these laws. But then again, the women are misusing it. It's the case of crying wolf all the time. When the real, genuine case needs the intervention of the judiciary, we all look at it with skeptical eyes and say, maybe, these guys are exaggerating it. In the end, to summarize, now what I will say is we need a robust judiciary. We have all the laws which are in place, but we need a robust judiciary and the implementation. That has to be done in a fair, timely manner, so people, be it husband or a wife, they both get justice.
Fair enough. Manali, the fact is that there are laws in place to protect women. But what happens when women misuse? So what are the checks and balances that can be laid, And if you've been following this case, if you would like to...
Yeah, I have followed it a bit only, whatever came in the media and all, because it just happened. And I agree, it's most unfortunate that, this gentleman took his life, and in his video he has blamed his in-laws and his wife. But I think we must not lose sight of the fact is that all these laws came into existence because of the atrocities that were being done to women in our country. Dowry deaths, let's not forget, dowry is still a very, very big problem in our country. And these are, there may be some amount of misuse, but I think we should not take away from the fact that there are a large number of women who are still suffering. And though there are laws, implementing those laws, getting something from, takes a lot of time. And it is sometimes not really, the system does not work fairly for women either. So one thing which I have noticed in my practice is that the only reason, I don't think people want to misuse laws. I don't think people want to come and tell a lie. But because sometimes they have nothing else left to negotiate with, and even it's not as if their spouses, their husbands or families are being so nice that, okay, you want a divorce, I'll give you, take care of the children, I'll take care of you. They are struggling so much for their basic needs that sometimes they feel that, maybe just putting some pressure may get them somewhere. And this is where I feel this is an unfortunate thing. Maybe if our law can address a system and a way in which we ensure that women will get something upfront, and not have to struggle for it, that would, I think, go in a long way. Because, filing a criminal case or a false case, it's a punishment even on the complainant. Yeah. Nobody wants to do it willingly. Correct. Even sometimes in genuine cases, people don't want to do it because they don't want to go through that hassle of, dealing with a criminal case. So I really feel that I think we should not get swayed by a few cases which where there may have been some misuse, and even in this case, frankly, we should not just go on media this thing. I think a fair chance should be given to the family of the wife also to respond and see what actually happened. We don't know, maybe he had some other mental, because he's taken a very extreme step. Correct. So anyway, this is my view in the matter.
Malvika, more than this case, of course, if you want to comment on that, but also what are the checks and balances? For instance, we've also been debating, will a prenup in place, would that have helped? I know in India it's not mandatory, but there are cases. So what is your stand on that?
So before I respond to this, I'd just like half a minute to continue with what Alkashri and Manali said. I so agree with them, of course. But in addition, I would like to say that it takes this incident or any incident, ever since women enabling laws have been passed, we have been hearing as a shouting echo simultaneously a clamor of misuse. And yet when politicians, for example, are framed for murder, or businessmen, there's an ED, nobody is talking about misuse of those laws. Nobody is talking about unraveling statutory protections otherwise of the accused in other cases because there is alleged misuse. Whereas we need to read the papers every day that misuse is rampant there. So to identify women's causes and neutralize that battle with the argument of misuse is, to my mind, must be removed from the narrative. So we should not be discussing misuse. We don't care. The point is that in the cost analysis, women are benefiting. And that's all we have to talk about. Just as in any other law which is subject to misuse, the broader benefit is there, which is why it's there in the first place. You don't neutralize it because of potential misuse. So this argument for misuse has to stop, or this argument. Now coming to the next, prenups.
For one second, Alka wants to just quickly come and then I will come to you.
See, I completely agree with what you're saying, and just going forward on that. But I do think that misuse of laws need to be checked because it erodes the credibility of the judiciary. And when a real genuine case comes, then people look at it.
I agree with you. All I'm saying is, let us not talk about misuse only in the context of women's issues. It becomes, that's all. Let's talk about it generally. When there's an ED raid or a CBI comes in and this, let's talk of misuse there. Why do we have to get defensive about women enabling laws is all I'm saying.
Okay, fair enough.
But having to add...
With a lawyer, there's always a but.
But 498A, I mean, it's a robust provision. The intent is right where it's supposed to be, in the heart. But yes, it has been misused to such a great extent that even the courts have to come in and say, please, stop it now.
My argument remains the same, that courts have stepped in only for the same reason that any establishment steps in on women enabling laws. So they will shout just as much as fathers and husbands are shouting, and it's unfortunate. There is no reason for those comments about misuse of 498A. Let them pass the same judgments with regard to misuse of a whole lot of other laws. But coming back to your second part of your question, which is with regard to
prenups.
Prenups. It's a very good idea. It's commonly thought wrongly that it is not within our jurisprudence, but that's not correct. Even though there's no statutory provision for it, there is a case law in which the High Court has said that we need to consider it, number one. Number two, the Indian Divorce Act does envisage prenups and even post-nups. Now, post-nups become particularly valuable because it's a negotiation of assets and so on after the family has settled together for whatever reason. For example, if there is a stressed family, and sometimes when they've come to me for advice, what we have done is they may not want to separate or divorce, that's drastic, but perhaps for better security, financial security of everybody concerned, the elders, the children, the so on, they come to a family arrangement, which becomes more, emerges from the marital situation, not like a HUF family arrangement. So it's a good idea. But then comes the other side. The law with prenups has to have equality of bargaining power. So we have to consider that when prenups are negotiated for women, or women negotiate it for themselves, which is hardly ever the case, do they have an equal bargaining power with the men? Most of the time it's been found that they don't. The UK has some law on it, which is good to consider, which is that we will treat the prenup as a baseline, but if we find that there's inequality of bargaining power while negotiating it, we will strike it down. So that's broadly like in an equity jurisdiction, discretion to be used.
Manali, your stand on prenups. We've had a conversation earlier.
Yeah, we've spoken about this earlier. And I mean, prenups could be a good thing again, only if we can ensure that they're going to be fair to both sides. in India, unfortunately, our socio-economic situation is such, people are so keen to marry off their daughters. If we have prenups, we will find that people will agree to all sorts of things, and then the woman will actually be stuck with an unfair deal if unfortunately the marriage doesn't work out. And that's where I feel that it's not, maybe we are not still there. I mean, a lot of people are now wanting to sign prenups. In fact, they want to sign them even knowing very well that they are not recognized by law yet in India, but just as some sort of evidentiary value, to have some value of that what the parties intended. But I personally think this is something which needs a deeper thought and some way, as Malvika mentioned, to ensure that both of them, husband and wife, are on an equal footing when entering into such an agreement.
So this equal footing is the way I have an issue. Even at the time of prenup, your wife, the woman may not be on an equal footing. Postnup is usually during times of stress. So again, there is no equal footing. So what is the, where do you stand and what is the solution?
I'm a staunch believer, and I think prenups should be made, they are enforceable. I mean, in UK it just happened in 2010, so I guess it'll take some time for us to get there. But in fact, Manali and I have worked on a common client in which we were negotiating a prenup, while very much knowing that, if tomorrow it goes to the court, it's going to be a different ball game altogether. But like on equal footing, etc., we can put in the safeguards in the prenups itself. Like in the UK, both the parties need to take advice from the lawyers. 28 days, you need that time period before you sign the prenup. So it's not on the last day they make you sign the prenup, because that will be a lot of influence and pressure on the parties. Financial disclosures have to be made in the prenups. So all this, I think, goes in a long way, because you see, practically speaking, again, when any marriage goes south, the husband and the wife are adults, they can kind of manage, but it's the children which are the greatest sufferers, and they are the biggest victims. Because, and I really do think if the prenups are made, at least it gives a kind of a guideline, a pathway, to the court and to the family and to the husband and wife, that this is where we agreed upon. Of course, there are certain things like the custody of the child, etc., which you can't put in a prenup. These are outside the purview of the prenup, but on distribution of assets, how they're going to divide it, the students, the children's education, etc. I think it's extremely important. And one more thing is it's got an emotional charge to it, prenups. Everybody says, we can't start a marriage thinking like, please sign this paper. So there's a lot of emotion attached to it. But my answer to that would be like, and they think, no, we are already thinking of a divorce when we are about to get married. It puts bad things in the head. It's like buying a car in a showroom. I mean, you don't take out a car without an insurance. You don't buy a car thinking tomorrow I'm going to have an accident. You don't do that. But you always invariably take an insurance on this. So prenup is kind of an insurance. And also times have changed now. So you have to move in with the times. Things need to change. Laws need to change with times.
Wow, that's a whole new debate. But Malvika, how often do you see gender biases being reversed? For instance, do women always have the upper hand when it comes to child custody? Do men do women pay alimony to men? How often do you see those kind of cases?
Women, I don't believe, have the upper hand necessarily with regard to custody. Those are very bitterly fought battles. And unfortunately, in my experience, often the fathers want more than access for two reasons. Partly it is to assert power, that, if you want my money, then I want the children just as much type of approach. The other is also in the hope that they will have to pay less if she's not the sole caregiver to the children. That's one part. What was your second question, sorry?
Do women pay alimony to men?
Yes. So, in my career, I have had 3 instances where the women were really far wealthier, and may I say, paid without question. Wow. And just, that's it, this is my assets, I want out. and paid substantially. In one case, it wasn't up to half. In another, it was as much as half. And I have never known a man to do that.
Manali, do you want to comment on this gender reversal?
In fact, I'm currently advising someone where this is precisely the case in hand, and in fact, the husband has stopped working, or at least claims he's doing nothing, or is unable to do anything, and because he wants his wife to, pay for for him. I don't know how that will play out eventually, but the wife is more than happy to pay and finish everything off. I think so where women are, and I agree, I think a lot of times when there is no clarity or there's all this negotiating for financials is used actually to get at something else very often. You know, you put pressure in whichever which way. That's why even men very often don't want to pay maintenance in the manner which they should, they ought to, because either they are being vindictive, they don't want to pay, and B, they always want to have control. And even after a divorce or even after a separation, want to have constant control on the wife, the ex-wife, the children, and the best way to do it is through money. That's the problem.
Which brings me to, if you want to comment on this point, and also Alka, one last point is on the inheritance laws. You know, on paper, yes, it is equal, but you know, how does it work out on ground? Are women bullied into, giving up for their rights for the men?
So the examples of what we've just seen goes a long way to show the patriarchal bent of mind, you see. I've also seen in the cases that we have done pertaining to family law, it's the ego that basically comes in. It's the ego and the emotion attached to all those years, and the guy always not that, I mean, this is a kind of a generalization, and my apologies to the men here, but the very fact remains that culturally there are certain things that's culturally, like in, I don't want to name countries, but there are certain countries which have this patriarchal bent of mind. So the husband invariably has to have the upper hand. And if
name the country, India is one of them.
Absolutely. No.
Probably top of the list.
Probably.
No, they might be worse, but India, yes, definitely is. So that is why I always, okay, now that is my take on it. So invariably it's the emotion and the cultural thing that kind of bends it. And look at it, kudos to the women. Even I have seen that women always tend to be more temperate. They seem to be more fair and less biased. I think it's something to do with the culture, and they all want to, move on.
Last take on the inheritance laws.
So actually it's not equal. Now after the 2005 amendment in the Hindu Succession Act, she is a co-partner, a daughter is a co-partner. But only in an HUF, how many, you're only catering to the very top 5% which has the kind of wealth which is in an HUF. But otherwise, may I say, 1956, when these statutes were passed in Parliament, the concept of will traditionally did not exist in Hindu law. And in fact, Section 30 of the Hindu Succession Act was enacted to neutralize even whatever benefit the daughter was getting as an equal heir in her father's property. To say, and that's how it was passed in Parliament, to say, no, but you retain the right to will if you don't want your daughter to have it. So that nowadays they keep talking of colonial legacies and how we don't want to and move on and so on. But the will, I would like any one of those to actually get rid of it, which is that it's not there amongst traditional Hindu law. But that's only Hindu law. Is to other personal laws as well. Women are not equal heirs, but obviously degrees of inheritance depend on various what personal law applies. But again, there are women in the role of daughters who inherit the way they do, and when we talk inheritance, we only talk in that context. But the wife gets even more marginalized. So, for example, the 2005 amendment, which enabled the daughter as a co-partnery, is at the expense of the wife in that household, isn't it? Because her husband would get proportionately less. And there are so many estates that have been unsettled now because of this so-called retroactive operation of this amendment which has been held by the Supreme Court, which has unsettled nearly, 40, 50 years of settled estates. So there is a lot of turmoil about this, but I think while the conversation is going on, let's see where it goes. One hopes to better equality.
We are out of time, but Manali, you have the last word.
Yeah, no, I think these are very complex questions. They cannot be. The main thing is that we have to change the mindset, because people still find ways and means to cut daughters out. And therefore, I think we need to sort of instill this, that whether it's a boy or girl, they are equal. They should be treated equal in the in inheritance, in estates. And in a wife is also equal. Yes, it's
not
very
at the cost of the wife.
Yeah.
Okay, on that note, thank you so much for this conversation and for being here. But, well, more power to us.
Thank you so much, ladies, for joining us at the third Law and Constitution Dialogue. I request Shri Rana Yashwant, Editor-in-Chief of India News, to please join us on stage to present a token of our appreciation to Alkashri Dahar, Founding and Managing Partner of Law Offices of India. That is an original copy of the Constitution, ma'am. Also presented to you is a very special photograph of the first Constituent Assembly. Thank you so much once again to Ms. Manali Bhandari as well for joining us and taking out your precious time to shed light on some very pertinent matters related to the family. And last but not least, we also have Malvika Rajkotia, founder Rajkotia Associates Advocates. Thank you so much, Malvika ji, for joining us at the third Law and Constitution Dialogue. We appreciate you taking out your precious time, ma'am. And with that, ladies and gentlemen, it's time for our next conversation. We have with us Shri Salman Khurshid, Congress Member of Parliament and Senior Advocate. He will be joined by Tarun Nangia, Editor of Legally Speaking, on the stage in just a short while from now. They will be discussing the Constitution and the Waqf. Tarun, I request you to take your place on stage. Let's please welcome Mr. Salman Khurshid with a huge round of applause. Thank you so much, sir, for joining us at the third Law and Constitution Dialogue. Tarun, over to you.
Good afternoon, everyone. It is indeed a great pleasure to have Mr. Salman Khurshid today at this gathering. I've always regarded him as one of the most sane voices we have in this country, speaks in a very measured manner. He needs no introduction really, but we have to formally give one. Of course, one of the most well-regarded senior advocates in this country, one of the most well-known external affairs minister that he served, also as law minister, and of course his contribution to politics in this country in the past many decades can't be denied. And most recently, of course, he's now helming the India Islamic Cultural Center. That is, you've taken charge there also. So a person whose imprint on social life in India can't be ignored, and we are happy to have him. On two very important topics, he'll be speaking on the Waqf Bill, which has been referred to the JPC, also on the Places of Worship Act, given what happened recently in the Supreme Court. So you know, people want to listen to you in depth, your opinions. So as an introductory comment on Waqf, can you give me a 5-7 minute answer explaining the rationale behind the position you have taken?
It's some news to me when you say that people want to listen to anybody in some depth and at some length. I thought we were living in an impatient world. Come on, give me in how many words do you have in a Twitter, Twitter and X now? But anyway, if you think that that's important, I'll try and put it across to you. As a prelude to it, as a caveat, let me just say this, that many things associated with religion, it may be true across the board to many religions, including the religion of our majority compatriots in this country, because there are so many segments and there are so many denominations that would have a different approach to religion. But be that as it may, knowledge about other people's religion seems to be very scarce as of now. My understanding is that in the past we knew a lot more about each other than we seem to know now. Although with modern technology and modern information, we should be much better informed, but we've chosen not to be that well informed. So coming to Waqf, there is a great deal of misunderstanding and misinterpretation of what Waqf is. It could be treated as a religious institution. It can be treated as a social institution. It can be treated as an economic institution, depending on how you want to approach it. Now, there are constitutional provisions like Article 26 that may protect an institution like Waqf, etc., etc. But without going into that, let me just say this, that Waqf has something to do with social organization of society. It's in some ways something like a safety net in society for people who are obviously indigent, people who cannot afford to look after themselves. But one peculiar aspect of Waqf is, and I think this is in contrast with Hindu religion. Hindu religion, the looking after your parents is taken very, very significantly. And in fact, we have this Pitra Paksh that even after your parents depart and they leave you, that every year what you have to do is to worship their memory and do something in acknowledging and respecting their memory, which is perhaps feed how many Brahmins and feed how many hungry people and so on. Here in Islam, traditionally, looking after your own family, and when I say family, it can be misunderstood, looking after your own progeny, your own children, is also treated as a charitable act. And therefore, the most controversial part of the present suggested legislation, the bill, is the removal of that provision, which is Waqf al-Aulad, to an extent, not entirely, but to an extent, saying that by declaring a Waqf al-Aulad, you must not meddle with or interfere with rights of inheritance, particularly of girl child, etc. Maybe a good thought, etc., but it's something that is built into the very concept of Waqf al-Aulad. But that's one issue. The larger issue is what has been attempted to be removed is something called Waqf by user. There is a concept in law, as we all know very well, and this concept was discussed at some length by the judgment in Ayodhya, which is the concept of a lost grant. This is known to common law from ancient times, that not always the property being utilized in a particular manner can be pinpointed to a document or a deed. And if that's not possible, but from extraneous evidence it's possible to show that it's assumed by people to be dedicated for a particular purpose, that it is actually to be treated as a lost grant. So what happens with waqfs is that a lot of waqfs don't actually have the paperwork available after hundreds of years, and because they've been continued to be used as a waqf, etc., so they are treated as a waqf. Now this is being questioned as far as the new legislation is concerned. So treated as a religious institution or treated as a socio-religious institution, but it's part of society as a whole, just as I believe, at least up to now, just as the joint Hindu family, the HUF is part of the nature of Hindu society. You may like it, you may not like it, you may think it's discriminatory, you may think that this is unfair, this is an unfair advantage, etc. But the fact remains that this is integral and intrinsic to Hindu society as we know it traditionally. Similarly, waqfs are also part of Islamic society as we know it traditionally. May have changed now. I have no idea, no data about how many waqfs are created in modern times. There are figures available about how many waqfs there are in the country, 8 lakh waqfs, etc., 2 lakhs in Uttar Pradesh, which are waqf by user and so on and so forth. But we have no data which shows that in the last 50 years how many waqfs have been created. Because there's a competing law between waqfs and trusts. You can have a trust, you can have a waqf. Under waqf, you have to go through the waqf law, the Waqf Act. Under the trust, you have to go through the Trust Act, etc. And people would probably choose trusts for easier handling than they would a waqf. Even if they belong to families, they can do so. So basically, it's a part of the structured economic structure of Islamic society or Muslim society, if you like, just as many similar attributes are part of the Hindu society. And I think that you have to ask yourself, have we come to a point where this should be changed, and can it be changed? That's all.
Since this is now going on news channels, what you speak, and this would be seen in posterity, I would want to know a couple of observations from you on the authority now given to district collectors under the new Waqf amendment. There is this issue of auditing by Comptroller, Auditor General. What do you feel? What is the response on these, in a sense, provisions made in the bill? Any inputs that you have given on this?
Well, we've given inputs because there have been many organizations that have made their presentations before the Joint Parliamentary Committee. And the Joint Parliamentary Committee is still examining many of these. So the basic structure of Waqf is something that people are more interested in.
Basics.
The peripheries are not that important. That there is regulation. The regulation has been there, and the regulation can be there. There is no problem. Constitutionally, there is no problem. Now, politically, you may have to choose, is this regulation advisable? Is this regulation popular? Is this regulation likely to meet resistance? And is that resistance something that we should overcome? You can take a political call on that. But the core issue of who is to decide whether there is a waqf in the traditional law as it existed right now, or still does exist, that the decision is taken by a Waqf board, which has, broadly speaking, a democratic structure. The decision is taken by the Waqf board. It is then re-examined by a tribunal where somebody has an issue with it. It goes to the tribunal. After the tribunal, there can be a revision. I don't know why people think that the tribunal's word is final. It's very important because there are inputs in the tribunal that are significant. But finally, it's to be decided by the High Court. It goes in revision to the High Court.
Now, two questions back to back I want to ask you. One is representation of Muslim women, as the bill requires at least 2 Muslim women on the boards. Secondly, a broader question, if you can answer. Professor Zamiruddin Shah, General Zamiruddin Shah once said that this society is like a salad, where distinct people with distinct identities stay together. And in the same prospect, people who oppose this bill have said there has been lack of consultation. If you could explain what that means, lack of consultation, who should have been consulted, which all people, and some inputs on that if you can share.
Well, very quickly, as far as women are concerned, I can't understand why anyone would have a problem with women being involved. I think if you look at Islamic history carefully, you'd find that right at the beginning in Islam, women had a very important role in commerce, in decision making, in what happened in the home, in the family, etc. Our Prophet of Islam did not propose marriage to his first wife. His first wife proposed marriage to him because she trusted him for his honesty and for his integrity and so on and so forth. So it's only without casting aspersions on anyone, it's modern society has developed in subcontinent where women have been considered to be outside the purview of decision making. And therefore they may have been kept out of the Waqf structure as well. But there is absolutely nothing objectionable. It's, I think, very
And
right.
the second question on consultation, where
consultations are going on. So I think for people to say we haven't been consulted may be premature because consultations are going on.
In 30 seconds, one last question before we end. The bill proposes replacing the election of Waqf board members with government nominations. What is your view on the same? And
I certainly think that there are difficulties, and I've seen it from my own side. I've seen that if there are not enough MPs in the House or MLAs in the House who can be elected to be part of the Waqf board, what do you do? That is a problem. But I think there's a larger problem with Indian society. But replacing elected persons by nominated persons, and that too nominated by the government, I mean, unless you have a procedure in which the nominations are done by a manner in which nominations are done by for high constitutional office, where there's a leader of opposition, there is somebody representing the opposition, etc., then there might be something said. But simply nominating and government having the power to nominate in place of elected persons, I think would just be replacing democracy with autocracy.
Thank you so much for sharing your free and frank views on this subject. Always, like you do, in a measured manner. You praise some aspects, you raise your objections on some aspects. Of course, the discussions are going on, and I think we will speak to you more on this and other platforms, but appreciate that you could find time to join us on this very important issue concerning a large population in India. Thank you so
very much. Thank you very much. Thank you.
Thank you so much, Mr. Khurshid, for joining us. Thank you so much, Tarun, for conducting that session. But up next is another very pertinent conversation, the Places of Worship Act. Mr. Khurshid, I will request you to please stay on with us for this conversation as well. I also take a quick moment to introduce our next panelists. Justice Iqbal Ansari, former Chief Justice of the Patna High Court, is with us for this session. We also have Mr. Mukhtar Abbas Naqvi, former Union Minister. We have Mr. Ashwani Kumar Upadhyay, advocate and petitioner in the Places of Worship Act case. And Mr. Khurshid has very gracefully agreed to stay on for this conversation as well. Moderating this session is Megha Sharma, Executive Editor of NewsX. Mr. Naqvi, welcome, sir, to the third Law and Constitution Dialogue. Can we quickly give a glimpse of what legally speaking is all about to our audiences and to our panelists as well? Mr. Upadhyay.
We are the mainstream media's dedicated platform to serve India's legal community.
एक देश, एक संविधान, एक झंडा. One country, one constitution, one flag. That is the core of our democracy. The legal community is the core of the core. We are here to build a community in the mainstream media for you, a platform for jurists, with jurists and by jurists. We are doing what it takes. Come join us and make this the go-to platform for serious news, views and conversations.
100 episodes of Legally Speaking have aired on NewsX. And only primetime national television news show dedicated to the legal community. More than 100 dedicated columns published in the Sunday Guardian in print and online. more than 1,000 dedicated columns published in the Daily Guardian in print and online, with a dedicated website.
Today, law is a very popular profession. Today, a lot of people want to join the law.
We need to meet the parameters of the offences.
With deep dives.
In a constitutional court, there are lots of cross tensions.
We have to have very good trained mediators of established reputation.
With legal luminaries from across the world.
How much can a person be surveilled in the future? This is a role of court.
Unlike other countries, our two nations have a commitment.
In-depth biographical interviews.
I did huge number of cases.
For the first 3 months in Cambridge, I was a very active debater.
Full live prime-time telecasts of the Ram Jethmalani Memorial Lectures organized by Mahesh Jethmalani.
Overwhelming thank you to NewsX and the Sunday Guardian Foundation for not only telecasting live this event, but for the relentless publicity campaign that preceded it.
It has been a great honor reminiscing the legacy of Ram Jethmalani, one of the greatest of our times.
Hosting the Will of Steel Awards in the memory of Ram Jethmalani on his birth centenary year in 2023. The largest legal and public service journalism awards in the world, with the award winner receiving 12 lakh rupees. Full live telecast of the L.M. Singhvi Memorial Lecture organized by Dr. Abhishek Manu Singhvi.
The practice of democracy through universal adult franchise is not just limited to Delhi, but is happening in the remotest parts of India.
And the first Law and Constitution Dialogue hosted by Legally Speaking with Justice Suryakant in 2022.
Media has a heightened responsibility due to the greater power that it enjoys. The power to shape the views and attitudes of hundreds of millions.
Live prime-time telecasts of the Justice J.S. Verma Memorial Lecture organized by Vivek Tankha.
Justice J.S. Verma, the iconic man of this place.
Our aim is to curate quality conversations with eminent jurists which take forward jurisprudence, also inform, educate, stir debate. This is what has been our aim at Legally Speaking. We also take up relevant issues from time to time that involve the future of the judiciary, also the court systems with eminent retired judges, also former ASGs, sitting ASGs, also eminent jurists. This is what we do on a weekly basis.
Because in the end, we need to restore and renew the logic of the mainstream media, which is to raise the bar, not just sink beneath it. It is our duty to put on the national agenda the very important issues raised by jurists who play such an important role in so many path-breaking matters in the country. Legally Speaking, the future of community service journalism in India's mainstream.
Also request Sri Kartikeya Sharma, Member of Parliament Rajya Sabha, to please join us on stage. Before we begin the conversation, we would like to extend a small token of our appreciation to all the panelists who've taken out their precious time to be with us to have a very pertinent conversation on the Places of Worship Act. Ladies and gentlemen, that is the original copy of the Indian Constitution as we mark 75 years. And we have another very special memento. This is a very special photograph of the first Constituent Assembly meeting from 1946. We hope this serves as inspiration to everyone who's joined us today in taking very important conversations on the law and constitution forward. Thank you so much. Thank you so much, Kartikeji, for doing the honors. We are now ready to begin the conversation. Megha Sharma, Executive Editor of NewsX, takes this forward. Megha, over to you.
Thank you, Devika. And I thank all of you for joining me for this discussion. We're talking about the Places of Worship Act, 1991. There has been a lot of controversy, heated debate that has been witnessed inside the parliament as well as outside when it comes to this enactment that was brought about in 1991 under the Prime Ministership of P.V. Narasimha Rao. Now, what this act actually speaks about is that it freezes the religious character of a place of worship with the cutoff date of 15th of August 1947, with the exception, of course, of the Babri Masjid, Ayodhya Ram Mandir site, which has been resolved with the Supreme Court passing a judgment in favor of the Ayodhya Ram Mandir temple. So why is it that this issue continues to emerge, continues to recur time and again? And the bigger question about whether there is a need to review this enactment, review this law, and how do we move forward? How do our parliamentarians move forward? How should the courts move forward in carrying out this very sensitive subject? All right, I'm going to start my conversation over here, and I'm going to take the first response from Mr. Mukhtar Abbas Naqvi ji. And the question about whether the country today, its countrymen, are living in denial about the temples, the Hindu temples, which were destroyed under the Mughal era, under the various invaders that came into India and caused wreckage, destructed the temples.
देखिए हमारा देश इस वक्त आज़ादी के अमृत काल के दौर से गुजर रहा है और इस अमृत काल में किसी भी तरह से सांप्रदायिकता का जहर नहीं बल्कि समावेशी सोच का, सद्भाव का अमृत निकलना चाहिए। और प्लेसेस ऑफ वर्शिप एक्ट 1991 एक विशेष परिस्थितियों में आया था और उसके बाद लगभग मैं मानता हूं कि बहुत कई दशकों तक किसी भी तरह से जो प्लेसेस ऑफ वर्शिप एक्ट थे उसके बाद से कोई ऐसा विवाद या किसी ऐसा तरह की समस्या नहीं आई। एक प्लेसेस ऑफ वर्शिप एक्ट के बाद लगातार जो एक पूरा का पूरा हमारा वक्फ सिस्टम है जिसने कि जो अनकॉन्स्टिट्यूशनल एनार्की है वो उस अनकॉन्स्टिट्यूशनल एनार्की की वजह से हर दिन जो है वो किसी न किसी जगह पर जो वक्फ सिस्टम में लोग हैं, वक्फ सिस्टम को मैं ये नहीं मानता कोई बुरा है, लेकिन जो डोमिनेट कर रहे हैं, जिन्होंने उस पर कब्जा कर रखा था, जो वक्फ वाफियाज थे, वो डिफरेंट प्लेसेस पर जो है वो दावे करने लगे, धावे करने लगे, उसका जो है वो रिएक्शन दिखाई पड़ने लगा। हमारा मानना है कि प्लेस ऑफ वर्शिप एक्ट 1991 उसके बारे में अभी सुप्रीम कोर्ट ने कहा भी है कि उसकी वो स्क्रूटनी कर रहे हैं, करेंगे, लेकिन मैं अगर आप मुझसे पूछेंगे तो किसी भी विदेशी आक्रमणकारी की क्रिमिनल, कम्युनल, क्रूर करतूत और गुनाह का जो है वो ठीकरा जो है वो आज की वर्तमान पीढ़ी पे नहीं ठोकना चाहिए और इस वर्तमान पीढ़ी को भी समझना चाहिए कि किसी भी विदेशी आक्रमणकारी की क्रिमिनल, कम्युनल, क्रूर करतूत को जो है वो उसको सुरक्षा कवच न बन करके उसको करेक्ट करने में सहयोग करना चाहिए।
ओके सलमान जी, आपका इसके बारे में क्या कहना है? What do you think? Is the country, are the countrymen today in denial that they were actually temples that were destroyed in the northern part of the country and therefore they at this point of time are wanting that these surveys be conducted, excavation happen at the sites of where mosques have been built?
Well, I think it's important to keep in mind that this is not, there may be a historical context in which this act was passed, but the act was not passed specifically focused on any specific community. There was a very important exception that one sense was required to be made, which was an exception made for Ayodhya. And that exception at that time appeared, and I hope that it continues to appear, as the putting a ceiling on any issues that could arise between communities in the country. And that's not just Hindu-Muslim communities. Communities in the country are many. There are Buddhists, there are Jains, there are Sikhs, there are Muslims, there are Christians, there are Hindus. So decisions between them of the past should not be raked up is basically what the purpose of this legislation was. And this is not new to India. This has been done everywhere in the world. The methodology may be different. In South Africa, when the Truth and Reconciliation Commission was formed, the idea was, let us move on, forget the past and move on. Whatever had to happen in the past has happened. Now let's move on and let's find a line that we can draw. India, I believe, consensually drew the line in 1947. This was done in 1991, but we chose to do it for 15th of August 1947, and it was a consensual approach. It was not a partisan approach. It was a consensual approach. And now to reopen it and to say, but what happened in the past then? The whole issue about who did what to whom in the past will be raked up. And you are not just raking up a mandir or a masjid issue. You are raking up an entire past that would say that India cannot live together. We are to live together. It's our commitment that we must live together. And whatever is needed to be done for us to be able to live together comfortably, I think that's what has been done, and that is what we must respect. And I do sincerely hope that the future will bring that about.
Justice Iqbal Ansari, now, the challenges that have been made in the slew of petitions that have been brought up in the court of law, speaking about how a claim being made that this particular law, this particular act is actually a violation of the right to freedom, the right to equality, the right to religious freedom. What do you make of these contentions in the court of law that are being made by the petitioners?
The question that you have put is basically to be answered by the Supreme Court in the dispute which has been raised before it as to whether this is constitutional or not. We have to remember that the Constitution of India envisages, amongst other things, fraternity, which means there has to be amity amongst the people. An emphasis is on integrity. We can't do anything which will disintegrate the society, be it on the religious line, be it on the linguistic line or regional, anything. So any kind of situation which will lead to disintegration has to be stopped. Now, as far as the freedom of religion is concerned, it's already there. But will my freedom of religion be complete only when I demolish one community's place of worship and go to my place? Because if you look into the pages of history, you will find that all through the ages, places of worship and prayer have been demolished, not by one religious community, by everyone. So in that event, those who are now claiming, it is not that their forefathers had not demolished. They had also demolished. But where are we going to? There has to be some end. And the society has to live in peace without tension. I have no doubt that if you read plainly, perhaps the Act leaves the scope for survey for the purpose of research. But to say that the survey has to be for the purpose of determining the title of the place of prayer or temple is wrong.
Right.
Because if it is only for academic purpose, yes, it is open. But if you look at it, the suit has been filed for title. It is not for making research that I will find out what is my past.
Yes.
It is for a place of worship. That we have to, in that place of worship, obviously, if there is something called in law, purposive interpretation of an act. The purpose was to say that we stand where we are. We will not rake the past. That's the purpose. So long as the act remains, that purpose has to be fulfilled by every court. And that means that you will not do anything which will lead to any kind of disruption in the society. When Justice Chandrachud opened it, he said its survey is open. Yes, it is open, but not open for the purpose of bringing a claim of another person. It is only for the purpose of academics. You can say that yes, Aurangzeb, for instance, I'm just taking the name of Aurangzeb because he is the most controversial person amongst the Mughals. He built Jama Masjid in place of a temple. That research is probably possible, but beyond that it's not. That's my idea.
Okay.
And that's how my idea is with regard to Constitution of India and then India as a nation.
Okay, all right. We also have with us Syed Nasir Hussain has just joined, but before I go to Syed Nasir Hussain ji, Ashwini Upadhyay, he's, Ashwini ji, you are one of the petitioners who challenged the act in the court of law. Now, the very same point that has been raised by Justice Iqbal Ansari, that surveys can be allowed to be conducted, but what should be the intent behind actually putting out that suit and seeking from the court of law to allow for the survey to be conducted?
देखिए, ये मामला हिंदू मुस्लिम का है ही नहीं है, जबरदस्ती इसको हिंदू मुस्लिम बनाया जा रहा है। ये मामला भारत की संप्रभुता और विदेशी आक्रांताओं के बीच में है। हम स्वतंत्र हो चुके हैं, संविधान के प्रियम्बल पे पहला शब्द है सोवरेंटी, हम यानी संप्रभु हो चुके हैं। संप्रभु का मतलब होता है गुलामी का निशान नहीं होना चाहिए। इस कानून का नाम है प्लेस ऑफ वर्शिप एक्ट, ये प्लेस ऑफ प्रेयर एक्ट नहीं है। देयर इज ए ह्यूज डिफरेंस बिटवीन प्लेस ऑफ वर्शिप एंड प्लेस ऑफ प्रेयर। जो मूर्ति पूजक होते हैं वो वर्शिप करते हैं, जो निराकार ब्रह्म की उपासना करते हैं वो प्रेयर करते हैं। इसमें लिखा है कि रिलीजियस कैरेक्टर कंटिन्यू रहेगा। रिलीजियस कैरेक्टर क्या है? मैं काले कोट में हूं सुप्रीम कोर्ट में तो मैं वकील जैसा दिखता हूं, मैं हॉस्पिटल में सफेद कोट पहन लूं तो मैं डॉक्टर जैसा दिखूंगा, मैं पुलिस लाइन में खाकी का कपड़ा पहन लूं तो मैं इंस्पेक्टर जैसा दिखूंगा, मैं तिलक लगा लूं तो हिंदू दिखूंगा, टोपी पहन लूं तो मुस्लिम दिखूंगा, क्रॉस पहन लूं तो मैं क्रिश्चियन दिखूंगा और साफा बांध लूं तो मैं सिख दिखूंगा। ये कानून अपीयरेंस की बात नहीं करता, ये कानून रूप की बात ही नहीं करता, ये कानून कहता है कैरेक्टर कंटिन्यू रहेगा। तो जस्टिस चंद्रचूड़ साहब ने बिल्कुल सही कहा कि कैरेक्टर, जैसे मेरा क्या कैरेक्टर है आप मेरे कपड़े से नहीं कर सकते, आपको मेरा कैरेक्टर जानने के लिए मेरा सर्वे करना पड़ेगा, हमसे बातचीत करना पड़ेगा। वैसे ही किसी भी स्ट्रक्चर को देख के आप ये नहीं डिसाइड कर सकते इसका कैरेक्टर क्या है।
Okay.
और ये कानून मैं आपको समराइज करता हूं। देश स्वतंत्र हो चुका है और सरकारें जो बनती हैं वो बाबर, हुमायूं, तुगलक, गजनी, गोरी के इलीगल काम को लीगलाइज करने के लिए कानून नहीं बना सकती। दूसरा, आप कोर्ट का दरवाजा नहीं बंद कर सकते। आपने वक्फ एक्ट बनाया, कोर्ट का दरवाजा बंद किया, लेकिन कम से कम एक छोटी विंडो दिया वक्फ ट्रिब्यूनल की। इस कानून में तो आपने वो विंडो भी बंद कर दिया। आप अगर वास्तव में प्लेस ऑफ वर्शिप एक्ट बना रहे थे तो प्लेस ऑफ वर्शिप बोर्ड भी बनाते, प्लेस ऑफ वर्शिप ट्रिब्यूनल भी बनाते और वहां हमें जाने का रास्ता देते कि भाई हमें जहां लगता है वहां चले जाए, वहां जाके देख लें। दूसरी बात मैं आपको बता रहा हूं, यह कानून बनाया गया पब्लिक ऑर्डर की आड़ में, और पब्लिक ऑर्डर सेंटर का सब्जेक्ट ही नहीं है। पब्लिक ऑर्डर स्टेट सब्जेक्ट है, कॉन्स्टिट्यूशन में काम का बंटवारा है। पब्लिक ऑर्डर स्टेट सब्जेक्ट है, सेंटर का सब्जेक्ट ही नहीं, इसलिए सेंटर के पास ये पावर ही नहीं थी। तीसरी बात, जस्ट मैं समराइज कर रहा हूं, क्विक 30 सेकंड। ये कानून हमारे देवी देवताओं में भेदभाव करता है। राम भक्तों के लिए जितना महत्वपूर्ण अयोध्या है, कृष्ण भक्तों के लिए उतना महत्वपूर्ण मथुरा है, शंकर जी के भक्तों के लिए उतना महत्वपूर्ण अपना काशी है, दुर्गा के भक्तों के लिए उतना महत्वपूर्ण भद्रकाली है, सरस्वती के भक्तों के लिए उतना महत्वपूर्ण भोजशाला है। यह कानून हमारे देवी देवताओं में भेदभाव करता है। दूसरा, यह हिंदू लॉ के भी खिलाफ है, इस्लामिक लॉ के भी खिलाफ है। हिंदू लॉ के खिलाफ इसलिए है क्योंकि वंस ए टेंपल ऑलवेज ए टेंपल। एक बार अगर प्राण प्रतिष्ठा हो गई, वहां पूजा पाठ शुरू हो गया, जब तक विसर्जन नहीं होगा वो मंदिर ही रहेगा। उसका गुंबद बदल जाए, उसकी दीवार टूट जाए, भारत में हजारों की संख्या नहीं लाखों की संख्या में मंदिर नहीं, पेड़ के नीचे पूजा होती है। नीम के पेड़ के नीचे, बरगद के पेड़ के नीचे, पीपल के पेड़ के नीचे पूजा होती है। वहां शिवलिंग स्थापित कर देते हैं, पूजा शुरू हो जाती है। आंधी तूफान आता है, पेड़ उखड़ जाता है, तो मंदिर का कैरेक्टर उसका खत्म नहीं होता। वैसे ही जब एक बार प्राण प्रतिष्ठा आ गई, कोई आक्रांता आया, उसने ढांचा बदल दिया, वहां नमाज शुरू करवा दिया, इसका मतलब ये नहीं कि वो मस्जिद हो गई। दूसरा, ये अन इस्लामिक क्यों है वो बता रहा हूं आपको। इस्लाम में लिखा हुआ है, साफ साफ लिखा हुआ है, आप होली कुरान को देख लीजिए, हदीसों को उठा के देख लीजिए। मस्जिद वहां बनेगी जो भूमि समतल हो। वर्जिन शब्द यूज किया है, मैंने जो कमेंट्री पढ़ी उसमें, मुल्ला की कमेंट्री, उसमें वर्जिन शब्द यूज किया। दैट लैंड शुड बी वर्जिन, समतल जमीन होनी चाहिए, या तो पुश्तैनी जमीन होनी चाहिए, या अपने जायज पैसे से खरीदी गई जमीन होनी चाहिए, या स्वेच्छा से दान की गई हुई जमीन होनी चाहिए। यहां आप बताइए, काशी मथुरा भद्रकाली भोजशाला में किसने दान किया था? और जो दूसरों के ऊपर मस्जिद बनाई जाए उसको मस्जिद नहीं, इस्लाम में उसको मस्जिद जर्रार कहते हैं, और मस्जिद जर्रार में नमाज पढ़ना हराम है, ये इस्लामिक लॉ कहता है। इसलिए मैं कहता हूं ये हिंदू लॉ के भी खिलाफ है, इस्लामिक लॉ भी खिलाफ है, और सबसे इंपॉर्टेंट ये सेकुलरिज्म के खिलाफ है।
बड़ा सवाल तो ये भी उठता है कि हम कितने हजारों मॉस्क्स को डिमोलिश करेंगे और फिर कितने टेम्पल्स बनेंगे इस पे, और ये सिलसिला कब तक चलते रहेगा?
देखिए, पहली बात तो ये एक झूठ फैलाया जाता है कि आपको मस्जिद की जांच करने के लिए खुदाई करनी पड़ेगी। हम चंद्रमा पे गए थे, क्या सीढ़ी बनाया? क्या सीढ़ी नहीं बनाया ना, टेक्नोलॉजी का यूज किया, चंद्रमा पे पहुंच गए। टेक्नोलॉजी यूज किया, हम मंगल पे पहुंच जाएंगे। हमने अग्नि ब्रह्मोस बनाया तो क्या हमने पहले आग जलाई? क्या नहीं, अग्नि ब्रह्मोस बना लिया। आज की डेट में इतनी टेक्नोलॉजी है, बिना दीवार टच किए यह बताया जा सकता है कि इसकी फाउंडेशन कब बनी, इसकी दीवार कब बनी, इसका गुंबद कब बना, सेम मटेरियल यूज हुआ है या अलग अलग मटेरियल यूज हुआ है।
बट द सेम क्वेश्चन सर, अगर आर्कियोलॉजिकल पर्पस के लिए अगर आप वहां पे सर्वे करते हैं कि आपको जानकारी जानने के लिए कि यहाँ पे हिस्टोरिकल साइट है, इसमें इज इट बिल्ट ऑन अ रूइन ऑफ अ टेम्पल और एनी अदर स्ट्रक्चर, दैट्स फाइन. But then what exactly is the intent for a lawsuit to be filed? That's the question that was also raised, as was mentioned
clear hai,
by Justice Ansari, that the Chief Justice of India, the former Chief Justice of India, said that it is all right to seek for surveys to be conducted, but only if the intent is right.
नहीं, intention बड़ा clear है. अगर वो मंदिर के ऊपर मस्जिद बनी है तो मस्जिद जर्रार है, वहां नमाज पढ़ना हराम है, और मंदिर के ऊपर मस्जिद बनी है तो आज भी मंदिर है, उसका जो कैरेक्टर है वो रिस्टोर होना चाहिए, और ये कानून भी कहता है। मैं एक एग्जांपल आपको देता हूं, ये कैरेक्टर रिस्टोर, जस्ट 30 सेकंड आपको एग्जांपल देता हूं। जिस कानून में जो शब्द यूज होता है वो उसके भले के लिए होता है। जैसे जिस कानून में SC ST लिखा है, इसका मतलब SC ST के भले के लिए है। जिस कानून में विमेन लिखा है यानी महिलाओं के भले के लिए है। जिस कानून में OBC लिखा है इसका मतलब पिछड़ों के भले के लिए। ये प्लेस ऑफ प्रेयर एक्ट नहीं है, ये प्लेस ऑफ वर्शिप एक्ट है। ये पूजा स्थल कानून है, ये प्रार्थना स्थल कानून नहीं है। इसलिए इसका इंटरप्रिटेशन पूजा स्थल यानी मंदिर के पक्ष में होगा, न कि प्रार्थना स्थल। और लास्ट में आपको बता दूं,
एडवोकेट उपाध्याय जी, आपने अपना पॉइंट हैज बीन एस्टैब्लिश्ड वेरी वेल मेड।
मंदिर के एयरपोर्ट पे कभी प्लेस ऑफ वर्शिप नहीं होता, एयरपोर्ट पे हमेशा प्लेस ऑफ प्रेयर होता है, क्योंकि प्लेस ऑफ प्रेयर को बदला जा सकता है, प्लेस ऑफ वर्शिप को बदला नहीं जा सकता।
ओके, ऑलराइट। आई एम आल्सो गोइंग टू गेट a viewpoint from Mr. Syed Nasir Hussain, Member of Parliament, Rajya Sabha from the Congress. Thank you very much for joining us for this discussion and being part of our dialogue. How do you have to view these developments, these unfortunate incidents that are taking place? Sambal particularly, the riots that took place, 12 people died. A situation of communal disharmony happened. Could this have been averted?
See, yesterday there was a fantastic judgment in Supreme Court. They gave a stay on all these mischievous things that are happening in the country, all the mischievous petitions that are being filed in the different courts. I think I welcome that. Two, we have to not just get into the nitty-gritties of the bill of from the Act of 1991. We should understand the times in which it was passed, why it was passed, what did the parliamentarians during that time think about the entire issue that was happening, that was there in the country, in what atmosphere it was brought in. I think they brought in to put a lid on all such issues. We got freedom in 1947. What happened before that? Who invaded? What was Bharat? Till where was Bharat? What was Akhand Bharat? Who came from where? If you look at temples, Hindu temples, you have to think of Jain temples, you have to think of Buddhist worship places. If you start digging up everything, then there'll be Shaivites, Vaishnavites. So many things happened in the past. I think 1947 is something which we need to remember. We became a nation, we became a democracy, we need to move on, we need to move forward, we should be a forward-looking progressive nation. Because for that reason, the Parliament in its wisdom passed that bill and said, enough is enough, we'll put a lid on this, we'll close this, except one issue, we'll close it, and here on out, we'll move forward, we'll not get into these issues. I think we have to understand the spirit behind that act, which is very, very important. If people, the ecosystem of Bharatiya Janata Party and the Sangh Parivar, if they really want to search for issues to have a vote bank in this country, to appease people in this country, to have a continuous vote bank on which they want to win elections in different states, they will start digging up these kind of issues. Come some election in some part of the country, there will be one such issue which will be emotive in nature, which will be polarizing in character, and on that basis they will be winning such kind of issue. If you look at the kind of atmosphere that has been created in this country, every issue is anti-minority, anti-Muslim. Why is it that? They want to polarize it. It is not Hindu-Muslim issue. It is the issue of BJP and that mindset versus the people, those who want to have this country in the present form, in a democratic form, we want to have a country where we need to move forward, where we need to live happily with each other. Now, what is happening here is, it is very, very clear. Important issues of the people, Aam Janta ke mudde, it's all sidelined. These are the issues which are debating. And this is the most unproductive things that are happening in our country. And unproductive, I call this because this will lead us nowhere. This will lead us nowhere. We need to go forward. We need to emerge as one of the strongest nations. That only can happen with unity in diversity.
Absolutely. All right. That was a fantastic point made. Mukhtar Abbas Naqvi ji, आपका क्या कहना है? क्या आपको लगता है कि abrogation of the Places of Worship Act 1991, is this akin to a movement that could be perceived as anti-Muslim?
देखिए, हमारे देश का जो कॉन्स्टिट्यूशन है, संविधान, वो सबसे दुनिया के जितने भी संविधान हैं, रिटन हैं, अनरिटन हैं, लिखित हैं, अलिखित हैं, उनमें सबसे बड़ा और बड़ा ही नहीं, बहुत ही व्यापक है. और इसीलिए जो है वो हमारे यहाँ कॉन्स्टिट्यूशन जो है वो सुप्रीम है, पार्लियामेंट सुप्रीम नहीं है. जितनी भी जो है वो कॉन्स्टिट्यूशनल सिस्टम है हमारा, चाहे जुडिशरी हो, चाहे लेजिस्लेटिव हो, चाहे विधायिका, कार्यपालिका, जितनी भी हैं, वो सब के सब जो है वो कॉन्स्टिट्यूशन के मुलाजिम हैं. कॉन्स्टिट्यूशन को उन्हें फॉलो करना है. अब सवाल पैदा होता है कि जो हमारा जब कॉन्स्टिट्यूशन और हमारे जो संविधान निर्माताओं ने जो हमारे संविधान बनाया, तो उसमें कई ऐसे पहलू हैं जिसे हम आज भी चेंज नहीं कर सकते. वो पत्थर की लकीर है. उस बहुत बार 106 बार 7 बार कॉन्स्टिट्यूशनल अमेंडमेंट्स हुए हैं, और उन कॉन्स्टिट्यूशनल अमेंडमेंट में भी उन जो पहलुओं को कभी भी जो है वो टच नहीं किया गया. वो पहलू है यूनिटी इन डाइवर्सिटी, एक भारत श्रेष्ठ भारत की. और जो अभी हमारे अश्वनी जी कह रहे थे, देखिए एक चीज़ हमें समझना होगा कि हम किसी भी समस्या का समाधान हमें करना होगा, उसे नेवर एंडिंग समस्या नहीं बनाना होगा. ये बात सही है, जो बात आपने कही उससे मैं इत्तेफाक करता हूँ कि बहुत पहले कुछ विदेशी आक्रमणकारी आए, उनकी कुछ क्रिमिनल, कम्युनल, क्रूर करतूतें हुई, और जिसका कि खमियाजा भी बहुत वर्षों तक देश ने भुगता. लेकिन आज जो है हमें तमाम ऐसे पहलू, जिन पहलुओं को कि हम समाधान के रास्ते पर, अब जैसे बाबरी मस्जिद का इशू था, लगभग 600 साल तक जो है वो राम मंदिर मुद्दे को लेकर के आंदोलन हुआ, संघर्ष हुए, कुर्बानियाँ हुई, फिर कोर्ट ने जो है, सुप्रीम कोर्ट ने एक यूनानिमस डिसीजन किया, और सभी वर्गों ने, चाहे वो हिंदू हो, मुसलमान हो, कोई भी हो, उन्होंने जो है उसका स्वागत भी किया और सम्मान भी किया, और वो इशू क्लोज हो गया. कुछ और इश्यूज हैं जिन इश्यूज को कि जिसको कि जो है वो करेक्ट करने की ज़रूरत है, लेकिन हर इशू जो है वो करेक्ट करने के लिए रास्ते में नहीं खड़ा हो सकता. कुछ इश्यूज हैं, डेफिनेटली कुछ इश्यूज ऐसे हैं जिन इश्यूज को कि जो बहुत ही गंभीर आस्था से जुड़े हुए हैं और उसका जो है वो सोल्यूशन होना चाहिए, समाधान होना चाहिए। इसलिए मैं मानता हूं कि हमें जो हमारा कॉन्स्टिट्यूशनल कमिटमेंट है, उस कॉन्स्टिट्यूशनल कमिट हमारे लिए जो है वो किसी भी लोकतंत्र के लिए कॉन्स्टिट्यूशन जो है वो धर्म ग्रंथ है उस लोकतंत्र का। तो इसलिए हम उस दिशा में हमें चलना चाहिए और समाधान जो है वो निकालने की ज़रूरत होनी चाहिए। और अदरवाइज तो जो है वो न हम नशी न किसी हम सफ़र से निकलेगा, हमारे पाँव का कांटा हम ही से निकलेगा।
सुमन खुर्शीद जी, आपका इस पे क्या कहना है? How do you view this? Do you think this is petty politics of vote bank that is being played out over here?
See, I would be unfair to those who presumably honestly believe what they are doing is a matter of their faith. So I will not be unfair to them. If political people get involved, then one can certainly say that people are trying to take political advantage. But if somebody believes he's doing it as a matter of faith, we must respect them. Because the very purpose of this legislation is not to be pointing fingers at each other. The whole purpose of this legislation is that now let us come together and live together. I have a very educational opportunity right now to discover that this is an issue of Islam, that Islam prohibits such places of prayer or places of worship, because none of the suits that have been filed for a declaration on behalf of Muslims that this is something that the Muslims should not be inflicted upon, etc. But if we continue to look at these ways and means of hurting each other, they are endless, absolutely endless. Do we believe in this country? Do we believe in the Constitution that you've just given to us? If we do, then we have to learn to take some burdens and move forward to say that we have a shared destination. The message that must go is that we have a shared destination and we believe and we will give up anything for this. And I think that was the attempt that the Supreme Court also made at the time of the Ayodhya dispute, that if we can come together and find a solution. So though no solution was found before the Supreme Court pronounced, but after the Supreme Court's pronouncement, one got a feeling that this is a solution and this is being accepted across the board. Now let's not unsettle that. Let us not destroy that good feeling that emerged after a long time, that we are now together. There's no need now to continue to pull ourselves asunder. And I would just appeal to everybody, if you have faith in each other, you are going to be a much more powerful country in the world than you can ever imagine.
Absolutely. I'll come to you, Advocate Upadhyay. Let me get in Justice Iqbal Ansari as well to seek a comment from him. Okay, fine. Yes. Go ahead. Yes.
सलमान सर, आप 1991 गवर्नमेंट में क्या थे? उस समय आप कानून मंत्री थे? अच्छा, ठीक है। देखिए, मैं आपको दो कानून दिखा रहा हूं, एक 1991 का है, एक 1995 का है। वक्फ एक्ट है, दूसरा है प्लेस ऑफ वर्शिप एक्ट। मैं तो ये कह रहा हूं, जब वक्फ एक्ट बना उसमें वक्फ बोर्ड दिया, आप प्लेस ऑफ वर्शिप एक्ट में प्लेस ऑफ वर्शिप बोर्ड दे दीजिए। वक्फ एक्ट में वक्फ ट्रिब्यूनल है, आप प्लेस ऑफ वर्शिप ट्रिब्यूनल दे दीजिए। वक्फ एक्ट में वक्फ सर्वेयर है, आप प्लेस ऑफ वर्शिप का सर्वेयर दे दीजिए। तो जैसे इसमें कोई कट ऑफ डेट नहीं है, इसमें 1947 की कट ऑफ डेट नहीं है, इसमें वक्फ एक्ट में ये अनलिमिटेड है कि 1500 साल पुराने गांव को भी आप वक्फ प्रॉपर्टी डिक्लेयर कर सकते हैं। मैं कह रहा हूं आप इसकी भी कट ऑफ डेट निकाल दीजिए, दोनों कानून को एक बराबर कर दीजिए। ये तो नहीं चलेगा, एक तरफ आपने कोर्ट का दरवाजा बंद किया और वक्फ ट्रिब्यूनल बना दिया, दूसरी तरफ ना ट्रिब्यूनल बनाया और कोर्ट का दरवाजा बंद किया। हिंदू यहां हजारों साल से नाइंसाफी झेल रहे हैं। अब मैं बार बार रिपीट कर रहा हूं, यह मामला हिंदू मुस्लिम का नहीं है, यह भारत की संप्रभुता का मामला है। और बहुत जिम्मेदारी के साथ कह रहा हूं, मुगलों ने न यहां कोई नया शहर बसाया, न उन्होंने कोई मस्जिद बनाई। उनके पास अयोध्या में खाली जगह की कमी नहीं थी, लेकिन उनको जन्मभूमि के ऊपर ही बनाना था। मथुरा में खाली जगह की कमी नहीं थी, बना सकते थे, नहीं, उनको जन्मभूमि के ऊपर बनाना था। मैं 30 सेकंड में बताता हूं उन्होंने क्या किया। जितने पौराणिक स्थान थे जिनका वर्णन वेद पुराण उपनिषद में था, उनका नाम बदला। जैसे भगवान कृष्ण ने 5 गांव मांगा, उन्होंने गजप्रस को गाजियाबाद बना दिया, तिलप्रस को फरीदाबाद बना दिया, सोनप्रस को सोनीपत बना दिया, पानप्रस को पानीपत बना दिया। द्रौपदी जहां पैदा हुई उसको पांचाल कहते हैं, उस पांचाल को फर्रुखाबाद बना दिया। जहां पांडवों ने अज्ञातवास किया उसको विराट कहते हैं, उन्होंने विराट को होशियारपुर बना दिया। हमारा एक शक्तिपीठ कीर्तेश्वरी, उसको उन्होंने मुर्शिदाबाद बना दिया। हमारा दूसरा शक्तिपीठ विंध्याचल, उसको मिर्जापुर बना दिया। हमारा एक बहुत बड़ा पवित्र स्थान था जमदग्निपुरम, जौना खान ने उसको जौनपुर बना दिया। तो उन्होंने क्या किया, कोई नया शहर नहीं बसाया। उन्होंने एक बार कंप्लीट कर रहा हूं, उन्होंने हमारे पौराणिक शहरों का नाम बदल के हमारा नामो निशान मिटाया। और दूसरा, कोई एक नई मस्जिद नहीं बनाई नमाज पढ़ने के लिए, हमारे स्वाभिमान को कुचला, हमारा नामो निशान मिटाने की कोशिश किया। अब आज की डेट में हम वेद पुराण उपनिषद सत्यार्थ प्रकाश के जो नाम ढूंढते हैं, हमको भारत के नक्शे पर नाम नहीं मिलते, और हम उन मंदिरों को ढूंढते हैं, वो मंदिर नहीं मिलते।
Why don't we study it in our history books? Why don't we have lectures? Why don't we speak about this? Is it necessary to destroy the entire country and then rebuild it all again?
मैं तो कह रहा हूँ वो मस्जिद ज़रार है, वो मस्जिद ज़रार है, वहाँ मुस्लिम के लिए नमाज पढ़ना हराम है।
Okay, Sayyid Nazir Hussain, yeah.
मोहनजोदड़ो हड़प्पा की खुदाई से सब कुछ निकाल के लाए हैं, लेकिन एक चीज मैं अभी कंफ्यूज हूँ। वो आपने मुल्ला का, आनंद नारायण मुल्ला जी का वो आपने कोट किया है क्या?
नहीं, मुल्ला की एक मुल्ला का पूरा वो है।
ठीक,
बहुत बड़े जूरिस्ट हैं। नहीं, मुल्ला बहुत बड़े जूरिस्ट हैं। सुप्रीम कोर्ट में उनका कोट किया जाता है।
ओके, सैयद नासिर हुसैन जी।
ये उपाध्याय जी, ये उपाध्याय जी जो है वफ के बारे में बात कर रहे थे, मैं उसके बारे में बात करना चाहता हूँ। मुझे ये बता दें, ये वफ एक्ट में कहाँ ये लिखा हुआ है कि कोई भी वक्फ बोर्ड या कोई भी वक्फ जो है ना, किसी भी जमीन को अपनी जमीन करके हथिया सकता है, नंबर 1। नंबर 2, शायद इनको पता नहीं है कि एंडोमेंट बोर्ड्स हैं, मुजराई डिपार्टमेंट्स हैं, हिंदू प्लेसेस ऑफ वर्शिप एक्ट्स हैं, हिंदू रिलीजियस प्लेसेस एक्ट्स हैं डिफरेंट स्टेट्स में। और मैंने, क्योंकि जेपीसी वक्फ का मेंबर हूं मैं, और वक्फ बोर्ड का भी मेंबर हूं कर्नाटका में 6 साल से, मैंने देखा है और पूरा कंपेयर करने की कोशिश की है। जिस तरह के प्रोविजंस वक्फ में हैं, लगभग उसी तरह के प्रोविजन, नाम अलग अलग दिया होगा, कहीं ट्राइब्यूनल दिया होगा, कहीं असिस्टेंट कमिश्नर दिया होगा, लगभग उसी तरह का जो है पावर्स वहां भी दिया गया है। एंडोमेंट का मतलब वक्फ है, वक्फ का मतलब एंडोमेंट ही है। एंडोमेंट बोर्ड पूरे ही स्टेट्स में, नंबर 1। नंबर 2 जो है, मैं तो कह रहा हूं,
मैं दिखा रहा हूं आपको।
मैं 1 मिनट, मैं तो कह रहा हूं कि हमारे देश में सिर्फ मुसलमानों के लिए नहीं, हिंदुओं के प्लेसेस ऑफ वर्शिप हैं, क्रिश्चियंस के प्लेसेस ऑफ वर्शिप हैं, जैन्स के हैं, बुद्धिस्ट के हैं, सिख्स के हैं। लेट देयर बी ए पैरिटी, लेट देयर बी पैरिटी इन एवरीवन। अब ये जो एंडोमेंट में जो लगभग उसी तरह के हैं, लगभग उसी तरह के हैं। अगर सरकार चाहे, अब इनके लिए एक हिस्टोरिक अपॉर्चुनिटी है, वफ का उन्होंने लेके आया है, साथ में वो सारे एंडोमेंट बोर्ड, सारे हिंदू प्लेसेस ऑफ वर्शिप एक्ट अलग अलग स्टेट में है, हिंदू प्लेसेस एक्ट, रिलीजियस प्लेसेस एक्ट अलग अलग स्टेट में, सबको कंबाइन कर दें, एक तरह के सबके लिए कर दें, वेल वेलकम इट।
बहुत अच्छा। देखिए, मैं करेक्ट कर दूं। देखिए,
I know we would love to have this discussion and it could go on for hours, and we'll do that in the future as well on our NewsX and India News platforms. Okay, 30 seconds.
ये सबसे बड़ा फैक्चुअल रॉन्ग है कि हिंदुओं के पास वैसा ही कानून है जैसा वक्फ के पास। ये सबसे बड़ा सच्चाई तो ये है कि 4 लाख मठ मंदिरों पे सरकार का कंट्रोल है, किसी एक मस्जिद पे सरकार का कंट्रोल नहीं, किसी एक दरगाह पे सरकार का कंट्रोल नहीं, किसी एक चर्च पे सरकार का कंट्रोल नहीं। मुंबई में सिद्धि विनायक सरकार के कंट्रोल में है, हाजी अली की दरगाह नहीं है।
जस्ट होल्ड ऑन। वक्फ बोर्ड क्या है, किसके अंडर है? वक्फ बोर्ड का एक मंत्री होता है, मंत्री सरकार का होता है। पूरा वक्फ बोर्ड इस सरकार के कंट्रोल में है, अब पूरी स्टेट में है। हाँ, सारे और सारे मुस्लिम इदारे वक्फ बोर्ड के अंदर आते हैं। वक्फ बोर्ड का मिनिस्टर होता है, वक्फ बोर्ड के ये माइनॉरिटी अफेयर्स मिनिस्टर थे हमारे मुख्तार अब्बास नकवी साहब, इनके अंडर जो है वक्फ काउंसिल आता था। वक्फ काउंसिल पूरे हिंदुस्तान के वक्फ बोर्ड को कंट्रोल करता है। आपको पता नहीं, गलत क्यों बन जा रहे हैं?
ओके, ऑलराइट,
ऑन क्या आइए यहाँ पे, आपको पता नहीं क्या बोलते हैं, पढ़ के आइए, पढ़ के आइए,
मुख्तार अब्बास नकवी,
आपको पता नहीं।
स्टेटमेंट बिफोर आई रैप दिस अप। यस,
देखिए,
ऐसा कानून हिंदुओं के लिए कौन सा है बताइए? परफेक्ट ऐसा कानून हिंदुओं के लिए
बहुत
आप सारे स्टेट के हिंदू रिलीजियस प्लेसेस एक्ट पढ़ लीजिए, हिंदू रिलीजियस हिंदू वर्शिप एक्ट पढ़ लीजिए, उड़ीसा का पढ़ लीजिए, बिहार का पढ़ लीजिए, तेलंगाना का पढ़ लीजिए, मेरे स्टेट कर्नाटका का पढ़ लीजिए, आंध्र प्रदेश का पढ़ लीजिए, तमिलनाडु का पढ़ लीजिए। आप नहीं मिसकोट नहीं, आप पढ़िए। मैं आपके साथ आप बैठिए मेरे साथ।
लास्ट में मैं यही कहूंगा कि जो रूट काज है उसको बहुत अभी डिटेल में अश्विनी जी ने कहा, मैं इतना ही कहूँगा वक्फ का जो सिस्टम है उसकी अनकॉन्स्टिट्यूशनल एनार्की जो है उसको जो है कॉन्स्टिट्यूशनल हेरार्की के फ्रेमवर्क में लाना चाहिए। वक्फ का जो सिस्टम है उसको जो असंवैधानिक अराजकता है उसको संवैधानिक प्रतिबद्धता के फ्रेमवर्क में लाना चाहिए, एक चीज़। और दूसरी इंपॉर्टेंट चीज़ है कि वही हकदार हैं किनारों के जो बदल दे बहावधारों के, तो अब ये बहावधारों का बदलिए और कहाँ तक मोहनजोदड़ो हड़प्पा मंदिर मस्जिद निकालते रहेंगे। धन्यवाद।
सर एक मिनट, सर मैं कांग्रेस का एमपी हूँ, जेपीसी का मेंबर हूँ, मुसलमान हूँ। मैं आपको कह रहा हूँ आपकी सरकार सेंटर में है, सारे रिलीजन्स को, सारे कम्युनिटीज के प्लेसेस ऑफ वर्शिप को एक तरह के एक्ट में लेके आया। We are ready for that.
Absolutely. Okay, all right. On that note, I'm completely out of time. I thank all of you for joining me. And it has been an insightful conversation. Debates, yes, but debates lead to consensus building, and that's what we are here for. Thank you all.
Thank you once again, Salman Khurshid, Justice Iqbal Ansari, Syed Nasir Hussain, Mukhtar Abbas Naqvi, and Ashwini Kumar Upadhyay for joining us at the third Law and Constitution Dialogue. What an absolutely riveting conversation it's been on one of the most pressing matters. Ladies and gentlemen, it gives me immense pleasure to introduce the chief guest for our keynote session, Justice Surya Kant, Honorable Judge at the Supreme Court of India. Let us welcome Justice Surya Kant with a huge round of applause. I take this moment to request Justice Surya Kant to please join us on stage, accompanied by Shri Kartikeya Sharma, Member of Parliament Rajya Sabha, and Mr. Tarun Nangia, Editor of Legally Speaking. We are deeply grateful, Justice Surya Kant, for you to join us at the third Law and Constitution Dialogue. I now take this moment to request Shri Kartikeya Sharma to say a few words to welcome Justice Surya Kant to the third Law and Constitution Dialogue.
Good evening, everyone. I'd like to take this opportunity to thank Honorable Justice Shri Surya Kant ji for taking out time from his busy schedule and being part of the Third Law and Constitution Dialogue, which marks the history and is a milestone because we celebrate the 75th year of the Constitution. And since we debate it in the Parliament today in the Lok Sabha and subsequently in the Rajya Sabha, I think it is only apt that the third discussion should also be by the fourth pillar, and who better than the Honorable Justice Surya Kant ji to enlighten us and show us the way on it. Sir, thank you very much for taking out time and being part of the legally speaking endeavor to take the Constitution to the people of the country, and also emphasize on the importance of the Constitution in our daily lives and how we use it and take it and make it a part of our lives in development, growth, and evolution as a democracy. Thank you very much, sir, for taking out time and gracing this occasion with your presence. Thank you very much.
Thank you, Kartikeya ji, for those words. I now request you to please present a token of our appreciation to Honorable Justice Surya Kant. As India marks 75 years of the adoption of its constitution, we present to you a copy of the original constitution, sir. Let's have a huge round of applause. Along with this, we take great pleasure in presenting to you, Justice Surya Kant, a photograph of the first session of the Constituent Assembly held on the 9th of December 1946. Justice Suryakant will be addressing our esteemed gathering on a plethora of topics, including the Specific Relief Act and the law, media, and social media. With that, ladies and gentlemen, I request Justice Suryakant to the dais to address the third Law and Constitution dialogue.
Thank you very much. Good afternoon to all the distinguished guests here. Instead of any formal address to a galaxy of personalities whom I know personally and with whom I am associated for a long time, with your kind permission, may I just start with the subject of today's interaction with you. I propose to speak on the 2018 Amendment Act in the Specific Relief Act with reference to, because I was asked to that, keeping in view the economic dimensions and the India marching ahead as a very strong economy in the global map, what are the consequences, what are the effects and impact of the 2018 amendment in the Specific Relief Act? I just thought that I will share my ideas on that. The 2018 amendment to the Specific Relief Act and its potential implications for India's future, both domestically and internationally, is the subject of discussion. India's evolving global positioning becomes particularly pertinent in this background, as it closely aligns with the modifications introduced by the amendment and the overarching object it aims to fulfill. When we speak of disputes arising from the breach of contracts with reference to the original Specific Relief Act of 1963, the granting of remedies to aggrieved parties is rooted in the old principle of ubi ius ibi remedium, which means that where there is a right, there is a remedy. The remedy of specific relief is treated differently across jurisdictions. For instance, civil law jurisdictions most commonly treat specific relief on the same level as a remedy for compensation or damages, whereas this is not so in common law countries. India, being a common law country, has treated the remedy of specific relief for several decades as one steeped in the principle of equity, but paradoxically subject to judicial discretion. In this regard, the legal framework governing the remedy of specific relief in India was encapsulated in the Specific Relief Act of 1963. The objective of this particular statute is to essentially safeguard civil rights and provide remedies for people whose contractual rights have been infringed. The remedies traceable under the Act include a recovery of possession of property, rectification of instruments, specific performance of contracts, rescission and injunctions, among several others. However, despite its wide import, this legislation was often perceived as rigid, primarily due to the imposition of the inadequacy test, which in turn is founded upon the notion of reversed onus of proof. Under this test, an aggrieved party seeking the remedy of specific performance was required to demonstrate that damages under the common law was either unascertainable or an inadequate relief. This test applied to suits for specific performance of contracts as well as to injunctions sought for enforcing contractual obligations. Consequently, specific performance was treated as an exceptional remedy, granting only when court was satisfied that the alternative recourses were wholly deficient and its decree would be effectively enforced. When Section 10 of the 1963 Act codified the inadequacy test Section 14 and 20 of that Act enumerated exceptions to the grant of specific performance, such as the availability of monetary compensation or the impracticality of enforcing contracts involving minute details, with courts predominantly favoring the award of damages in cases of breach and specific performance being invoked only as an exceptional remedy. The efficacy of the 1963 Act was significantly undermined. The lack of mandate for specific performance of a contract, irrespective of mitigating circumstances exhibited by the losing party, substantially affected the sanctity of contractual obligations. I believe that it is not uncommon for parties to breach their contractual obligations, as the damages awarded often prove to be less burdensome than the cost of performance. Promisors frequently resort to breach when the gains from such breach outweigh the damages assessed by the court. This phenomenon aligns with the efficient breach theory in law and economics, which posits that voluntary breach of contract accompanied by the payment of damages can be economically justified. Proponents of this theory contend that in certain instances it is economically efficient for contracts to be breached. By limiting remedies to monetary damages, the legal framework arguably incentivizes parties to breach contracts when the cost of performance exceeds its perceived value. This, to my mind, eventually derailed the aim of the statute to provide relief to parties and functioned almost as a sort of ancillary legislation with not much application. In this legal framework of the 1963 Act, then came a 2016 expert committee's recommendations. That being the state of affairs, over time it became evident that the existing framework under the Specific Relief Act 1963 was increasingly unfeasible, and an expert committee was therefore constituted to undertake its review. This decision was necessitated by the substantial developments that had occurred since the 1963 when the Act was enacted, particularly in the context of contemporary scenarios involving contract-based infrastructure development, public-private partnerships, and other public projects requiring abundant investments and enforceability of contracts. The review was also aimed at aligning the Act with the objective of ensuring the ease of doing business. Notably, the Specific Relief Act had not undergone any amendment since its inception. The expert committee, therefore, in its report, underscored that the Specific Relief Act in its existing form was inadequate to address the demands of India's rapid economic growth and industrial expansion. It emphasized the need for extensive reforms to facilitate the enforcement of contracts and ensure timely dispute resolution, both of which are crucial to the creation of a business-friendly environment. More specifically, the committee highlighted the limitations of the inadequacy test, which restricted the remedy of specific performance to a narrow set of circumstances. It observed that in many cases, plaintiffs were unable to fully substantiate the losses incurred due to a breach, nor were the claimed amounts consistently awarded. While damages might compensate the injured party, they fall short of fulfilling the contractual obligation that the remedy of specific performance is designed to achieve, often resulting in delays and additional costs. If I were to express this analogy in my own words, denying specific performance in favor of awarding damages is something like refusing indoor admission to a patient, to a critically rather ill patient, and opting instead to administer him just the basic first aid. While the latter may provide some relief, it often falls short of addressing the underlying issue comprehensively, leaving the affected party inadequately remedied. Let us also see when the 2016 committee was constituted and it's decided to make certain sweeping recommendations for amendment in the 1963 Act. Let us see what were the position in law in various other jurisdictions. When we peek over the fence and look beyond our own legal system, the remedy of specific performance varies significantly across jurisdictions, reflecting diverse approaches to contract enforcement. Under common law systems, specific performance is directed against the defendant personally, where the court requires the defendant to fulfill their contractual obligations or face the consequences, such as being held in contempt. In contrast, civil law systems take a broader view. The remedy focuses on achieving the promised result for the promisee rather than merely directing the debtor to act. This approach allows the promisee to have defects cured or substitutes obtained at the promiser's expense. In common law nations, and that I will refer to even United States of America, specific performance may be ordered if explicitly provided for within the agreement. However, the limitations remain the same, namely, specific performance is generally resorted to only when legal monetary damages are inadequate or an incomplete remedy for breach. Similar is the situation in United Kingdom, where broad discretionary powers are granted to the courts. Even in civil law jurisdictions, though the applicability of specific performance is propagated, nonetheless, actual performance of a contract is ordered only in exceptional cases. In countries like France and Germany, the laws are quite wide and they allow substituted performance instead of actual performance, subject to the imposition of restrictions. For example, German law grants specific performance as a matter of right, but with limitations tied to the adequacy of compensation. Enforced performance is typically ordered only when monetary compensation is inadequate. This includes situations where a profit-earning asset is damaged and the loss of profits during the repair period cannot be adequately compensated. However, under the German law, if specific performance results, it's quite interesting provision. If specific performance results in the promisee receiving a benefit greater than what was originally agreed upon, specific performance can be denied. Instead, the promisee would be entitled to compensation equivalent to the value agreed upon by the parties at the time of entering into the contract. A common limitation across most of the jurisdictions pertains to personal contracts, particularly those requiring the promiser's personal services. Courts generally, and in my opinion rightly so, refrain from enforcing such promises in light of potential infringement and violation of personal freedom and liberty. Additionally, courts are often reluctant to oversee or evaluate the quality of personal service, which could involve significant judicial supervision. Lastly, all legal systems recognize the impossibility of enforcing specific performance where it is not feasible for the promiser or any third party to fulfill the promise. This principle underscores the practical limitations of the remedy across jurisdictions. Now, reverting back to the recommendations of the 2016 Expert Committee and the deficiencies pointed out in the Specific Relief Act of 1963, along with the transformation of the economic landscape, the 2018 amendment, to which I am now straight coming, the 2018 amendment came into force. This amendment indeed marked a significant shift, making specific performance available as a matter of right rather than an exception. This amendment is a testament to the measure that India has effectuated in comparison to other contemporary jurisdictions to create a more streamlined framework which fosters predictability and certainty in commercial contracts. One of the most crucial changes brought about by the 2018 amendment, in my considered opinion, it relates to the onus on the plaintiff to prove readiness and willingness to perform their contractual obligations. Under the old framework, the plaintiff was required to make an express averment to this effect in their pleadings. The amendment thought it retains the burden on the plaintiff to prove readiness and willingness, but it does away having to specifically make any averment to this end in the pleadings. Similarly, the amendment removes the prohibition on enforcing contracts with arbitration clauses through specific performance, allowing for a more integrated and pragmatic approach to dispute resolution. In contrast to the earlier provision, which allowed compensation either as an alternative or in substitution of specific performance, the amendment enables plaintiffs to claim compensation as an additional relief alongside specific performance. This ensures that plaintiffs are adequately compensated for losses while also obtaining the performance of the contractual obligations. Moreover, the courts are now empowered to appoint experts. This is also a very significant provision that has been added. The courts are now empowered to appoint experts to examine the nature of commercial contracts, determine breaches, and assist in resolving complex issues. These experts may also be examined by the parties subject to the court's permission, which introduce a more informed and effective adjudication process. The 2018 amendment also brings to fore the concept of substituted performance, allowing an aggrieved party to procure the performance of the contract from a third party or its own agency in the event of a breach. The expenses incurred for such substituted performance can be recovered from the defaulting party. Additionally, the amendment includes provisions to allow third parties who have been conferred benefits under a contract to specifically enforce such agreements. This serves as an exception to the traditional doctrine of privity of contract, expanding the scope of enforcement in line with contemporary needs. Recognizing the complexity and public interest involved in large-scale infrastructural projects, particularly those involving government agencies and public-private partnerships, the amendment of 2018 places an embargo on granting injunction that could delay or impede the completion of the infrastructure-based projects. To further streamline this, the 2018 amendment provides an exhaustive list of infrastructure projects covered under the statute, ensuring clarity and uniformity. Special courts are also to be designated by state governments to handle suits related to infrastructure contracts under this Act, enhancing efficiency in resolving disputes in such critical areas. Lastly, to address delays in litigation, the amendment mandates the expeditious disposal of all matters under the Act within 12 months from the date of service of summons to the defendants, within a maximum extension of 6 months. This time-bound resolution conforms with the overarching objective of facilitating an enterprise-friendly landscape and ensuring swift enforcement of contractual obligations. The Act, of course, ideally provides for adjudication of the suits within 12 months, but I have a caveat here. When a law is enacted fixing timelines for expeditious disposal of cases in a timeline manner, it is equally critical to conduct corresponding judicial impact assessments while also making adequate provisions for enhancing judicial infrastructure to meet such challenges. I hope this aspect the stakeholders will keep in mind. These changes through the 2018 amendment that I have highlighted are only a few instances among the many that seek to collectively modernize the Specific Relief Act aligning it with India's evolving economic topography and emphasizing timely, efficient, and effective resolution of contractual disputes. Essentially, the amendment to the Specific Relief Act of '63 aimed to create a more pro-business climate and secure setting by making specific performance the rule rather than the exception, with damages serving as an alternative remedy. This shift reflects a stricter approach to enforcing promisers' performance, acting as a deterrent against uncertain and undesirable contractual behavior. Greater certainty in contract enforcement is expected to enhance India's attractiveness as a destination for both foreign and domestic investments, which would greatly contribute to the economic growth of the nation. The expanded availability of specific performance also offers notable efficient outputs, minimize the risk of undercompensation or the risk of overcompensation. It reduces the reliance on liquidated damages clauses. It also limits strategic behavior and mitigation challenges. And most importantly, it grants primacy to the moral obligation of honoring one's promise. This provision, I'm talking 2018 amendment, one of the clause, has also successfully mixed moral science into legal framework. What was earlier understood to be a mere moral obligation has now been made an enforceable obligation. Additionally, it simplifies the litigation process by avoiding the complexities associated with calculating damages. In essence, the amendment not only strengthens the enforceability of contracts, but also the broader objectives of promoting economic stability and encouraging greater certitude among investors, ensuring that contractual obligations are met efficiently and equitably. It represents a key advancement towards addressing the uncertainties surrounding the execution of contracts in India. India is presently positioning itself as a global economic powerhouse driven by comprehensive legal, policy, and judicial reforms aimed at boosting investors' confidence and trade-enabling infrastructure. However, this was not always the case. Post-independence, India largely adopted a closed economic model with limited trade and restricted access to its markets for foreign entities. This approach was driven by a focus on self-reliance and protection of the domestic industries. The transformative journey of India's economic conditions was initiated through the pioneering reforms of 1991, defined by a total overhaul aimed at restructuring the economy. The post-1991 era emerged as a definitive catalyst for foreign direct investment inflows, witnessing a remarkable surge propelled by regulatory reforms and the opening of India's economy to global investors. Transitioning from a modest annual growth rate of 23% during 1981 to 1990, FDI experienced a remarkable acceleration, soaring at an annual rate of 44%. I believe that India now asserts itself as an economic powerhouse, having secured FDI of US $725.96 billion over the last 10 years and foreign institutional investment of $38 billion across sectors such as service, software, telecommunications, pharmaceuticals, and automobiles. Despite instabilities occurring throughout the world and overcoming the slowdown brought by the COVID-19 pandemic, I am also informed that as per the World Bank's Ease of Doing Business report, India has improved its position from 142nd in 2014 to 63rd in 2019, reflecting significant strides in regulatory and procedural efficiency. Additionally, there seem to be heightened efforts toward reducing over 39,000 compliances and decriminalizing some old and obsolete laws. In fact, judicial efficiency, which is a key component of the Ease of Doing Business Index, has also received considerable attention. India's lengthy dispute resolution process, averaging 1,445 days to resolve a commercial dispute, as per the 2018 report, has substantially reduced. Establishing commercial courts at the High Court and District Courts levels in 2015 has also streamlined the resolution of the contractual disputes, reducing delays and costs. I believe that the judiciary has taken a pragmatic approach in interpreting commercial laws, instilling confidence among foreign investors, and fostering domestic business growth. The repeal of laws like Sikh Industrial Companies Act of 1985, to which I have at once prescribed as the sanctuary for defaulters, has also contributed to reshaping the legal framework. While it may be premature to place complete trust in the quasi-judicial commercial tribunals such as the National Company Law Appellate Tribunal or National Company Law Tribunals, their potential for success lies in appointing subject specialists under secure and transparent service conditions. A fair and independent working environment for these tribunals could mark a significant milestone in India's progress. Given this metamorphosis, the role played by the 2018 amendment to the 1963 Specific Performance Act becomes especially focal, as it is vital in enhancing enforceability. The crux of this amendment can be captured by the words of, I remember Sir Edward Fry, who in his epochal work on the specific performance of contract says, a perfect system of jurisprudence, I'm quoting him, a perfect system of jurisprudence ought to enforce the actual performance of contracts of every kind and class, except only when there are circumstances which render such enforcement unnecessary or inexpedient, and that it ought to be assumed that every contract is specifically enforceable until the contrary is shown. What finally becomes apparent is that the 2018 amendment is part of a larger strategy to ensure that India's legal landscape is copacetic with the needs of international businesses, prompting trust and ease of doing business program, while also improving its own global economic standing. However, it also highlights the ongoing need for further reforms to address existing gaps and complexities, particularly when viewed through the perspective of foreign investors. I firmly believe that the time is ripe for engaging collaborative exchanges among jurisdictions built on mutual understanding and respect for cross-border legal frameworks. By creating an ecosystem where the sanctity of commercial laws in such countries who believe in the rule of law and is mutually recognized, we can pave the way for more seamless international trade and investment. Such cooperation would not only strengthen global legal harmony, but also inspire greater trust and confidence in transnational commercial dealings. With that, I conclude my remarks and hope that I have been able to throw some light on the 2018 amendment, which let us see in due course of time how it really gives a path, a roadmap for I would say, a very fast economic growth which we expect for the country because of the impediments created by the litigations arising out of different kind of contracts. I hope that at least in commercial contracts, the things would now become easier as far as the enforcement part is concerned. Thank you very much for giving this opportunity to me to share my view. Thank you.
Thank you so much, Justice Suryakant, for those enlightening words. We are ever so grateful for your presence at the third Law and Constitution Dialogue, sir. Let's extend our gratitude with a round of applause for Justice Suryakant. I also now request Dr. Aishwarya Sharma, Chairperson of the Sunday Guardian Foundation, to present the vote of thanks for our chief guest.
I would like to take this opportunity to thank our chief guest, Honorable Justice Suryakant, Honorable Judge, Supreme Court of India, for taking out time from his busy schedule and gracing this, this event on this very historic occasion when we celebrate the 75 years of the adoption of the Constitution. Your deep insight, sir, into the legal framework of different laws gives us pointers to dwell deeper. Thank you, sir, for your blessings and support for our initiative, Legally Speaking, which allows a discussion on law, thereby making law more accessible to a large body of people. Your insights about the expansion of judicial infrastructure, the ease of doing business, aiding faster disposal of cases, greater certainty for contract enforcement, as we position ourselves as a globally expanding economy, have been deeply influencing our approach to achieve judicial efficiency, which has improved greatly as per the 2018 report. Thank you, sir, for taking out time. Jai Hind.
Thank you, Dr. Sharma, for the vote of thanks. And once again, we thank Justice Suryakant for taking out time from his busy schedule to enlighten our live audience as well as our viewers who are watching us from their homes and online. The third Law and Constitution Dialogue, it would have been incomplete without your presence, sir. As I've mentioned time and again, we are ever so grateful for you to be with us today and share your thoughts on some very pertinent matters in modern India. Once again, Justice Suryakant, Honorable Judge, Supreme Court of India. Ladies and gentlemen, before we proceed for our next sessions, could we please quickly have a look and a glimpse of what Legally Speaking is all about. Legally Speaking is, of course, the thought leader behind the event today.
We are the mainstream media's dedicated platform to serve India's legal community.
एक देश, एक संविधान, एक झंडा. One country, one constitution, one flag. That is the core of our democracy. The legal community is the core of the core. We are here to build a community in the mainstream media for you, a platform for jurists, with jurists and by jurists. We are doing what it takes. Come join us and make this the go-to platform for serious news, views and conversations.
100 episodes of Legally Speaking have aired on NewsX, India's first and only primetime national television news show dedicated to the legal community. More than 100 dedicated columns published in the Sunday Guardian in print and online. more than 1,000 dedicated columns published in the Daily Guardian in print and online, with a dedicated website.
Today, law is a very popular profession. Today, a lot of people want to join the law.
We need to meet the parameters of the offences.
With deep dives.
In a constitutional court, there are lots of cross tensions.
We have to have very good trained mediators of established reputation.
With legal luminaries from across the world.
How much can a person be surveilled in the future? This is a role of court.
Unlike other countries, our two nations have a commitment.
In-depth biographical interviews.
I did huge number of cases.
For the first 3 months in Cambridge, I was a very active debater.
Full live prime-time telecasts of the Ram Jethmalani Memorial Lectures organized by Mahesh Jethmalani.
Overwhelming thank you to NewsX and the Sunday Guardian Foundation for not only telecasting live this event, but for the relentless publicity campaign that preceded it.
It has been a great honor reminiscing the legacy of Ram Jethmalani, one of the greatest of our times.
Hosting the Will of Steel Awards in the memory of Ram Jethmalani on his birth centenary year in 2023. The largest legal and public service journalism awards in the world, with the award winner receiving 12 lakh rupees. Full live telecast of the L.M. Singhvi Memorial Lecture organized by Dr. Abhishek Manu Singhvi.
The practice of democracy through universal adult franchise is not just limited to Delhi, but is happening in the remotest parts of India.
And the first Law and Constitution Dialogue hosted by Legally Speaking with Justice Surya Kant in 2022.
Media has a heightened responsibility due to the greater power that it enjoys, the power to shape the views and attitudes of hundreds of millions.
Live prime-time telecasts of the Justice J.S. Verma Memorial Lecture organized by Vivek Tankha.
Justice J.S. Verma, the iconic man of this place.
Our aim is to curate quality conversations with eminent jurists which take forward jurisprudence, also inform, educate, stir debate. This is what has been our aim at Legally Speaking. We also take up relevant issues from time to time that involve the future of the judiciary, also the court systems with eminent retired judges, also former ASGs, sitting ASGs, also eminent jurists. This is what we do on a weekly basis.
We welcome.
Because in the end, we need to restore and renew the logic of the mainstream media, which is to raise the bar.
Let us welcome to the stage Mr. Syed Nasir Hussain, Congress Rajya Sabha Member of Parliament. He will be joined by Mr. Rishabh Gulati, Editor-in-Chief of NewsX, to have a conversation on Constitution and the Waqf.
Nasir Hussain ji, pleasure once again. Thank you for sitting down to have this conversation.
Yeah, thank you so much.
I've known sir for a very, very long period of time. We've been sitting on television conversations. Very clear and forthright. Earlier spokesperson, now of course, Member of Parliament, the Rajya Sabha. Nasir Hussain ji, a huge debate is going on in this country based on the premise of the misuse of the Waqf board. What's your position on this?
What is that is being misused by the Waqf board? And then we have been asking this in JPC for long. What is it that is being misused? The entire Waqf Amendment Bill has been brought and based on the misinformation that has been spread by the BJP ecosystem in this country. Look at the accusation. They say that Waqf board can take away any land by just claiming it is their land. Can, in any democratic country, there can be a law through which any organization can claim any land as its own without relevant papers or without relevant documents? They say Waqf has 9 lakh acres of land, 10 lakh acres of land. I would say that 85% of Indian villages or 90% of Indian villages, there are Muslims. So wherever there are Muslims, there will be a masjid, there will be a qabristan, there will be a dargah, there will be a Eidgah, donated by someone or the other at some point of the time. So obviously there will be land. According to the proportion of the communities that are living in this country, there will be their religious places. There will be their properties belonging to religious places. So I think the kind of information that the misinformation that is being spread, that is something which we need to counter.
Secretary, but does the Waqf in principle have the powers to acquire or claim land regardless of private property or public property anywhere in the country?
See, Waqf Board doesn't have any power to register any land as its land, number one. First of all, Waqf Board in this country doesn't have even an inch of land which they can say it is theirs. All these properties or lands belong to a particular institution or a particular Waqf in a particular place. They don't belong to the Waqf Board. Waqf Board is only a supervising board kind of a thing or a custodian of these properties. They don't own any land. One. Two, every inch of land in this country can be registered only by the revenue authorities. It cannot be registered by the Waqf Board.
So what are the cases then? Are we mistakenly assuming things when, for example, in Kerala, we hear a case of the Waqf Board unilaterally claiming land? Is this an assumption or are these anecdotal cases only?
See, that is what. No? In that particular case, I am told that there is a judgment of the court which says that land belongs to the Waqf. I would like to explain here. See, in many of the states, especially in Karnataka, in Telangana, Tamil Nadu and all, there were acts like Land Reform Acts were there, Inam Abolition Acts were there, Land Sealing Acts were there. Through these acts, lands were taken away from lots of people, including Waqf, and redistributed among the poor and the farmer. But after that, there are judges in High Court, there are judgments in High Courts and Supreme Court saying that once a Waqf is always a Waqf, that nobody can take it. So that's the reason why the Waqf Board is claiming the land that was taken away by the government and given to some other person. So now it's a conflict between an act passed by the state government and the judgment passed by the court.
Okay.
So someone should step in, and obviously the state government will step in and say we'll implement both, and compensation will be given to either of them.
Okay. The other point of conflict is the Archaeological Survey of India. The Archaeological Survey of India says that there are more than 250 protected monuments under the ASI which are being claimed by the Waqf.
See, ASI, when they came to JPC, they had said it is 120. There's a newspaper reporting which says that it is 250. But the point is, if there is a masjid which was built about 300 years, 400 years, 500 years back, and worship, there is namaz going on in that masjid, and if the ASI says that it should be a protected monument, it can be a protected monument, but at the same time, the nature of worship or the nature of place can't be changed. So if the namaz is going on, it will be Waqf, and it will also be a protected monument. Something has to be worked out there.
Okay, this is not only an issue right here at the center, sir, it's also been an issue in your home state of Karnataka. What is the position of the Congress government in Karnataka on this?
See, Congress government is very clear. 1995 Act, as amended in 2013, should be implemented in toto. If there are any issues, that has to be sorted out by the authorities there in the government and in the bureaucracy.
In the end, sir, if there is an assumption being made that we want to take away governance or government, whether at state and center, from religion, when it comes to both Hindu institutions, temples where government rules, the Waqf you mentioned also has representation from government. Is government's business to be running religious institutions or religious properties?
See, no, it is not solely government business to run the religious institutions, but at the same time, there should be some sort of a monitoring by the government. It should be basically a democratic body. There should be elected people in that. There should be domain in-charges, domain specialists in that. There should also be government representatives to oversee as to what is happening there. Number one. Number two is that there is this misinformation being spread that there is only Waqf Board, there's nothing else for the Hindu community, nothing else for the Jain community. I think almost all the communities have some sort of an administrative structure in some form of the other. Every state has, say, in some state it is called as Endowment Board, somewhere it is Muzrai Department, somewhere it is Hindu Places Worship Act, somewhere it is Hindu Religious Places Act. It is there. 19-20 का फर्क हो सकता है. More or less the same powers are there for everyone. See, I am a Muslim, I am a member of JPC, I am a member of Work Board, I am an MP. I would say, let there be similar powers or similar provisions to all the boards of all the communities, and let them have the freedom of governing their own religious institutions.
Okay, I know our time is limited, sir, but you are a member of the JPC. The JPC has asked the Karnataka Yogalukta to submit a report on Waqf properties. Should it?
All boards in the country have been asked to, we have given them a list of queries. We have asked them to give us as to how many registered work properties are there, how many unregistered are there, in how many properties encroachment is there, how many has been sold out or taken away, how many disputes are there. I think most of the states have given that, some of the states are yet to give. And that will be one good information for the JPC to have an idea as to how many disputes are there, and disputes with whom, what is the nature of dispute is also very important, because if this kind of an information is being spread, that Waqf versus Muslim versus Hindu, Waqf is taking away Hindu land, Waqf is taking away that community's land and all. I think I would say I've been a member of Karnataka State Board of Waqf for the last 6 years. 99% of the cases of the Waqf Board are either with the Muslims themselves or with the government.
Okay, but there remains a perception which you are saying is being created by one particular party, but we'll have to see how it goes. Nonetheless, you're a member of the JPC itself.
200%, I would like to say this is the misinformation that is being created by the ecosystem of the Sangh Parivar and the BJP, only to polarize, to divide, and create an environment where they want to say, see, Congress or the other parties didn't have the guts to do this. This is what we are doing.
Okay.
The entire amendment, I would once again like to assert here, that is being brought on the basis of the misinformation that has been spread in this country through social media and the electronic media to polarize and to divide the country into different
Mr.
elections.
Jagdambika Pal, who's chairman of the JPC, will be sitting with us this evening for a contrarian point of view. Nonetheless, Syed Nasir Hussain, thank you very much for joining us.
Thank you.
Thank you so much, Mr. Nasir Hussain, for taking our time for this. I request Kartikeya Sharma ji to please present a token of our appreciation to Mr. Syed Nasir Hussain. With that, Kartikeya ji, I request you to please stay with us on stage as we welcome our chief guest, Shri Arjun Ram Meghwal, Honorable Union Minister for Law and Justice of India. Let us welcome Shri Arjun Ram Meghwal ji with a round of applause. I request Mr. Kartikeya Sharma to please now present a token of our appreciation to our chief guest, Shri Arjun Ram Meghwal. As India marks 75 years of the adoption of its constitution, we present to you a copy of the original constitution, Mr. Meghwal. Along with this, we take great pleasure in presenting to you a photograph of the first session of the Constituent Assembly held on 9th December 1946. Kartikeya ji, I please welcome you to the dais to welcome our chief guest.
Good evening, everyone. I'd like to take this opportunity to thank the Honorable Minister for Law and Justice, someone who we hold in very high esteem. And thank you very much, sir, for taking out time we know you have a very busy schedule, especially with the debate in the Parliament happening right now. But that goes to show that all the four pillars of the democracy are equitable, and you taking out time for this debate and this discussion is something that stands testament to the fact that not only the Parliament and both the Houses of Parliament will discuss on 75 years of completion of the Constitution, but as a responsible media house, we would also want to have the discourse and the debate over here in the public domain so that it can have the desired impact on one and many, because somewhere or the other, I think the Constitution, which is a living document, is the only piece of legislature that guides in the evolution of a democracy. And thank you very much, sir, because legally speaking, NewsX, India News, Sunday Guardian, Daily Guardian, the entire ITV network family, we want to not only extend a warm welcome to you, but also that we stand for what kind of a brand of journalism and how we want to address our viewers is sort of done by the kind of content we create and the platforms that we have created. Thank you very much once again for taking out time from your busy schedule to grace this occasion with your presence. Thank you very much, sir. Thank you, Arjun Megwal ji.
Thank you, Kartikeya ji, for those words. I now request Mr. Rishabh Gulati and Mr. Rakesh Singh to please join us on stage for another riveting conversation with our chief guest, Shri Arjun Ram Megwal.
आदरणीय मंत्री जी, हमारे साथ इस नीति और संविधान डायलॉग जो हम ऑर्गेनाइज कर रहे हैं उसमें जुड़ने के लिए बहुत बहुत धन्यवाद. फॉर पीपल वाचिंग दिस ब्रॉडकास्ट, सर इज आल्सो द पार्लियामेंट्री अफेयर्स मिनिस्टर, सो ही हैज अ वेरी हेक्टिक डे. तो मेरा पहला सवाल सर ये होगा, जो संविधान में पार्लियामेंट में लोकसभा में 2 दिन चर्चा आज शुरू हुई है, फिर राज्यसभा में 2 दिन चर्चा होने वाली है, ये क्या संविधान की तपस्या के लिए है, क्या कोई गंभीर मुद्दे भी हैं जो इस चर्चा से निकले?
देखिए, आपने बहुत ही शानदार एक क्वेश्चन किया है. 2014 में मोदी जी आए एज ए प्रधानमंत्री इस देश में. इससे पहले हमारा जो 26 नवंबर था, इसको हम कानून दिवस के रूप में मनाते थे, जिसको हम अंग्रेजी में लॉ डे कहते हैं. प्रधानमंत्री नरेंद्र मोदी जी का संविधान को सम्मान करने का विषय जब वो गुजरात में मुख्यमंत्री थे तब से था. तो उन्होंने कहा, भाई ये संविधान दिवस क्यों नहीं हो सकता. और जब बाबा साहब B.R. अम्बेडकर साहब की 125वीं जयंती थी 2015 में, तब 19 नवंबर 2015 को सोशल जस्टिस एंड एम्पावर्ड मंत्रालय से एक सर्कुलर जारी हुआ कि आगे से 2015 में तो हम मनाएंगे ही संविधान दिवस, लेकिन आगे से प्रतिवर्ष हम संविधान दिवस मनाएंगे. इसलिए ये मोदी जी का इनिशिएशन है, ये तो मानना ही पड़ेगा और देश को स्वीकार करना पड़ेगा. इससे पहले कहां था? मोदी जी हैज टेकन ए इनिशिएशन, तब जाकर के ये 2015 से हम संविधान दिवस मना रहे हैं. उस समय भी 2 दिन चर्चा हुई थी संविधान पे, पहली बार लोकसभा और राज्यसभा में, और लोगों ने समझा कि बाबा साहब B.R. अम्बेडकर साहब का कितना कंट्रीब्यूशन संविधान के निर्माण में रहा. इस बार कोई चर्चा का हमारा कोई उद्देश्य, ऐसा मुझे लगता है कि शुरू में जब सत्र शुरू हुआ था, मैं पार्लियामेंट अफेयर्स के नाते कह रहा हूं कि हमारे एजेंडे में ये नहीं था, लेकिन उनके एजेंडे में कोई अमेरिका में घटना घटी, उसको लेकर के आए और वो हल्ला करने लगे. फिर उन्होंने कहा, देखो हम चला सकते हैं. उन्होंने कहा अपोजिशन साइड से, आप संविधान पे चर्चा करोगे क्या? तो संविधान पे चर्चा करने में हमें कहां तकलीफ है. मैंने कहा कर लेंगे. तो दोनों बार BSc में उनकी ओर से इशू आए. हमने कहा हमारे गवर्नमेंट बिजनेस है, उनको आप करने दो. उन्होंने कहा नहीं, पहले आप संविधान पे चर्चा करो. तो संविधान पे चर्चा की डेट डिसाइड हुई, 13-14 लोकसभा और 16-17 आपका राज्यसभा. इसलिए सरकार संविधान पे चर्चा हो, कोई डिमांड आए, किसी भी दल से आए, तो सरकार ने स्वीकार किया. और आज लोकसभा में हमारे राजनाथ सिंह जी ने चर्चा शुरू की कि संविधान की जो हमारी ग्लोरियस जर्नी है वो कैसी रही है, और मुझे लगता है शानदार अच्छी चर्चा हो रही है.
मेघवाल साहब, जिस तरह से 1 नेशन 1 इलेक्शन की चर्चा है, आपने कैबिनेट से कल उसको जो है मंजूरी दिलाई है, उसको लेकर विपक्ष का तेवर तल्ख है. विपक्ष का साफ तौर पे कहना है कि 1 नेशन 1 इलेक्शन की जगह 1 नेशन 1 हेल्थ सिस्टम होना चाहिए, 1 नेशन 1 एजुकेशन सिस्टम होना चाहिए. क्या इसको लेकर क्या कहेंगे?
देखिए, वो हम अलग से आपको ब्रीफ करेंगे, लेकिन मुझे आपके माध्यम से उनको कहना है, क्या 1952 का चुनाव लोकसभा और विधानसभा साथ साथ नहीं हुए थे? 1957 का चुनाव साथ साथ नहीं हुआ था, 62 का चुनाव साथ साथ नहीं हुआ था, 67 का चुनाव साथ साथ नहीं हुआ था। आपने 71 में मध्यावधि चुनाव करवाया और उसके बाद 356 का जो आर्टिकल है राज्य सरकारों को गिराने का, उसका मैक्सिमम दुरुपयोग किया, इसलिए काल चक्र टूट गया और मॉडल कोड ऑफ कंडक्ट लग जाता है, डेवलपमेंट में भी दिक्कत आती है, गवर्नेंस भी बिगड़ता है। इसके लिए प्रधानमंत्री नरेंद्र मोदी जी ने 2019 में सभी दलों की एक बैठक बुलाई थी, आपको जानकारी के लिए बता देता हूं, सभी दलों के, और उसमें दल के कोई फ्लोर लीडर नहीं थे, जो दल के उनके अध्यक्ष थे, राष्ट्रीय अध्यक्ष, वो सब थे। उसमें कांग्रेस को छोड़ करके सारे आए थे, सबने स्वीकार किया कि ये अच्छा सुझाव है। उसके बाद जो फॉर्मर प्रेसिडेंट ऑफ इंडिया है रामनाथ कोविंद जी की अध्यक्षता में कमेटी बनी, उस कमेटी ने सबको सुना भी आप बताओ क्या इसमें खराबी है, और कई देशों में हो रहा है, इंडोनेशिया में हो रहा है, यूनाइटेड स्टेट में हो रहा है, कई देशों में हो रहा है, और इसमें गड़बड़ कहां है। लॉ एंड ऑर्डर आपका, जब पुलिस की जरूरत होती है, लॉ एंड ऑर्डर में चुनाव होता है तो वहां लग जाता है। तो ये तो एक बहुत अच्छा मुझे लगता है इलेक्शन रिफॉर्म का एक स्टेप है, इसको विपक्षी दलों का सहयोग करना चाहिए, इसका विरोध नहीं करना चाहिए, मैं ऐसा मानता हूं।
लेकिन मेघवाल साहब, जहां तक राज्यसभा में बात की जाए 163 जरूरत पड़ेगा 2/3 बहुमत के लिए, वहीं जो है लोकसभा की बात किया जाए 362 आपको मतों की जरूरत पड़ेगा, तो ऐसी स्थिति कैसे पूरा होगा, क्या आपको लगता है?
अच्छे काम के साथ अच्छे लोग जुड़ जाते हैं जी जुड़ते हैं, 370 में जुड़े ही थे ना।
मेघवाल जी, जो अभी डिस्ट्रप्शन चल रही है पार्लियामेंट में, अब ये रूटीन बन गया है, ये थर्ड टर्म है, सेकंड सेशन है, क्या किया जाए इसका? एज अ पार्लियामेंट्री अफेयर्स मिनिस्टर इसका हल क्या है?
मुझे लगता है कि कुछ लोग ऐसे हैं, कहीं बाहर बैठे हैं, जो इंडिया की जो इकोनॉमिक साइज है जो तेजी से आगे बढ़ रही है, उससे उनको शायद कोई पीड़ा हो रही है, ईर्ष्या हो रही है, या भारत में स्टेबल गवर्नमेंट क्यों है, कोई न कोई ऐसी षड्यंत्रकारी कोई एक्शन लेते हैं वो, और फिर उसको किसी न किसी मीडिया में छपवाते हैं, और उसके बाद हमारा संसद सत्र शुरू होता है उससे पहले उसकी खबर यहां आ जाती है। आपका हिंडनबर्ग रिपोर्ट क्या है, आपका पेगासिस की रिपोर्ट, मतलब उससे उसके बाद भी नहीं आती, पहले भी, बस उस जब सत्र शुरू होता है उसके 2-3 दिन पहले आती। इस बार भी ऐसा ही हुआ, तो हमें सावधान तो रहना ही पड़ेगा ना। जो इंडिया की इकोनॉमी को डिस्टर्ब करना चाह रहे हैं, ऐसे अगर लोग कोई चीज कहते हैं, फिर हमारे यहाँ आकर के लोग हमारे जो इंस्टीट्यूशन है उनको नहीं मान करके उनकी बात पे पूरा विश्वास करके यहाँ हाउस को चलने नहीं देते हैं, तो वो ठीक परंपरा नहीं है।
मेघवाल साहब, क्या खतरा,
यही हम उनको समझा रहे हैं कि ये ठीक परंपरा नहीं है।
मेघवाल साहब, खतरा क्या बाहर से है या अंदर से है, किस तरह खतरा आप जो है?
कुछ ऐसे लोग हैं जो बाहर की जो एजेंसी हैं जो भारत के विरोध में बोलते रहते हैं, वो कोई खबर छापते हैं उसको ज्यादा विश्वास करते हैं, ये खतरा है, और कोई खतरा नहीं है। बाकी देश एक है, मजबूत रहेगा देश, कोई चिंता की बात नहीं है।
मेघवाल जी, लेकिन अगर ऐसी षड्यंत्र साजिश होती हैं और भारत के अंदरूनी मामलों में केस अगर यहाँ हो नहीं हो हमारी एजेंसी डिसाइड करेंगी, न्यूयॉर्क में केस फाइल होते हैं, हम ऐसा क्यों नहीं करते हैं? हम फ्रंट फुट पे क्यों नहीं खेलते हैं? क्योंकि अगर हमें पता है और अगर आप पूरा आरोप लगा रहे हो कि ऐसे लोग हैं, ये षड्यंत्र साजिश कर रहे हैं, हम वापस उनको नाम से बुलाकर बोलते क्यों नहीं है कि आप ये षड्यंत्र साजिश कर रहे हो?
नहीं, जो हमारा प्रयास है वो हम करते हैं, लेकिन जो कानूनी उपाय है उस संबंध में भी हम गंभीरता से विचार कर रहे हैं। ऐसी बात नहीं है। जो उन देशों में क्या हमारी कंपनियों पर, उन देशों के क्या नियम है, उनकी कंपनियां भी हमारे यहाँ काम करती है, रेसिप्रोसिटी रहनी चाहिए। ऐसे जैसे अभी हमने इंग्लैंड से एक संबंध किया कि भाई यहाँ का वकील वहां प्रैक्टिस कर सकता है, वहां का वकील यहाँ आके प्रैक्टिस करे, तो बराबर के अधिकार में, रेसिप्रोसिटी के अधिकार में हमें कोई दिक्कत नहीं है, हमें कोई दिक्कत नहीं। लेकिन वन वे नहीं हो सकता है।
You're using the word reciprocity, डिप्लोमेसी में इसको इस्तेमाल किया जाता है। तो क्या मेघवाल जी आप कह रहे हैं कि अगर ऐसा कोई व्यक्ति या संस्था हो
जिसके अगेंस्ट करप्शन एलिगेशंस हो और उनका यहाँ पर भारत में कोई भी फाइनेंशियल लेना देना हो, तो हम भी ऑप्शन ओपन रखते हैं उनके ऊपर केस फाइल करने का।
देखिए, मैंने कहा ना, जो हमारे लॉज हैं बने हुए, पहले तो हम उसके तहत ही काम करेंगे, फिर अगर हमें लगता है कि कुछ सुधार की जरूरत है तो उस दिशा में भी आगे कदम बढ़ाएंगे।
मेघवाल साहब, राज्यसभा के सभापति के खिलाफ जिस तरह से विपक्ष ने नो कॉन्फिडेंस मोशन जो सिग्नेचर हस्ताक्षर जो दिया है, क्या आप मानते हैं कि विपक्ष का साफ तौर पे कहना है कि जो सभापति हैं वो विपक्ष की बात नहीं सुनते, सत्ता पक्ष के पक्ष में काम करते हैं, इस तरह की बात कहना क्या आप मानते हैं?
देखिए, राज्यसभा के सभापति, चेयरमैन राज्यसभा, उनके खिलाफ भारतीय संसदीय इतिहास में पहली बार ऐसा एक नो कॉन्फिडेंस मोशन आर्टिकल 67B के तहत विपक्ष लेके आया है। वो उनका अधिकार है, लेके आए, लेकिन लेके आने के बाद वो प्रेस कॉन्फ्रेंस करके उस प्रस्ताव की चर्चा क्यों कर रहे हैं? उपराष्ट्रपति जी पे क्यों आरोप लगा रहे हैं झूठे? अगर जब वो चर्चा में आएगा तब चर्चा करनी चाहिए ना, हाउस के अंदर है वो, तो दैट इज ए हाउस, दैट इज ए प्रॉपर्टी ऑफ द हाउस। उसको वो बाहर ले जाते हैं, प्रेस करते हैं, प्रेस करके, और इसका मतलब आप उपराष्ट्रपति जी के खिलाफ प्रस्ताव लेकर आए, उस पर आपने बाहर चर्चा शुरू कर दी, जो संविधान इजाजत नहीं देता। आज हमारे राज्यसभा में हमारी तरफ से बहुत लोग बोल रहे हैं कि भाई ये इजाजत नहीं देता कि आप उपराष्ट्रपति जी का सारे दोष ढूंढने लग जाओ, अपने ट्विटर हैंडल पे उसको डालो, ये आपको शोभा भी नहीं देता और संविधान इजाजत भी नहीं देता। जब वो 14 दिन के बाद चर्चा में आएगा प्रस्ताव राज्यसभा में, उस समय जो बोलना बोलिए। इसका मतलब विपक्ष जो उपराष्ट्रपति जी का एज ए चेयरमैन राज्यसभा बाय वर्च्यू ऑफ द पोस्ट उनका सम्मान नहीं करना चाहता, उनका अपमान करने की सोच रखी है उसने, जो ठीक दिशा में नहीं है।
मेघवाल जी, समय हमारे पास कम है, तो लेकिन दो छोटे सवाल और हैं। सबसे पहले सेंसस अब अनाउंस किया गया अगले साल के लिए, क्या इसके बाद डीलिमिटेशन एक्सरसाइज भी होगी, क्योंकि 33% रिजर्वेशन ऑफ विमेन इन पार्लियामेंट भी आने वाला है 2 साल में?
जो नारी शक्ति वंदन अधिनियम तो पास हो गया पार्लियामेंट से, जिसमें 33% रिजर्वेशन लोकसभा और राज्यों की विधानसभाओं में रहेगा। 2026 तक हमारा डीलिमिटेशन को संविधान के द्वारा ही फ्रीज किया हुआ है, हमने नहीं किया। हमसे पहले जो शासन करते थे उन्होंने कहा कि 2026 तक कोई डीलिमिटेशन की एक्सरसाइज नहीं करेगा, तो 2026 के बाद ही ये सारी प्रक्रियाएं शुरू होगी। सेंसस आपने ठीक कहा कि इसमें हम डिजिटली सेंसस करने का प्रयास करेंगे, और सेंसस जैसे ही होगा उसके बाद एक डीलिमिटेशन आयोग बैठेगा। वो डीलिमिटेशन आयोग 2026 के बाद, क्यों 26 तक तो फ्रीज किया हुआ है एज पर कॉन्स्टिट्यूशन, तो 26 के बाद जब वो डीलिमिटेशन आयोग कौन सी सीट महिलाओं के लिए रिजर्व होनी चाहिए, कौन सी सीट अभी जो एससी की है क्या वो एससी की रहे या जनरल हो जाए, कौन सी सीट एससी की है वो एसटी की करनी है, या कौन जगह एसटी की पॉपुलेशन बढ़ गई जहां जनरल सीट है उसको एसटी की करनी है, ये सारी एक्सरसाइज वो डीलिमिटेशन आयोग करेगा। निश्चित रूप से ये कार्रवाई होगी, और अगला जो चुनाव आएगा तब जो नारी शक्ति वंदन अधिनियम है वो लागू होगा, और महिलाओं को 33% लोकसभा में और विधानसभा में रिजर्वेशन मिलेगा।
मेघवाल साहब, एक सोशल मीडिया से लास्ट में मैं क्वेश्चन मैं हर बार पूछता हूं, सोशल मीडिया पे जो एक ट्रेंड कर रहा है कि कानून मंत्री और पार्लियामेंट अफेयर्स मिनिस्टर हैं, तो एक सवाल जरूर पूछने के लिए कि जो बांग्लादेश में जो स्थिति है, आखिरकार बांग्लादेश को लेकर सरकार को जो इस पर रिएक्शन होना चाहिए, उससे जरूर जो है आप मंत्री जी से पूछिएगा कि आखिर सरकार चर्चा क्यों नहीं कराने के लिए, जो विपक्ष भी कहता है, लेकिन ये सोशल मीडिया का प्रश्न है, मैं पूछ रहा हूँ।
विपक्ष इसमें चर्चा कहाँ चाह रहा है? विपक्ष तो किसी और पे चर्चा चाह रहा है, विपक्ष तो इसमें आलोचना ही नहीं कर रहे हैं। बांग्लादेश में हिंदुओं पे जो अत्याचार हो रहा है उसमें विपक्ष आलोचना ही नहीं कर रहा है।
हाँ, आलोचना नहीं।
मैं आपकी जानकारी के लिए कह रहा हूँ। देखिए, ये दुर्भाग्य है कि बाबा साहब अम्बेडकर को हम याद करते हैं, लेकिन संविधान जब बन रहा था और जब ये देश के 2 बंटवारे हुए, ईस्ट पाकिस्तान वेस्ट पाकिस्तान के नाम से पाकिस्तान देश बना, एक भारत रहा, उस समय भी बाबा साहब ने कहा था कि ये बांग्लादेश में और पाकिस्तान में जो माइनॉरिटीज रह गई हैं, हिंदू विशेष करके सरदार कम्युनिटी के सिख लोग, उनके साथ ये अत्याचार कर सकते हैं। इसलिए आप थोड़ी अदला बदली का जो प्रस्ताव है ना जनसंख्या वाला, उसको आप लागू कर दो। उस समय भी कहा था उन्होंने। आज बांग्लादेश में जो अधिकतर जिनके साथ, जिनको हम हिंदू भी कह रहे हैं, अत्याचार हो रहे हैं, वो मतवा समुदाय के लोग हैं। वो कहते हैं श्री हरि बोल, ये हमारा वाक्य हम बोलेंगे। वो कहते हैं श्री हरि बोल, यहां मत बोलो। ऐसा थोड़ी होता है। लेकिन सरकार बहुत चिंतित है और सरकार कार्रवाई, जो अपेक्षित कार्रवाई, सरकार कार्रवाई कर भी रही है।
Mantri ji, it's one of the toughest jobs in Parliament, which is to try to get consensus to keep Parliament functioning, which is the Minister of Parliament Affairs. Being Minister of Law and Justice is another tough job. Thank you very much, sir. आपने इतने busy Parliament सदर के बीच में हमारे लिए समय निकाला। बहुत बहुत धन्यवाद।
Thank you.
Thank you very much.
धन्यवाद सर।
Thank you so much, Arjuna Meghwal ji, for joining us at the third Law and Constitution Dialogue. I now request Shri Kartikeya Sharma to also please present the vote of thanks.
Actually, it is supposed to be Aishwarya who does the vote of thanks because I had already introduced the Honorable Law Minister. But sir, I would like to take this opportunity to thank you profusely. You have really been... You all, so I'll hand it over to Aishwarya. This is the right person.
I would like to take this opportunity to thank Honorable Law Minister and Minister for Parliamentary Affairs for gracing this occasion as we celebrate the 75th year of the adoption of the Constitution of India. It has given us a great opportunity to discuss crucial issues that are central for our great country, and the Honorable Minister has been kind enough to take our questions and be there to support this occasion and support Legally Speaking, NewsX and ITV Network. Thank you, sir.
We once again extend our gratitude to Shri Arjuna Meghwal ji for joining us at the third Law and Constitution Dialogue.
Ladies and gentlemen, as the founder of the ITV network, Kartikeya Sharma, also Member of Parliament Rajya Sabha, escorts the Union Law Minister out. Let's prepare for our next session, which is on digital arrests and cybercrime. We have some very interesting panelists in this, including Mrs. Jasinder Sehgal, who's been a victim herself of digital arrest. To put perspective, we have Dr. Muktesh Chandar. He's the former DGP of Goa and a Special Commissioner of Police. We also have Shri Hemant Tiwari, who's DCP IFSO, who's joining us on this conversation, as well as Shri Pavan Duggal, who sits with us very often on television to discuss this. It's become a very ever-present crisis. Could I request Muktesh ji, Pavan ji, and Shri Hemant Tiwari to kindly come on stage. Ladies and gentlemen, we've all been through it. We are all seeing it, these spam scams that are going on. I'm sure you're getting phone calls also. What do we do about them? Let's have this conversation. Our senior news editor, Devika Chopra, is conducting. Devika.
Thank you so much, Rishabh, for that. As Rishabh mentioned, this is, of course, becoming a menace. Day by day, we're hearing more and more reports and cases every day. In fact, while we were reading up on it, we found out that there were 42,000 cases of digital fraud that were reported last year, of which 9.45 crores was recovered. Indians have lost 120 crores in digital arrest frauds in just the first 4 months of this year. And these are all reports that have literally come out today. The Home Minister has presented this data as well. Karnataka, meanwhile, lost 109 crore in just 641 digital arrest cases. So this, ladies and gentlemen, is truly a problem of the hour. What we have to realize is that today more and more people have access to mobile phones, and as many people also have access to the internet, which means that they're easily connected via apps like WhatsApp. And I have with me Jasinder Sehgal ji. She is a 79-year-old woman. Ma'am, am I correct? She's 79 years old. And she was under digital arrest for 5 days. 5 harrowing days. When I was listening to her tale outside, I was extremely shocked and extremely worried for this rising trend. So I will begin by asking Mrs. Sehgal, if you can just explain, ma'am, to our viewers watching and everyone else, perhaps our lawmakers who are also watching, Parliament is on session, maybe this will come up. What exactly happened to you, ma'am? Who called you? What did they say?
Well, a digital arrest is you get this call and they ask you your name, they give you the Aadhaar number, and they ask you to verify it. So which you do. And then they tell you that there is a warrant of arrest for you within 3 hours, and you are involved in child trafficking, you are involved in money laundering, and you're taken aback, you're shocked. You deny it, and you keep on denying it, then it is a public prosecutor or a crime branch.
So you were called, essentially you were called.
I was called.
And you were told that the call is being made by the Enforcement Directorate, the ED.
Absolutely.
And that you were charged with child trafficking. Ma'am, can you explain to our viewers what exactly happened next? What did they tell you?
They told me that you are involved in child trafficking, 400 children, and 400 children, and you have got 3.1 crores in the Chennai bank, money laundered money, and you have 3.5 crores in the RBL bank in Delhi. So I deny it and I say I have no knowledge of any money there. I don't know these people, but I do have an RBL account. So they tell me we have in our custody Mr. Anil Deshmukh, who is the prime witness, and there are 3 others, and they send me photographs on the phone. Just to tell you that when there is a digital arrest, your phone is connected to them all the time. You cannot disconnect. So they send me pictures of these people and they say, we have the evidence, we would like to help you, and because you are 79 years old, if you can clear your name, we will help you. And then from there, I don't want to go into unnecessary detail. There's a prosecutor, there's a Supreme Court judge, and there are various people who scare you, frighten you so much that...
Just take a moment, ma'am. See, this is what, viewers, we really have to understand that this is going to be a huge problem if this is not addressed. And you can see the way in which people are being terrorized. There's not a singular pattern. It's from young people to the elderly, but mostly the elderly who are being terrorized, literally, by these cyber criminals. Jacinderji, I'm going to let you gather yourself.
No, I want to tell you that I live alone in a farmhouse. I don't have anybody with me. My children are not living with me. So for me, it was doubly scary.
And they told you that they've surrounded your farmhouse?
Yes, they frightened you. They tell you the ED, the police is outside your house, your telephone is hacked. You cannot, if any call you make, they tell you all kinds of things which you believe. That is the most horrible thing about this thing, is that you believe them completely.
Absolutely. Let me bring in, I'll come to you in just a moment, man. Pawan Duggalji, let me bring you into the conversation. Where exactly are we then failing as far as our systems are concerned? Do we now need to perhaps hold some sort of, or launch campaigns to generate awareness? Because really the prime target in most of the cases, which even I've read, were the elderly.
Clearly, we are at a time when fear and panic have become an integral part of our lives post-COVID-19. And therefore, it's not just her, it can be you, me, anyone. And now the latest trend in these cases is, one of our clients has lost about 6.4 crore rupees thanks to a digital arrest. But the latest flavor they gave was, well, we've got sharpshooters around your entire house.
Yes.
You try to act funny, we will shoot you and your entire family down.
Imagine.
Now, that's the position once you come in. You quickly realize, I have nothing more to do, let me give the entire money and come out. So bottom line is, most of the time, people are forgetting that the empowerment tool lies in their own hand, which is to disconnect the call. Now, let's start understanding basic common sense. No police officer is going to reach out to me in my home or in my office on a video call. No Chief Justice of the Supreme Court of India is going to be on a video call just to call me up and say, look, I'm passing this order against you. Most of the time, people are losing their common sense. Why? Because they are fearful.
Yes.
Somewhere down the line, everybody has to hide something in their lives. And they quickly realize, maybe this is the golden moment that's coming where my skeletons are going to come out. So let me try to avoid that and buy peace by actually giving money. They quickly leave aside reason, come up with this. Therefore, capacity building is more important. People need to be told there's nothing known as digital arrest in the Indian law. The law says arrest is a physical phenomenon.
Yes.
You go to physically a person, arrest him physically. However, thanks to this new Bharatiya Nyaya Sanhita 2023, which has come from 1st of July 2024, these cyber criminals have been very successful in creating this new narrative, this new myth, that now the new criminal laws have come in. The new criminal laws allow you to be digitally arrested using technology. And if you try acting funny, you will have to face consequences for ED, for the IT Act, for the Bharatiya Nyaya Sanhita. Most of the people are able to buy this particular fiction of narrative. Therefore, capacity building has to be your only mantra. People have to be told, mind you, now we have entered into a new cyber world era, where you will have to start inculcating an element of distrust and mistrust in your minds. Let's learn to start suspecting every information that I'm seeing, reading or hearing, till such time I've not independently verified the authenticity or veracity of the same. And the cyber criminal laws, there's nothing known as digital arrest. They know there's no provision under the Information Technology Act, there's no provision under the Bharatiya Nyaya Sanhita. You try coming up with indirect provisions and you land up in the current mess where Indian cybercrime ratio, conviction ratio, is less than 1%. Not any case of digital arrest has even now reached the court of law. Leave aside any conviction.
But Pavanji, do we have the technology or the skilled manpower then that is required to operate our systems in this day and age, where cybercrime is at an all-time high? Do we have the technology to track where those calls are coming from, who's making it? And I'll come to another interesting aspect regarding the banks. But before that, I just want you to address.
Well, we are having some technology, but cyber criminals are today 50 steps ahead of us. And this is thanks to artificial intelligence. Now they're using new programs now like Fraud GPT, whose only job is to let you know how they can commit new kinds of innovative frauds that have not yet been committed in human history. But by and large, I'm finding the gap between the current capacities of the government and the cyber criminals constantly widening. And because cyber criminals are now using technologies like virtual private networks, scrubbing their footprints, ensuring that the electronic footprints are not available, also ensuring that the relevant incriminating electronic evidence is tampered, altered for all times to come so that there can be no conviction in a cybercrime matter. These are all elements which are contributing. Our capacities need to be tremendously enhanced. We've got some brilliant officers, but I think as a nation, we are lagging far behind. And I think we have to make them realize that this is now going to be a constant phenomenon. The golden age of cybercrime has arrived. And this golden age will be with us for the next many decades. So the more quicker we are more prepared to deal with this, the better it is.
And unfortunately, we used to think that it's things like WhatsApp University or fake messages in AI, that will be the doom of society. But truly, this is perhaps one of the bigger problems. Jacinderji, I want to come back to you, ma'am. I want to understand from you. You also mentioned that your bank didn't really extend any help as far as your case was concerned because you were making or you were made to make large transactions in a very small amount of time. Now, why that is peculiar is because someone like me, who perhaps would make a 20 or 30,000 transaction somewhere, I actually promptly get a call from my bank saying that this is an unusually high number, or say 50,000 or maybe 1 lakh. And they give a prompt call that, is this you making this transaction? But how much money was extorted, ma'am? And did your bank really reach out or help?
My bank was sleeping when this happened. I sent 45 lakhs to a MYK Enterprises in Solan. I sent 2 crores to a Syed Mars in Bangalore. And I sent OP Malhotra in Solan another 65 lakhs. These transactions were done one after the other. And the bank knows me for the last 12 years. I have never in my life dealt with any such people. I don't know them. They're dubious, suspicious accounts. I mean, they are so suspicious, just their names are suspicious. And the bank did not even stop to scrutinize and see where they were going, what was the KIC, why was I sending. I did not get any call from the Ratnakar Bank Limited, RBL, till I collapsed, and my daughter was informed in Cape Town, and she called the bank. And they said, oh, has that happened? Then she has been scammed. I mean, this is no bigger letdown than that from a bank where I have a relationship manager who knows everything about me, and there were no checks, no balances, no signals, why this money was going out. I had left the mandatory form. In that RTGS form, there was a mandatory column which said purpose of remittance. I had not put in the purpose of remittance. Then how were they sending this money? It could have been for money laundering, it could have been for anti-criminal activities, anything. I have been let down very badly by the RBL Bank, and they now don't even want to talk to me. They're saying it's your fault, you did it, we are not responsible.
Hemant Tiwari ji, sir, you actually took out some details of ma'am's case before you came here. How does then one deal with the bank in this system? Because like I said, most of us do get prompt messages or calls from our bank the moment they suspect some suspicious activity. The reason why I'm asking that is, does this somewhere then tell us that there are moles within the larger system? Are there people who are leaking information? Are there people, because it's a very well thought out plan, right? You know that a Jasinder Sehgal lives alone in a farmhouse. You probably know that she doesn't have her children with her. So clearly the targets are very specific. But how is this information really even reaching these cyber criminals? Do we need to have a larger conversation about the entire system?
We have been dealing with such cases for about a year. The digital arrest first case, I think, came to our notice somewhere in March. So it is around 8-9 months. And as per around 40 cases we are investigating, there is nothing to say that victims are well researched and targeted.
Okay.
You must understand that the scamster, they are kind of running an industry where their job is to call anyone and everyone whose number they have. Number goes through various channels because the data security protocol are very weak. If we are going for shopping or anywhere, we are easily giving our number. We are doing some transaction. Let's suppose we went to some shop, purchase something, we gave our number and we did a card transaction.
Yes.
So these three details came to them, that particular shop or restaurant, and from there it get leaks. So they randomly call everyone, they send the email to everyone, which all emails they have, which all numbers they have. Now who are the target? Number one, those who pick up the call, they become susceptible. And second, after picking up the call, mostly these calls are IVR generated, where some computer voice will say that we are calling from TRAI, and there is an important notification about your number. For further detail, press 9. Or we are calling from Mumbai Cybercrime or Customs or DHFL or some courier company, there is an important notification, you press 9. If we are aware that we have nothing to do with these people, we should not go for any further conversation and we should cut the call short. But still, if we go, then we become further more susceptible.
Yes.
Those scamster does not have much of our information. Actually, they might have our number, our name, at max Aadhaar number if we have shared it somewhere. From there, they start talking to us and they extract all the information and most of the information from the victim itself. And then, after extracting the victim, first they try to threaten the victim like anything on one pretext or other. And secondly, they take the information about the near and dear one, like if ma'am is there, their sons, daughters, sisters, brothers, and they try to find out what they are doing. Let's suppose a call like this comes to some rickshaw puller or not so well-to-do person. So as soon as the scamster realizes that this person is not capable of extracting money, they themselves will cut the phone and they
Okay.
will go to the another victim or another
Right.
call. So once they realize that this is the potential customer for them or potential victim for us and they can extract money, then they start threatening. Sometimes they threaten for themselves, but most of the time they threaten for their near and dear one. Because if someone is coming to arrest me, I may face it. Okay. If someone is coming to arrest me, she can think, okay, I will face it. If I have done something wrong, I will face it. But they will threaten you like your son, which you yourself have told that he is working in US or he is working in Merchant Navy. So they will threaten, yes, your son is there, and if you are not
Okay.
cooperating with us, so the particular police will come and arrest the son. So they
Yes.
try to put you under pressure for your near and dear one, and then they extract the money.
Okay.
And then it comes to bank parts, how the banks are involved. You asked that.
Yes, I'll come to that in just a moment, but I want to bring in Dr. Muktesh Chandar into the conversation as well. Dr. Chandar, Jacinderji, what was the total amount that was extorted?
3 crores 10 lakhs.
3 crores 10 lakhs. That's not a lousy sum of money that one can just forget. And I want everyone to remember that. But Dr. Muktesh Chandar, I want to understand from you. There's a very important and necessary digital India movement that is on right now. These are some of the drawbacks of what happens when we have more and more access to the internet. But how do we solve or perhaps come up with a solution for the problem of digital arrests without hindering people's faith and confidence in digitalization?
First of all, let us understand that there is nothing digital in digital arrest. This whole concept is wrong. It is pure extortion. No cyber means are used. It's a call. You are threatened to such an extent that you lose your balance of mind. It is called hacking of human mind. So they know that this is the way you can be threatened, and then you only transfer the money to their accounts, like in the name of Reserve Bank of India or somebody. The problem is that at that time, as Dr. Dugal was mentioning, awareness. There is no such thing called digital arrest. Then and there the thing should stop. Suppose they are saying deposit the money in this account. These accounts are of the firms, not Reserve Bank of India. Reserve Bank doesn't seize money like this. No police officer seizes it like this. So these telltale signs are from the very beginning available. The problem is that the legal awareness or the basic awareness about the rights, your rights are not there. And at that time, I have seen victims where they put you in such a threat as if a gun is on your head and you
Yes.
lose your sense of mind. The simplest solution is to cut the phone. And another thing I want to tell you is very important here, which probably is missing in most of the conversations I'm seeing this. Why is that an educated person, legally aware person, or an IT savvy person gets threatened because of, in the name of CBI, or in the name of ED, or in the name of crime branch, Mumbai police or Delhi police or whatever, is that perhaps there is some kind of fear about these agencies also in the minds of the people. That suppose you have not done anything wrong, there is no narcotics, you have not done any child trafficking. Why should you worry? You should have this confidence as a citizen of India and faith in the criminal justice system,
Yes.
that if I have not done anything wrong, nothing is going to happen. But that fear is there of these agencies. So how do we generate that kind of confidence? That lies on everyone in the system.
Yes, I completely understand your point, and everyone thinks about this, that why is it that educated people are also falling for this? But as Jacinderji pointed out, a lot of times you are threatened, literally you're told we've surrounded your house. So even if you know that this is something that's criminal, that's happening with me, what will you do? Because you can't really verify the veracity. Pawan Dugalji, you have 30 seconds, sir. Unfortunately, you have to wrap up. But I want to understand from you, does this then call for some sort of an emergency mechanism to be put into our phones? Like we have an SOS button, or we have numbers like 112, etc.
112 is there. There is no need for any other number.
No, but since you can't call, you can't cut the call because there's a fear that's placed in you that you'll be shot or that we'll come into your home. So what is it that we need to do? Some sort of SOS mechanism needs to be introduced. What would you suggest?
I would suggest some kind of a mechanism, but ultimately focus back on awareness and ultimately
Yes.
make banks responsible. At the end of the day, money is going via my bank account into somebody else's bank account. Bankers cannot say, hold on, I have done nothing, you are responsible, you go to the cleaners. Sorry, you are an intermediary under the Information Technology Act. You are mandated to exercise due diligence. You've not done that. Under the IT rules of 6th of July or 6th of April 2023, you are now mandated to even ensure that your users go ahead and do not violate the provisions of the law. And at the same time, we have nothing as far as the Reserve Bank of India is concerned on norms for these bank accounts, for the purposes of grading bank accounts. Ultimately, most of this digital arrest money is going into Indian bank accounts located within India. So the
Yes.
banks can be made responsible, accountable. Let them get the monies out of their kitty to the affected victim. That could be a good starting point going forward. We will see a massive diminishing of these so-called returns from cyber arrest, but ultimately, till such time that happens, that's onus is on the government, onus is on Reserve Bank of India, but right now, the focus is on us. Let's learn to protect ourselves. We are at the center of the digital Kurukshetra. We are going to be attacked on a 360-degree view. Let's come and try adopting cybersecurity as a way of life, cyber prudence and cyber hygiene to guide us.
That's an excellent
Let me
thought.
add here
Yes.
that there is a 112 app available. You can, while you are under digital arrest, so-called digital arrest, you can still invoke that 112 app and the police will know your coordinates and they will come to assist you.
That's an excellent thought, and hopefully it's been educative for the people.
That is what I am saying. 112
This is
app
what
will
he's
still
addressed.
work while you are connected to a Skype call or a WhatsApp call. 112 will still work.
Okay, Jacinderji, 30 seconds, ma'am, for you to conclude the conversation.
Yeah, after having gone through this experience, I think the banks are the only ones who can stop this because they know very well that customers don't send out money in 50 lakhs, 70 lakhs and crores in 3 days. It is for the bank to stop these scamsters. And I don't think there's any better solution
We are
than
missing
that.
the KYC norms of mobile phones also. KYC norms
Yeah,
of data
yeah.
and KYC norms of these current accounts.
Absolutely.
They are not individual accounts. They are in current accounts where large money transaction can take place without suspicion.
Yeah.
Some excellent points there raised by all of our panelists. Once again, we're extremely grateful to you for taking out your time to join us at the third Law and Constitution Dialogue. A very pertinent conversation. Ladies and gentlemen, please, a huge round of applause.
I also had the call from DHL couriers calling some scandal. I don't know how these guys get their phone numbers sorted, how they get bank accounts sorted, UPI transactions sorted when all of us have to go through KYCs. Nonetheless, I'll request Priya Saigal, Editorial Director of NewsX, to kindly come on stage and give away the mementos to our guests. All of them will be getting a copy of India's Constitution, because we are here, of course, to mark the 75th anniversary of the adoption of India's Constitution. Let's have a round of applause, ladies and gentlemen. Ladies and gentlemen, we have jam-packed back-to-back sessions after this. Justice Mukul Mudgal is joining us. After that, we have Justice Sanjay Kishan Kaul. After that, Dr. Abhishek Manu Singhvi, then Shri Manish Tiwari. So it's back-to-back, so don't go anywhere as we get set up for our next session. To Ms. Sehgal, ma'am, be in touch with us so that we can track your case as it goes forward. Thank you very much. Thank you very much, Priyaji. Thank you very much to all our guests. Thank you very much for joining us. With that, ladies and gentlemen, let me request Justice Mukul Mudgal to kindly come on stage. He's going to be discussing sports governance in India. He's, of course, the former Chief Justice of the Punjab and Haryana High Court and Chairperson of the FIFA Governance Committee. Megha Sharma, Executive Editor of NewsX, will be conducting the conversation. We'll be hosting. Yes, sir. Sir is going to speak about reforms in law, and I believe he's given a lot of technical questions to Megha. So this is going to be a technical session. Looking forward to it, sir.
Thank you so much, Justice Mukul Mudgal, for taking out the time and speaking with us on the third Law and Constitution dialogue that we are holding over here. Let's dive straight into it. We're talking about reforms in law, you're talking about arbitration, and you know, there need to be prosecution on a number of issues that you have raised these grievances. So you spoke to me just a moment ago about the abolition of Order 21, and where you talk about, you know, execution that takes longer than the actual lawsuits in the court.
Look, I'm happy that Justice Kaul is here, who's done a lot of original side practice, so he will certainly know what I mean. You see, the battle of a person who succeeds in a suit, who is called a decree holder, starts really when the execution proceedings take place. And execution can take very long because it goes to another judge, not the same judge. If you abolish Order 21 and say that same judge who has passed the judgment shall enforce it not later than 60 days, that will clear a lot of barriers.
Okay. And then talking about these false affidavits and how there needs to be prosecution on these false affidavits. You could give me a detailed account of what are these lacunae that have to be filled?
Look, there are routinely affidavits which are filed, which are false, to the knowledge of the deponent. Of course, sometimes the lawyer is also responsible. If prosecutions are resorted to which are available in law, then it will have a deterrent effect. It will have a deterrent effect, and it will lead to less litigation and faster litigation.
And you've spoken about also, you know, false pleas. You said that courts should award heavy costs for all these false pleas that are piling up in the courts.
Yeah, if false pleas are resorted to, then 1 minute. If false pleas are resorted to, then the court must impose heavy costs. It would be a deterrent. No point saying 500 rupees, 1,000 rupees cost. Some people delay the proceedings, especially the
I'll
defendants.
just request you to keep your mic a little closer to your mouth.
Defendants delay the proceedings, and I think if heavy costs are imposed for false or wrong statements, it will lead to a expeditious disposal.
You also want to bring to focus the case of arbitration. You talk about, you know, lawyers have a long time because they're first attending the courts and then they are figuring out the arbitration cases. So you spoke to me and you told me that, you know, the hours should be designated from 11 a.m. or 10:30 a.m. to 4 p.m. for the arbitration cases to be heard.
What happens is a lot of delays caused by lawyers who appear in court also appear in arbitration. So there's always a problem. Sometimes they say my case is reaching in Supreme Court or the High Court, and the courts would generally be, the arbitrators would be generally reluctant to dismiss a case on that ground. So it gets adjourned. Secondly, the lawyers who have court cases and arbitration like to come only at 5 o'clock. At that time, most of them are tired, and sooner or later, the arbitral proceedings get adjourned. So if you restrict arbitrations to Monday to Friday and from 10:30 or 11 to 4, you'll see a lot of expeditious disposal.
Right, absolutely. You also spoke about Section 34, challenge to the award. Section 34, challenge 34, challenge to the award.
Yeah.
If you could describe to us what exactly it is in
You
layman's
see, what
terms.
happens when an award is passed, the remedy for a dissatisfied party is to go and challenge it in a court under Section 34. Barring 4 or 5 high courts which have original jurisdiction, all these awards are challenged in district and sessions court, civil judges court. Now, you see, civil judges, those judges of the district judiciary would be very reluctant to interfere in an award. Supposing I, as a former Chief Justice of Punjab and Haryana, have passed an absurd award, the district and session judge who hears the challenge would be very reluctant to set aside my award, he just adjourn it. That's how the matters keep on getting delayed. Okay.
So what could be a measure to
All-
not let this happen?
All challenges in all states of India must lie before the High Court, Section 30. That will certainly improve.
Okay, all right. Then again, talking about counterclaims, you say there is no fee involved in an individual or a client counterclaiming to the claim that has already been filed.
Sometimes, or most of the time, what happens is a claim is filed, and the defendant who is defending the claim files a counterclaim. The purpose largely, in many cases, is to delay the proceedings, because counterclaim also takes time. And the party which is stronger financially and economically, doesn't matter to it a delay, but somebody who's claiming amount with a smaller party will certainly be hurt by such a thing. And therefore, if there is a claim and a counterclaim, ask them to pay arbitral fees according to the quantum of the claim or the counterclaim.
Okay, and let's also talk about the Plea Bargaining Act. You've spoken about how it should be modern and practical for all parties to be advantageous, to take advantage of it.
This Plea Bargain Act, I think, was enacted, mostly forgotten. I don't think anybody uses it. You see, I'll give you an instance. There is a fight in the neighborhood. Two groups clash with each other. There are some injuries. Later on, the elders of the area get the matter settled. But there is a precept which says, no, it's an offense against public morality. It cannot be handled. I think it's time we moved on from such dated concepts.
All right.
Have a modern, practical and sensible Plea Bargaining Act.
Talking about plea bargains, and then there are hundreds and thousands of people who have been charged and prosecuted in court. They are languishing in courts. And
Before
they do
we
not
pass on
have
to
the,
that,
yeah.
there's one more thing I'd like to say about arbitration.
Yeah.
Is, there is a recent judgment of Kalashnath versus DDA,
Yes.
which says that the damages have to be actually proved. I think this is based on a Maula Baksh, which is the judgment of 60s. And the economic times have changed completely. My view is Kalashnath needs to be revisited, where two corporates have entered into an agreement and have specified the damages in event of a default. I don't think the arbitration should go into that issue. Should award, I think Justice Kaul is sitting here, he would know that proving of damages takes a long, long time, and matters.
Right, okay. And then coming to, use of Probation of Offenders Act.
Yeah, that also is very important.
Yeah.
Again, a forgotten act, there are small offenses, people are serving jail time, sometimes more than their maximum period. Therefore, I think it's necessary to have Probation of Offenders Act more rigorously. It exists on statute, but hardly used. And lastly, there are under trials who get bail, but cannot furnish the financial security. There's a judgment of Justice Krishna Iyer, which clearly says that in such a case, personal bond is enough and bail should be granted.
Okay. Now I also want to focus on the other role that you are fulfilling currently, which is the chairperson of the FIFA Governance Committee. If you could shed more light into what all goes into you chairing this committee, and how does the world of sports governance look like?
Chairing the committee is the usual thing. You listen to some 11 people in the governance committee, some very learned, some not so. So you have to listen to everyone, but then you have to take a firm stand. That is how I think works. There are 211 countries governed by FIFA, which I think more than the United Nations has, because of various reasons.
And also you were also appointed as the chairperson of the Ethics and Governance Committee of Kho Ultimate.
But nothing has come to me as yet.
Okay. And I want to overall generally talk about the sports governance evolution in our country.
You see, lots of efforts have been made. The sports code came into being. Then sports law was suggested by a committee headed by me. But it's still in limbo, in the sense that you see, this sports law, sports governance needs certain reforms, such as term limitation, such as, practices of disclosure of, it's called a third-party declaration. That should be there. There are various things like this, too long to go into, which should be there in every sports association. There are, BCCI has its faults, but still the best governed sport body in the country.
Yes, I absolutely was coming to that. BCCI, the most powerful, the richest cricket body across the globe, and which is in India. But barring BCCI, we have not seen any progress, whether it is in the field of football or basketball or tennis. Do you think India has, at this point of time, the potential to have more of such sports bodies that are going to be, then setting an example for the rest?
Look, football in Melbourne Olympics, we finished 4th. We were semi-finalists, lost to Yugoslavia or Czechoslovakia 3-1, which was a great performance. Unlike boxing, where our medals are given to both the losing semi-finalists, here it wasn't given. But from there, we have slid down to 134 in the world rankings. Now they're near 100. It's improving, but we need to pay a lot of attention to development of youth, have football academies, because football is the world's most popular sport. And it's the cheapest sport to play. You have the ball and you have some area, you start playing.
Yeah, absolutely. Thank you so much, Justice.
Thank you for the opportunity.
For joining me and telling us all these important things with regards to bringing about reform in our judiciary.
Kind of you to have me.
Thank you so much, sir, as always, for gracing this occasion. You were with us last year as well. Really, really appreciate the extent of your time to not only sit with us, but have this conversation with us. Before you leave, sir, could I request Karthikeya Sharma ji to kindly come on stage and gift you a monogrammed copy, sir, of the Indian Constitution. And this, of course, is a photograph of the first Constituent Assembly that took place in 1946. Something for the officer. Thank you. Justice Mudgal, really appreciate your time. Thank you very much. Let's get another seat put on the stage. Please, sir, please this way. And with that, further ado, I would request former Judge of the Supreme Court of India, Justice Sanjay Kishan Kaul, to kindly join us on stage. He'll be speaking on truth and reconciliation in Kashmir, after which we'll do a quick Q&A session with our moderators, including myself. I'll request our Executive Editor, Megha Sharma, to kindly join us on stage as well. Justice Kaul, the microphone is yours.
Very good evening to all of you. Truth and reconciliation in Kashmir. Why did I pen down that epilogue to Article 370 judgment, which was a concurring judgment, was because I truly believe that the state, which has been very naturally endowed, has seen very troublesome times. And those troublesome times has reached a situation where you had in 1990 a mass exodus of the Kashmiri Pandit community from there. This happened before, it happened again. And 30 years has not seen them move back. So what is that is required to be done that in your country people who are displaced from their homes are able to go back? Is prosecution after 30 years a possibility? Can you do something about it? Very difficult because the evidences are gone, the other aspects are gone. So I don't think that is something, a way which could continue. So it's in that context and looking to some of the experiences of in different countries that it weighed with me. So if you look at Klinker's right on the Truth and International Law Commission, they said the importance is that the right of a victim of a human rights violation is the truth in itself. So it paves the way for a possible reconciliation. And if we look to international cases of, say, robberies in Honduras handed down in the American court, state has an obligation to prevent human rights violations. But if they can't do that, it at least has an obligation to acknowledge that such a thing has happened and, if possible, fix the responsibility. The Albert Sachs, while dealing with the apartheid regime, and that is what I must say inspired me to write that last portion, said that the commission always was, truth came out, I quote, you don't have the denial, the bodies were recovered, decent burials were given, people learned about the last moments of their loved ones, and there was a sense of public acknowledgement of terrible things that were done. It was enormously positive and affirmative for the whole society, but it wasn't coupled with sending the people who came forward to testify what had happened to them in jail. This was the encouragement to enable the truth to come out. As I said, fixing responsibility would become a problem in this scenario, and it would discourage the people to come forward and state the truth. Even participants in what has gone wrong did come forward at that time, felt pained by what they had done, but acknowledged so the society could move forward. This has been the story in Rwanda. This has also been the story in Uganda, where after doing so, some of the people were prosecuted in a different way, were threatened, so the report never came out. If we have to work this in the context of Kashmir, I feel that it must not be a criminal court. It ought to be a fostering a national reconciliation. A balance needs to be struck between endeavoring to heal the individual relations between offenders and the communities. And this is more significant because this has lasted long enough, and I think it's time that the peace movement goes further. My view is some couple of things which are important is that a Truth and Reconciliation Commission is to be established to address the impunity, break the cycle of violence, and provide a forum for both the victims. So commission has to be an adjunct to a criminal court, not a court of law by itself. The quantum of evidence will be very large. So amounts of evidence which may by way of direct witness testimonies, etc., say in South Africa was 22,000 testimonies. So there has to be an ability and novel method of assessing and classifying the evidence, may even require statistical analysis and technological support. I also believe that the support systems have to be there for deposing before the commission, and one should not face a scenario where people deposing then feel that in a social context or in a criminal context, they feel threatened. I would also like to propose certain aspects that, in my view, are crucial to the functioning of the Truth and Reconciliation Commission. Firstly, a credibility of the Commission. It's extremely important that the Commission must be manned by persons having moral and a professional repute and credibility. Need not necessarily all of them may be in judicial in nature. Having a place of conduct and set best practices, because how the integrity and professional ethics have to be maintained, how the evidence will be recorded, there must be a plan for it. And there has to be support from stakeholders. Commission would necessarily require support from national agencies, coupled with the political will, I think, which is most important, as also financial resources to undertake what can be put as a Herculean task. I noted in my opinion that the dispensation to devise the best methods of the Commission must be left to the constitutionalism which evolves to encompass responsibility both for state and not state actors with respect to human rights violations. While I get down to the question answers, I would like to just, this prelude which I thought I should set forth what the scope and thought process was. I'm reminded of the narrative poem by Henry Wordsworth Longfellow, the Song of the Hiawatha. All your strength is in your union. All your danger is in discord. Therefore, be at peace henceforward, and as brother live together. It's time for the people of Kashmir to embrace the past, and people who left the valley to come back with dignity and peace. Thank you.
Justice Call, thank you so much, sir. When we did this conference last year, it was your last working day, I remember, and the Supreme Court, and you had a farewell dinner to attend, so you were unable to be with us. Thank you for joining us today. Let me ask you the most human question. Have you had a chance to go back to Srinagar, to travel to Kashmir in the recent past? What are your thoughts about it now?
Oh, many times. I have been traveling almost every year, more than once, to Kashmir. I have seen it come out of that scenario where it was. I've been to difficult areas also. Been to a temple downtown where my family were the priest, and they said, you can't go. I said, no, I'm going, whether without security or otherwise. I've seen tourists come from all around. I've seen them walking the Jhelum, walking the Dal Lake, and crowds at 10, 11 at night. I last year stayed after 30 years in my own house with my family and my children who were walking areas there. And interestingly, I had an opportunity to invite some of my neighbors whom I knew their forefathers but never would know this generation. And they said, well, someday all of you coming back is a security to ourselves itself. Gave me a lot of encouragement.
Interesting.
Right. And talking about Kashmiri Pandits particularly, do you think after the abrogation of Article 370 and certain other measures that have been taken by the government of India, there has been a sense of justice that they feel? Or do you think the last 30 years have just been brushed under the carpet?
No, there is a problem which started, let's understand, before 1989. It culminated in 1989. I could sense that going wrong at least for a few years, not to this extreme. But in 1984 onwards, I thought there was a problem. 87 afterwards saw it aggravated. So the issue is for them, how do you get them back? People who have lived aside 30 years are not going to suddenly uproot themselves from a new place and come back. But yet, everybody who stays in a village and goes to a city or travels to somewhere else for work, they would like to keep a small place by themselves to get back home. I think it is important that they must feel secure where they can get back to their own homes. I'm not a great believer in the ghetto situation.
Yeah.
I feel they should be able to go and live in peace where they want. That's the only way they will reconnect with the system.
Is the situation then becoming, sir, of truth and reconciliation to set up this commission? You mentioned there'll have to be political will. We've had action in the past where individuals that you know have been appointed to be sort of friends of the process. Many of these have not really succeeded. Is the time right for something like this?
So let's understand, there have been two phases. There have been phases when the Kashmiri Pandit community moved out. There's been a phase after that when, to save the nation, the army moved in. When army moves in, there are bound to be certain... the army is meant to fight a war. It's not meant to control law and order. So there will be situations. So there have been sufferers pre that. There's another section of society which is post that. But it cannot be a remedy only for the post. What has happened is the post suffering is what has been focused on. There has been a denial mode, I believe, that look, we don't know how the Kashmiri Pandit left, why they left. That's not acceptable. If you have to heal them, you have to accept that they left because there was a situation there making them leave. And therefore now when you're talking about they're coming back, you must create an environment which will encourage them to be secure in their home place, whether for a short period or some period in a year.
Okay, and talking about the Truth and Reconciliation Commission, and you spoke at length about this in your introductory speech, would you be willing to be part of it?
See, I feel a very difficult choice. I would have liked to, but I think the fact that I am party and author to this judgment may create some element of conflict of interest for me to be able to perform this task.
So what was in your mind, sir, now that some time has elapsed, and when this case came before you, the government had made some moves, they had made some decisions, and the case was brought before you for review. What were you thinking? Was it simply a point of technical legality, or was there a larger question that you had to toy yourself with?
So see, one part of it is the constitutionalism of it. One may disagree with our view, one may agree with our view. That's how the situation is. No part of society is always in sync with what one may hold. But I didn't hesitate, I think, to look into the constitutional aside and keep my personal side to some extent away from it. I was not really prejudiced, if one may say, by existence of Article 370. Personally, my family has been a state subject there, so for me to hold property, do any of these things was very permissible in the given regime also, so I know. But it had to be tested on the constitutional scheme of things, where 5 judges, including myself, opined in a particular way. Chief Justice Chanchud penned down the main judgment. I gave a concurring view. And why I specifically wrote, apart from the direction I was choosing, was also a very strong belief that I must write this epilogue, because I felt that so much time has passed, we must move forward. If we keep looking backwards, then things will never improve. After all, the country went through 1947, a partition, which is a trauma by itself also. My family bore the brunt of that also. But everybody comes out of it. People came out of it and got along with their life. And there is some amount of solace to be provided. A similar kind of a thing has to arise from what has happened here. And I do believe with the current scenario, with tourism being there, with people traveling, it's the right kind of time to provide a healing touch, also with now an elected government in power there.
Talking about healing touch, and there have been reservations that have been made. Seats have been reserved in the assembly elections recently that happened the first time since 2019. Do you think these are just, tokenism that is being handed out to the Kashmiri Pandits, to the POK refugees?
So the nominated seats for Kashmiri Pandits, one for POK refugees?
Yeah, so I can't deny there's some element of tokenism which comes, but the tokenism is important in so many ways. In so many parts of society, we do have a system of tokenism to take over. And that tokenism sends a signal. Yeah. And I think we can't reduce the significance of that tokenism, even if it amounts to, say, 1 or 2 people being representative there.
I have to ask you a larger question, sir. I know our time is limited, but we have not only seen the abrogation, but we also saw the creation of Ladakh. There is a conversation regarding statehood. But what do you make about, from the governance point of view, as you see it, the creation of Ladakh as a separate entity of governance?
So the idea of, possibly it's a political idea. The political idea was that Ladakh should be administered separately. It's a very, very small population, a larger area in that sense. Whether those aspirations have been met or not, I don't think I'm in a position really to say. There are some troublesome aspects out of it, where possibly the Ladakh area expected something more to come out of it, or they were feeling they were not getting their due in a trial scenario. So, on so far as Jammu and Kashmir is concerned, the government has been committed to restoration of the state. So, I presume that will happen sooner than later.
Yeah, they made that submission in court. So, when it comes to the governance of the state, the security situation still remains troublesome. Is it fixable in our times?
So, once I was in Kashmir and somebody asked me, how secure is it? I said, as secure as any other part of the world. Look around the world and see the scenario. Look at Delhi at times what happens. The only thing is because Kashmir has been through a problem, so any incident gets blown into certain level. The valley consists of 10 districts, out of which 3.5 districts are a little troubled. The incidents occur there, what is happening. But when it says so, nobody says which part of Kashmir has this incident taken place. Incident at times occur in the Jammu region at the border areas. So look at a world scenario, I think. Why isolate Kashmir itself? Look at well-developed nations like England and US, what is happening. So the level of security, the level of thought processes, level of how people can travel will in a sense depend on the environment all over the world. I don't think it is today anything worse than that. Some incidents may occur, but especially I know, for example, they don't touch the tourists at all, because they know that they've seen that the tourists coming means their livelihood improves. The whole economy is based on tourism. Everything else is linked to tourism. They are not really industries or any other things which are sources of income. So the tourism needs to be tackled at a very, very professional level, I think, there. As I believe that all over the country, we are not looking to tourism as much as we should, considering that we have such a varied culture which is available in our country.
Okay, last thought, sir.
It's been some time now since the judgment came out. It's been almost a year since your retirement from the bench. Are there takers when you have conversations? Are there believers that yes, this is a process that needs to happen, a truth and reconciliation on the likes of what happened, for which Nobel awards were won? Are there takers for this?
So if you look at, I have not seen any dialogue on it at all. How does a dialogue occur? A dialogue occurs where we expected the government to take a little forward step on this. Unless they do, I don't think this will move forward. Number of people ask me, you wrote this, when is it going to happen? I said, how can I decide or tell you how it's going to happen or when it's going to happen? I really don't think it will honestly come by unless there is a concerted view by citizenry and the government to take it in this direction to heal the wounds. It will want people to look beyond just politics of it to a healing process.
Yeah, moving forward, taking forward this process, again, what is it that the government can do more besides, talking about abrogation 370? Is there a need right now to recognize that the genocide that happened, the killing of the Kashmiri Pandits back in the day, 30 years ago, it should be recognized as such?
Yes, the community expects that. I was, being in office, I was more secluded. I couldn't. Post the period of retirement, some of them came to me, and what my feeling of interaction with them is, what they're interested in is that you can't take us back to what it was originally. At least acknowledge something wrong has been done to us and facilitate us to have our small places where we can go. That's, I believe, from my conversations, the expectation of the community that has been displaced, that, create that environment for us. There has to be a political will to do it. There has to be a people's will to do it. I think if we have to move in that.
You said conversations need to happen. So for 5 years, we've done hundreds of hours of programming on the concept that the seats that were reserved or left empty in the erstwhile Jammu and Kashmir Assembly for the areas that are now POK should be filled. They should be filled with POK refugees, should be filled with Kashmiri Pandits. We have now seen 3 of these seats filled. So yes, if the conversation begins, it's a process that can happen, which is why we're here today to have that dialogue. This is being telecast on 9 news channels. It will be published in at least 5 of our newspapers. Justice Sanjay Kishan Kaul, as always, sir, it was a treat to have you. Thank you so much for joining us and speaking your heart on this subject, sir.
Thank you for calling me there. Thank you so much.
Thank you, sir.
Yes. Yes.
Thank you very much, sir. Full sympathies, your feelings, what you just projected. But I would like to know that, since you have got the knowledge, that since 89, when this happened, everybody knew which house was occupied by who. The government knows, the police knows. Why? What stops the government from taking over those houses and ask those people, how are you here? Show us the paper. If they don't, give them 1 week to vacate and lock the house up. Make it a government property. Then ask the Kashmiri Pandit to please come back. If he doesn't, then government takes it over and gives it to somebody else. But secondly, all the people who are staying there, aren't they part of the sleeper cells which India is facing? If that be so, what stops us? Because they are aiding the terrorism which is going on. They're continuously doing it. So we must do something about it. And do you think, sir, that security is complete or it has to be upgraded? The whole area should be under one command and control.
So I mentioned this, that just creating ghettos of the community, to my mind, is not the solution. The person must be able to move into his house, his property, his base. That's the only way after 30 years that the next generation will be encouraged to come back there. I would tend to agree with you that possibly there needs to be a survey of people who, there are law in question where they said if people have sold in difficult times, something should be looked into. I don't think much has been done there, I must say. And I believe that's the way forward. So far as command structure is concerned, I think there is a security command structure in place. Please understand this is a cross-border and within-border problem, more encouraged by the cross-border issues. And it will always remain some part of a challenge, as other parts are there, a little more than that. But it's not unsurmountable as a situation. And I think if the community tends to come back, it'll help in assimilation with the current community. Some of the youngsters who have not seen the better times when people have lived together.
Sanjay Kishan Kaul, thank you so much, sir. What an honor it's been for us to have an authority as yourself on the Constitution. I request now Mr. Kartikeya Sharma, Member of Parliament, Rajya Sabha, to please join us on stage and present a token of our appreciation to Justice Kaul. Could we please have a round of applause for Justice Sanjay Kishan Kaul? What an absolutely enlightening conversation. I now take a moment to introduce our next guest. With us is Dr. Abhishek Manu Singhvi, fourth-term Member of Parliament. He's an eminent jurist, senior advocate, Supreme Court, former chair, Parliamentary Standing Committees on Commerce, on Law and on Home, a member of the Congress Working Committees, Congress Supreme Decision-Making Body, top senior counsel of the Supreme Court, former Additional Solicitor General of India, and the senior-most national spokesperson of the Congress, chair of the Congress Department on Law, Human Rights and the RTI, an author, a well-known media face and commentator on many diverse issues. He joins us on the third Law and Constitution Dialogue. Taking the conversation forward with him is Priya Sehgal, Editorial Director of NewsX.
Thank you, Devika, and thank you, Dr. Singhvi. It's always a pleasure to have you, and as I always say, he's one of my favorite guests because he makes law and politics both simple to people like, I think, people like me, because we are all eminent lawyers in the panel, in the audience also today. Dr. Singhvi, welcome to our panel today. We are also celebrating 75 years of the Constitution, but they've, in Parliament there have been a lot of debates on a lot of issues where lawyers like you have a vital role to play. For instance, we've had the Places of Worship Act that is really doing the rounds today. We've had the Supreme Court also pass a landmark judgment on it. So what is your take on this?
Thank you, Priya. Normally get paid to speak before judges. This time I have to, the judge has to keep silent and I have to be able to. Thank you for a very generous introduction. Well, it's interesting you talk about the Place of Worship Act because I appeared just yesterday as one of the two lead counsel in that batch, and without encroaching on the sub judice nature of the matter, I think an excellent holding order has been passed by the Supreme Court just yesterday, and we appear at 3:30, 3:45. It has two parts, which is why it's excellent. It prevents further suits being registered till they hear the whole matter. And they can be filed, but they are non-starters. And for the existing matters, it prevents any effective, the exact words are effective, final or interim orders being passed in the existing suits. Now, why do I say it's important? First and foremost, while the matter is pending, as one of the judges put it yesterday, there cannot be a race between the apex court and the courts subordinate across the length and breadth of India, where suits are being filed almost like rabbits. Every day we find a new suit coming up in a different part of the country. The Supreme Court will decide it. The Supreme Court will hold one way or the other. But certainly on the interim, on the balance of convenience, etc., it is indisputable, but there must be a quietus, a stability, and no upheavals while the Supreme Court is seized of the matter. That is the basis of this order. It's not any final order. Now, if you ask me the larger question about my own views on the Act, I have no hesitation, and I don't mean to impinge on the Supreme Court. That's only an interim order. We'll be arguing it finally, and I don't know which way it will go. But I have no doubt that a well-considered legislative decision was taken way back to draw a line. You know, nobody's saying that the line is right. All lines are arbitrary. And I approach it from a different viewpoint. I have no doubt that any number of monuments and buildings and places of worship in India lie on top of diverse religious structures. I am a Jain, you are a Buddhist. There are many Jain and Buddhist structures over which other structures stand. And so also Hindu structures. The question is very simple: how far will you go? Where will you stop? At the Qutub Minar? At the Taj Mahal? You already invoked Ajmer Sharif. So, as Gandhiji said, an eye for an eye will do nothing but make everybody in this room blind. So you need to draw a line. The Act has drawn a line for us. And I don't think there is any value in opening it. Last point. Unfortunately, the courts below, till yesterday, and I'm glad the Supreme Court is crystal clear now, has had a very weird nuance in my understanding. The nuance is that you are prohibited from going to dinner by a law of Parliament. Parliament says, I cannot go to dinner in this ballroom. But yet you are entitled to examine which kind of dress I must wear for dinner. That is apparently the basis of the Supreme Court not acting earlier and not stopping these suits, something which the court rightly did yesterday. So the argument was that, look, while the structures can't be changed, why can't you have surveys to find out the nature of the structure? If the end result is predetermined by an act of Parliament, now more than 30 years old, then what's the point, at least till you finally decide the validity of the act, to keep on inquiring that while we can't touch the structure of the act, let's find out the nature by surveys. It's exactly like my dinner analogy, although it might sound facetious.
But the petitioners are also questioning the validity of the 91 Act, which brings us to my next question. You know, what are the pillars of the basic principles of Constitution? Where does judicial review begin and end?
Well, the pillars of the Constitution is a large question. We can have a whole program or a whole afternoon on that.
Give us a short answer, if a lawyer can...
A short answer is difficult, but there are several fundamental pillars of our Constitution. They are institutional and non-institutional. The pillars I would identify, there can be many more, is of course secularism is one pillar. And secularism not in the sense in which we politically use it all the time, but in the sense of India being the world's, planet Earth's most diverse spot, where it's a sense of self-preservation when we want to impart a sense of belonging to every Indian. As Bhargav said, of the people means each person gets a feeling of co-ownership of democracy. So you have to give that feeling. Another pillar is fraternity, a word hardly remembered. It is much more than the negative word tolerance. It is a word which is supposed to encourage actual cherishing of diverse viewpoints. A third word is federalism. These are all pillars. And it's exciting how India has become a very federal country, although our framers thought of it as a unitary country. And that's a different story altogether. And then there are other institutional pillars like Parliament, like the Election Commission, the CAG. These are all pillars which have stood the test of time, which make us different from every other country in our neighborhood. Indeed, I always say that roughly 30 to 40 countries became independent from the yoke of imperialism in the 1930s and 40s. And ask yourself this remarkable question: why is India the only one out of those which came out from Dutch imperialism, British imperialism, French imperialism, etc., which has remained a democracy? It's because of these pillars. And you see the wrecks and ruins of constitutionalism littering the landscape in all around our neighbors. So we have to cherish these pillars.
But you know, in operational reality, it doesn't always work like that.
Absolutely. Absolutely. And that's a much larger issue. We are going to debate it on Monday. And I will be one of the speakers on Monday, so I don't want to anticipate my own address in Parliament. But the operational reality, there's a hiatus between the theory of the pillars, the text of the Constitution, the context of the Constitution, and the spirit in which we are operating. The Constitution does not contemplate the operational reality of the meaning of inclusiveness and plurality, which we are seeing for some years now. The Constitution does not contemplate the sense of fear or divisiveness, which we are also seeing. The trust deficiency, the distrust quotient. The Constitution does not contemplate the new definitions of federalism we have. We can use fancy words in lectures: cooperative federalism, competitive federalism. What is the reality? I'm giving only examples. I have done, never before in 75 years, but I've done the last 2 years, at least 4 governors' cases from 4 diverse states of India, where a bill is sent to a governor, and the governor in 9 out of 10 bills simply doesn't decide. Because you know that if you send it back and it is referred again back to you, then you have no discretion. So you decide not to decide. then you have to go to court to get a direction to the governor to decide. And in 3 of those cases, when we have gone to court and got that direction, the governor passes one or approves one bill out of 9 or 2 bills and then refers the rest to the president. What suffers? Governance. This is happening in the south, it is happening in eastern states, it is happening in northern states, all parts of India. I am myself a counsel in those. Take, for example, CBI use. Right or wrong, the CBI can't enter your home without your consent. Now today, you have weird examples where they said something happened on railway land. Railway is a central subject, so CBI can go there, even though the entire thing is happening in state X. These are examples of abuse of federalism, different from the pillar of federalism, which constitutional law like Bomai taught us. And I can multiply the examples. The Election Commission has acquitted itself well in maybe 80% cases. But in the 20% where push comes to shove, their record is very poor. I happen to be the person who's dealt with those 20% cases, and their record is one-sided. Same can apply to so many institutions. Parliament today, when have you in 75 years seen a disruption of, a expulsion or rather mass suspension of Parliament of 142 persons? I mean, short of somebody murdering someone or slapping someone in Parliament, never has any conduct been so egregious as to justify 142 suspensions en masse. Where you might as well have a unilateral ex parte parliamentary democracy where you don't need the opposition then. So these are many examples you can multiply.
Which brings us to another debate that is doing the round, and actually this is the right forum for it also. You know, we hear a lot about the basic structure. You know, what is the basic structure? Can you just help us out in explaining the history and the origin of the basic structure?
I must advise you to have separate programs for each of the questions you're asking. But basic structure is a fantastic doctrine. Let me assure everybody who's interested and not interested. And I am sometimes shamed by seeing pygmies talking about, in denegatory terms, something which is the pride of India and the envy of the world. The basic structure will remain the ultimate bulwark, according to me, between dictatorship for any length of time in this country and democracy. The basic structure in one sentence, why I call it fantastic, no other country thought of it, no other judiciary thought of it, says that a constitutional amendment passed by 2/3 of parliament, etc., can itself be unconstitutional. A constitutional amendment can be unconstitutional is an amazing doctrine. And I don't have the time to discuss with you, but how it developed, how it picked up the philosophical roots from a German called Conrad, who gave a lecture in BHU, who talked of the essential features, and how that lecture found its way to a Madras professor, who then gave it to Nambiar, the father of our current last AG, Venugopal. And by that time, Golaknath, he tried to use it, Nambiar, and it didn't succeed. Along came Keshwananda Bharati. Nambiar was not so well, so he said, go to Palkiwala. And he passed on the draft which he had made. And Palkiwala, with his brilliance, developed it into a fantastic doctrine. And ultimately, in that 6-6 versus that 13th judge, 13th was lucky for India. Justice Khanna ultimately said, A, that the basic structure means some parts, the essential parts of the constitution are unamendable. And more importantly, what is unamendable or not will be decided on a case-to-case basis by the judiciary. So there's no point lamenting that this is an unelected body, these judges aren't elected. They have the last word, and ultimately you have left it to them thinking that absolute power corrupts, and the executive dictatorship, which sometimes can happen in the Westminster model, will not be allowed to be happen in case you start tinkering with the basic structure. Otherwise, as Conrad said, and I in fact in a lecture in Rajesh Jindal, traced it back to a 1920 set of 2 articles, one by a Frenchman, one by a German, Schmidt and Heroux, who said philosophically that ultimately it means that if a law is passed saying that all blue-eyed babies alone shall have the right to vote, well then law is passed by 2/3 is valid. What's the problem with it? Basic structure says no. So it's a fantastic doctrine.
Are you surprised that people in parliament are questioning it? Because it says the power of the parliament is not absolute. So obviously the parliament is going to be questioning.
Well, the power of parliament was never intended to be absolute. Forget basic structure. Much before
basic structure was never in the constitution also.
No, much before basic structure, these judges were reviewing parliamentary legislation for decades. So how can you say parliamentary power is supreme? The supreme power till Keshwananda Bharati was the constitution. So you tested laws passed by parliament against the higher anvil of the constitution and you struck down innumerable laws. The only difference between basic structure and judicial review is that this is a superior power of judicial review which says that even a constitutional amendment can be unconstitutional. But the judges have been wise and sparing. They don't use it indiscriminately like a wild, unruly horse. They've actually struck down constitutional amendments, very few and far between, on basic structure. And I think this power, any constitutional functionary or private state actor or private actor who denigrates this doctrine, I think needs to relearn his constitution.
Can you recall any recent examples where the basic structure has been called into question or some debates which have made a point?
There have been many examples. I mean, sometimes good, sometimes bad. I don't necessarily agree that the National Judicial Commission bill should have been struck down. Not because I was the lead speaker, and that not that reason, but there is a view that the collegium system in the judiciary has also partially failed. But that what was used is important. The principle used to strike down the National Judicial Commission bill a few years ago by the Supreme Court was independence of judiciary, which is a basic structure. Then there are many more examples today. And I think that residual power of saying that must remain. It must remain.
We've also another recent debate I want your views on is your stand on the EVMs. You know, you were part of the delegation that went and met the Election Commission. Also, Congress has been raising this. Where do you stand on it personally?
First of all, I'm speaking personally, not as a spokesperson for any party. My personal stand, and I was just discussing it outside there, is a much more nuanced one. The demand can be for ultimately changing the EVMs and going back to whatever paper ballot. But that demand has to await the fullness and ripeness of time. When it will happen, nobody knows. So I don't think you generate much resonance by saying, in a general sense, EVM hatao, EVM debunk karo. My stand is much more nuanced. I think there are very serious, and I've examined it on data. I've led delegations to the EC, and I have had meetings where data is, I'm talking of hard data. The nuanced reaction should be that a lot of things which actually alter the level playing field of elections need to be looked at by the Election Commission, and they are not sufficiently looked at. Take one example, which we gave to the Election Commission officially about 3 weeks ago. I'm not saying it's right or wrong, but you need to examine raw data. The Election Commission needs to examine it. I'll give you 3 quick examples, there's not enough time. Example 1, in Maharashtra, 118 constituencies, of which 102 were won by the state ruling party, had differences exceeding 25,000 votes on the names of the voter lists, that is 35, 40, more than 25, between the 4-month period between the Lok Sabha and the Rajya Sabha elections. Now that's a massive number of seats and a massive number of difference in that short time. Second example, you have no reason to not progressively increase the VVPAT trail from 5% or so, which you have now, to a much larger number. Assume I'm wrong. Your job is to evoke confidence in the system. The average person must have much more confidence. So why don't you start dealing with the paper trail in, let's say, each year increase 10% and reach 50%. 5% is not a valid sample size. Number 3, that paper falls straight into a untouchable kind of box. You need some system by which contemporaneously, a day or two later, that paper can be checked. Do it only in maybe 25% cases and then 35% cases, and maybe put a cap of 40% cases. Do you know that the total time extra taken to declare the result, if you start doing a physical verification of this kind, is not more than 36 to 48 hours. Now 48 hours addition to a 7-week election cycle is not oont ke muh mein jeera also. It's nothing. So if you are able to give confidence to the electorate by a 48-hour delay in declaring results, but doing a paper trail examination, I don't think it's any great thing to say that, look, it will delay the election results. You've already taken 7 weeks. And there are many more nuances. So my point is, I'm not saying EVM hatao, EVM galat hai. These are the things which the Election Commission, and I am sorry to say, the Election Commission on such queries has not always acquitted itself creditably.
Well, that is a debate I will leave for the Parliament. But another debate, hot topic is this one nation, one election. I mean, I know where your party stands, but again, since you're speaking in an individual capacity.
One nation, one election is a very, very warming, attractive, prima facie, extremely attractive concept, especially to drawing room classes. It's a wonderful sense of uniformity, discipline, organized. सब चीज टाइम पे होती है, एक साथ होती है, सही होती है. In practice, apart from a serious doubt on constitutionality, I don't think it can work. If it works naturally, no doubt. It worked naturally from 1947 to 67 or 66. Now, the moment you have a democratic will changing, and you have a hiatus in not one but 5 states, you need a law to say that despite the democratic will changing, by whatever, withdrawal of support, defections, whatever, changing fickle loyalties, a law says that you shall continue to the nearest date, which you are now currently suggesting is a midway mark. Now, how constitutional it is to artificially prop up something without the numbers. I agree, you can have a reset button. You can start the whole system once. But subsequently, again, if you have a 1967 and a 1990s situation, to always keep on a mandatory legal reset button means that you have become a minority government, but you shall continue till the next reset button. It's unattractive, it's an implausible and an unworkable concept. The main thing nobody answers of the proponents is how it will work. And the report which has come is riddled with such general blanket statements which have lots of infirmities.
Does it impinge on the principles of federalism also?
That's the other aspect. Of course it does. Regional parties today rule more of India than either national parties like Congress or BJP. In population terms and in geographical terms. Regional parties rule much more. Now, regional parties have different cycles of electoral politics. You are actually affecting that, and federalism will be an issue. These are all constitutional challenges possible. It has a great sense of order and a great sense of good uniformity. But it's actually, if you examine it deep down, it's only appealing to our sense of, orderly conduct. There are a lot of ways in which you can insulate the disruptive cycle of elections, but I don't think one nation, one election, just because you may be a government who wants one language, one dress, one habit, one approach, one religion,
one prime minister.
Can't be one. No, I won't say that. I am nuanced in my response, but you can't have one. The whole thing we celebrate in this country is diversity. I always say it has to be unity in diversity, not uniformity upon diversity. You can't have uniformity upon diversity.
Also, you wear many hats. You're a lawyer, you're an MP, you're also a national spokesperson for the party. I've seen you argue the same thing in 3 different ways. You do it in a press conference, you come and make the same case in court, then you come to the parliament. So are there different ways of communicating?
It may be interesting for you, but it's a great learning process for me. I believe that it's extraordinarily learning. It's not good for health, and I don't do it as much as I used to do in my younger days. But it's extraordinarily interesting learning process, because you'll be surprised if you pick a theoretical topic X. I mean, I'm not saying what the topic is. You can pick a theoretical topic X and make a frame in the morning, 2 hours arguing 3-4 cases on it. The approach, the idiom, the style is cold, logical, pointed, volume X, page Y, and then the judge decides something. If you take the same theme X, and I've done it innumerable times driving from court to parliament, which is 2 kilometers away, and you open a debate, which I've done for years and years, the same theme has a different idiom and a different rhetoric in parliament. The audience is different, how you put it is different, the canvas is wider, the style is different. And then I have done this again on the same day at 4 o'clock. You do a Gagar Mein Sagar, what I call the Nobel Prize for Miniaturization, for the press, a press conference at 4 o'clock. The same theme will have to be encapsulated in a few sentences with or without some spins to sound sufficiently attractive for the press to listen to it. Now, these 3 things are similar, but they have totally different approaches, audiences, receptivity, absorption, and styles.
Who is the most difficult to convince? Your parliamentary colleagues, the media, or your lawyers?
All are difficult to convince. This is not ultimately based on result. It's based on trying to deliver a decent performance. I mean, you'll be surprised how many people come back to us to argue cases after I lose their cases. People are intelligent enough. They know the weakness and the strength of a case. They want their point of view to be put effectively. They know that after that also they are likely to lose. I don't think they blame that person, be it in parliament or in courts, so much.
Speaking of parliament, you also spoke earlier about so many MPs being suspended. How do you, a lot of people are talking about, especially from the opposition, about the relevance of parliament today. Government is very happy, they're getting their work done. So is the opposition walking into the government trap? Why not go and debate inside the house instead of, disrupting the house?
I don't want to sound political on the narrower issues, but certainly I believe that parliament is the temple of democracy. We don't have democracy, remember. We have parliamentary democracy. We have two words, not one. And we tend to think of only one word. It's a parliamentary style of democracy. And if you diminish or dilute parliament, you diminish democracy. Parliament is the grand inquest of the nation. Grand inquest means it's the place to raise issues. It's the place to seek answers. And it's not a place to get results. It's a place where you can just raise everything for the attention. That's why it's called the grand inquest. Now you must have violently differing views. This is the heart of Voltaire's saying, what parliament represents in a British system. Not so much in the Senate and the reps, because there's a different system there. There's a third entity, a veto. But in parliament, you are supposed to have the principle of Voltaire that I disagree totally with what you are saying, but I will defend to death your right to disagree with me. If you imbibe that, then you have healthy parliamentary democracy. Now, that means you give time. That means you are prepared to hear unpleasant views.
Both sides.
That means both sides, obviously. See, one side will have less difficulty because the numbers are with them. In any system, I may be more numbers or you may be more numbers. But the majority, it is actually a place where you have to show largesse to the minority, to the opposition. And I think once you do it, we've had examples. I mean, the person who liked to abuse was the ultimate Democrat in this respect. He said, give extra time. Do you know, it's very interesting. I just read yesterday, I'm not talking about any current context. When the first impeachment motion was moved against a person like Mavalankar, there's been no impeachment motion in the Rajya Sabha till now, but there has been impeachment motion against the speakers way back in the 60s. Nehru said that this is a frivolous, false one. But you must give extra time to the opposition because they've raised such a huge issue. This is on record. I'm not talking about Nehru. I'm giving an example of the spirit of parliamentary democracy. Take Central Hall, for example. The new building you have is fantastic. I mean, it's luxurious. But Central Hall in the old building is something where a Vajpayee would sit there, a Singhvi would sit here, a Rajnath Singh would sit there, a Sharad Pawar would sit there. And the rule in Central Hall is that everything you say is off the record unless you say it's on the record.
Correct.
And the oldies in your field, the journalists know that. And you would have everything free and fair. Now the two ladies in Bangladesh can't sit in their Central Hall. The Nawaz Sharifs and the Ziaul Haqs of Pakistan have no Central Hall. So Central Hall is not a space, it's a concept. That's the heart of parliamentary democracy. Unfortunately, this time by a physical space change, we don't have a Central Hall. I have to walk half a kilometer to sit in the lounge of the Lok Sabha, and they have to walk half a kilometer here. We both have a canteen, luxurious no doubt, but we don't have a Central Hall concept.
Or you can come here and meet everybody.
No, there is a move afoot across parties, not one party, even the ruling party, to approach the Honorable Prime Minister and say that, look, create a Central Hall kind of space for us. Because you have no idea of the spirit of democracy which is there in Central Hall. The freedom, the openness, the lack of fear, the cross-fertilization of ideas with no fear of being misreported.
Okay, my last question is, there is also a move to increase the number of MPs. You think that will create more chaos or have more structured debate? Will it improve the quality of debate, representation?
That's an issue which impinges on something else. That's an issue of population. And the real issue there is not about acrimony or not. The delimitation, if it suggests, as it is likely to, a huge increase in population, then you are devaluing one man, one woman, one vote. By saying that despite an increase in population, this table has the same number of seats. This table is now 10. It got 2 seats earlier when it was only 5. Now it is 10.
Right.
The counter argument is that those states which have controlled population get diminished. So that's a vexed issue. But I think you will have to have a middle path. You'll have to increase Lok Sabha, and possibly the new building is now able to hold 700, 800 people. I mean the new chamber. Our chamber is more or less the same, but their chamber is increased. For that eventuality. Now where you will put a line, I don't know. That will have to be done with some acrimony, and a middle line between those states who have been successful in population control versus those states where population is increased. Because one man, one vote, one woman, one vote is the fundamental heart of a level playing field for elections, and that is the heart of democracy.
Last question. I wanted to remember, if you can recall the 3 debates that you felt really, made you proud to be in Parliament. It doesn't have to be from your side, but just 3 debates that really,
I have had the privilege of being asked to open from the Treasury benches virtually every major debate from 2006 to 2012-13. One which stood out was the Lokpal debate, because I was chair of the Standing Committee on Law. And in 4 months, we reported on a very, very disruptive, vexed issue, the Lokpal bill. You'll be surprised how vexed it was. And we had everyone except Anna Hazare coming and giving evidence before a committee of which I was a chair. And we had stalwarts on my committee, from the Lalu Prasads to the Paswans. Arun was there for a while, Arun Jaitley, Mr. Jethmalani Senior, so many, every party on that committee. And these people came and gave. Prashant Bhushan came, Arvind Kejriwal came, and they gave a report. And I wrote the report personally, opening Parliament's Annexe on 4 or 5 Saturdays and Sundays. And that report has had minimum dissensions. It's a report you must see. But what happened thereafter was all hell broke loose when we went to Parliament. Because inside the committee, real work is done. Cameras are not there, confidentiality is there. So there were hardly 2-3 dissents. But in the House, things broke. But the debate which followed, they asked me to open, which is not normally done for the chairman of a committee which is opined on the subject. But they asked me to open. And we had a wonderful debate. And Arun for the other side opened. As you know, the respondent opens in Parliament, not the petitioner, not the ruling party. And he cited the footnote which I had put in the report about how the Lokpal had travelled a full circle 38 years from the time when Nehru had asked a young member of Parliament in 1962, to which zoo does this animal belong, when my father, as a 30-year-old Lok Sabha member, used the word ombudsman. And then my father invented and coined the words Lokpal and Lokayukt. That's on record. Yeah. So that's how the debate started. And the amount of cross-party support and spirit it generated, it was a very strange coincidence that 5 failed bills of Lokpal finally found fruition 35 years later under a committee of which I was chairman. So that's how sometimes things happen. But there have been other very interesting debates, and I've done a lot of them, which is always memorable. When Parliament functions, you have gems, you have great, great debates. But sometimes it doesn't.
Sometimes it doesn't. So last thing, are you a better politician or a better lawyer?
That's a difficult one. I think I'm bad at both. But law has always been my first love. And I actually genuinely don't like the word politics, so I like to say that I am a professional who's in public life. The public life is a better word than politics, because politics, which is not a bad word at all at one time, has become very demeaned and diminished. So I enjoy multiple roles. I mean, the third role is that of the media with which I started. As I said, multitasking is the bane of my life. It's also the joy of my life. So I don't know what will happen if I leave the bane of my life or the joy of my life.
Well, last word goes to you-know-who. Thank you so much for this conversation.
The beauty of our country is unity in diversities, as you said also. It is unique throughout the world, and we are being respected and we are being appreciated because of these diversities. And if you know that the origin of our Indian subcontinent, it started from the supercontinent connected with Australia and moved to Asian plates, and it's collided. So my point is, in between is traveling, Adivasis came, then Dravidians came, and then your member of parliament said that Aryans came, then Mughals came, then Portuguese came, then Britishers came. These diversities, we should maintain it, and there is a book by Nehru Sahab, Nehru ji, that the discovery of India, a serial was also there. So why this kind of things present government is doing to divide the country? And our historical fact is that we are beautiful in diversities. Thank you.
The anchor will summarize.
I have another question. It's a legal question. Yeah, Mike, please. It's a legal question. So, Dr. Singhvi, we had, many judgments on the issue that says that judicial review in our constitution is a part of basic structure. Now, you're going to argue Places of Worship Act as a lead constitutional, and it's a matter of national importance. So, to my understanding, what I have seen when I was reading this act, that prevents judicial review. So, do you think, basis the judgment that we have on this subject, will this impinge the constitutional validity of Places of Worship Act? Because I see as a lawyer that this appears to be a big legal hurdle.
Okay, the first longish comment with a question hidden in it. The first part I can only say I agree. I mean, I can't say more than I agree with the first part of your question completely. I, of course, have no time to go back and travel back in time as much as you have. But certainly the first part I agree, but it's a larger philosophical question. You know, when we practice fraternity, inclusiveness, pluralism, we actually do no favor to anyone. We are actually acting for self-preservation. A diverse country, India is by far the most diverse spot on planet Earth. When the Americans talk of salad bowl or melting pot, they have no idea what diversity is compared to India. So this is a self-preservatory exercise we do for our own good. We don't do any largesse to anyone, and we're not being specially kind to anyone. So that part is fully agreeable. The second part I've already answered when I talked about the pillars of the Indian Constitution in terms of conception, design and theory, and the operational reality of many of them. It is not enough to have the text of the Constitution. It is not enough to have the context. It is the spirit. And I gave you 7, 8 examples of that. So I think both parts of your question stand answered in that sense, without repetition. As far as your other question is concerned, I think the issue is not a question of ouster of judicial review per se, because it has been held for decades now, from the time when emergency happened and those clauses were put in the Constitution that you oust judicial review of this or that those ouster clauses are not final. Ultimately, the court, and especially the Supreme Court, will always have the residual power of doing judicial review, despite a specific clause saying no civil court should look into it. Those clauses only oust civil suits of the kind going on now. And the real issue there is only going to be A, is this act valid? B, is the drawing of the line valid? And C, is it in any other sense, for lack of legislative competence, which is the third ground raised, invalid? I don't think judicial review is an issue in that one, because Constitutional Court's judicial review is admittedly alive and kicking, despite such clauses which are intended to bar only civil courts starting to go behind the act.
Dr. Singhvi.
Of course, that is why it is looking into the validity of the act. That's how it's looking into the validity of the act. It's actively, just yesterday, the matter started.
Thank you very much, Dr. Singhvi, for this conversation and to celebrate 75 years of the Constitution. Thank you so much.
Thank you so much, Dr. Abhishek Manu Singhvi, for joining us. I request Shri Kartikeya Sharma, Member of Parliament, Rajya Sabha, to please join us on stage and present a small token of our appreciation to Dr. Abhishek Manu Singhvi. He's being presented with a copy of the original Constitution. So this is also a very special photograph of the first Constituent Assembly session. Without further ado, let me introduce our next guest. We have with us Manjari Chaudhary, GC of Maruti Suzuki India, the largest car manufacturers in the country. The General Counsel, Manjari Chaudhary, joins us at the third Law and Constitution Dialogue. Taking the conversation forward with her is Tarun Nangia, editor of Legally Speaking. And of course, we're going to be perhaps taking a little bit of a break from all the politics that we've been discussing all day long. Manjari ji, thank you so much for joining us. Tarun, over to you.
Thank you so much. In fact, for the benefit, because we have an audience which, in a sense, is from the legal field, but we have a lot of audiences from diverse fields here today. I would like to give a bit of introduction about Ma'am Manjari Chaudhary. Of course, she is GC, which other people would understand who are not in law, is legal head of Maruti Suzuki. I think there would be no Indian who would not know what Maruti Suzuki is. So she is the one who's the legal head. And one qualifier that you must know, that there are 20 top listed companies in India. Out of those 20 top listed companies, there is only one woman GC, and that is Manjari Chaudhary. So that's quite an achievement. It is something that we must applaud. When I was researching, I found out that she's the only woman GC. So that's, and of course, ma'am, you worked, in USA, you were with General Electric, and Europe. Now you're working with Maruti. Also, when I was researching about you, I found out that you started off as a professor, an academic, then moved to a law firm, then you moved to an in-house role. So then you also now are the founding member of the General Counsel Association of India. So quite in one life, isn't it?
Thank you, Tarun, and thank you for the kind introduction. Yes, I seem to be a bit of an aberration today in this gathering, but we are as much lawyers as many of you sitting here in the audience and those who came up on the dais. We just chose to be in-house as opposed to litigating. I do have family that litigates, people in that. So yes, it's been quite a journey and very diverse from academics to law, but a very fulfilling and very satisfying journey. In-house counsels play a very huge role today, as opposed to what we were usually, used to seeing companies having a little legal cell where there was a lawyer sitting who was always used only to do litigation. And, if there's some matter, we go to court, take his support, help, usually would report to a CFO as opposed to the managing director of the company. Those times have changed. And over the last 10, 15 years, perhaps 20 now, and today the whole scenario is very different. I think it's also a lot to do with the advent of multinationals into India, and they brought in this culture. But I think a lot of the GDP that we contribute today is contributed mostly by the commercial sector in India, and the General Counsel has a huge role to play in ensuring that that is done in the best possible way. So I think the role of General Counsel has gone from being just a law advisor to being one of an effective and a strategic business partner to the MD and CEO, to the board, and to the senior management of any company. So they partake in decision making.
You're on television where millions of people would be watching you. So I would want to know from you two things, that the Indian economy is not what it used to be 15, 20 years ago. A much larger economy, a lot of complexity. Also, when you're heading the legal department of one of India's, not one of India's, the largest automobile company, what are the challenges and what are the learnings? Because this is a different role for you from General Electric, which is a different kind of company.
True. I think the role is always very challenging, and one of the things is trying to balance law with commercial exigencies, business exigencies. When you run a business, it's a profit-making organization. We all understand that. And the whole aim is that what do we do to further the profit of the organization or to take the business interests forward? And to match that with the regulatory regime of the area and the jurisdiction that we work in is and can be very challenging at times. And how do you navigate that, I think, is the single largest challenge that one faces. To do it effectively, to be solution-oriented, to be providing the best possible solutions within the legal framework so that you ensure your companies remain on the right side of law. I think that's the biggest job that we have.
In fact, I think there are two people here in the audience who are more qualified than me to ask you questions. We have Professor Rajkumar, Vice Chancellor of Jindal Global University, and Senior Advocate Aman Lekhi, who I think if they ask you a question each, I think that would entail good, interesting responses. May I request both of you to ask a question each to Ma'am Manjari Chaudhary? Can we get a mic for Professor Rajkumar and Senior Advocate Aman Lekhi? You can take my...
Yeah, sure.
Thank you so much, Tarun, and thank you for being part of this really thoughtful conversation. One of the things I wanted to ask you is that the entire world of, General Counsel office is a relatively newer phenomenon in India. Historically, I remember many years ago, if you look at, say, even the Tata Group, all of Tata's litigation was handled by one man by name Palkiwala.
Yes.
So we have come a long way in the Office of General Counsel. But then the fact remains that if you look at United States and even other jurisdictions, there is a far greater seriousness and a higher degree of attention paid to the Office of General Counsel, including their role and the responsibility that they undertake with regard to broader compliance and due diligence matters. When do you think we will be at a stage where promoters as well as companies, corporations and business enterprises in India will take the Office of General Counsel far more seriously, and the Council can actually play an even greater role than they are currently playing?
Great question, Dr. Rajkumar, and thank you for that. I think I'll break your question up in two parts, because there is a vast number of corporates today that have actually already arrived at the definition of the General Counsel's office that you're referring to, and General Counsels are playing a huge and a vital role. I can vouch for that. I have done it in General Electric, and now I'm doing it in Maruti Suzuki as well. And you'll be quite surprised that Maruti Suzuki, being a old PSU and now a Japanese organization, I think the role of the General Counsel is extremely valued and supports strategic decision making very effectively. But yes, we do see many corporations which still need to, ramp up and come up to speed on that. One of the things that can happen, and that is also because we founded the General Counsels Association of India primarily for that reason, because once you come to work in-house, your license is suspended and you do not fall into what they call the advocate under the Advocates Act, and that's something that we are now working towards getting rectified. I think it's high time it got done to bring that level of gravitas, to bring a privilege that is accorded to another, say it's anybody in a law firm or otherwise. The same privilege should happen to a General Counsel. It doesn't mean you have to go litigate in court. Litigators are there for it and we respect them for that. But it is all about bringing that level the level has already gone up. It is about bringing that recognition as a specialized stream of law. And I think by corporates, it's a chicken and egg story. So once the regulators look at it and make that necessary change, the view of the corporations, the ones who really need to catch up, also changes, and it is vice versa. So I think that's the next step.
Thank you. Over to Senior Advocate Aman Lekhi for a question.
Well, my question will be slightly unorthodox. Yes. You said you're qualified and virtually part of the legal community, but in a role of a general counsel, so off the mainstream. And the myriad legal issues which are generally clouding news today and are part of the spectrum of news available, when you see or read about them and familiarize yourself with the controversy surrounding, do you at any point of time regret that you are off the mainstream and as the General Counsel not in a position to actively contribute to the development of those legal issues which may to some extent also have a bearing on the role which you play?
You know, that's a great question too. I don't think I have any regrets at all, not because I am a general counsel and I have to say it, but I think as you grow more senior and as you grow, we have associations and we've got trade associations where we work quite actively. That will surprise you, that even to work as think tanks for the government to, you know, kind of help to bridge that gap between when the regulator makes those regulations and when they get implemented. It is on the corporate world mostly that they get implemented on, but usually there is a little bit of gap which then you struggle with the regulator to kind of rectify. But the role of the General Counsel is quite pivotal at that, and as part of think tanks we have a huge contribution to make, and I'm sure once we are able to take this next step with the blessings of the government and the regulator, I think there is a far greater path ahead for general counsels.
Thanks.
Thank you so much for coming in and in fact interacting. And see, generally general counsels, we invite judges, as you saw, Justice Suryakant was here, Salman Khurshid was here, so many. So GCs I'm happy that they are now coming out and speaking. Earlier it was limited to senior advocates, law firm managing partners and judges. I'm happy that you come, you're vocal. And of course, one last question before we end. You spoke about your role at the General Counsel Association of India. Could you say what you, in a sense, do there in about 30 seconds? What is your goal via that organization?
We just have primarily, we have 5 different goals, but the most prominent and significant one, the reason why we set this up, a few of us who are like-minded, was to bring about recognition to the role of the General Counsel as a specialized stream of law where we need to be at par with any other advocates, which we were when we started off. We had our license, and the way we look at chartered accountants or company secretaries, they don't lose their licenses. So it's all about bringing that level of parity, given the role has evolved over a passage of time. That's our first and most important goal.
Thank you so much for joining us. So, ladies and gentlemen, that was Manjari Chaudhary, General Counsel, Maruti Suzuki India Limited. Thank you.
Thank you, Tarun. Thank you very much for having me here. Thank you.
Thank you so much, Manjari ji, for joining us at the 3rd Law and Constitution Dialogue. A huge round of applause for Manjari Chaudhary, GC Maruti Suzuki India. I request Kartikeya Sharma ji to please present a token of our appreciation to Ms. Manjari Chaudhary. And with that, we move on to our next session. Joining us is Shri Manish Tiwari, member of Lok Sabha from the Congress. He will be moderated by Priya Sehgal, editorial director of NewsX, and they will be discussing the key successes and failures of the Indian Constitution. What a pertinent time to be having this particular conversation. Manish ji, thank you so much for joining us. Priya ji, over to you.
Thank you, Devika. And I welcome Manish, former Union Minister, National Spokesperson, and of course, one of the most articulate voices of the Congress in Parliament. But Manish, today it's really, we are rising above really party politics, and I really want you to take a look at the Constitution, because we are also celebrating 75 years. And, what would you say are the successes and the key successes and failures of the Constitution? I know it's too vast of this thing, but if you can just narrow it down into a few points.
Well, Priya, first of all, thank you very much for having me here. 75 years down the line, when we look at the Indian constitutional experiment, it can be said without any ambiguity that this experiment has been a success. Way back in 1946, even before India attained independence, when the Constituent Assembly met, some of India's finest minds, they did not get into the act of tearing down buildings and building new buildings. They actually sat down, the best of them, for over 3 years and created a document, a ground norm, which would guide India's destiny over the next decades. And there are many countries in the world where constitutions have been scrapped, constitutions have been rewritten, where republics were founded, republics got extinguished. But in India, the constitution has not only endured, but it has thrived. And to a very, very large extent, the credit goes to the Supreme Court, because in 1973, when the Supreme Court, by a sliver of a majority of 7:6, put the basic structure doctrine into place, that actually, if I may say, saved the Constitution from being amended in a manner whereby its originality would have been lost. And so therefore, if you look back, there have been jurisprudential milestones on that journey which have only served to strengthen the Indian constitutional experiment.
But we've also had, this conflict between the parliament and the judiciary, in terms of even where the basic structure is concerned. So can you, walk us through some of those milestones?
Well,
one second. Can we have no silence at the back, please?
Well, that stress is natural in a democracy, because obviously between Parliament, which represents the sovereign will of the people, and the Supreme Court or the judiciary, which is the final arbiter of the Indian constitutional scheme, if there wouldn't be tension, it would have been unnatural. So therefore, the fact that there is tension and at times there is even conflict serves to balance out various interests. And if you go back to the founding years of the Indian Republic, you had a very conservative court, and you had a progressive parliament which wanted to fulfill the commitments that it had made. And so therefore, many of the original constitutional amendments, the creation of the 9th schedule in order to make that immune from judicial challenge, were some of the innovations which Parliament had evolved in order to insulate and firewall scrutiny, judicial scrutiny on each and every action. But the court has been equally progressive and proactive, and it has stripped off or stripped down, each of those so-called firewalls which Parliament had built, and has actually made everything amenable to judicial review, which in any democracy is really a very good thing to do.
That is because you're on this side of the fence. When you were in government, were you so happy with judicial review?
Well, judicial review is a functionality which the courts must exercise, because after all, Parliament is also a creation of the Constitution. Parliament is a creature of the Constitution. The judiciary is also a creature of the Constitution, and the whole doctrine of separation of powers is really predicated upon the executive, the legislature, and the judiciary balancing each other out. But unfortunately, in a Westminster-style democracy, when the executive and the legislature fuse together, so therefore, and then you have what I call whip-driven tyranny, which runs the proceedings of the legislature, then who really acts as a check or as an arbiter on the excesses of the executive. And that is only the judiciary. And they do it through the process of judicial review.
We've had, the recent Places of Worship Act. We've had the court stepping in. Your take on the debate, and also was the act open to review, the 91 Act?
Look, if you go back to the very writing of the Constitution of India, even though the word secular may have been included by the 42nd Amendment in 1976, but the Indian constitutional design per se was extremely pluralistic in nature. And therefore, if you look at the fundamental rights, the kind of protection which has been given to both your right to profess, propagate, and follow your faith in the manner in which you think it is appropriate, the protection which has been given to the minorities, were all a part of the basic design of the Constitution. So therefore, if you start really unraveling history, or if you start digging into the past, the question is, where does it stop? Does it really stop in the 15th century? Or would it really rewind back to the 17th century? Or would you like to rewind back to the before Common Era? So once you start taking a revisionist view of history, there is no stopping you. Because you may then want to draw the line here, but then somebody will come and draw the line further to the right. So under those circumstances, I don't think it serves us either as a republic or as a society if we keep taking these revisionist views, because you are essentially then trying to look at the destiny of India through a rear view mirror rather than moving forward.
But there is also this whole debate around the word secular, that it was added later, and should we now drop it? And they're saying the review of the Places of Worship Act is also against the principles of secularism, the act itself.
Well, the fact is that the Constitution of India, or its preamble as it stands, does talk about a sovereign, democratic, socialist, secular republic. So therefore, that is what we are. Now, whether it was added later or it was there at the inception is neither here or there, for the simple reason the Constitution of India, as it stands today, is after almost 100 or so amendments. Then are you going to say that, this amendment is correct, but that amendment which does not suit us is incorrect? So those who talk about the purest theory of the Constitution forget the fact that it is a living document. And it's a living document which has been adapted to the changes which have come about in the polity and society over a period of time. So this cherry picking that this amendment suits my political predilections and that amendment does not agree with my ideology or philosophy is frankly a non sequitur of an argument.
Which in your view is the biggest failure of our Constitution?
Well, that's an interesting question. And if you actually go back to the debates of the Constituent Assembly, the Indian constitutional scheme as it was conceived was supposed to have powerful states and a weaker center. But when the partition of India was agreed upon in the June of 1947, the 6th of June 1947, if I'm not mistaken, the pendulum swung 180 degrees. So the Union Powers Committee, which was a part of the one of the committees of the Constituent Assembly, then decided to have a stronger center and relatively weaker states. And therefore, the whole mechanism of the concurrent list and a lot of powers being put into the concurrent list in order to give both states and center the right to be able to legislate on them, in my opinion, represents a failure of our constitutional scheme for the simple reason that the balance between the states and the center somewhere got lost in the process. Because if you go to Article 1 of the Constitution, it says that India is a union of states. And it does not say that the states are constituents of the Indian Union. Right? So therefore, there is a very deliberate formulation which has been used in the very first article of the Indian Constitution. And therefore, that's why from the early 50s itself, you've had this raging debate on federalism with the states, irrespective of whatever shade of politics or political hue they were represented by at various points in time, have always been clamoring that the states require greater flexibility, a greater amount of autonomy, greater legislative space. And therefore, I think in the founding years of the Indian Republic, given the manner in which the Republic came into existence, did end up skewing the balance in favor of the center and against the states. And that's a balance which, unfortunately, for reasons best known to our subsequent generations of parliamentarians, we decided not to correct.
Well, national parties feel that it's better to have a stronger center. But we've also now, there is the talk of increasing the number of seats in parliament. The southern states are saying that, we are going to be penalized for, our policies on population. So where is the way out? Because the government is very adamant on going ahead with this.
The question is, how are you going to run that parliament?
That is also true.
It's already difficult to run a house of 543. How are you going to run a house of 750, 1,000? If you want to convert it into the National People's Congress, which is just a figurative rubber stamp of a legislative institution, then it's a different matter. I think this whole business of increasing seats in Parliament needs to be very, very carefully thought through, because after all, the primary function of Parliament is to make laws for the country. That's the fundamental function for which Parliament has been conceived. And the process of making laws requires a very sustained deliberative effort. And therefore, if you are going to have a larger number of people in Parliament, primarily because when the number of 543 odd was agreed upon, you had an X population of the country, and now you have an X plus plus population of the country, then you will also have to really see as to whether then you need to strengthen the committee systems, whereby you will have to make it almost mandatory that every legislation then goes before a committee to be properly scrutinized. I would find it difficult that in a house which is larger than what the current Lok Sabha or the Rajya Sabha is, thoughtful deliberation on national issues and especially legislation would then be easy.
But we are also talking, we are having this debate on one nation, one election. Where do you stand on that? Because, of course, the government is saying we're trying to streamline the process, we're trying to prevent wasteful expenditure.
Look, you'll have to really see the draft of what the government has conceived in terms of legislation, because till the time you do not see as to what that legislation is, it'll be completely inappropriate to comment about it. You can shoot the breeze till the time the cows come home. But essentially the draft needs to be seen, because eventually what really happens when the electoral cycle breaks down in a particular state, or when the electoral cycle breaks down even with regard to the national legislature. And then if you are going to really re-elect a national or a state legislature for the remaining period of that term, are you then really saving money, or are you wasting money if money is the argument that you are making, is something which is moot. So therefore, it really has to be seen as to whether even constitutionally it is feasible. Because let's not forget, federalism has been held to be a part of the basic structure of the Constitution. Now, if federalism is a part of the basic structure of the Constitution, then even under Article 368(4), whereby an amendment which impacts the states has to be passed by half the states, would not also come into play. Because if there are certain features of the Constitution which are unamendable, till the time Kesavananda Bharati holds the field, how really are you going to even implement it? It will fall foul of the basic structure doctrine. So I think I have not really applied my mind to either the report which this commission under, or committee under former President Mr. Kovind has given its report, but it would be interesting to see. But off the bat, I can say that the whole construct of the one nation, one election will fall foul of the basic structure doctrine.
That's a very good argument. But finally, how relevant is Parliament today? You know, we've seen the opposition protesting more outside than inside. Shouldn't you take your protest inside where it really matters, because you have the rest of the year to protest outside?
Well, so there are two answers to that. The first answer is that Parliament will have to very, very seriously look at the 10th schedule. Because while the anti-defection law has failed in its principal objective of curbing defections, it has sucked democracy out of Parliament. So therefore, legislative institutions, as I said, have become handmaidens of whip-driven tyranny. Number two, Parliament is for whom? Is Parliament only the preserve or the prerogative of the government of the day? Or does the opposition, in terms of raising issues of people, is an equal stakeholder in the parliamentary process? And that's a question which unfortunately has never been answered. In fact, I had suggested it to one of the presiding officers in an informal conversation that if you want to keep Parliament in play without disruption, what all that you need to do is between 6 and 9 in the evening, twice or thrice a week, have a Rule 193 discussion on a subject, agreed to by the joint opposition. So therefore, you will have Parliament functioning very smoothly, because ultimately the logjam is the opposition wants certain issues to be discussed. The government is diffident about that. It leads to an unnecessary logjam. And so therefore, government has to show flexibility and magnanimity. And if, let's suppose, you're able to find a modus vivendi whereby the concerns of the government and the concerns of the opposition are both accommodated, Parliament will run very smoothly.
Okay, finally, Manish, which is the debate that you really enjoyed, as an MP, taking part in over the years? You've been now an MP for 15 years, right?
Well, I think the quality of debate in Parliament, and I say this with all respect, was much, much better before the anti-defection law came in. Because when you had to walk the extra mile to actually build a consensus, not with the opposition alone, but within your ranks also. And there was actually a premium on everybody's vote. The propensity to participate in parliamentary proceedings was far, far greater, because you knew that you could actually contribute to making a law or a policy better. But unfortunately, at 2 o'clock in the afternoon, when Parliament meets for its principal business, that is legislation, the House is empty, more or less. And there's an unwritten understanding between the Treasury and the opposition benches that the quorum call will not be made. Because if a quorum call is made, Parliament would get adjourned.
That is true. Finally, we've seen, Parliament debates and prime-time television debates. The functioning of the media and the Parliament. Do you see that the media is actually, as a more disruptive force or as a more positive force? Because we are raising issues that are not being debated in Parliament, at least being debated outside.
Well, I think what used to be called new media about 20 years back, which is television, I think is old and fossilized media today. And so therefore the entire pattern of media consumption has completely and absolutely changed. The plate has become the mobile phone really. And there are far, far more diverse and active platforms which have become the primary sources of media consumption. So under those circumstances, how really relevant do they consider Parliament to their lives, is a moot question. But eventually, if Parliament keeps itself in play, Parliament keeps functioning, and people see it as an institution which is prone to working and not disruption, I think even the quality of media debates would also get much better.
Otherwise, I think Twitter is now, social media is becoming the new Parliament, and influencers are the new MPs, I think, by the end of it.
Well, I think Twitter or X has also become old media, because if you talk to younger people, they say that Twitter or X or Facebook is for the 40 or the 50 plus. That's what I'm saying, that the whole patterns of media consumption are changing or have changed so rapidly that that is a subject of, I must say, a longer and another discussion.
But whenever we interview Manish Tiwari, sorry? Exceptions are always here, sitting right here. But with Manish Tiwari, one must always have a dictionary in hand whenever I used to interview him. But, have you also changed your language and simplified it for the Twitter X generation?
Well, my language is what it is. And if somebody cannot figure it out, I think if they go and consult a dictionary, they learn a few additional words also.
Educated husband. Thank you so much, Manish, for this conversation. Thank you.
Thank you so much, Manish ji, for joining us. I request Kartikeya Sharma ji to please join us on stage to present a token of our appreciation to Shri Manish Tiwari, Member of Lok Sabha of the Congress and Senior Advocate. Thank you once again, Manish ji, for joining us at the third Law and Constitution Dialogue. Without further ado, let me introduce our next guest. Shri Vivek Tankha, Senior Advocate and Member of Parliament, Rajya Sabha, also joins us this evening to have a riveting conversation with Tarun Nangya, Editor of Legally Speaking, on Constitution and Politics.
It's a pleasure to have Mr. Tankha on this event today. And of course, there are a lot of non-lawyers here, so I must also give an introduction. So he has served as the Advocate General of Madhya Pradesh long ago, then served as the Additional Solicitor General of India, very famously more than a decade ago. Now he is the second time sitting Member of Parliament from the Congress Party, and a very vocal voice in the party forum and in Parliament. Unlike other lawyers, you wear dual hats. You are in court, you are in Parliament, so you make law and you also argue for clients. That's why you will give a different perspective to things. Could you just, in a sense, give a comment on that role of yours as a lawyer and yours as a lawmaker?
Tarun, first of all, thanks for inviting me, Kartik. let me tell you that it's a confession. I never thought I would be entering such active politics to begin with. I had many offers in the 90s and the early 2000s, and those were good offers. But I would always tell people putting me these offers that I want to first do well in my profession, which is my real calling. So I was happy to be the State Advocate General, and that was the time, if you remember, Madhya Pradesh got divided, we reorganized. You can say I was one of the authors of the Reorganization Act, and also one of the persons who was solving the problems arising out of reorganization. So there was a wealth of experience. Then as Additional Solicitor General, it was a different ballgame in Delhi. And finally now as a Member of Parliament. I have enjoyed each part independently. But I also feel one adds to the other. So for me, this is what I was doing earlier. Parliamentary activity is only an extension of that.
See, one thing that you would appreciate, that the kind of legislation that Parliament makes is clogging our courts with unnecessary cases. I'll point out two instances. The prohibition law on liquor in Bihar. Now the courts are clogged with these matters, so they don't get time to adjudicate on matters which, concern people, and, disposals are necessary. Also, there are many other laws which, for example, the laws on twin conditions for bail, that have also, led to a lot of litigation. Do you think the parliaments fall short on, maybe discussing better so that, we could have laws that would not clog the courts with litigation?
We have very eminent parliamentarians sitting here in the front row also, and eminent law officers also, past law officers. But let me tell you, do we really matter? There's a debate, but there's a preconceived law which is put up in the parliament. You put in your best arguments. I don't think they're interested in changing it. The debate is like a farce which takes place because it is necessary. Because you have a parliament, it has to pass a law, there has to be a 2-hour discussion where you have ration time to speak. Some people get an opportunity, some don't get an opportunity. People like Kapil Sibal don't participate because they don't get time. They said, as an independent, we get only 3 minutes. How do I contribute in 3 minutes? Kartike? Yeah, once in a way they get 5 minutes. So it's a very slipshod situation. I feel there should be more seriousness in this whole apparatus, this whole approach. Parliament should actually be a serious lawmaking body. If I was now in a constituent assembly, and if we were remaking our Indian constitution, I would have separated the executive from the legislature. The fact that you have ministers responsible to the parliament, the ball game changes. Make parliament only for lawmaking, like you have in America. More of a presidential system.
Many times parliamentarians, much like you, when they talk to us privately, they say, Tarun, much work gets done in parliamentary committees. There is a free and frank discussion that leads to the evolution of good laws. But going by the past many years, it doesn't seem that that is happening. What needs to improve?
No, parliamentary committees is a good step forward. In fact, if we have contributed in lawmaking, it's more through the committees. I have been part of many JPCs. I have been I'm still a member of that Law, Justice and DOPT standing committee. So we do make and contribute in lawmaking, because there, at least, when you discuss laws, you're not talking as a party man. You're contributing as a member. In a standing committee, it's not so much of party. It's more as a lawmaker. But when we're debating in parliament, we are debating as a party man. There's a difference. Kartike would know, Manish would know. If I'm wrong, they would say that. But that is the difference I've seen.
One thing that I would want to know from you, that about the central hall. A lot of MPs are talking about the new parliament not having a central hall. How did it enrich conversation? Does it really matter if the central hall is not there in new parliament?
I completely endorsed what majority of parliamentarians say, and I am part of that there should have been a central hall. You can't have a effective parliament and a communication system without a central hall. Today when I finish, if I'm not sitting in the house, I have to go and go to the cafeteria or go home. Earlier times, if I would get up for a while, I would walk into the central hall. Parliamentarians from Lok Sabha, Rajya Sabha, they all would sit there. We would chit-chat. Today I don't know who's in the Lok Sabha. And the Lok Sabha people don't know who's in the Rajya Sabha. Even ex-parliamentarians, ex-ministers would come into the central hall. Even journalists, accredited journalists used to be there. So I don't know why this new system was evoked. And frankly speaking, in my opinion, there should have been a better consultative process about doing away with a central hall when the parliament was new parliament was being established. I am sure it should not be left to whims and fancies of a few individuals to decide whether we should have a central hall or we should not have a central hall. It's the country which should decide, not the whims and fancies of few people.
I also want to know from you that in your experience, that now this is the second term that you're part of parliament. If you can give 3 suggestions that you would want things to change, 3 quick suggestions, and then we can move on to the next set of questions.
Number 1, I hate parliament proceedings being disrupted. If we are in parliament, parliament must work. I checked with my friends in US and UK, my parliamentary friends in these 2 places. They said there's no question of parliament being disrupted. There could be a noise or a shore for 5-10 minutes, and then again the parliament starts. How could you not have parliament for the whole day? It doesn't matter which party is in power. BJP was doing it earlier. We and others are doing it now. And maybe for valid reasons. But this whole concept of parliament not working, and maybe this is also because of the kind of engagement today the ruling party has with the opposition. You don't want to engage yourself with the opposition in the parliamentary agenda. I gave a suggestion in writing to the chairman. I said, look at the British tradition. You know, in UK, 1 day is given to the opposition. 1 day is given to the opposition. You lay down the day's agenda. So if as a Congress, I have 1 day at my disposal, I'll put my issues on that 1 day. There will be no disruption in other 5 days, or 4 days.
One last answer on the use of question hour. Do you think it's being effectively used? The question hour.
No, not at all. I'll tell you, I'm most dissatisfied. You get a very vague answer, and when you get that vague answer, you put a couple of supplementaries. Half the time, people who are answering you are ill-informed or less informed. And then, if you want to ask more, you'll be told that you can use other provisions of the rules to take it forward. I feel it's not as effective as it should be.
This was a short but a really engaging conversation with you on Parliament. Some interesting points you made, and we would now like to invite one more panelist to join you to continue the discussion.
Sure.
Mr. Tankha, some pertinent points there raised, and we will of course be taking that forward with Shri Aman Lekhi, former ASG and senior advocate, who also joins us at the third Law and Constitution Dialogue. Tarun was just having a conversation about whether parliamentarians are doing a good enough job of drafting the laws which seem to be clogging up our courts. So, Tarun, taking that conversation forward, we will of course be discussing the 3 new laws that have been introduced. Are they addressing the deficiencies of the past? Tarun, over to you.
Thank you, thank you. So we continue our conversation. Of course, we have the benefit of having senior advocate Aman Lekhi, who has defended the government as the Additional Solicitor General of India for many years. And so we will get both sides, from the prosecution side as well as from somebody who defends people in court on a day-to-day basis, MP and also senior advocate. Your first comment on the 3 new criminal laws, and then we'll go to senior advocate Aman Lekhi.
On the 3 criminal laws. Frankly speaking, what was the need to change? I mean, today, everybody is trying to find out which law now I have to apply in this case, because the numbers have changed. What was the need to change numbers? Why are you making things difficult for the entire legal law fraternity, judges, students, policemen, everybody? I mean, frankly speaking, you've changed things for the state. I'm always a votary. I welcome change. Change always must be for betterment, for good. Now, if you are going to amend 6 or 7 or 8 sections of Evidence Act, and you repeal the entire act and bring in a new law, 80% of the old sections are only renumbered. What is this change you're talking about? This is not a change. Only thing is you made things difficult for everybody.
So you mean India has not given itself a new law? That is
No, you have given a new law, but the new law is actually the old law with a few changes. So you could have amended the old law. You wanted to change the name, you could have changed the name of the old law. Who stops you? So what I say is, every time to say that I'm going to bring a new thing is not an acceptable way of changing.
Point very well taken. We will now take the introductory comment for Senior Advocate Aman Lekhi. Of course, now you are appearing, you're no more ASG, so now you're appearing in your defense counsel.
Let me first clarify. Even as an ASG, it's not as if you take sides. In fact, the role of a law officer of the government is not to be partisan.
Yes.
So, and I've never been partisan. And that's one of the reasons why I left. So anyway, that's a different story altogether. I broadly agree with Mr. Tankha, but I'll be slightly more emphatic. I personally feel that as to the criticism of the old laws are concerned, it's criticism of the uninitiated in law. And it is wholly unwarranted, totally unjustified, and utterly gratuitous. What it shows is betrays ignorance of our legal system. To denounce it as colonial is utterly wrong, totally wrong. And the greatest testimony to this particular fact is the remodel laws, which more or less, as Mr. Tankha said, continue the old law. So that is something, that's a reality which you cannot in any way move away from. Now, what is very important is, if you look at the 3 laws, insofar as the Evidence Act is concerned, the principles of the Evidence Act, there are certain fundamental principles of the Evidence Act, which remain unchanged in the new laws, because relevance, admissibility, best evidence, these are the 3 principles continued. Insofar as the CRPC is concerned, to say the CRPC is a colonial construct is baffling, because the 1898 code, which is the pre-independence one, was substituted by the 73 code. That is way into independent India. And there have been 3 law commission reports dealing with that, all Indian. Insofar as the IPC is concerned, in the 160 years, 170 years the IPC was there, there has been no major change. Even in fact, the changes that have been made in the current code, in my opinion, are not changes which are in any way in advance of what should be done, but are in some way extremely retrogressive, if not at times utterly stupid, in the sense that if you look at terrorism, terrorism is in an offense relating to harm to body. Now you cannot possibly have terrorism and harm to body. So the basic understanding of the placement of the sections, which is what is being reorganized, is utterly wrong. And finally, when you look at what this is recodification. As far as recodification is concerned, it's a massive exercise. It is supposed to address it for the purposes of, in some way, dealing with the anomalies which are there. Now, far from addressing the anomalies, it has created more anomalies. And I can carry on. So as far as this particular approach is concerned, I personally feel it is unnecessary. And as Mr. Tankha said, 80%, I don't think it's 80%. In fact, it's more than 95% of the law is more or less the same. 80% is an understatement. And except for a few changes, say in the illustrations or marginal notes or grammatical mistakes, there is no other change in the law.
One thing that we have noticed that people have praised the new laws a lot for the use of DNA evidence. Every police station in the country will have a team that will go to the crime scene, protect the crime scene, and earlier the evidence was ocular, which means the policeman, for the benefit of my audience, the policeman used to beat out and take a confession, but now DNA evidence has been made compulsory, so every police station I will have a DNA party, they will go take evidence, and that will in the end aid the prosecution in proving their case. Do you think that's one of the good aspects of this law?
The law always evolves. Tarun, there's nothing wrong in bringing in new scientific methodologies of investigation. I mean, today it's DNA, tomorrow it'll be something more. So this evolution was coming all the time. I mean, if it happened so many times, there were amendments, presumptions change also many times. So what we are, as he rightly says, all this could have been just brought as an amendment. You don't need to change the book. You need to change 2 lines. That could have been just an amendment and everything else would have remained the same.
Point well taken. I'll go to Senior Advocate Aman Lekhi.
I really don't see. There are rhetorical flourishes which I feel make more of political than legal statements. So you have timelines, you have DNA and everything. It's not as if there was no DNA evidence before the amendment. It is part of the investigatory process. And now it's not enough merely to have some DNA evidence. You need to have...
There is one topic also that we are now witnessing on a day-to-day basis is this criticism of judges on social media. Suddenly we see a judge makes a comment in Supreme Court and there are armies of people who start to criticize a judge, and of course judges have also spoken about it, that trolling happens. Since you're an eminent parliamentarian and you see this issue from, the perspective of, parliamentarians can speak out, lawyers can speak out, judges can't speak out. Anything you want to speak on behalf of the judges or your comment on this?
These are 2 separate issues. One is, when you're sitting in a court as a judge,
yes,
you have to be careful about what you say and speak. You can't be taking sides. You have to hear 2 sides, look at the law and decide the matter. I am a votary of independent judiciary.
Okay.
I am a complete votary of independent. It doesn't matter which party is in power. If there's no independent judiciary, there is no democracy to begin with. And if you want to keep our fundamental rights and our rights safe, you need independent judiciary, always. It doesn't matter whether he's practicing or I'm practicing or who's practicing. Number 2, if you are moderate in your language, nobody is going to troll you.
Is it?
If you come with those flourishes and say awkward things, they get reported and people troll you. So if you are going to speak, don't be scared, then don't be concerned that people troll you. I feel that judges are open to public criticism. They should be open, they are like everybody else. In fact, I say that even the law of contempt is an archaic law. You don't have contempt law in US. If you are good, if you are correct, what you are saying or doing is correct, people will judge you. You should not be bothered if 1 or 2 people find you wrong. So my issue is that judges should not be concerned about being trolled. My thing is, you should be open to criticism, and this is a public position, a public post. You are deciding rights of common man. So obviously, people have a right to speak about you.
Point very taken. So on criticism of judges on the social media, Senior Advocate Aman Lekhi will speak.
Well, I personally feel criticism is basically euphemism for ideologically driven agendas. I personally feel that is so. We have, insofar as those, I'll put the expression criticizing in inverted commas, we choose episodes and events on which we speak. And the choice of those elements is an element of gatekeeping. Now, gatekeeping is supposed to construct discourse in a particular way. So you highlight certain aspects so as to either divert attention from others or needlessly focus on issues which can be best avoided or be treated as non-issues. As far as criticism is concerned, I don't think judges can be averse to criticism, or criticism of judges is unwarranted. What I am against is the use of criticism to promote an agenda. Okay. And insofar as that question is concerned, that you cannot have a general proposition that you can't do this and you can do that, because insofar as speech is concerned, drawing of lines is completely unwarranted. It has to be done on an individual basis. To the extent it is unnecessary, criticize it. If it is not, welcome it.
Thank you. I would like to thank Senior Advocate and Member of Parliament, Mr. Vivek Tankha, Senior Advocate Aman Lekhi for coming here, for making time and speaking on important issues related to judiciary, related to Parliament. It was a pleasure having both of you. Thank you so much for coming. Thank you so much.
Could I request Kartikeya Sharma ji to kindly come on stage? Gentlemen, please stay for a second. We have a special Forget Us Not. It's a monogrammed copy of the calligraphy edition, which weighs 5 kilos of the Constitution of India. So you've heard it. The calligraphy has been done by an individual from Jabalpur, which of course is hometown for Mr. Vivek Tanka. Round of applause, please. They're also getting a framed copy of a photograph of the first Constituent Assembly meeting held in 1946. And a copy also for Senior Advocate and former Additional Solicitor General, Mr. Raman Lekhi. Sir, appreciate you taking out the time to be part of this conference, not only physically here, but of course across all the 9 news channels of ITV network, and of course so many social media verticals where this is all streaming live as we speak. With that, ladies and gentlemen, let us welcome an individual who has literally been speaking in Parliament less than half an hour ago. Lok Sabha MP of the Bharatiya Janata Party, Chairman of the Waqf Committee, Mr. Jagdambika Pal is with us. Tarun, you want to say a word? No. We will be having Rakesh Singh, the Managing Editor of ITV Network, along with our Senior News Editor, Devika Chopra, who will be moderating this session. Jagdambika ji, please, let's have you on stage.
जगदम्बिका जी बहुत बहुत धन्यवाद आपका बहुत ही इंटेंस सेशंस चल रहे हैं आजकल पार्लियामेंट में तो वंस अगेन थैंक यू वेरी मच सर फॉर टेकिंग आउट द टाइम टू डू दिस बहुत ही पर्टिनेंट कॉन्वर्सेशन
आप धन्यवाद दे रहे हैं मैं क्षमा मांग रहा हूं मुझे राकेश जी ने आपके 2:30 बजे का टाइम का कमिटमेंट लिया था और आई हैव मेड इट कमिट आल्सो बट बिकॉज ऑफ ओनली हाउस वाज इन सेशन आई कुड नॉट कम तो फर्स्ट ऑफ ऑल आई मस्ट जस्ट
We completely understand, sir, but we're
मुझे आज
grateful
बोलना
that
भी
you've
था
taken.
संविधान पे तो अभी मेरी स्पीच खत्म हुई और स्पीच खत्म करने के बाद मैं सीधा चला आया आपके कार्यक्रम में.
We're ever so grateful, sir.
Thank you.
But without further ado, I want to begin the conversation. जगदम्बिका जी, वक्फ एक्ट आप जेपीसी के चेयरमैन हैं तो आपसे कोई बेहतर नहीं हो सकता ये इस कॉन्वर्सेशन के लिए इस मुद्दे के लिए. पहले तो हम ये समझना चाहेंगे कि क्या वक्फ एक्ट को रिव्यू करने की आवश्यकता है?
देखिए कोई कानून बनता है मैं खाली वक्फ की बात नहीं कर रहा हूं इवन कॉन्स्टिट्यूशन है तो कॉन्स्टिट्यूशन की कितने अमेंडमेंट्स हो चुके हैं तो इससे लगता है कि जब समय बदलता रहता है वक्त की रफ्तार में देश के हालात पे हर कानून में परिवर्तन होता है और डेमोक्रेसी की सबसे बड़ी ब्यूटी यही है कि अगर आपका संविधान फ्लेक्सिबल ना हो कानून में अगर संशोधन आप ना करें तो फिर तो आप एक चीज़ें स्टैटिक हो जाएंगी. तो वक्त भी जो प्रिंसिपल एक्ट है 1995 तो आज उसमें ज़रूरत है. ज़रूरत किस बात के लिए है कि जो वक्फ जिस पर्पज के लिए आदमी करता है कौन करता है कोई वाकिफ करता है जिसकी पर्सन जिसकी अपनी डेडिकेटेड प्रॉपर्टी है तो वो अपनी डेडिकेटेड प्रॉपर्टी को डेडिकेट करता है ऑन द नेम ऑफ द गॉड या अल्लाह एंड फॉर द रिलीजियस पर्पजेज फॉर द चैरिटेबल पर्पजेज एंड फॉर द पायस पर्पजेज. तो अगर वक्फ का पर्पज ये है कि हम अपनी संपत्ति को अल्लाह के नाम पे ईश्वर के नाम पे अगर हम वक्फ कर रहे हैं कि इसका फ़ायदा आम पसमानदा मुस्लिम्स को गरीब को ख़वातीन को बच्चों को उनके एजुकेशन के लिए हेल्थ के लिए मिले तो स्वाभाविक है कि अगर ये लग रहा है कि वो वक्फ का पर्पज नहीं पूरा हो रहा है. आप देखिए कि वक्फ की कितनी बड़ी प्रॉपर्टी लोग कहते हैं या जो आंकड़े भी हमारे पास आए कि रेलवे और डिफेंस के बाद सबसे ज़्यादा वक्फ की प्रॉपर्टी है करीब मतलब 9.75 लाख एकड़ और करीब 8 लाख वक्फ हैं. तो इतनी परिसंपत्तियाँ हैं. इसके बावजूद भी कहाँ देख रहे हैं कहीं कि कोई मेडिकल कॉलेज हो कोई यूनिवर्सिटी हो कोई एजुकेशन के क्षेत्र में काम हो रहा. तो इससे साफ और आप ये भी सुनते होंगे कि वक्फ की प्रॉपर्टी को कहीं मुतवल्ली खुर्द बुर्द कर रहे हैं या कहीं उसका मिसयूज हो रहा है. तो जब ये हालात होते हैं तो वक्त के साथ फिर आज जो सरकार इस वक्फ को अमेंडमेंट करने का एक बिल लेकर के आई अगर उसे पास करना होता जैसा एक लोगों को सवाल उठता है कि साहब ये एक्ट पास हो जाएगा तो वक्फ की प्रॉपर्टी चली जाएगी मस्जिद चली जाएगी दरगाह चली जाएगी खानकाह चला जाएगा ईदगाह चला जाएगा एक ऐसा परसेप्शन क्रिएट हो रहा है लेकिन अगर मान लिया इस एक्ट का यही पर्पज होता तो फिर एक्ट को सरकार पास कर सकती, दोनों हाउसेज में बहुमत है, मेजॉरिटी है। लेकिन इसके बावजूद खुद सरकार के संसदीय कार्य मंत्री, अल्पसंख्यक मंत्री ने कहा कि स्पीकर साहब से कि साहब हम इस पे और डिटेल डिलिब्रेशन डिस्कशन चाहते हैं कि थ्रेड एंड वेयर जितने स्टेक होल्डर्स हो, चाहे इंडिया मुस्लिम पर्सनल लॉ बोर्ड हो, इस्लामिक स्कॉलर हो, वाइस चांसलर्स हो, फॉर्मर जजेज हो, या हमारे हर स्टेट्स की जो वक्फ बोर्ड है, माइनॉरिटी कमीशन है, या स्टेट के जो ऑफिशियल्स हैं, इनके साथ एक डिटेल डिलिब्रेशंस हो, इसलिए इसको जेपीसी को सुपुर्द कर दिया जाए। तो खुद सरकार ने सुमोटो इसको अगर जेपीसी को सुपुर्द करने का आग्रह किया और स्पीकर साहब ने इसको जेपीसी को दे दिया और वो जिम्मेदारी मुझे मिली। तो इससे साफ तो मैं आपके माध्यम से कर देना चाहता हूँ कि सरकार का नज़रिया ये है कि अगर इस कानून में प्रपोज अमेंडमेंट्स हैं तो वो लोगों के साथ, पूरे देश के स्टेक होल्डर के साथ एक चर्चा हो, और वो भी स्टेक होल्डर से आप देखते होंगे, आपको भी रिपोर्ट्स आती होगी कि पिछले 3 महीने में हम 29 मीटिंग्स कर चुके हैं
जी।
दिल्ली में 29 बैठकें ज्वाइंट पार्लियामेंट्री कमेटी के मेंबर्स की।
पाल साहब एक महत्वपूर्ण सवाल ये है कि क्या यह सच है कि वक्फ जो है भारत में किसी भी संपत्ति पर अपना दावा कर सकता है?
देखिए, वक्फ का तो एक प्रोसेस है। आखिर वक्फ बोर्ड क्यों दावा करेगा? वक्फ तो उसका होता है कि कोई व्यक्ति अपनी प्रॉपर्टी को वक्फ करता है और वो जिस पर्पज के लिए करता है उस पर्पज में उसके काम आता है। लेकिन जो सवाल आपने उठाया बड़ा महत्वपूर्ण है। अभी आपने देखा कि पिछले दिनों वाराणसी में उदय प्रताप कॉलेज की 100 एकड़ जमीन पे वक्फ ने कह दिया। आपने एक आसाम फॉर्मर मेंबर ऑफ पार्लियामेंट रहे हैं, उन्होंने कहा जो नई पार्लियामेंट बनी है वो भी वक्फ की प्रॉपर्टी पे है और वक्फ है। फिर समाजवादी पार्टी के मुंबई के नेता ने कहा कि साहब जो मेंबर ऑफ पार्लियामेंट्स हैं वो वक्फ की मतलब प्रॉपर्टी तो उसका किराया दे। जबकि मैं एक बात आपको बता दूं राकेश जी, 1911 में जब ब्रिटिशर्स थे तो उन्होंने कोलकाता से राजधानी, कोलकाता से दिल्ली बनाने के लिए उन्होंने यहाँ 2 मौजे का एक्विजिशन किया। पूरे लैंड का 1911 में एक्विजिशन हुआ, कंपनसेशन दिया गया और सरकार ने उसको ले लिया। 1970 में, कहा 1911 में जब ब्रिटिशर्स ने पूरी राजधानी के लिए कर दिया, 1970 में वक्फ बोर्ड ने कहा कि 123 प्रॉपर्टी हमारी है, जिसका कि आज भी कोर्ट में, हाई कोर्ट में स्टे है। तो आप सोचिए कि ब्रिटिशर्स ने उस समय कैपिटल के लिए इसी लुटियन जोन्स और आसपास में जो प्रॉपर्टी का कंपनसेशन दे चुके हों उसको भी वक्त आज क्लेम कर रहा है और उसका विवाद चल रहा है। एएसआई की जो प्रॉपर्टीज हैं जो नेशनल इंपॉर्टेंस, किसी देश में एएसआई कोई प्रॉपर्टी को ओन नहीं करता है
जी।
अब बहुत से हमारे लॉ के जानने वाले लोग बैठे हैं। एएसआई का काम किसी भी मुल्क में, किसी भी देश में, जो उस देश का चाहे किसी भी सेक्ट का कोई मॉन्यूमेंट हो जिसकी हिस्टोरिकल इंपॉर्टेंस हो, नेशनल इंपॉर्टेंस हो, तो उस लेवल पे बाहर से दुनिया के टूरिस्ट आते हैं, वो जाते हैं। ऐसे एएसआई के साथ भी है वक्त पे। अभी पिछले दिनों कर्नाटका में आपने सुना होगा कि कर्नाटका में मैं खुद भी गया, बेलगाम गया, बीजापुर गया, हुबली गया। जब से ये जेपीसी को सुपुर्द हुआ, खाली बीजापुर में 16,000 एकड़ जमीन किसानों का को वक्फ की नोटिसेज मिल गई हैं। अब वक्फ के किसान जो ओवर मतलब जनरेशन से वो कल्टीवेट कर रहे थे, अब और वहाँ वक्फ बोर्ड के मंत्री हैं, उन्होंने अदालतें लगानी शुरू कर दी, वक्फ अदालत, म्यूटेशन भी कराना शुरू कर दिया, दाखिल खारिज और टेम्परिंग। तो ये 38% लोगों ने बताया कि जब से आपकी कमेटी को रेफर हुआ है तो 38% नोटिसेज वक्फ बोर्ड की बढ़ गई हैं। अभी महाराष्ट्र के लातूर में आपने सुना होगा कि वहाँ किसानों की, तो ये जो चीज़ें आ रही हैं इसकी एक प्रक्रिया है, लेकिन इसके बावजूद भी उसी प्रक्रिया को दूर करने के लिए आपका बड़ा महत्वपूर्ण सवाल है कि क्या किसी भी प्रॉपर्टी को वक्फ कोई घोषित कर सकता है? तो आज इस तरह की जो एक कन्फ्यूजन है या जिस तरीके से ये डिस्प्यूट उठ रहा है, इसको पटाक्षेप करने के लिए आज ये हो रहा है कि भाई जो भी वक्फ की प्रॉपर्टी हो वो वक्फ की प्रॉपर्टी को रजिस्टर्ड किया जाए और रजिस्टर्ड करके एक वामसी पोर्टल है, उस वामसी पोर्टल पे वक्फ की प्रॉपर्टी को रजिस्टर्ड कर दिया जाए और अगर वामसी पोर्टल पर रजिस्टर्ड हो जाएगा जो भी वक्फी प्रॉपर्टी, या एक्ट के पास होने के बाद भी 6 महीने तक हो जाएगा, तो वो वक्फी रहेगा। ये लोगों में अब क्या है, बरेली के एक मौलाना है, उन्होंने कहा सड़कों पे हम आ जाएं तो रूह कांप जाएगी
जी।
अब आप देखते होंगे जाकिर नाइक वहाँ से बैठ करके मलेशिया से कहाँ से वो कह रहे अगर 50 लाख लोग पार्लियामेंट के पोर्टल पे इसको डिसअप्रूव कर देंगे तो ये डिसअप्रूव हो जाए। तो आप सोचिए इंडियन पार्लियामेंट्री डेमोक्रेसी में अभी तो ये कानून भी नहीं बना, और ये कानून जो विचार कर रही है अकेले कोई रूलिंग पार्टी नहीं कर रही, सभी पार्टी के 31 मेंबर ऑफ पार्लियामेंट्स हैं जिनके सामने लगातार हम बैठ के कर रहे हैं। एक बैठक कम से कम 6.5 घंटे एवरेज हमारा है, और इसके बाद स्टेट्स में भी हम जा रहे हैं। हम अब तक महाराष्ट्र हुआ है, कर्नाटका हुआ है, तमिलनाडु हुआ है, तेलंगाना हुआ है, उड़ीसा हुआ है, आसाम हुआ है। तो इस तरीके से आप देखते हैं कि तमाम राज्यों में जाके वहाँ के भी स्टेक होल्डर से मिले। इतनी डिटेल डिलिब्रेशन, इतनी एक्सरसाइज शायद कभी किसी जेपीसी में नहीं हुई। हमारा भी पर्पज है कि एक ऐसा फुल प्रूफ कि जो एक वाकिफ है, जो वक्त जिस पर्पज से करता है उसके पूरा ट्रांसपेरेंट ढंग से उसके उद्देश्य को पूरा किया जाए। लेकिन आज आखिर क्यों विरोध हो रहा है, जब वक्त की प्रॉपर्टी का सब रजिस्ट्रेशन हम कराने जा रहे हैं और इस कानून के प्रपोज में अच्छा कलेक्टर मान लिया इस पे होगा, तो अब उससे सारी रिकॉर्ड कीपिंग रखने का काम आज भी लैंड का होता है, या ट्रिब्यूनल में हो कि अभी तक ट्रिब्यूनल का एक डिसीजन फाइनल होता था। लेकिन आप दूसरे सिविल मामलों में अगर आप कहीं भी एग्रीव्ड हैं तो यू कैन गो टू द हाई कोर्ट, यू कैन गो टू सुप्रीम कोर्ट फॉर अपील। अभी इसमें अपील का कोई प्रोविजन नहीं है।
तो अगर जी सर, इसी पॉइंट पे एक बहुत और महत्वपूर्ण सवाल है। मैं अभी रिकॉर्ड्स पढ़ रही थी गवर्नमेंट ने जो रिलीज करे हैं, 40,000 से ऊपर केसेस, 40,975 एज पर गवर्नमेंट records cases are currently pending in tribunals, as you've pointed out. These are against waqf claims, and इसमें से over 9,000 cases, 9,000 से ऊपर केसेस मुस्लिम्स ने डाले हुए हैं अगेंस्ट द इंस्टीट्यूशंस विच आर मैनेजिंग वक्फ। तो क्यों है कि कोई जुडिशियल ओवरसाइट नहीं है? क्योंकि ये भी कहा गया है कि जो मुस्लिम नेशंस हैं, सऊदी, कुवैत, ओमान, पाकिस्तान, बांग्लादेश, तुर्की, इन सब में वक्फ कम्स अंडर द लॉज एंड इंस्टीट्यूट्स क्रिएटेड बाय द गवर्नमेंट्स। तो ऐसा क्या है कि भारत में हम ये इम्प्लीमेंट नहीं कर पा रहे, या ये जब कॉन्वर्सेशन होती है तो ये कहीं एक एंटी मुस्लिम का इट बिकम्स एन एंटी मुस्लिम कॉन्वर्सेशन?
तो आप एकदम आपने इतना महत्वपूर्ण सवाल उठाया है कि आज वक्फ की इतनी प्रॉपर्टी डिस्प्यूटेड है, ट्रिब्यूनल में पेंडिंग है, 9,000 से ऊपर वो है, लगभग 54,000 करीब प्रॉपर्टीज हैं जो डिस्प्यूट में पड़ी हैं, इसलिए कि आप हाई कोर्ट जा नहीं सकते, अपील में सुप्रीम कोर्ट जा नहीं सकते। और जो आपने जिक्र किया कि तमाम इजिप्ट हो, टर्की हो, सऊदीया में हो, बहुत जगह आखिर ये वक्फ का कोई वो नहीं है। तो आपने देखा कि जब कॉन्स्टिट्यूएंट असेंबली थी तो कॉन्स्टिट्यूएंट असेंबली में भी डॉक्टर भीमराव अंबेडकर जी हों, के एम मुंशी जी हों, या सरदार पटेल हों, या पहले राष्ट्रपति डॉक्टर राजेंद्र प्रसाद जी हों, सब ने कहा था, उस समय उन्होंने टर्की और इजिप्ट का उदाहरण दिया था कि बहुत से सेक्ट है, खोजा सेक्ट है वहाँ पे, और ये है, वो लोग नाराज भी हुए जब वहाँ पे एक यूनिफॉर्म सिविल कोड बनाया गया। तो आज अब कहीं ना कहीं उन लोगों ने जब यूनिफॉर्म सिविल कोड की बात कही कॉन्स्टिट्यूएंट असेंबली में, उस समय नहीं बन पाया, लेकिन डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी में आर्टिकल 44 में डाला गया। तो आर्टिकल 44 में आज वो नीति निर्देशक के तत्व हैं। तो आज जरूरत है, मैं तो कह रहा हूँ इससे जुड़ा हुआ सवाल, कि फिर तो आपने जो सवाल किया उसमें एक ही रास्ता है कि जो बाबा भीमराव अम्बेडकर जी ने कहा, या सरदार पटेल ने कहा, या राजेंद्र जी ने कहा, या के मुंशी जी ने कहा, अंगारकर, ये तो जरूरत है कि फिर एक समान नागरिक संहिता हो, क्योंकि फिर ये क्यों हो अलग अलग। आज 15 कानून ऐसे होंगे, हिंदू के भी तमाम होंगे, सारे कानून खत्म हो जाएंगे, एक यूसीसी रह जाएगा। तो इस तरीके से मुझे लगता है कि आज ये जरूरत है, जो आपने पहला सवाल किया था कि आखिर क्यों जरूरत है, आज तो आपने उससे आगे बढ़ के एक सवाल कर दिया कि अभी तो जरूरत थी कि आपने ये पूछा कि प्रपोज अमेंडमेंट की जरूरत क्या है। भाई 1995 का अमेंडमेंट हुआ या 2013 का अमेंडमेंट हुआ, वो कब हुआ? कहीं ना कहीं चुनाव के जस्ट पहले हो गया। लेकिन अगर आज अमेंडमेंट हो रहा तो अभी कोई चुनाव भी नहीं, आज एक ट्रांसपेरेंट ढंग से बनाने की बात हो रही। लेकिन जब आप तमाम इस्लामिक कंट्रीज की बात कर रहे हैं तो इससे साफ है कि फिर जब हमारा संविधान सबको इक्वलिटी और जस्टिस की बात करता है, सबको, चाहे आर्टिकल 14 की बात हो या फंडामेंटल राइट हो, आर्टिकल 19 की बात हो, तो ये सबकी है। तो जब सबका बराबरी का हक है, तो जिस समय शरीयत की बात हो रही थी या उसको भी, उस समय भी उन कंट्रीज में कहा कि नहीं, ये जरूरत है कि एक कानून हो, क्योंकि सेक्ट तो बहुत होते हैं, तो अलग अलग सेक्ट के कितने कानून चलेंगे। जब हम एक ऐसा संविधान दे रहे हैं कि उसमें चाहे राइट टू फ्रीडम ऑफ स्पीच एक्सप्रेशन हो, राइट टू सेटल या आर्टिकल के 19 के सभी जो आपके मौलिक अधिकार हैं, तो फिर डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी को कौन लागू करेगा?
पाल साहब एक, क्योंकि यहाँ पर डिलिब्रेशन हुआ, एक कांग्रेस के सांसद आए थे नासिर हुसैन, उन्होंने कहा कि ये मौजूदा सरकार की जो सूचना अभियान के अलावा कुछ नहीं है, ये केवल दिग्भ्रमित किया जा रहा है। क्या कहेंगे आप?
अब नासिर साहब हमारे जेपीसी के कमेटी के मेंबर हैं और लगातार वो हमारी मीटिंग में भाग लेते हैं, कंट्रीब्यूट कर रहे हैं। जेपीसी बनी है तो ये नहीं कि केवल हम किसी के लिए फार के लिए सुनने के लिए अगेंस्ट, मतलब जेपीसी बनने का मतलब है कि किसी को भी अपने व्यूज देने हों, सजेशंस देने हों, ऑब्जेक्शंस करने हों, तो वो सभी हमारे सामने आते हैं एज ए विटनेस और हम उनको क्रॉस करते हैं, क्रॉस एग्जामिनेशन करते हैं, और जो भी कंटेंट्स ऐसे उस पर सभी मेंबर सवाल करते हैं।
लेकिन विपक्ष तो ये साफ तौर पे कहता है कि मुद्दों से भटकाने के लिए इस तरह के आप लेकर आते हैं।
देखिए, विपक्ष तो लगातार उन बैठकों में भाग ले रहा है। विपक्ष, अगर मैं जब असम और उड़ीसा के और वेस्ट बंगाल के टूर पे था तो उन्होंने कहा कि हम नहीं जाएंगे, तो हमने उनका इतना ऑनर किया कि हमने असम और उड़ीसा के बाद अपना टूर हमने स्थगित कर दिया। तो मैं तो ज्वाइंट पार्लियामेंट्री कमेटी को किसी पार्टी लाइन पे नहीं देखता हूँ, और ज्वाइंट पार्लियामेंट्री कमेटी होती भी नहीं है। ज्वाइंट पार्लियामेंट्री कमेटी या पार्लियामेंट्री स्टैंडिंग कमेटी, पार्लियामेंट में तो हम एक बार अपनी आइडियोलॉजी के साथ, पार्टी की आइडियोलॉजी के साथ चलते हैं, लेकिन जब हम स्टैंडिंग कमेटी में बैठते हैं या जेपीसी में बैठते हैं तो वहाँ कम से कम हम वो बात करते हैं जो कॉन्शियस हो या देश के हित में हो या आम जनता के फायदे में हो या जो लीगली जिस तरीके से हो। तो मुझे लगता है कि अभी तो ये बात क्यों कमेंट करनी चाहिए, जब हम उस प्रोसेस में उन्हीं लोगों ने डिमांड किया कि साहब इसका समय बढ़ा दिया जाए
जी।
तो आप ही बताइए कि अगर समय भी बढ़ा दिया गया तो सरकार की क्या मंशा है? सरकार की मंशा है कि ज़्यादा से ज़्यादा के लोगों के साथ इंटरेक्शन हो सके। जितने लोगों स्टेक होल्डर्स हैं, अभी 2 दिन पहले हमने देवबंद के इस्लामिक स्कॉलर को, मौलाना अरशद मदनी साहब को बुलाया था, वहाँ के वाइस चांसलर को बुलाया था, उनसे पूछिए, 3.5 घंटे उनके साथ डिबेट हुई। जो स्टेक होल्डर्स आए हैं, चाहे मतलब हमारे ऑल इंडिया मुस्लिम पर्सनल लॉ बोर्ड हो, चाहे जमात उलमा हो, चाहे ऑल इंडिया सुन्नी मुस्लिम पर्सनल लॉ बोर्ड हो, चाहे सिया के हों या चाहे देवबंद हो, चाहे अजमेर शरीफ के सज्जादा नसीन हो या मुंबई के अपने हाजी अली दरगाह के हों या उड़ीसा बंगाल के, मतलब हैदराबाद में गया ओवैसी साहब से पूछिए, ओवैसी साहब से पूछ लीजिए, उनको बुला लीजिए, हमारे सामने डिबेट कराइए। हमको अकेले क्यों बात कर रहे हैं? आज आपको डिबेट करना था मेरे साथ करते, तब मुझसे वक्त पे पूछते, तो मैं एज ए चेयरमैन मैं बिल्कुल तैयार हूँ, और जब भी कभी चाहिए बुला लीजिए मुझे।
वैसे से आप तैयार हैं?
बिल्कुल तैयार हूँ, बिल्कुल तैयार हूँ
पाल साहब,
बिल्कुल तैयार हूँ, वक्त पे जब बात करना चाहे कर ले।
Okay, all right. Sir, we will of course take you up on that very, very soon. A huge round of applause, please, for Shri Jagdambika Pal, who's joined us at the 3rd Law and Constitution Dialogue. Thank you so much, sir, for being with us.
Thank you very much. Could I request Kartikeya Sharma ji to kindly come on stage to felicitate Jagdambika ji. I know you've just spoken in the Lok Sabha on the Constitution, so we have a copy of the Constitution for you to take home, sir. Let's have a round of applause, please. He's literally just come from the Lok Sabha straight after his speech. There was a 2 adjournments that took place, which is why he's got delayed, but thank you very much for coming. This is a copy, sir, of the 1946 Constituent Assembly. With that, could I request one of our honored guests, Vasu Ranjan Shandilia, to kindly come on stage. We're going to get another copy of the Constitution. Vasu, if you're here on stage. Yeah, okay, we'll do that very shortly. We'll get the photograph taken very, very shortly. Could I just request then our team to get set for the next session? Tarun Nangia will be moderating. We have with us Mr. Ashok Kumar Mittal, who is a Member of Parliament in the Rajya Sabha. He is the founder and Chancellor of LPU. Professor Dr. C. Rajkumar, founding Vice Chancellor of O.P. Jindal Global University, is with us. And Justice A.N. Mittal, former Judge of the Allahabad High Court, all with us. We were going to be discussing next in legal education and beyond. Let's have that conversation. Tarun, can we get you on stage, please?
Good evening, all of you, and this is one of my favorite subjects, legal education, next in law, what's happening next in law, and a very eminent panel that I have today. We have representations from politics, from law, and from education. So all the three bases are covered. But without wasting much time, we will start with somebody who has revolutionized legal education in the country. Professor Rajkumar. The last thing was about last week when we all got an opportunity. Even Honorable MP, Shri Kartikeya Sharma ji also visited the Constitution Museum. And we saw learning via being part of the museum, via interactive learning. Movie theater where you can sit and learn. So you're changing education. Could you just reflect on that before we move on?
Yeah, thank you so much, Tarun. There was an effort which was quite unique for an institution to be able to establish a museum. And one of the things that when we set out to establish the Constitution Museum was that we had 5 objectives, and one was to promote civic education. For a lot of us, the Constitution ended up becoming a tool for lawyers and judges, but it has not yet seeped into the imagination of ordinary people of India. And so the first objective was to be able to promote enlightened citizenship and civic education. When you and I were in school, we had a subject called civics. Yes. And that subject, we got introduced to Constitution. But over the years, neither the subject exists nor the Constitution is taught in the way we had learned. In fact, I can say about all 4 of us in the panel. The second was that we were very conscious of the fact that we wanted to celebrate the members of the Constituent Assembly. If I ask many of us here, you would probably identify 10 members of the Assembly at most, maybe 15, 20. But the 300 members of the Assembly who were unsung heroes, so little were known about them, including 15 outstanding women who actively participated, so we want to pay tribute to them. The third objective was that we were very conscious of the fact that we need to make the Constitution more democratic and accessible for people. So in terms of information about the Constitution, we want to ensure that ordinary people are able to visit the museum. So the museum is an open invitation for people, and we don't charge anything as well. And the fourth, of course, was to recognize the fact that we are also celebrating the 75th anniversary of the adoption of the Constitution and what has happened in the last 75 years. And the fifth was to use the university, where a lot of young people are there, to be able to promote that ideas of Constitution and democratic governance so that they can become responsible citizens in the future.
Thank you, thank you. We'll go to Professor Ashok Kumar for his opening comment on legal education and what next for legal education. India is a country where, we have so many graduating and so many lawyers every year. Of course, now law has become diverse. There are lawyers practicing artificial intelligence as a stream, which the older lawyers are not. So how legal education needs to keep pace with the changing requirements of today's India?
Thank you very much, Tarunji. Actually, all systems are evolving, so is education. And of course, legal education is no exception to that. And I'm happy that in India, the legal education has been seen in a different way and being evolved regularly. Like, you are talking about artificial intelligence.
if a new laws come on artificial intelligence, it's bound to come. There is nothing new in that. If there is a law, there will be evolution of education with that law. There used to be sale tax, then VAT came, now GST came. So we continue to evolve education. Similarly, in technical side also, if the new law comes, new technology comes, we'll have to evolve law, and that's a continuous process. But more than that, what I feel, it is said, students, while he's in college or in university, is he really learning law? Is it? Or not? That's a question. I also was a law student. So when you're in college, we do study 20, 30, 40 laws in 3 years or 5 years, not more than that. But there are thousands of laws in our country alone. Central laws, then state laws, then local laws, so many other things. So we can't study all the law. We understand the concept of law. That's one thing. Do we practice law while we are a student? Second question. No. There is internship. We do send our students to courts, 6 weeks visits, 2 months visits. But what do they do there? I was a student. He was also a student. What do they? We just go, chat, discuss, take tea and come back. We don't learn. We didn't used to visit courts. Means no learning. So how can we combat that problem? And advocates were given us good certificate that he has done a good job without being done any work in the court. So at LPU, we have evolved a process to combat that. Okay, we say that you will go for internship and will be paid for that. If you are getting money for your services being rendered to some advocate or to some organization, it means you are doing some serious work. Because when an organization or an advocate pays you money, he will make sure that you work there. And we evaluate how much money do you earn while you are under the supervision of some advocate or some other agency or some other organization. So that's our benchmark, one of the benchmarks. Of course, we do see what has he learned, what has he not learned, but that's one of the important benchmarks. And we also involve them, okay, please do some drafting, and especially when they are working some legal firms. The drafting is important there. Are you able to do drafting? And you are being paid for that drafting by that legal firm? So that kind of things we are doing. And I hope
the judges usually have the last word on every segment. So I think Justice A.N. Mittal, your opening comment on this and what both the eminent chancellors said and how you see law, legal education progressing in this country.
Thank you very much for calling me here. Certainly, as two panelists have said, that certain improvements have been done in the legal education, but still, taking into consideration the modern technologies, and everybody knows that now law is the only study after doing it one cannot be unemployed. He will get job as per his qualification, as per his choice, no doubt. But as far as the legal education is concerned, certainly as told that there are thousands of laws which one cannot study. I agree with that. The syllabus must be drafted in such a way. Now everywhere the 5-year law course is being done. In 5 years course, we utilize 2 years for the either arts subject or science subject or some management subject or some other. My opinion is that instead of that 2 year, utilizing for the teaching of history, geography, whatever it is, it should be only 1 year. And next 2 years must be general studies of the law, like legal history, like jurisprudence, like Constitution of India, like other aspects, torts, and other things. Now, as I have experienced that if a person wants to go to a law firm or he is opting for the corporate law, you are giving him an education in the Indian Penal Code that is not required for him, because he will not practice in the criminal side. May be possible that he may switch over to the criminal side, but as you told that every law is not possible to be studied. So my opinion is that 1 year should be devoted to the art subject, next 2 years must be devoted to the general subjects, and remaining 2 years there must be specialization studies. Somebody wants to go to taxation, IPC is irrelevant for him. Somebody wants to go to constitution, for litigation, for him CPC is most relevant, drafting is most relevant, pleadings is most relevant, conveyancing is most relevant. So my opinion is that first year general subject, next 2 years general legal subjects, and next 2 years specialized subjects, and I suppose that only 6 months are given for the specialized subject. One option is taken from the student that whether he wants which specialized subject, maybe personal law, maybe constitutional law, maybe property law, maybe taxation, maybe international law, maybe personal law, whatever it is. So my opinion is that at least in a five-year law course, 2 years must be devoted for the specialization of that course.
Point very well taken. We'll take a final question. We have two honorable MPs, Kartikeya Sharma ji and Vivek Tankha ji. The idea of next gen law came from him. So one question from him. Secondly, from Vivek Tankha ji, I learned is a deep involvement in education in Madhya Pradesh. In education. So you need lawyers in Gram Panchayats also. Those small courts where you work with so many bar associations, the kind of legal education required there is entirely different. Not the complicated sort of education that you need in Supreme Court, Delhi High Court or other commercial courts. So before we end this, one large question each from both the MPs, and then we can end this panel.
No, in fact, this is a very distinguished panel that you have in front of us. My one question to the panel is that a lot of new subjects have crept into our system. A lot of old subjects are not relevant as much in terms of actual practice. And we've been emphasizing, Rajkumar ji was there in our committee also, standing committee, that there's a huge need to revamp the curriculum. We are, you know, what was 30 years back, the curriculum continues to be the curriculum even today. When, like for instance, AI is the new buzzword. Now, so on and so forth, there are many subjects which today we do read in the law faculties. But virtually they have no relevance when we come into practice. I feel that a lot of new subjects which are relevant for today's world need to be introduced in the curriculum. That's what I feel.
And one question from a member of parliament, Kartikeya.
Well, I think maybe the process needs to become more easier for full-time professionals to become lawyers. That has become a big challenge. I think the way the space has evolved, people who have interest in law, but are professionals in their own profession or running businesses or whatever, do not find it very easy to do a law program anymore, what used to be the case. So a specialized program for professionals who want to learn law, it should be there, and then there should be a distinction between a graduate and a professional who's already reached a certain understanding. They cannot be treated the same. So if something of that sort can be done, would be greatly appreciated.
Two good suggestions if anybody wants to comment, and then we end.
Thank you very much. Kartikeya is my colleague. It's up to Bar Council of India. If they amend certain rules, it is doable. UGC, AICT, other regulatory bodies have already done that. The professionals are said professor of practice as far as the education is concerned. Similarly, those who are professionals or professors, they should also be allowed to do practice. Some tweaking is required in the rules, not even the law, in the rules of Bar Council of India. Yeah, BCI rules. I think you can play important role in that.
So, Karthikeya, quickly I want to respond that if you are not keen to use the law degree for legal practice, that innovation has already happened in the sense that it has come much late in India. We started almost 4 years ago a BA in legal studies. NLS Bangalore just brought the humanities and social sciences in the form of a BA program. We have master's degree which are not LLM but masters focusing on law and business. So these are all precisely meant for professionals who want to study law but may not necessarily want to practice law. And globally that has been the trend. And Bar Council does not come into the picture because BCI is much more interested to focus on the legal practice. To answer your question, I entirely agree with you. The curriculum and course structure needs much more constant revision because of the kind of social, institutional and even business expectations from the role of lawyers. We are only in the early stages of artificial intelligence and robotics and machine learning. Increasingly, we will find more and more issues of this kind which are intersectional issues where it will have constitutional law implications, administrative law implications, even commercial law implications, and the existing paradigm of legal education is woefully inadequate. Although I must confess that the BCI does not prohibit innovations within a law school to do that. And so many schools have done it, including ours. But at a larger level, when we have 1,750 law schools in India, there is a need for a regulatory architecture which should push that reform.
Thank you, Professor Rajkumar, Honorable MP Ashok Kumar ji. And
certainly, I agree with Mr. Tankha that the law syllabus must be revisualized, and much emphasis must be given on the part of the drafting, who wants to go in the law firm or in the practice. And certainly, it shall be a good step that if the law professors are also permitted to practice in a court of law. And one thing I may also tell, that there is much difference in LLB and LLM. In LLB, it is taught that this is the law. But in LLM, you study that why this is the law and what is the law of other countries. The goal of a LLB student is to take a degree. But the goal of the LLM student is to gain the knowledge about the law. And I am surprised. I just came to know that there are 1 year LLM. In 1 year LLM, what you can do? Unless you study the constitutional debates, you cannot understand the constitution. Unless you study the Saman, the Dean Roscoe Pound, HLA Hart, you cannot understand the jurisprudence. So the specialized studies must be done.
Thank you so much for making time and coming on this panel. Thank you so much.
Thank all of our experts for joining us today. And I request Karthikeya Sharma ji to please join us on stage to present a token of our appreciation to Professor C. Rajkumar, Founding Vice Chancellor of OP Jindal Global, to Mr. Ashok Kumar Mittal, Rajya Sabha MP and Founder and Chancellor of LPU, and Justice A.N. Mittal, former judge of the Allahabad High Court. Much to take away from that conversation on Next in Law. Is legal education keeping up with the times? With that, ladies and gentlemen, I will take a moment to introduce our next set of guests. Joining us at the third Law and Constitution Dialogue is Shri Subimal Bhattacharjee, cyber technology expert. I'm going to request all our guests to start making their way to the stage, please. Shri Subimal Bhattacharjee, cyber technology expert. Ms. Meghna Bal, Director, SCA Center and Advisor, Koan. Shri K.J. Alphonse, former Union Minister and Advocate. And Shri Karthikeya Sharma, Rajya Sabha MP. Our last conversation for the day revolves around artificial intelligence. Is it a threat to governance, politics and judiciary? It will be moderated by Mr. Rishabh Gulati, Editor-in-Chief of NewsX.
Hello, I'm Karthik. Nice to meet you. So please. Thank you. That's the norm. Yes, sir.
Can I get my mic working? Thank you very much. All right, it's been a marathon day. We've done 21 sessions. We've had 22 members of parliament. We've had sitting judges of the Supreme Court. We've had the law minister. And here we are to have a specific question. And it's a privilege not only to have one of the members of the Rajya Sabha, who's of course the founder of this network, who serves in the parliamentary committee that deals with this subject, but also the person who's been a former union minister under the subject would have come, and it's a brand new subject to talk about. Let me start with Karthik ji to just get a perspective on this. Karthik ji, about 2 months ago, there was a case reported that somebody used a deep fake of Sunil Bharti Mittal trying to convince his own company employees to start transferring funds in Dubai. Just 2 weeks ago, this is a case from England where deep fake videos of Elon Musk have been used in a Bitcoin scam. We are now talking about millions of dollars where if you get a video call and it looks like your CEO and your chairman is on the video call and he's asking you to quickly transfer funds, and sometimes the employee will just do it. It's becoming that scary. Are we ready for this world, sir?
Rishabh, I'd just say the genie's out of the bottle. And it's very difficult to quantify or pontify how it will evolve. I think it was at the second Law and Constitution dialogue where Justice Suryakant spoke about the perils and the dangers of AI if it were not regulated and if the issues were not addressed exactly a year ago. So, because I sit on the IT committee and this is an issue which has come up before us, what I can definitely say is that, we really need to have a framework to address this issue. It's an evolutionary space that we are in. There has been legislation which has been made. The European Union Parliament has just recently done that. But it has not been coherent and it has not been done in the same systematic way everywhere. And because of the nature of the product and the impact it has, it is very, very difficult to understand and quantify how it will impact each and every aspect that it touches. So, a lot of discourse, discussion, debate needs to be done before we can actually start getting to that point where we can regulate and bring it into a framework. Yes, to answer your question, without regulation, we're going to face some very serious challenges.
Okay, KJ informs 2017. We have an individual called Jordan Peters. He made that first Barack Obama deepfake video, which released on YouTube. And he said, listen, I can do it. It just took me a few months to do it. Today, with a simple GPU, freely available software, you can use HeyGen on the internet. Taking videos from the internet, you can not only recreate the voice, you can recreate the face speaking that voice. It's already here, sir. We have to catch up. How do we catch up?
Let me take a very radical stand. I think the human species is already finished. We don't exist anymore. The fact that we human race, species, is today dependent on your mobile, on the social media platforms for truth, and for our responses, and for our emotions. I think the human species is already finished. It's dead. What can we retrieve out of it? Things are going to get worse. Today, you tell me if the human species is there, he's supposed to use his intelligence. Today, with the kind of dependence we have on the social media that everybody has, not only the kids, are we thinking? Are we reacting emotionally the way we should rationally? We are not. Now, with the AI coming in, things are going to get much worse.
Can we regulate? I don't really think so, because the way technology is evolving, I don't really think anybody can cope up with regulations and bring in regulations anticipating what's going to happen. Because the kind of development that's going to happen is so quick that before we can even respond to it, things are going to change. It's like I got COVID 5 times. And I asked my doctor, why is it that I've taken all the vaccination? He said, no, this is a different variant. You are vaccinated against the other one. The same thing is going to happen here. You're going to have a regulation coming in, and within a few weeks, that regulation is not going to, is incapable of taking care of the new technology which is going to happen within weeks, not even years. Earlier it was decades, then it came years, now it's going to be weeks in which new technology is going to come. And in any case, my view is the human species is dead. I made a statement in the parliament to the Minister for Environment. I said there's an Oxford study which says that the human species will be extinct in the next 100 years. And a very mischievous question, will the government expedite the process? And the minister, of course, said yes, yes, yes.
Okay, I was in school when the movie The Matrix came out, but let me get Meghna in on this. Meghna, how real is this? Is it because in India, somebody faking a video of Narayan Murthy, okay, and saying that, you know, invest in this scam. These scams are real. That's happening right now. Now, we are coming to term, we were having a discussion on digital arrests, where people call you and they say, I'm calling from crime bureau, okay, you are about to be sent to prison unless you give us money and do this, do that. This is a world we are tackling with. What happens when it sounds like the actual commissioner of police is calling you?
First of all, I'm not sure whether the recipient would know what the actual commissioner of police would sound like, but let's get empirics into it, right? Because all policy decisions should be evidence-based. And the evidence around deepfakes is that people do not find them any more convincing than other forms of misinformation. In fact, there's this wide study that was done by Harvard researchers of 5,000 respondents. They don't find it any more convincing than other textual or audio misinformation that is not AI-based. And a lot of it, and their inclination to believe it, kind of attenuates with their political beliefs. So that's one consideration. The other consideration is that when you look at the last general election in India, there was a huge concern that deepfakes were going to take over. But when, you know, the forensics came out, it emerged that it only accounted for about 1% of misinformation. And the other, I mean, what I'm getting to is that there is this belief that deepfakes are inherently bad or inherently illegal, but they have a lot of benign uses as well. I mean, the technology can be used for cancer research. It's used by NGOs to, you know, get their messages out to a wider audience. So, for instance, an NGO in the UK used it to make David Beckham speak in multiple languages. You know, there's an app called MugLife where you can animate pictures. So it has a lot of benign uses, benign use cases. The problem is that there's this perception that it is inherently bad, but it isn't. And that is, and if you're talking about deepfakes, again, you're not talking about a novel harm, right? You're talking about misinformation and disinformation. And if you look at technology longitudinally, you can't look at deepfakes just as a new avatar of misinformation without considering the history of misinformation.
So misinformation is going to happen whether people are forging letterheads and signatures or they're forging videos. But does it become a lot more difficult? Are you as cynical on this, Mr. Bhattacharjee, that we are in a lot of trouble and we don't even know it yet?
Well, we are. Is it working? Thank you. Well, we are in trouble, but we are not in that level of trouble that possibly it's made out to be. Artificial intelligence is not something that came when ChatGPT came. It was there for more than 30, 40 years. Myself, as a student of mathematics, 30 years back, I have studied artificial intelligence. The problem started when the generative AI started coming in the scenario, and it could do a lot of things that possibly we thought wouldn't be possible in the period of time that it has come in the horizon. The large language models, the huge amounts of data that we have, and the processing of the data, the algorithms, the biases that they carry, all of that have created a scenario where the scope for misuse and going to do things that possibly could challenge mankind arises. So it's a question of the time that we will have to legislate, we will have to bring the society
to those levels of understanding.
No, but what the question then is for the people who are going to be part of the legislature, one of them is sitting with you. What is the legislation? How do we legislate? Do you say that these websites, do they have to be watermarked? What can you come up with that somebody within a couple of hours can't get around?
I think there are attempts already being made, and as Mr. Sharma mentioned about the European Union's ratification by the countries is just now happening, and then it should be in place. But to come more to your point, I think even if you look at India, when we don't have a specific artificial intelligence legislation, but if you look at the provisions of the Data Protection Act, or even if you go back to the IT Act of 2000, we would have ways and means to look at AI because it is fundamentally dealing with data. A large concept if you look at it.
AI is a different thing, because as we speak, one of India's largest news agencies has just sued ChatGPT for copyright infringement because it takes all their content and then spits it out without giving them credit. So that's a whole different conversation. But before I get the MPs back, let me get Meghna back in. Meghna, do I own my own face and voice once I upload videos on the internet? Does Barack Obama still own them? Does Elon Musk still own them? Can you impersonate someone? Is that legal?
Yeah, so Indian courts are very clear on personality rights. And it's also, an infringement of your privacy right, on your voice, on your likeness, on the reproduction of your likeness. There was a case involving Anil Kapoor, but earlier cases as well on this. So it's very clear that personality rights are a no-go area. And if you go on ChatGPT and you ask it to generate an image of a public personality, it refuses to do so. You were talking about regulation, so let's talk about it from a standpoint of watermarking, which is something the European Union has put out. Watermarking is extremely ineffective when it comes to deepfakes because it can be manipulated really easily. Detection is the other kind of technological solution. Again, not very future-proof because it becomes harder and harder. Basically how deepfakes work is that there is a generator and a detector, and the whole point of the deepfake is to fool the detector. So you have a technology where detection is, basically set up to fail. So the point is that I don't think we should hard code these things because the European Union has come out with an act that lacks proportionality as well as granularity. There are a lot of loopholes in it. At the same time, it over-regulates. I think what we need to do is we need to continue to prompt larger companies to think innovatively about how they can mitigate the harms of their products. At the same time, as we've seen, there was a sting by India Today last year that showed that a lot of the deepfake production is actually happening offline, where there are these agencies that are soliciting politicians and other kinds of public personalities to engage with them so that they can generate deepfakes of the opposition, etc. So I think forensics need to get into it.
So it's forensics, but now we receive the other, because now no matter what you hear or what you see, the person just says, oh, this is an AI deepfake, or my voice doesn't exist. But Kartikeji, the sort of trend in governance in India on these deeply technical matters often in the past has been what the Europeans are doing and what the Americans are doing. How do we carve our own path?
I think we've come out of that mindset. We are not following suit as we used to. And I think that's a welcome change in the mindset of the lawmakers in our country. And because every situation, every country is very different. In this particular matter, I don't think technology per se is bad. The intent to use it is bad or good. So for instance, you can use AI in medicine for development and betterment of medicine, and you can also use it for biological terrorism. Now, what do you put it to use at? That is the question, because AI, to me as a layman, unlike the others on this panel, for me it's the power, the computing power, coupled with categorized and readable data. When you merge the two, anything is possible. Now, where do you stop? The problem is, so as a regulation has to basically play the role of what not to do and what is bad for us, or what could possibly or plausibly be bad for us. That is what we need to focus on. And if we can, and there's no right or wrong answer for it, it's work in progress. And we have to evolve as we go along. As a matter of fact, as a independent member of parliament, I have written, and I'm actually putting together a small proposal where I think we should institute a committee of future affairs in this country, because that's something that we are, we are at the same disadvantage.
This would be a parliamentary committee of future affairs.
Absolutely, why not? I mean, that's what the need of the hour is, because we are confronted with the problems that the rest of the world is also seeing at the same time. They don't have any tacit advantage over us. Now we need to sort of get ahead of the curve and understand how does it affect us, especially in the adversarial manner.
Okay,
and if we can quantify that, that will at least solve a big part of the problem, if not the whole problem.
Okay, so you and I, often talk about data darkness, all right? So are you getting inputs from industry, the best of the best, the guys who know how to do this, that this is what's happening, this is what the problem is, this is how deep it is, this is the number of cases?
So, Rishabh, no one controls AI and its evolution, and no one can. It's impossible to do so. So you have to get ahead of it and curate it. That's your best shot at being able to try and get the regulation in which will not adversely affect people, their fundamental rights, and any transgression that happens. So, I mean, we have to understand there's no right or wrong, black or white. We have to just try and understand how the medium is evolving, get ahead of the curve, and try and safeguard the fundamental rights and the fundamental premise that the law and our constitution grants to each and every individual.
Okay, let me be less dystopian, Mr. Alphonse, because the same was said when the hydrogen bomb was built, that that's the end of humanity. We went through when we first got connected to the internet and viruses became smarter than antivirus software. We've sort of gotten past that. We have survived it. We are more interconnected. All of us have a device in our pocket that's permanently connected. Who's listening to it all the time, whether it is the big tech companies or worse, we don't know. But is it necessarily a doomsday scenario?
Yeah, no, let me come to the positive part. Being a former IAS officer, if I had this AI technology or generative technology when I was a district collector of Kottayam, and incidentally Kottayam is the only zero poverty district in the country, I was a district collector there for 4 years, I could have done much bigger miracles as a district collector. And later, I was Commissioner of Delhi Development Authority. I would have functioned much more effectively if I had these present tools of the AI. Forget about generative AI, just AI, what exists today. I could have done a much better job of demolishing. I was a demolition man. As a member of parliament, as an independent MLA, I became an independent MLA. I could have used the tools so much more effectively to deliver health care, education, so many things in my constituency. If I had these tools when I was the MLA, just about 15 years back, as tourism minister of India, I could have just sold India so much better if I had these tools. So there is so much of positivism in this, but the problem really is the human race is destructive. Our mind is an anarchy, it's in our DNA, it's in we are a wicked species. There is no other species on the face of the earth.
So are the machines taking over then?
Pardon?
Will the machines take over then?
Of course the machine is taken over, that's what I was saying. It's taken over, it's going to get worse. Today, every decision that we take basically depends on the social media and your self-esteem, what you think you are. Can you talk to young people about dreams? About what they want to do with their life? They say, what? What is a dream? You are living in some other world? I've just written a book saying the winning formula. No, and people are going to say, you are crazy. You're talking about dreams and making a difference with your life. These things don't come on my social media anymore. The biggest social media guy today, I think, YouTube guy, is a chap called Beast. Yeah. Beast has got 70 million followers.
Oh, it's 100 million plus now, sir.
What does the Beast convey? I really think, and a whole lot of people with 50 million, 100 million followers, it's all trash. And this is what.
Okay, but we've heard this before.
I'm sorry, but just to extend what sir is saying, we've not been able to regulate social media. It's been around for a while, and you're talking about AI. So it's not as simple as that. And one of the jobs that will be in danger is also of journalists.
Yeah, true that. I mean, I can make a deep fake of myself and then go home. There will be somebody else anchoring right now.
May I say
which
one
will
more
look
word?
like me.
I think we're just going to have complete anarchy. What's going to happen? You think our bank accounts are safe? We read every day 100 million passwords being stolen, and tomorrow It's going to be so much easier to steal anything under the sun.
Okay,
and
but
nothing, you will know nothing.
Okay, so the question is, we have to navigate this. I've seen these conversations that when we were young, we were told don't watch too much television. Now kids are doing doomsday scrolling. They just keep scrolling. So it's a different kind of problem. But let me take it to the root level, Mr. Bhattacharya. When you go to the police and you have one of these scams on which now Netflix series are being made, that these guys do fishing expeditions, and if they make 1,000 calls, so somebody will give them their OTP, or somebody will let them download an app that lets them take over their phone and do banking transactions. It's a zero priority for the police. They don't take it seriously. They make a note of it and hope maybe your bank reimburses you. It's not a policing priority. It doesn't seem to be a legislative priority because this is a well-known problem before we get into the deepfakes.
My phone was lost day for us today. My
Sir.
iPhone stolen. With all the IDs and everything, cops say when he switches it on, someday we will track it down.
Yeah, it's a truism, yes.
Well, what happens is, Rishabh, the police community across the country are already overwhelmed with the number of cases that come and the nature of the cases that come. And that is a much bigger worry. If you see the national portal for cybercrime reporting, 1930 and cybercrime.gov.in, on an average they got about 60 to 70,000 calls daily. So that would be possibly 1/10 of what actually is happening, because people don't report generally such kind of cyber crimes out of various reasons. Now, police themselves per se, as you said, they try to avoid or keep you away, and then they are already overwhelmed with the kind of things that are coming. So I think there is a massive
But has
awareness.
the cybercrime become easier? Because earlier, okay, if the guy had to sit and dial 100 numbers, now he has a bot, okay, that
yes.
tells you I'm TRAI and I'm about to block your phone.
Absolutely.
Press this button.
Absolutely. AI has become a force multiplier for cyber attacks and on the modules with which you do the kind of cyber attacks that are happening. So definitely that is there. But I think, we still don't have a doomsday scenario. I think it's a question of optimal management. We need to track when we go to the regulatory part, the computing speed at which things are going, where one day the machines might take over the speed at a high, at which the human brain processes, and two, all the different apps and possibilities that happen because your algorithms are getting so much more faster and sophisticated,
Yes,
and
but
all of
trust
that.
me, as a journalist, I live by YouTube algorithm and I fear it.
This on technology. Sorry, the human mind functions much lower
Okay,
speed
all right,
than...
all right.
than-
I have limited time because I have to let you guys go home and have dinner.
Fraud chat 4.0.
Yes, absolutely. So, but Meghna, as a person who literally researches this and works in this and deals with the stakeholders, how do you then educate those who have to eventually legislate? What do you provide them?
So I think Mr. Alphonse kind of touched on it. One is that there need to be widespread sensitization and awareness campaigns with the public. So it's a strategy of inoculation in a sense, where you're basically informing people that, it's typically not common practice, and companies have to do it as well. I mean, it's not only about people calling people and pretending to be, they're using their boss's voice. Even phishing emails are extremely effective, where someone pretends to be your boss and gets you to give them money. I mean, it happened to someone in my organization. We couldn't believe it, that she actually believed that someone else in the organization would ask her for 50,000 rupees over email, but she sent the money anyway. So that's what I'm saying, is that these things need to be considered holistically. AI is just a means. Yes, it definitely can be a false multiplier, but it's just a means to a certain type of harm. It's not that there are not other technological means as well. The biggest kind of way to safeguard against this is to inoculate, which is to inform the public, to make people more aware, and to sensitize them to the fact that, one, the police is not going to be, calling you and to arrest you on video chat. But I think the other side of that is, particularly in the context of these digital arrests, is that there needs to be a little more trust building between the public and these law enforcement institutions, right? Because I think there is a trust deficit there, which is what these scamsters are able to leverage and take
Mr.
advantage
Bhattacharya, I'll leave the last word with you, because earlier it was greed, right? They would tempt you that you won 10 lakh rupees. If you just give us this OTP, we'll transfer the money to your account. Now it's fear. all right? We've caught you, we're going to arrest your family, we'll arrest your son, we have some basic data about you, which we obviously gleaned from some fishing expedition, and you're now scared, right? You're scared, not maybe because you committed a crime, because you think that the agency can frame you nonetheless, and you're willing to pay up. So what awareness do we do here? When you get that call, what awareness can we do? How do you know? What do you do?
No, I think you have to understand very clearly that, a policeman is not going to come on a chat room and then call you to another room where someone changes his uniform or something like. I think that basic understanding has to be there, and I'm happy the government is doing some kind of a campaign also. However, Rishabh, I think, and we have the presence of a member of parliament, former minister, and a very credible bureaucrat, that we should look at getting the corporates to put a certain % of their advertisement budget into awareness building. I have told most of the banks and all that, even if you put 2% of your advertisement budget in doing this awareness thing, it really helps.
Okay, all right, we have a practical solution, yeah.
I think it's the solution's a lot simpler than that. You don't need to spend any money. We know that what are the gateways that people come through on, just the banks themselves. Every time a customer comes and logs in, they have to go through a gateway. If they only use that gateway to inform people, that itself will be very educative, because their reach is so large. And if you say, let's say, someone like Google, you get them on board and say, this is the service that we want you to do, and many other platforms like Paytm and so on and so forth, reach is not a problem. It's their willingness to do it and actually dedicate a certain aspect of the inventory towards it. So they won't actually have to spend monies, they just have to use those gateways where everyone goes through those gateways on a regular basis anyway.
Okay, I know we are out of time on this conversation, but for all of those who've been watching at home, you'll have to think about it. This is why we're having the conversation, because it's become a serious issue. I remember looking at the Barack Obama deepfake 7 years ago and going, oh, this is interesting. In fact, this is actually pretty cool. And now understanding that people are losing money, that doesn't mean that what is representative. Yeah, go on, make a point.
Rishabh, one thing I want to add, we do have a safer double-step authentication system in India
than anywhere in the world,
compared to anywhere else in the world.
The OTP, which we all love to hate.
So it's not that we've not regulated or we are not taking care. The problem is awareness. And ultimately, unless it is addressed, people will keep on getting sick.
Yes, so
Can
please.
I tell you one thing positive?
People are trapped to share their, OTP, and that's the social engineering part is a big issue.
I'll tell you the one positive thing. I lost my laptop from India International Center. The police put 15 cops on the job. I got my laptop within 6 hours. Otherwise, I had no backup. My book would have been gone. Within 6 hours, they traced it and amazing results.
So it is possible. So technically it is possible. It is possible to do these things, but it's a matter of getting it done amongst a whole host of priorities. But be aware is where we're going to leave it on to, because this is now here. It might sound like your father's voice or mother's voice or your friend's voice. It may not be. So you have to think twice over. Karthikeya Sharma, KJ Alphonse, Mr. Bhattacharjee, and of course Meghna Bal. Thank you very much. And thank you for this concluding session of the third Law and Constitution Dialogue on the eve of the 75th anniversary. Thank you and good night to all our viewers who've been watching this across 9 news channels and across 42 live streams all over the internet. Thank you very much for watching.
Never say never.
Dr. Gupta has his own viral moment because he's the one who postulated so much. I used to come to the studio. I know someone Noida. Absolutely. There's a video of somebody giving 60 cards.
Thank you so much, Mr. Alphonse, for taking out the time for this, sir. And thank you so much to Mr. Subimal Bhattacharjee and Ms. Meghna Bal for taking out the time to have this very important conversation at the third Law and Constitution Dialogue. Extremely pressing matters of the modern world have been discussed, and hopefully our viewers, our live audience, have a lot to take back from the day that we've had. I'd also like to inform everyone that you'll be able to find all sessions on NewsX YouTube so that you can go back, watched something that you've perhaps missed. With that, we come to the end of the third Law and Constitution Dialogue. I do request all of our guests in the audience to please kindly join us for dinner on the terrace.
We are the mainstream media's dedicated platform to serve India's legal community.
एक देश, एक संविधान, एक झंडा. One country, one constitution, one flag. That is the core of our democracy. The legal community is the core of the core. We are here to build a community in the mainstream media for you. A platform for jurists, with jurists and by jurists. We are doing what it takes. Come join us and make this the go-to platform for serious news, views and conversations.
100 episodes of Legally Speaking have aired on NewsX, India's first and only primetime national television news show dedicated to the legal community. More than 100 dedicated columns published in the Sunday Guardian in print and online. More than 1,000 dedicated columns published in the Daily Guardian in print and online, with a dedicated website.
Today, law is a very popular profession. Today, a lot of people want to join